ಯಾವ್ಯಾವ್ದು ಕೈ ಹಾಕಿದಾರಮ್ಮ ಅದರಲ್ಲಿ? R6 and R9 ಬಾ ಐಎ ನಂಬರ್ಸ್ ಹೇಳ್ತೀರಾ ಹಂಗೆ? ಅದ್ಯಾರ್ಗೆ? 6 ಗಾ? 1 2 3 R9 ಗಾ? ಆಮೇಲೆ ಅಬ್ಜೆಕ್ಷನ್ ಏನಿಲ್ಲ ಅಲ್ವಾ? ಹಾ 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 ಅಲ್ಲೋಗಿ ಕೇಳಿ. ನಾನು ಹಾಕಿಸ್ತೀನಿ ಬಿಡಿ. ನೆಕ್ಸ್ಟ್ ವೆಡ್ನೆಸ್ಡೇ, ಇವತ್ತು ಕೇಳಕ್ಕೆ ಹೋಗ್ಬಿಡಿ. ನಾಳೆ ಆಗಲ್ಲ, ವೆಡ್ನೆಸ್ಡೇ ನೆಕ್ಸ್ಟ್ ವೆಡ್ನೆಸ್ಡೇ ಬೇಕೇ ಬೇಕಾ? ಏನಕ್ಕೆ ಹಾಕಿಲ್ವಂತೆ? ಏನಕ್ಕೆ ಪೋಸ್ಟ್ ಮಾಡಿಲ್ವಂತೆ? ಹಾಂ ಅದು ಯಾವುದೋ ಇದಂತೆ ನೋಡಿ, ಕ್ರಿಮಿನಲ್ ಪಿಟಿಷನ್ ನಾವು ಕೊಟ್ಟಿದ್ದೀವಿ ಬಂದಿಲ್ಲ ಬೈತಾರೆ. ಅಲ್ವಾ ಸಾಕಾಗುತ್ತೆ. ಮಧ್ಯಾಹ್ನ ಏನು ಗೊತ್ತಾವ, ಏನೋ ಅಷ್ಟು ಹೊರತಿದೆಯಾ ಈಗ ಏನೋ ಗೊತ್ತಾಗ್ತಾನೆ ಇಲ್ಲ. ನಂಗೆ ಗೊತ್ತು, ಓದ್ತಿನೂ ಹಂಗೆ ಮಾಡಿದ್ದಾರೆ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬರುತ್ತೆ ಬಿಡಿ, ಬೈತಾರೆ ಚೆನ್ನಾಗಿ ಬೈಸ್ಕೊಂತಾರೆ ಅಷ್ಟೇ. ಬೈತಾರೆ ಸಾಕಾಗ. ನಾಳೆ ಕೇಳಿ
ಏನ್ ಮೇಡಮ್ ಮ್ಯಾಕ್ಸ್ ಎಷ್ಟಾಗಿಲ್ಲ? 26 ಇಂದ ನೋಡಿ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀರಾ? ಕ್ರಿಮಿನಲ್ ಎಲ್ಲ ವೆಡ್ನೆಸ್ಡೇಗೆ ಅಂತ ಕೊಟ್ಟಿಲ್ವಾ? ಮತ್ತೆ ಕಂಪೋಸ್ಟ್ ಆಗಿಲ್ಲ ಕೇಳಿ. ಸರ್ಸಿಲ್ಲ ಅಂದ್ರೆ ಮಧ್ಯಾಹ್ನಕ್ಕೆ ಹಾಕಿದ್ದೀರಾ? ಆಯ್ತು, ಅದಕ್ಕೆ ಯಾಕೆ ಮೆಮೊ ಹಾಕ್ಬೇಕು? ಕೊಡಿ, ಯೂಸಲ್ ಕೋರ್ಸ್ ಅಲ್ಲಿ ಬರುತ್ತೆ, ಕೊಡಿ ಮೆಮೊ. ಕೊಡಿ ಕೊಡಿ ಕೊಡಿ, ಯೂಸಲ್ ಕೋರ್ಸ್ ಅಲ್ಲಿ ಬರುತ್ತೆ, ನಾಳೆಗಲ್ಲ. ಅದಕ್ಕೆ ಯಾಕೆ ಮೆಮೊ ಯಾಕೆ ಮೂವ್ ಮಾಡ್ತೀರಿ? ಕಂಪ್ಲೇಂಟ್ಸ್ ಮಾಡಕ್ಕಾಗಲ್ಲ, ಡಿಸ್ಮಿಸಲ್ ಆದ್ಮೇಲೆ ಮೆಮೊ ಬೇರೆ ಕೋರ್ಟ್ಗೆ ಬರ್ಲಿ. ಲೆಟ್ ಇಟ್ ಕಮ್. ಯು ಆಲ್ರೆಡಿ ಫೈಲ್ಡ್ ಅನ್ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ವಾ? ಯೂಸಲ್ ಕೋರ್ಸ್ ಅಲ್ಲಿ ಬರ್ಲಿ, ಅರ್ಜೆನ್ಸಿ ಏನಿಲ್ಲ. ಆಯ್ತು ಕೊಡ್ರಿ, ಮೆಮೊ ಕೊಡ್ರಿ, ಬರುತ್ತೆ ಟುಮಾರೋ. ಯಾಕೆ ಅರ್ಜೆನ್ಸಿ ಏನು? 22ರಿಂದ ಅರ್ಜೆನ್ಸಿ ಇರ್ಲಿಲ್ಲ, ಈಗೇನು 25ಕ್ಕೆ ಅರ್ಜೆನ್ಸಿ? ಕೊಡಿ ಕೊಡಿ, ಲೆಟ್ ಇಟ್ ಕಮ್ ಇನ್ ಯೂಸಲ್ ಕೋರ್ಸ್. ಆಯ್ತು ಬರ್ಲಿ ಬರ್ಲಿ, ಕೊಡಿ. ಟುಮಾರೋ ಏನ ಅಲ್ಲ ರೀ, ಯಾವ್ದಾರ ಡೆಮಾಲಿಷನ್ಸ್ ಆ ತರದ್ ಏನಾದ್ರು ಇದ್ರೆ ಕೇಳಿ, ಅರ್ಜೆನ್ಸಿ ನಾಳೆನೆ ತಗೊಳ್ತೀನಿ. ಮತ್ತೆ ಬರ್ಲಿ ಬರ್ಲಿ, ಕೊಡಿ. ನಾವೆಲ್ಲ 4 ದಿವಸದಲ್ಲಿ ಹಾಕ್ಸ್ತಾ ಇದೀವಿ, ಬರುತ್ತೆ ಅಲ್ವಾ ಮೇಡಮ್? 2 days ಅಲ್ಲಿ ಬರ್ತಾ ಇದೆಯಲ್ಲ? 2 days ಅಂದ್ರೆ ಆಯ್ತು, ಕೊಡಿ. ತಗೊಳ್ಳಿ ಮೆಮೋಸ್ ಎಲ್ಲ ತಗೊಳ್ಳಿ. ರೀಚ್ ಎಷ್ಟಾಗುತ್ತೆ? ಇವತ್ತು ಕೊಟ್ಟಿದ್ದಲ್ಲ, ನೆಕ್ಸ್ಟ್ ವೆಡ್ನೆಸ್ಡೇ ಕ್ರಿಮಿನಲ್ ಏನಾರು ಕೊಟ್ರೆ. ಬಟ್ ಮೊನ್ನೆ ಕೊಟ್ಟು ಮೆಮೊ ಹಾಕ್ತಿಲ್ದು ತರ್ಸ್ಕೊಳ್ಳಿ, ಯಾಕೆ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ. ಡೇಟ್ ಕೊಟ್ರೆ ಯಾಕೆ ಪೋಸ್ಟ್ ಮಾಡ್ಲಿಲ್ಲ ಅಂತ.
Mentioning from page number 6, 22 to 27.
Serial number 28, my lord.
ಅದರ್ ಸೈಡಿಗೆ ಇಂಟಿಮೇಟ್ ಮಾಡಿದೀರಾ? ಗುರುದೇವ್ ಟಿ ಗಚ್ಚಿನ ಮಟ್ಟಿಗೆ ನೀವು ಅಪಲೆಂಟ್ಗ ಬಟ್ ಹೇಳಿದಾರೆ ಅಂತ ನಿಮ್ ಕನ್ಫರ್ಮ್ ಇದ್ರೆ ಹೇಳಿ, ಇಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲ ತಗೊಳ್ಳಿ. ಏನಾಗಿದೆ ಕೌನ್ಸಿಲ್ಗೆ? ತಗೊಳ್ಳಿ. ಅಪಲೆಂಟ್ ಕೌನ್ಸಿಲ್ 6 time on the ground that the proxy counsel 6 time on behalf of the appellant counsel on the ground that counsel on record is not keeping well, and also submit that already 1312
Serial number 28, my lord.
1312
28 to 32.
My lord, serial number 28, my lord.
28 to 32 30 ಹೇಳಿ ಏನು
Serial number 28, my lord. Day after tomorrow, my lord. I will come personally, my lord.
ಅದ್ ಬಂದಾಗ ಹೇಳ್ರಿ ಈಗ ಯಾಕ ಈಗ ಮೂವ್ ಮಾಡ್ದಾಗೆಲ್ಲ ಯಾಕೆ ಹೇಳ್ತೀರಿ ಅದನ್ನ ಹಾ ಕೇಸ್ ಬಂದಾಗ ಕರೆದಾಗ ಮಾಡಿ ಅದನ್ನ ಮತ್ತೆ ನೆಕ್ಸ್ಟ್
Serial number 28, my lord.
ಪೀಪಲ್ ಹ್ಯಾವ್ ನೋ ಸೆನ್ಸ್ ಅಟ್ ಆಲ್ ಹಾ
33
to 41
Lord, serial number 28, my lord.
yes counsel which matter
28, my lord. Day after tomorrow.
28 ಏನಾಗ್ಬೇಕು ಹೇಳಿ
Day after tomorrow, my lord.
no adjournment counsel
My lord.
No adjournment.
Day after tomorrow, my lord. Kindly, my lord.
no adjournment
My lord, serial number 40, my lord, Sam, for the appellant. my
ಹೇಳಿ
lord.
ಏನಾಗ್ಬೇಕು
It may be taken up after 1 week, my lord.
no madam ಟೇಕನ್ ಅಪ್ ಬೇಡ್ರಿ ನೀವ್ ಏನ್ ರೀಸನ್ ಹೇಳಿ
My senior is not well, my lord.
2/6 ಸೇರು ಕನ್ಫರ್ಮ್ ಸೀನಿಯರ್ ಬೇಕಾ ಇಲ್ಲ ನೀವು ಅಸಿಸ್ಟ್ ಮಾಡಿ ಕೊಟ್ಟಿ no adjournment
My lord, party wants to engage senior.
ಪಾರ್ಟಿಗೆ ಹೇಳ್ದಂಗ್ ಕೇಳಕ್ ನಾವ್ ಇಲ್ಲಿ ಕೂತಿಲ್ಲ ನಾನು ಓದ್ಕೊ ಬಂದಿದ್ದೀನಿ ಯು ಅಸಿಸ್ಟ್ ದಿ ಕೋರ್ಟ್ ದಟ್ಸ್ ಆಲ್ ಹಾ ನೆಕ್ಸ್ಟ್
42 to 45.
ನೀವಂತೂ ಓದಿ ಅಸಿಸ್ಟ್ ಮಾಡಲ್ಲ ಕೋರ್ಟ್ನವ್ರು ಓದ್ಕೊ ಬಂದ್ರು ಬಂದ್ ಟೈಮ್ ಕೇಳ್ತೀರಿ
At least two days may be given.
No,
my
madam.
lord.
42 to 45
46 to 50. 51 to 56.
55 my lord.
ಹಾ ಹೇಳಿ
I have informed SV Prakash 2 weeks time.
Opponent counsel seeks time and also submit that already informed counsel for the KVR R1 and hence list this matter on 1311
Please.
Serial number 52.
hmm
52.
ಹೇಳಿ ಏನಾಗಬೇಕು
Sir, my senior is not feeling well. He's
ನಾಟ್
got fever.
ಫೀಲಿಂಗ್ ವೆಲ್ ಅದರ್ ಸೈಡ್ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದಿರಿ
Martin,
ಅವ್ರು ಮಾಡ್ತೀನಿ ಬೇಡ ಮಾಡಿದಿರಾ
ಮಾಡಿ.
ಮಾಡ್ಬಿಟ್ಟು ಮೆನ್ಷನ್ ಮಾಡಿ ಅವ್ರು ಬಂದು ಆಮೇಲೆ ತಕರಾರು ಮಾಡೋದ್ ಬೇಡ
57 to.
Sir, I may be pardoned. Sir, I may be pardoned. My serial number is 48, sir.
48 ಏನಾಗಬೇಕು ಹೇಳಿ
Sir, ಅದು admission ಗೆ ಉಂಟು sir.
ಎಸ್ ಕೌನ್ಸಿಲ್ ಅಡ್ಮಿಷನ್ ಅಲ್ಲಿ ಇದೆ 48
ಹೌದು, I am ready. Shall I make submission, sir?
ಅಸಿಸ್ಟ್ ಮಾಡಿ ದಟ್ಸ್ ಆಲ್
ಹೌದು sir. This is the second
ಏನ್
appeal
ಹೇಳಿ
filed by the plaintiff, sir. Both the lower courts have dismissed the suit.
ಆಮೇಲೆ ಮಾಡಿ ಅಡ್ಮಿಷನ್ ಕೌನ್ಸಿಲ್
ಆಯ್ತು sir.
ಕೌನ್ಸಿಲ್ ಅಡ್ಮಿಷನ್ ಬಂದಿದೆ ಅಸಿಸ್ಟ್ ಮಾಡಿ ಯಾವಾಗ ಫ್ಯಾನ್ ಗಾಳಿ
ಇವತ್ತೇ
ಕಡಿಮೆ
ready.
ಮಾಡ್ಕೊಳ್ಳಿ
ಇವತ್ತೇ ರೆಡಿ ಇದ್ದೇನೆ
ಕೇಳಿಸ್ತದೆ
sir.
ಕೋರ್ಟ್ನವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ ಅನ್ನೋದು
ಹೌದು ಸರ್.
ಆಯ್ತು
ರೆಡಿ ಮಾಡ್ಬೇಕಾ ಸರ್?
ಎಸ್
Sir, this is the suit is one for declaration of title and injunction
Hey,
filed by the.
counsel.
Yes, sir.
ಸರ್ ಪ್ಲೀಸ್ ಕೇಳಿಸ್ಕೊಳ್ಳಿ ಸರ್. ಇನ್ನು ನಿಮ್
ಹಾ.
ಸೀರಿಯಲ್ ನಂಬರ್ ಬಂದಿಲ್ಲ
ನಿಮ್
ಪ್ಲೀಸ್.
ಸೀರಿಯಲ್ ನಂಬರ್ ಬಂದಿಲ್ರಿ, ಬಂದಾಗ ಸಬ್ಮಿಷನ್ ಮಾಡಿ ಕೋರ್ಟಿಗೆ ಅಸಿಸ್ಟ್ ಮಾಡಿ.
Okay, sir. Okay. Thank you, sir. Thank you. I may be pardoned, sir.
Orders matter serial number 1.
Serial number 1, Tilakaraj. Filing a petition by the council who is not on record.
Appearing for the
In
appellant,
MSA.
my lord. MSA was filed by H.N. Baswaraju. He's left the office right now.
Yes, madam. ಹೇಳಿ RP ನೀವು ಹಾಕಕ್ ಬರಲ್ಲ ಅಂತ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್.
My lord, 1 week time may be given. We'll persuade H.N. Baswaraju advocate to sign on the wakalat.
Petitioner counsel seeks time. List this matter after 1 week ಕೊಡಿ madam.
Much obliged.
611. Serial number.
ರೂಪೇಶ ಬಿ. ನಾನ್ ಫೈಲಿಂಗ್ ಅಪ್ ಪೇಪರ್ ಬುಕ್.
ಇದರಲ್ಲಿ ಪೇಪರ್ ಬುಕ್ ಮೇ ಬಿ ಡಿಸ್ಮಿಸ್ಡ್ ವಿತ್ ಒಂದು.
ಯಾವಾಗ ಆಗಿರೋದು ಹೇಳಿ. 10/1/24 ಆಮೇಲೆ ಟೈಮ್ ಕೊಟ್ಟಿಲ್ಲ. ಆಮೇಲೆ ಅವಾಗ ಏನಕ್ಕೆ ಬಂತು ಇನ್ನೊಂದ್ಸಲ?
ಈ ಪೇಪರ್ ಬುಕ್ ಅಂತ ಲಾಸ್ಟ್ ಟೈಮ್.
ಸೆಕೆಂಡ್ ಟೈಮ್ ಬಂದಾಗ ಏನಕ್ಕೆ ಬಂದಿದೆ? ಅದರ್ ಸೈಡ್ ಇದಾರ? ಏನ್ ಪೇಪರ್ ಬುಕ್ ಬೇಕಾ ಬೇಡ? ಡಿಸ್ಪೆನ್ಸ್ ಮಾಡ್ಬೋದಾ? ತೊಳಿ ಆಯ್ತು, ಅದಕ್ಕಿಂತಲೇ ಬಂದಿದೆ, ಟೈಮ್ ಕೊಟ್ಟಿದೆ ಅವಾಗ. ಮತ್ತೇನ್ರಿ
ನಮ್ಮ ಪಾರ್ಟಿ
ಯು ಓನ್ಲಿ ಟುಕ್ ಟೈಮ್.
ಅದು ಗೊತ್ತಾಯ್ತು, ನಮ್ಮ ಪಾರ್ಟಿ ಕೇಳಿದೆ, ಸ್ವಲ್ಪ ಫೈನಾನ್ಷಿಯಲ್ ಕಷ್ಟ ಇದೆ.
2 weeks to do the needful. Accordingly, time of 2 weeks is granted finally. Directed to clarify the office objection within a time. ತೊಳಿ. Appellant counsel submits that paper book may, filing of paper book may be dispensed, and counsel for the R1 submits that
Kindly have it in the next week, my lord.
next week.
Amputation ಆಗಿದೆ ಕೈ.
ಹೌದಾ, ಆಯ್ತು.
Suit for damages.
ಹಾ.
Liability.
ಕನೆಕ್ಟೆಡ್ ಅಲ್ಲಿ ಯಾರು ಕಂಪ್ಲೈ ಮಾಡ್ಬೇಕು?
ಅಲ್ಲ ಕನೆಕ್ಟೆಡ್ ಹೇಳ್ತೀನಿ ಅದು.
ನೀವೇ ಕಂಪ್ಲೈ ಮಾಡಿಲ್ಲ?
ಅಲ್ಲಲ್ಲ ಅದನ್ನ ಹೇಳ್ತೀನಿ ಈಗ.
ಕಂಪ್ಲೈಂಟ್ ಲಾಸ್ಟ್ ಟೈಮ್ ಇತ್ತು.
ಅದು ಗೊತ್ತಾಯ್ತು.
ಆದ್ರೂ ಮಾಡಿಲ್ಲ.
ಅಲ್ಲಲ್ಲ ಅದನ್ನ ತಾವು ಇದ್ ಮಾಡ್ಬೇಕಾಗತ್ತೆ.
ಏನ್
ಮಾಡ್ಬೇಕು.
ಏನ್ ಹೇಳಿ?
ಇದ್ರಲ್ಲಿ ಅದಾಯ್ತು, ಅದು ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಆಲ್ರೆಡಿ ಇದಾಗಿದೆ, ಡಿಸ್ಪೆನ್ಸ್ ಆಗಿದೆ.
ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಅದರಲ್ಲಿ ಇದೆಯಲ್ಲ ಇನ್ನೊಂದ್ರಲ್ಲಿ ಕನೆಕ್ಟೆಡ್ ಅಲ್ಲಿ.
ಹಾ ಇದೆ.
ಅದ್ ಮಾಡ್ಬೋದಲ್ಲ?
ಅಲ್ಲ ಡಿಸ್ಪೆನ್ಸ್ ಹಿಂದೆನೆ ಮಾಡಿದ್ದೀರಿ. ಡಿಸ್ಪೆನ್ಸ್ ಹಿಂದೆನೆ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀರಿ.
ಮಾಡಿದ್ರೆ ಮತ್ತೆ ಬರುತ್ತೆ.
ಅದೇ ಅವ್ರು ಹಾಕಿದಾರೆ ಅದ್ರ ಮೇಲೆ. ಆ ಅಬ್ಜೆಕ್ಷನ್ಗೆ ಈ ವರಲಕ್ಷ್ಮಿ ಅನ್ನೋದು ಇವರು KEB ಅವರು ಅಪೀಲ್ ಆಗ್ತಾರಲ್ಲ, ಅದರಲ್ಲಿ ವರಲಕ್ಷ್ಮಿ ಅಂತ ಇನ್ಕ್ಲೂಡ್ ಮಾಡ್ತಾರೆ. ಒರಿಜಿನಲ್ ಸೂಟ್ ಅಲ್ಲಿ ಇಲ್ಲ. ಅವರು ಬೈ ಪರ್ಸನ್ ಏನ್ ಬೇಕಾಗಿಲ್ಲ, ಆಫೀಸ್ ರೆಪ್ರೆಸೆಂಟ್ ಆಗಿದೆ. therefore ಮೇಲೆ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್
ಅಂದ್ರೆ ಯಾವುದು ಆನ್ ಬಿಹಾಫ್ ಆಫ್ ದಿ KEB.
ಹೌದು, ಸೆಕ್ಷನ್ ಆಫೀಸರ್ ಸೆಸ್ಕಾಂ
ಹೆಸರು ಮೆನ್ಷನ್
ಮಾಡಿದ್ರೆ ಬೇಕಾಗಿಲ್ಲ, ನಾಟ್ ನೆಸೆಸರಿ.
ಕೌನ್ಸಿಲ್ ಫಾರ್ ದಿ ಅಪಲೆಂಟ್ seeks for dispensation of permission of this court to dispense. The counsel for the appellant submits that paper book may be dispensed. R1 also submits that filing of paper book may be dispensed, but list this matter in the next week, since it is a case of amputation
For damages.
and
As
suit for
against
damages,
contractor.
and hence filing of paper book is dispensed. List this matter on next week. Other date kodi madam. 6/11. The counsel appearing for the respondent, appellant in RSA 154 of 2022 would submit that while filing the appeal by the KEB, name of the section officer is mentioned and office objection regarding non-mentioning of the same, and hence the said office objection is overruled. Shivananda DS.
My lord, LR applications are filed yesterday. Office may be directed to put up. ಅದು ನಿನ್ನೆ ಹಾಕ್ತೆ, ಅದು ಯಾಕಂದ್ರೆ R6 R9 ಗೆ
ಈಗ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಷ್ಟೇ. ಹಾಕಿದ್ರೆ
ನೋಟಿಸ್ ಡಿಲೇ ಇದೆ.
ಸರಿ ಇದೆಯಾ? ಅದು ಯಾಕೆ ಇಷ್ಟೊಂದು ಅಯ್ಯೇ?
ಅಲ್ಲ ಎರಡು ಅಂದ್ರೆ ಎರಡು
ಹಾಕಿದಾರ. ಮೂರು ಸಪರೇಟ್. Appellant counsel files memo, application for bringing LRs of R6 and R9 in terms of IN number 1 of 25, 3 of 25, 2 of 25, 4 of 25, 5 of 25, 6 of 25. And hence issue notice against the LRs of R6 and R9.
Yes.
IN 1 of 25, 3 of 25, 2 of 25 against R9 LRs, and remaining IS against LRs of R6.
Yes.
Returnable by date code. 2/12. Non-compliance of office objection raised on IN number 2 of 25 to 4 of 25 for bringing LRs of deceased R3.
In this case, date of death of person's name, date gottilla.
Yes, sir. Bandide madam.
Last application file application, my lord. Date of information is not available even till today.
Sorry, nee date of your death barililla andre abatement heng compute ಮಾಡೋದು?
ಅಲ್ಲೇನ ಇದೆ, ಊರಲ್ಲಿ ಯಾರು ಇನ್ಫಾರ್ಮೇಶನ್
ಬಿಟ್ಬಿಡ್ರಿ ಹೇಳಿ.
ಊರಲ್ಲಿ ಯಾರು ಇನ್ಫಾರ್ಮೇಶನ್ ಕೊಡ್ತಿಲ್ಲ ಸ್ವಾಮಿ.
ಏನ್ ಮಾಡ್ಬೇಕು ನಾವು? ಅದಕ್ಕೆ ನಾವು ಬಂದು ತೆಗೆದು ಕೊಡ್ಬೇಕಾ?
ಅಲ್ಲ.
Does not arise since the appeal against said respondent is dismissed by order dated so and so. Last time 14/10 ಅಲ್ಲಿ ನೀವು ಟೈಮ್ ತಗೊಂಡಿದ್ರಲ್ರಿ, ಫೈನಲಿ 2 weeks ಟೈಮ್ ಅಂತ.
ಅದೇ ಡೇಟ್ ತಿಳ್ಕೊಳ್ಳೋದಕ್ಕೆ, ಬಟ್ ಯಾರು ಮಾಹಿತಿನೇ ಕೊಡ್ತಿಲ್ಲ.
ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ? ನಾನ್ ಕಂಪ್ಲೇಂಟ್ಸ್ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ಲ IS?
ಬೇಡ ಸ್ವಾಮಿ, ಇಶ್ಯೂ ನೋಟಿಸ್ ಕೆಪ್ಟ್ ಓಪನ್ ಮಾಡಿ ಇಶ್ಯೂ ನೋಟಿಸ್ ಮಾಡಿ.
ಕೆಪ್ಟ್ ಓಪನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ?
ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಬಂದ್ರೆ ಡೀಟೇಲ್ಸ್ ಸಿಗುತ್ತೆ.
ಮೊದಲು ಯಾರು ಅಪಿಯರ್ ಆಗಿದ್ರು ಅವರಿಗೆ?
ಹಿಂದೆ ಪ್ರೀವಿಯಸ್ ಅಪೀಲ್ ಅಲ್ಲಿ ಅಪಿಯರೆನ್ಸ್ ಆಗಿದ್ರು, ಇಲ್ಲ ಅಪಿಯರೆನ್ಸ್ ಆಗಿಲ್ಲ.
R3 ಗೆ ಯಾರು ಅಪಿಯರ್ ಆಗಿದ್ರು?
ಇಲ್ಲಿ ಇನ್ನೂ ಅಪಿಯರೆನ್ಸ್ ಆಗಿಲ್ಲ.
ಈಗ ಅಪೀಲ್ ಅಗೇನ್ಸ್ಟ್ R3 ಸ್ಟ್ಯಾಂಡ್ಸ್ ಅಬೇಟೆಡ್ ಅಲ್ವಾ?
ಅದು ಅಪ್ಲಿಕೇಶನ್ಸ್ ಫೈಲ್ ಮಾಡಿದ್ವಿ ಸ್ವಾಮಿ. ರೀಕಾಲ್
ಏನಕ್ಕೆ?
yesterday I'll file application to recall the order to abate the to take steps ಅಂತ.
One more application now.
Please, yesterday I'll file applications.
Third, appellant counsel would submit that he has filed one more application
to recall the order.
Recall the order dated 12/9/25 And hence the registry is directed to put up the same. And in the meanwhile, counsel for the appellant is directed to get the date of death of the ಯಾರ್ ಡೆತ್ ಸತ್ತೋಗಿರೋದು
R3
R3.
please ma'am.
List this matter on ಒಂದು ವಾರ ಬಿಟ್ಟು ಕೊಡಿ ಮೇಡಮ್, ಅಷ್ಟೊಳಗೆ ಮಾಡಿ ಮತ್ತೆ ಕೊಡಲ್ಲ, ಇಲ್ಲ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತೀನಿ ನೆಕ್ಸ್ಟ್ ಎಲ್ಲ. ಎಸ್ 611
Much better.
5.
ನಾನು arraying of R6 in RSA before the trial court along with counsel submission. ಹೇಳ್ರಿ.
ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ the respondent number 6 has been arrayed as the respondent in RA malaj. The trial court ಎಲ್ಲಿ OS ಹಾಕಿದ್ರು ಅಲ್ಲಿ array ಮಾಡಿರಲಿಲ್ಲ. Now because
Original suit ಅಲ್ಲಿ not a party.
yes,
appellant appeal court ಅಲ್ಲಿ
first appellate court ಅಲ್ಲಿ the advocate had arrayed him as a party.
ಯಾಕೆ ಅಂತ ಮಾಡಿದ್ರು?
As a necessary party because
Impleading application.
ಹೌದು.
ಆಯ್ತು.
They have impleaded him. For that very reason, we have also impleaded him as a necessary party in the RSA malaj.
RSA.
Please.
Totally.
I have mentioned that in my para number 3 of the petition.
The counsel submission is that R6 was impleaded in the first appellate court and hence he has been made as party in RSA and hence counsel submission is accepted. List the matter for admission.
Please.
On 1311.
Obliged.
Admission ayilala?
ಇಲ್ಲ ಸ್ವಾಮಿ.
ಆಯ್ತು.
Obliged.
Non taking of steps in respect of deceased R2 and R3 void order dated 14/10/25. SV Prakash ಹೇಳ್ರಿ ಮೇಡಮ್.
ಇಂಟಿಮೇಟ್ ಮಾಡಿದೀವಿ ಮೇಲೆ
Appellant
ಬಂದಿಲ್ಲ
appellant counsel again seeks time and finally 2 weeks time granted. List this matter on 1312.
1311.
Huh?
1311.
Sorry, 1311.
7.
Non-filing of necessary application to bring the LRs of deceased sole appellant as per order dated. ಹೇಳ್ರಿ.
Not showing any interest, my lord.
ನೀವು ಇಂಟಿಮೇಟ್ ಮಾಡಿದಿರ ಅವರಿಗೆ?
Yes, my lord.
ತೊಗೊಳ್ಳಿ. The counsel appearing for the appellant would submit that in spite of information is given to the appellant to bring the LRs of sole appellant, the legal heirs of appellant are not giving any information or instructions to file an application. And hence appeal is dismissed as abated. And in the earlier occasion also this court on 14/10/25 made it clear that finally time of 2 weeks is granted to file a necessary application to bring the legal representatives of deceased sole appellant on record or otherwise the appeal will be abated. And hence ಅಷ್ಟೇ ಮಾಡ್ಬಿಡಿ. ಮೊದಲೇ ಅಬೇಟೆಡ್ ಬಂತಲ್ಲ. ನೆಕ್ಸ್ಟ್ ಪವನ್ ಕುಮಾರ್ BK. Compliance of office objection raised on PF furnished by the counsel for appellant that is DPF of rupees 700.
ಮತ್ತೆ ಮಾಡ್ತೀನಿ ಅಲ್ಲಿ ವೇಟ್ ಮಾಡಿಸಿ ಮಾಡಿದ್ವಿ. ಅವ್ರು ಹೇಳಿದ ಅಮೌಂಟ್ ಕಟ್ಟಿದ್ವಿ. DPF ಬಂದಿದೆ. ವಿಲ್ ಪೇ 700 more my lord. ಅದಾದ್ಮೇಲೆ ಎರಡು ಮೆಮೋ ಇದೆ.
ಹೊಸೋರ್ ಮೆಮೋ ಏನಕ್ಕೆ?
my lord
ಒಂದು ಮೆಮೋ dated 24 filed by counsel for appellant for having served copies to the counsel representing R1 to R5 in execution.
ಹೌದು, ಅದು ಸರ್ವಿಸ್ ಮಾಡಿದೀನಿ, ಮೆಮೋ ಹಾಕಿದೀನಿ.
ಆಯ್ತು.
ಎರಡನೇ ಮೆಮೋ ಬಂದು R19 ಲಾಸ್ಟ್ ಟೈಮ್ ಡಿಸೀಸ್ಡ್ ಅಂತ ಬಂದಿತ್ತು. ಅಂಡರ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ my lord I filed another memo stating that R19 has no legal representative.
No heirs?
No legal heirs my lord. Orders may have to be passed to say that the appeal is abated as against R19.
ಇದರಲ್ಲಿ ನಾವು ನಿಮಗೆ ಸರ್ವ್ ಮಾಡಕ್ ನೋಟಿಸ್ ಇದು ಕೊಟ್ಟಿದ್ವಾ?
ಹೌದು, 14/10 ತಾವು ಅನುಮತಿ ಕೊಟ್ಟಿದ್ವಿ.
ಆರ್ಡರ್ ಮಾಡಿದ್ವಿ.
ಅನುಮತಿ ಕೊಟ್ಟಿದ್ವಿ, ನಾನು ಮಾಡಿದೀನಿ. ಮೆಮೋ ಹಾಕಿದೀನಿ.
Counsel for the appellant would submit that in terms of the order passed by this court dated 14/10/25. Copies of this RSA is furnished on the counsel R1 to R5 who appears in execution petition number 38 of 25. And hence memo is taken on record. ಯಾಕೆಂದ್ರೆ ಅವ್ರು ಅಪಿಯರ್ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಕೋರ್ಟ್ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕು. ನಾವ್ ಹಂಗೆ ಅದ್ರ ಮೇಲೆ ಮಾಡಕ್ಕಾಗಲ್ಲ.
ಏನಕ್ಕೆ ಮಾಡಿದ್ದು ಇದು ಇದ್ರೆ ಪೊಸೆಷನ್ ಇರೋದು.
The counsel appearing with the appellant would submit that R19 notice was returned with an endorsement is no more. And counsel submit that deceased R19 is not having any LRs and hence memo is taken on record. So notice ಏನಾಗಬೇಕು ಮತ್ತೆ ಕಂಪ್ಲೇಂಟ್ಸ್ ಏನು ಮಾಡ್ತೀರಾ ಪಾಸ್ ಅವರು? PF ಕೊಡ್ರಿ.
ಇವಾಗ್ಲೇ ಕೊಡ್ತೀನಿ. ಡೇಟ್ ಮೇಲೆ
ಕೊಟ್ಬಿಟ್ಟು ಬನ್ನಿ. ಡೇಟ್ ಕೊಡಲ್ಲ, ಕೊಟ್ಟ ಮೇಲೆ ಕೊಡೋದು.
ಮತ್ತೆ R1 to R5 ಗೂ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಾಗುತ್ತೆ.
ನೋಟಿಸ್ ಹೋಗ್ಬೇಕು, ಅದಕ್ಕೂ PF ಕೊಡಬೇಕಾಗುತ್ತೆ.
ಎಲ್ಲ ಒಟ್ಟಿಗೆ ಕೊಟ್ಬಿಡ್ತೀನಿ. ಡೇಟ್
ತೊಗೊಳ್ಳಿ. counsel appearing for the appellant would submit that he is going to pay the deficit PF today in the office and if PF paid issue notice and also directed to furnish the PF to issue notice against
R1 to R5.
R1 to R5. ಮತ್ತೆ ಈ PF ಯಾರಿಗೆ ಅಂತ ಇನ್ಯಾರಿಗೆ?
ಇದು ಲಾಸ್ಟ್ ಟೈಮ್ ತಾವು R6 to R18 ಗೂ ನೋಟಿಸ್ ಮಾಡಿದ್ರಿ ಲಾಸ್ಟ್ ಟೈಮ್. ಅವರು ಬೇರೆ
R6 to 18 ಯಾಕ್ರಿ 700 ರೂಪಾಯಿ ಬೇಕು PF?
ಸರ್ ಅದು ಇಷ್ಟೊಂದು
ಇಷ್ಟು ದಪ್ಪ ಇದೆ, ನಾನು ಫುಲ್ ಕಟ್ಟಿದ್ದೆ.
ಮಟೀರಿಯಲ್ ಅಷ್ಟೊಂದು ಇದೆಯಾ?
5,000 ರೂಪಾಯಿ ಏನೋ ಕಟ್.
ಓ, ಅಷ್ಟಕ್ಕೆ ಹೋಗ್ಬೇಕು.
ಐ ವೇಟ್ ಇಟ್, ಅಲ್ಲಿ ವೇಟ್ ತಗೊಂಡು ಕೊಟ್ಟಿದ್ವಿ, ಆಮೇಲೆ ಕಮ್ಮಿ ಅಂತ ಹೇಳುದು. ಅದೆರಡು ಪೇಡ್ ದ ಫುಲ್ ಅಮೌಂಟ್.
ಅದೇನಿಲ್ಲ, ಅದು ವೇಟ್
ಅಲ್ಲ ಜಾಸ್ತಿನೇ ಕಟ್ಟಿದ ನಮ್ ಕ್ಲರ್ಕ್.
ಕೊಡ್ಬೇಕಾದ್ರೆ
ಕೊಡ್ತೀನಿ ನಾನು, ಕೊಡ್ತಲ್ಲ ಅಂತ
ಇಲ್ಲ, ನೀವೇ ತಗೊಂಡೋಗಿ ಮಾಡಿಸ್ಬಿಟ್ಟು ಪೋಸ್ಟ್ ಮಾಡಿಸ್ಬಿಡಿ.
ಇಲ್ಲ ನಾನು ಕೊಡ್ತೀನಿ, ಪ್ರೋಸೆಸ್ ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳ್ಬಿಟ್ರೆ
700 ರೂಪಾಯಿ ಜಾಸ್ತಿ ಆಗಿದೆ ಅಂದ್ರೆ ಆಯ್ತು. ಇಶ್ಯೂ ನೋಟಿಸ್ ಅಗೇನೆಸ್ಟ್ ಆರ್ 1 to 5 also, and appellant counsel is directed to pay PF forthwith.
Yes ma'am.
9
ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕೊಂಡಿದ್ದಾರೆ.
ಏನ್ ಮಾಡ್ಬೇಕು ಅದಕ್ಕೆ? ನೋಟಿಸ್ ಆಲ್ರೆಡಿ ಆರ್ಡರ್ ಆಗಿದೆ, ಸರ್ವಿಸ್ ಮಾಡಿಸ್ಕೊ ಬನ್ನಿ. ಡೇಟ್ ರಿಟರ್ನಬಲ್ ಬೈ ಡೇಟ್ ಕೊಡಿ ಮೇಡಮ್. PF ಇವತ್ತೇ ಕೊಟ್ರೆ
ಇವಾಗಲೇ
2/12.
In this case, my lord, office raised objection with regard to boundary, my lord. My lord, the injunction sought for by the appellant is different, and the injunction suit filed by the respondent is different, my lord. In this regard, my lord, as appellate court has also given finding with regard to the both the properties are different, despite granted injunction against me, my lord.
ಆಯ್ತ್ರಿ.
Therefore, my lord, I have filed application for temporary injunction in respect of my property, my lord. I have clarified, my lord, the office has raised objection.
ನಿಮ್ ಪ್ರಾಪರ್ಟಿ ಶೆಡ್ಯೂಲ್ ಏನ್ ತೋರಿಸಿದಿರಿ?
Nam property, your lordship, can you turn to page number?
ಏನ್ ತೋರಿಸಿದಿರಿ? ಅದೇ ತೋರಿಸಿದಿರ ಇಲ್ಲುವೆ?
ಅಲ್ಲಿ ನಾವು ಅಯ್ಯ ಹಾಕಿರ್ಲಿಲ್ಲ, ಅವ್ರ ಅಯ್ಯ ಹಾಕಿದ್ದು.
ನೀವೇನ್ ಕೇಳೇ ಇಲ್ಲ.
ನಾವು ಅದೇ ಬೇರೆ ಪ್ರಾಪರ್ಟಿ, ಇದೇ ಬೇರೆ ಪ್ರಾಪರ್ಟಿ ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಕಂಡು ಅದನ್ನ
ನೀವು ಕೆಳಗಿನ ಕೋರ್ಟಲ್ಲಿ ಇಂಜಂಕ್ಷನ್ ಕೇಳೇ ಇಲ್ವಾ?
ನಾವು ಕೇಳಿಲ್ಲ.
ಈಗ ಇಂಜಂಕ್ಷನ್ ಕೇಳ್ತಾ ಇದೀರಿ.
ನಾವು ನಮ್ ಪ್ರಾಪರ್ಟಿ ಕೇಳ್ತಾ ಇದ್ದೀವಿ.
ನಿಮ್ ಪ್ರಾಪರ್ಟಿ ಡಿಸ್ಕ್ರಿಪ್ಷನ್ ಏನು?
ನಮ್ ಪ್ರಾಪರ್ಟಿ, your lordship, can you turn to page number 78?
ನೀವು ನಿಮ್ ಪ್ರಾಪರ್ಟಿ ಅಂತ ಡಿಸ್ಕ್ರಿಪ್ಷನ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ, ಲೋಯರ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹೇಳಿದಿರ್ತಾನೆ.
ನಾವು ಹೇಳಿದೀವಿ.
ಅದೇ ತರ ನೀವು ಇಲ್ಲೂ ಹಾಕಿದ್ದೀರಾ?
ಹೌದೌದು.
ಎಲ್ಲಿದೆ?
your lordship, can you turn to page number page number 40, my lord.
40.
page number 40.
ನೀವು ಡಿಫೆಂಡೆಂಟ್?
ನಾವು ಡಿಪೆಂಡೆಂಟ್.
ನೀವು ನಿಮ್ಮ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಪ್ರಾಪರ್ಟಿಲಿ ಡೀಟೇಲ್ಸ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಅಲ್ಲ, ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಹೇಳಿಲ್ಲ. ಇದು ಡ್ಯೂರಿಂಗ್ ದಿ ಕೋರ್ಸ್ ಆಫ್ ಎವಿಡೆನ್ಸ್ ವಿ ಹ್ಯಾವ್ ಪ್ರೊಡ್ಯೂಸ್ಡ್ ದಿ ಡಾಕ್ಯುಮೆಂಟ್ಸ್, ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ನೋಟೆಡ್ ಡೌನ್ ದಟ್ ಅದು ಎರಡೂನು ಬೇರೆ ಪ್ರಾಪರ್ಟಿ ಅಂತಾರೆ. ಬಟ್ ಮೈ ಕಂಟೆನ್ಷನ್ ಇಸ್, ಮೈ ಲಾರ್ಡ್, ನಮ್ ಕ್ಲೈಂಟ್ನು ಇನ್ನೊಂದು ಸೂಟ್ ಹಾಕ್ಬೇಕಾಯ್ತು, ಹಾಕಿರ್ಲಿಲ್ಲ ಅಷ್ಟೇನೆ. ದಟ್ ಇಸ್ ದಿ.
ಸರಿ, ಈಗ ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ?
ಈಗ ಇದು
ನಿಮ್ ಡಿಸ್ಕ್ರಿಪ್ಷನ್ ಏನ್ ಕೊಟ್ಟಿದ್ದೀರಿ? ನೀವು
ನಮ್ ಡಿಸ್ಕ್ರಿಪ್ಷನ್
ದಾಖಲೆ ಕೊಟ್ರಿ?
ಹೌದೌದು, ಸಿನ್ಸ್ ಫ್ರಮ್ 1949 ಇಂದನು ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಟ್ರಿ.
ಯಾಕ್ರಿ ಇಷ್ಟೊಂದು ಮಾತಾಡ್ತೀರಿ? ನೀವೊಂದು ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಟ್ರಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ, ಇದು ನಮ್ ಪ್ರಾಪರ್ಟಿ ಅಂತ. ಆ ಪ್ರಾಪರ್ಟಿ ಡಿಸ್ಕ್ರಿಪ್ಷನ್ ಏನಿದೆ ಅದೇ ಡಿಸ್ಕ್ರಿಪ್ಷನ್ ಈಗ ನಿಮ್ ಐಯಲ್ಲಿ ತೋರಿಸಿ, ಅದನ್ನೇ ಹೇಳಿ ತೋರಿಸಿ ಎಲ್ಲಿದೆ ಅಂತ. ಹೌದೌದು ಬೇಡ, ನಂಗೆ ಅಲ್ಲಿ ಬಂತು ಇಲ್ಲಿ ಬಂತು.
That has been extracted by the trial court in the operative portion of the judgment itself.
ಇದೆಯಾ?
ಹೌದು, page number 40 of the judgment.
40.
ಹೌದು, para 30 below.
para 30 ಅಲ್ಲಿ ಇಲ್ರಿ. appellate court
judgment.
ಯಾವ್ದಾವ್ದೋ ಪ್ಯಾರಾ ಹೇಳ್ತೀರಿ ನೀವು?
I'm sorry. appellate court judgment, para 30, page number 40. ಕೆಳಗಡೆ ದಿ ಕಾಪಿ ಆಫ್ ದಿ ಸೇಲ್ ಡೀಡ್.
ಪೇಜ್ ಅಲ್ಲಿ ಇರೋದು 34ರಲ್ಲಿ ಇರೋದು appellate court ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 30. ನೀವು ನೋಡ್ರೆ 40 ಅಂತೀರಿ. ಎಲ್ಲಿದೆ ಹೇಳಿ?
ಕೆಳಗಡೆಯಿಂದ ಇನ್ ಎಕ್ಸಿಬಿಟ್ D12, ದಿ ಕಾಪಿ ಆಫ್ ದಿ ಸೇಲ್ ಡೀಡ್ ನಿಂಗಪ್ಪ ಸನ್ ಆಫ್ ಮಲ್ಲಪ್ಪ.
appellate court ಅಲ್ರಿ? appellate court ಪ್ಯಾರಾ 30.
ಹೌದೌದು.
D12 ಯಾವ್ದು ಇಲ್ವೇ ಅಲ್ವಲ್ಲ ಇಲ್ಲಿ ರೆಫರ್ ಮಾಡಿರೋದು? ಓನ್ಲಿ ಎಕ್ಸಿಬಿಟ್ D1 and D2. ಬೇರೆ ಬೇರೆ ಕೊಟ್ರೇನ್ರಿ ಫೈಲು? 1138 of 25. The revenue entries. ಹೇಳಿ. In exhibit D12, copy of the sale deed.
The copy of the sale deed, boundaries mentioned are yes to east, land of Karibasappa Mahadevappa.
ಒಂದೇ ನಿಮಿಷ. ನಿಮ್ಮ ಐಐಗೆ ಎಲ್ಲ ಹಾಕಿದ್ರಿ? ಅದರಲ್ಲಿ ಎಲ್ಲಿದೆ?
ನಮ್ಮ ಐ. Your lordship, my ಐ is at ink page number 78, my lord.
ಐ ನಂಬರ್ ಎಷ್ಟು?
ಐ ನಂಬರ್ 2, my lord.
ಐ ನಂಬರ್ 2 ನಾ?
ಹೌದು.
ಅಪ್ಲಿಕೇಶನ್ ಫಾರ್ ಟೆಂಪರರಿ ಇಂಜಂಕ್ಷನ್
ಹೌದು.
ಐ ನಂಬರ್ 1 ಇದೆಯಲ್ರಿ?
ಸರ್
ಆಯ್ತು.
ಅದರಲ್ಲಿ
ಈಸ್ಟ್
ಈಸ್ಟ್
ಕರಿಬಸಪ್ಪ ಮಹಾದೇವಪ್ಪ ಪ್ರಾಪರ್ಟಿ.
ಹೌದು.
ಲ್ಯಾಂಡ್ ಆಫ್ ಕರಿಬಸಪ್ಪ. ವೆಸ್ಟ್
ಸಲಗನಹಳ್ಳಿ ವಿಲೇಜ್ ಬೌಂಡ್ರಿ. ನಾರ್ತ್
ಅಗೇನ್ ಕರಿಬಸಪ್ಪ. ಮತ್ ನೀವ್ ಇಲ್ಲಿ ಬೇಡರ ಹಳ್ಳ ಅಂತ ಹಾಕಿದ್ರಿ.
ನಮ್ದು ಇದು ನಮ್ ಬೌಂಡ್ರಿ, ಅದು ಅವರು ಡಿಫರೆಂಟ್ ಬೌಂಡ್ರಿ. ಇದು ಪ್ಲೇಂಟಿವ್ ಬೌಂಡ್ರಿ. ಇದು
ಯಾವ್ದು
ಇಲ್ಲಿ ಮೆನ್ಷನ್ ಮಾಡಿ 2 ಬೌಂಡ್ರಿನೂ ಸ್ಟಾರ್ಟ್ ಮಾಡ್ತಾರ ಅವರು ಸಾಹೇಬ್ರು.
ಎಕ್ಸಿಬಿಟ್ D12 ಯಾರ್ದ್ರಿ? ಡೀಡ್ ಆಫ್ ನಿಂಗಪ್ಪ.
ಹೌದು.
ನೀವ್ ಅದನ್ನೇ ರೆಫರ್ ಮಾಡ್ತಾ ಇರೋದು.
ಹೌದೌದು.
ಈಸ್ಟ್ ಏನು? ಲ್ಯಾಂಡ್ ಆಫ್ ಕರಿಬಸಪ್ಪ ಮಹಾದೇವಪ್ಪ.
ಹೌದು.
ಸರಿ ಇದೆ. ವೆಸ್ಟ್ ಸಲಗನಹಳ್ಳಿ ವಿಲೇಜ್ ಬೌಂಡ್ರಿ. ನಾರ್ತ್ ಏನ್ ಅಗೇನ್ ಕರಿಬಸಪ್ಪ ಮಹಾದೇವಪ್ಪ ಲ್ಯಾಂಡ್ ಅಂತಿದೆ. ನೀವ್ ಏನ್ ತೋರಿಸಿದ್ರಿ ನಿಮ್ ಶೆಡ್ಯೂಲ್ ಅಲ್ಲಿ? ಈಗ ಏನಲ್ಲಿ ನಾರ್ತ್ಗೆ ಬೇಡರ ಹಳ್ಳ ಅಂತ ತೋರಿಸಿದ್ರಿ. ಇಂಟರ್ಚೇಂಜ್ ಮಾಡಿದಿರಿ. ನಾರ್ತ್ ಸೌತ್ ಇಂಟರ್ಚೇಂಜ್ ಮಾಡಿದ್ರಿ.
ಟೈಪಿಂಗ್ ಮಿಸ್ಟೇಕ್.
ಈಗ ನಂದೆಲ್ಲ ಸರಿ ಇದೆ ಅಂದ್ಬಿಟ್ರಿ. ನಾವ್ ನೋಡ್ಬೇಕು ಇಷ್ಟೆಲ್ಲ. ನೀವು ಅಲ್ಲಿ ಹೋಗಿ ಮಾಡ್ಬೇಕು.
ಕೆಳಗಡೆ ಅವ್ರ ಬೌಂಡ್ರಿ
10 ನಿಮಿಷ ವೇಸ್ಟ್ ಮಾಡಿದ್ರಿ. ಕಾಸ್ಟ್ ಎಷ್ಟ್ ಹಾಕ್ಬೇಕು? ಮತ್ತೆ
ಅವ್ರ ಬೌಂಡ್ರಿ ಕೆಳಗಡೆ ಹೇಳ್ತಾರೆ.
ಮತ್ ಅದೇ ಮಾಡ್ತೀರಲ್ರಿ ಸೋಮಶೇಖರ್? ಹೋಗಿ ಕರೆಕ್ಷನ್ ಮಾಡ್ರಿ.
ಆಯ್ತು, ಮಾಡ್ತೀವಿ.
ನೀವು ನಿಮ್ ಪ್ರಾಪರ್ಟಿಗೆ ಇಂಜಂಕ್ಷನ್ ಕೇಳ್ತಾ ಇದ್ರಿ. ನಿಮ್ ಪ್ರಾಪರ್ಟಿ ಆಸ್ ಪರ್ ಎಕ್ಸಿಬಿಟ್ D12. ಹೌದಾ?
ಹೌದು.
ಬೌಂಡ್ರಿ ನೀವು ಈಸ್ಟ್ ವೆಸ್ಟ್ ಸೌತ್ ನಾರ್ತ್ ಇಂಟರ್ಚೇಂಜ್ ಮಾಡಿದಿರಿ. ಅದ್ ಕರೆಕ್ಟ್ ಮಾಡಿ ಹೋಗಿ.
ಏನ್ ಹೇಳಿ? ಇದರಲ್ಲಿ ರೆಕಾರ್ಡ್ಸ್ ಬೇಕಾಗುತ್ತೆ.
ಅದಾದ್ಮೇಲೆ ನೋಡೋಣ.
ರೆಕಾರ್ಡ್ಸ್ ಬಂದ್ರೆ ಯಾಕಂದ್ರೆ ಅವ್ರ ಮ್ಯೂಟೇಶನ್ ಎಂಟ್ರಿ ಮೇಲೆ ಡಿಗ್ರಿ ಮಾಡಿರೋದು ಅವ್ರಿಗೆ.
ಸೋಮಶೇಖರ ಬಂದ್ರೆ ಹೆಂಗೆ?
ಅಲ್ಲಿ ರೆಕಾರ್ಡ್ಸ್ ಬಂದ್ರೆ ನನಗೂ ಈಸಿ ಆಗ್ತೈತೆ.
ಫಸ್ಟ್ ಬೌಂಡ್ರಿ ನೋಡ್ರಿ ನೀವು. ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಅದಿರೋದು. ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಷನ್ ಇಸ್ ನಾಟ್ ಅಕ್ಸೆಪ್ಟೆಡ್ in view of taking note of exhibit D12 and the same not tallies with the boundary shown in IA number 1 of 25 and hence directed to correct the same and list this matter. ಯಾವಾಗ ಬೇಕು ಹೇಳಿ? ಎಷ್ಟು ಮಾಡ್ತೀರಾ?
ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ
ಕೊಡಿ ಮೇಡಮ್. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಮಂಡ್ಯಗೆ ಯಾವಾಗ್ಲಾರು ಕೊಡಿ.
ಅಲ್ಲಿ ಪೊಲೀಸ್ ಪ್ರೊಟೆಕ್ಷನ್ಗೆ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕೊಂಡವ್ರು ನಮ್ಗೆ ಅದಕ್ಕೋಸ್ಕರ
411.
ಅಲ್ಲಿ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕ್ಬಿಟ್ಟು ಈ ಪ್ರಾಪರ್ಟಿಗೆ ಪೊಲೀಸ್ ಪ್ರೊಟೆಕ್ಷನ್ ಕೇಳ್ತಾವ್ರು. ಅದಕ್ಕೋಸ್ಕರ
ಆಯ್ತು ಮಾಡಿ. ಫಸ್ಟ್ R. Shashi Kumar.
Hearing on it then.
Recalling the application and for the recalling the order dated 22/4/24. ಹೇಳ್ರಿ ಏನ್?
My lord, this matter, my lord, the judgment is passed by this honorable court, my lord. Subsequently, judgment is passed.
ಇದ್ರ ಕೇಸ್ ಏನ್ರಿ ಇದು?
Yes, my lord.
PM ನಾರಾಯಣ ಸ್ವಾಮಿ.
Yes, my lord.
ಹೇಳಿ ಏನಾಯ್ತು? ಲಾಸ್ಟ್ ಟೈಮ್ ಯಾಕ್ರಿ ಬರ್ಲಿಲ್ಲ?
Yes, madam. Cause list is not.
ಏನ್ ಕಾಸ್ ಲಿಸ್ಟ್? ಹೇಳಿ ಏನಾಯ್ತು?
Last date, my lord, I filed a
called twice and earlier counsel Sri Shashi Kumar is present before the court on both the occasions in the morning and also in the afternoon, but the counsel on record for the appellant Sri PM Narayana Swami is absent in the morning and also in the afternoon, and the applicant is also absent before the court. However, one more opportunity is given to the appellant and also so and so. ಹೇಳ್ರಿ ಏನಾಯ್ತು?
last time also
ಪರಿಸರ ಏನಕ್ಕೆ ನಾವು ಡೆಫರ್ ಮಾಡುವಾಗ ಏನೋ ಆರ್ಡರ್ ಮಾಡಿದ್ದೀವಿ, ಒಂದು ಡೀಟೇಲ್ ಆರ್ಡರ್.
Before that, before last date, madam.
The court wide
order for
dated
records ಮಾಡಿದ್ರಿ ತಾವು.
Records ಗೆ ಬಂದಿದೆಯಾ? Appellant only had executed the wakalat as well as other papers. Shashi Kumar and would submit that appellant had not only executed the wakalat and also sent the affidavit filed in support of the application which have been. This court already heard the matter earlier and disposed of sounds, and now the appellant has filed an application for condonation of delay of 41 days and recall the order dated so and so. Subsequent development, when the appellant approaches this court to recall the earlier order, which was dismissed on the ground of delay, as well as on merit on 17/4/23. When such dispute is there, it is appropriate to send the present wakalat executed to the new counsel and also the affidavits which have been filed in support of the application, that is IA number 2 of 24, as well as IA number 1 of 24. The earlier counsel would submit that there is a chances of adopting of an ingenious method in signing the signature in different method, and hence the trial court records wherein admitted the present appellant herein has signed the document also can be secured, and the same can be sent to the handwriting expert. Hence there is a force in the submission of the said counsel. Now the issue involves is with regard to the entrustment of papers to the respective counsels who pleaded before the court on behalf of the appellant. Hence it is necessary to get the records of the trial court. Kodri.
Last time I filed one complaint, the appellant has filed before the bar council. The lordship can compare those signatures also.
OS ಇದು ಲಕ್ಷ್ಮಣ್ಣ. ಈಗ ಕೋರ್ಟ್ ಮುಂದೆ ಕೊಟ್ಟಿರೋದು ಅಪ್ಲಿಕೇಶನ್ ಕೊಡಿ ಮೇಡಮ್. ಫಸ್ಟ್ RSA ಹಾಕಿದ್ರಲ್ಲ, RSA ಜೊತೆ ಒಂದು ವಕಾಲತ್ ಹಾಕಿದಾರೆ ನೋಡಿ.
RSA ಜೊತೆ ಅಫಿಡವಿಟ್ ಅಲ್ಲಿ ಇದೆ.
ಅಫಿಡವಿಟ್
ಪೇಜ್ ನಂಬರ್ 80 onwards ಇದೆ.
ಎಲ್ಲ ಒಂದೇ ಇದಾವಲ್ರಿ ಸಿಗ್ನೇಚರ್ಸ್.
One more request, madam.
ನೀವೇನೋ ಲಾಯರ್ಗೆ ಇಂಟ್ರೆಸ್ಟ್ ಮಾಡಿಲ್ಲ ಅಂತಾನೆ ನಿಮ್ ಕ್ಲೈಂಟ್. ವೇರ್ ಇಸ್ ಯುವರ್ ಕ್ಲೈಂಟ್? ಹ್ಯಾಂಡ್ ರೈಟಿಂಗ್ ಎಕ್ಸ್ಪರ್ಟ್ ಕಳಿಸ್ತೀನಿ, ಆಮೇಲೆ ಬಂದ್ರೆ ಅವನ ಮೇಲೆ ಕ್ರಿಮಿನಲ್ ಕೇಸು. Let him face the consequence.
One more request, madam.
ಹ್ಯಾಂಡ್ ರೈಟಿಂಗ್ ಎಕ್ಸ್ಪರ್ಟ್ ಅಲ್ಲಿ ಸಿಗ್ನೇಚರ್ಸ್ ಈಗ ಸ್ಪೆಸಿಮನ್ ಸಿಗ್ನೇಚರ್ ಕೋರ್ಟ್ ಮುಂದೆ ತಗೊಂಡಿದ್ದೀವಿ. ಜೊತೆಗೆ ಇಲ್ಲಿ ಅವನು ಹಾಕ್ಬೇಕಾದ್ರೆ ಫಸ್ಟ್ ಲಾಯರ್ಗೆ ಇಂಟ್ರೆಸ್ಟ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ವಕಾಲ್ ಸೈನ್ ಮಾಡ್ಕೊಟ್ಟಿದ್ದಾನೆ. ಹೌದಾ? ಅದ್ರ ಜೊತೆಗೆ ಅಫಿಡವಿಟ್ ಹಾಕಿದ್ದಾನೆ. ಈಗ ಮತ್ತೆ ನಿಮಗೆ ಇಂಟ್ರೆಸ್ಟ್ ಮಾಡುವಾಗ ಇದು ನನ್ನ ಸಿಗ್ನೇಚರ್ ಅಲ್ಲ, ನಾನು ಲಾಯರಿಗೆ ಕೇಸೇ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಇನ್ನೊಂದು ಹೇಳ್ತಾನೆ. ಬಟ್ ಇಲ್ಲಿ ಸಿಗ್ನೇಚರ್ ನೋಡಿದಾಗ ಕೆಳಗಿನ ಕೋರ್ಟ್ ಸಿಗ್ನೇಚರು, ಕೋರ್ಟ್ ಮುಂದೆ ಮಾಡಿರೋ ಸಿಗ್ನೇಚರು, ಫಸ್ಟ್ ಅಪೀಲ್ ಹಾಕ್ಬೇಕಾದ್ರೆ ಕೊಟ್ಟಿರ್ತಕ್ಕಂಥ ಸಿಗ್ನೇಚರು ಎಲ್ಲ ಒಂದೇ ಇದಾವೆ. ಈವನ್ ಕೋರ್ಟ್ ಕ್ಯಾನ್ ಕಂಪೇರ್ ದಿ ಸಿಗ್ನೇಚರ್ ಅಂಡರ್ ಸೆಕ್ಷನ್ 73. ಬಟ್ even when the appellant is denies that, this can be sent to the handwriting expert. If handwriting expert gives opinion, signatures all signed by him are one and the same, then criminal case will be registered against your client. ಮತ್ತೆ ಹೇಳಿ, ಅದಕ್ಕೇನೆ ರೆಕಾರ್ಡ್ಸ್ ಕಾಲ್ ಫಾರ್ ಮಾಡಿದ್ದು, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ಸ್. ವಕಾಲತ್ತು ಅಫಿಡವಿಟ್ ಎಲ್ಲ ನೋಡ್ರಿ ಅವಂದೇ ಸಿಗ್ನೇಚರ್ ಇದೆ. ಇಲ್ಲಿ ಬಂದು ಈಸ್ ಪ್ಲೇಯಿಂಗ್ ವಿತ್ ಕೋರ್ಟ್. ಅರ್ಲಿಯರ್ ಅಡ್ವೊಕೇಟ್ ಕೇಸ್ ನಲ್ಲಿ ಬಂದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಆರ್ಡರ್ ಬರೆದ್ರು ಈ ಕೋರ್ಟ್ ಆ ಲಾಯರಿಗೆ ನಾನು ಕೇಸೇ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾನೆ. ಆ ಲಾಯರ್ ಜೊತೆ ಕರ್ಕೊಬಂದ್ ಕೇಸ್ ಇಂಟ್ರೆಸ್ಟ್ ಮಾಡಿದ್ ಬಂದ್ ಲಾಯರ್ ಕೂಡ ಕೋರ್ಟ್ ಮುಂದೆ ಹೇಳ್ತಾರೆ, ಇಲ್ಲ ನನ್ ಜೊತೆಲೆ ಬಂದಿದ್ದ, ನನ್ ಕಾರ್ಲೆ ಕರ್ಕೋಗಿದ್ದೆ, ಲಾಯರ್ ಆಫೀಸಿಗೆ ಇಂಟ್ರೆಸ್ಟ್ ಮಾಡಿದ್ವಿ ಕೇಸ್ ಪೇಪರ್ಸ್ ಅವನೇ ಸೈನ್ ಮಾಡಿರೋದು ಅಂತಲೂ ಹೇಳ್ತಾರೆ. ಹಿಂಗಿದ್ದಾಗ ನಿಮ್ ಕ್ಲೈಂಟಿಗೆ ಕೇಳಿ, ಮತ್ತ ಅದೇ ಅವನು ಇಫ್ ಹಿ ಸೇಸ್ ಸೋ like that only, let him face the consequence, that's all.
11.
Post the matter along with year 1/23 for admission on 13/11.
Number 12.
Ajay Prabhu, ಹೇಳ್ರಿ. 722 days delay.
Yes, bro. Lord,
reason in
OS file was, Lord, OS suit was filed for Lord declaration and injunction. Lord, on the basis of concocted the document, Lord, sale it was registered.
ಆಯ್ತು.
In favor of defendant number 1.
ಅದೆಲ್ಲ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಬೇಡ ಈಗ. ಫಸ್ಟ್ ಯು ಆರ್ಗ್ಯೂ ಆನ್ IA ಮೇಲೆ, ಕಂಡೋನೇಷನ್ ಆಫ್ ಡಿಲೇ ಮೇಲೆ ಏನ್ ಹೇಳಿದ್ರಿ ರೀಸನ್?
Lord, that
ಅಪೀಲ್ ನೀವೇ ಹಾಕಿರೋದು.
ಹೌದಾ? ಅಪೀಲ್ ಅಂದ್ರೆ ಆಸ್ ಅ ನೆಕ್ಸ್ಟ್ ಫ್ರೆಂಡ್ ಆಫ್ ಅಪೀಲೆಂಟ್.
ನೆಕ್ಸ್ಟ್ ಫ್ರೆಂಡ್ ಗೆ ಅಪೀಲೆಂಟ್ ಗಾದ್ರೂ ನೀವೇ ಹಾಕಿರೋದಲ್ಲೇನ್ರಿ?
ಹೌದು, ಅನಿತಾ ಕಿಶೆಟ್ಟಿ.
ಈ ಅಪೀಲ್ ಫೈಲ್ ಮಾಡಿದ್ದಾರು, ಈ RSA ಫೈಲ್ ಮಾಡಿದವರು ಯಾರು?
ದಿ
ಒರಿಜಿನಲ್ ಅಪೀಲೆಂಟ್,
ಸನ್ ಆಫ್ ಅಪೀಲೆಂಟ್. ಸನ್ ಆಫ್ ಅಪೀಲೆಂಟ್.
ಹೌದು. ಫಸ್ಟ್ ಅಪೀಲ್ ನೀವು ಯಾರಿಗೆ ಕೊಟ್ಟಿರ ಅಪೀಲ್ ಫೈಲ್ ಮಾಡಕ್ಕೆ?
ಫಸ್ಟ್ ಅಪೀಲ್ ವಾಸ್ ಫೈಲ್ಡ್ ಬೈ ದಿ ಡಿಫೆಂಡೆಂಟ್, ದಿ ಡೈವರ್ಜೆಂಟ್ ಫೈಂಡಿಂಗ್ಸ್.
ಆಯ್ತ್ರಿ, ಈಗ ಡೈವರ್ಜೆಂಟ್ ಫೈಂಡಿಂಗ್.
ಹೌದು. ಸೊ ಅದರಲ್ಲಿ ನಮ್ OS ಅಲ್ಲಿ ನಮ್ ಫೇವರ್ ಆಯ್ತು, ಆದ್ಮೇಲೆ ಅವರು ಡಿಫೆಂಡೆಂಟ್
ಆಯ್ತು, ಆದ್ಮೇಲೆ ಪ್ಲೇಂಟಿಫ್ ಅಪೀಲ್.
ಎಸ್ ಮಿಲೋಡ್.
ಅವಾಗ ಏನಾಯ್ತು?
ಸೊ ಮಿಲೋಡ್
ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡಿದ್ರೆ ಇಲ್ಲ ಅಪೀಲ್ ಅಲ್ಲಿ?
ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡಿದೀವಿ. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅಪೀಲೇಟ್ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಹೆಲ್ಡ್ ದಟ್ ಮಿಲೋಡ್ ದಿ ಇಬ್ರು ಪ್ಲೇಂಟಿಫ್ಸ್ ಇದ್ರಲ್ಲಿ ಪ್ಲೇಂಟಿಫ್ ನಂಬರ್ 1 ತೀರೋದ್ ಕಾರಣ ದಿ ಹೋಲ್ ಸೂಟ್ ವಿಲ್ ಡೆಬಿಟ್ ಅಂತ ಹೇಳಿ ಮಾಡಿದ್ದಾರೆ.
ಅದೇನಾರಾಗ್ಲಿ ರೀ, ನೀವು ನಾಲೆಡ್ಜ್ ಬಗ್ಗೆ ಹೇಳ್ರಿ.
My lord,
ಏನ್ ಬರ್ದಿದ್ರಿ ನಿಮ್ಮ affidavit ಅಲ್ಲಿ?
I read that I have to take care of my mother.
Appellant who is of unsound mind.
Yes, my lord.
Has been looked after by the son, that is next friend.
Who
Who is representing the appellant and one grandmother. Who is aged about 74 years. ಹೌದಾ?
ಹೌದು. ಅವರ ನೋಡ್ಕೊಳ್ಳಿಕ್ಕೆ
requires continuous care. ಹೌದಾ?
ಹೌದು.
ಆಯ್ತು. appellant ಏನೋ unsound mind.
ಹೌದು.
ನೆಕ್ಸ್ಟ್ ಫ್ರೆಂಡ್ ಏನ್ ಮಾಡ್ತಾ ಇದ್ದ ಜಡ್ಜ್ಮೆಂಟ್ ಆದ್ಮೇಲೆ?
Lord, he was taking care of them, my lord. That is the reason.
ಆಯ್ತು. ಟೇಕಿಂಗ್ ಕೇರ್ಗೂ ಇದಕ್ಕೂ ಏನ್ ಸಂಬಂಧ? ಅಪೀಲ್ ಫೈಲ್ ಮಾಡೋದಕ್ಕೂ.
Lord,
due to financial condition to me, I could not approach advocate early, where I had been told regarding paying court fee in terms of referring appeal before this court. And only after procuring so much of amount, ಎಷ್ಟು court fee ಕಟ್ಟಿದ್ರಿ ಹೇಳಿ?
my lord, 60,000, about 60,000.
Initial purchaser respondent, the appellant has approached the court advocate only in the last week of December, and therefore the appellant was advised to 60,000 ಕಟ್ಟಿದ್ದೀರಾ?
ಹೌದು.
ಹೇಳ್ರಿ.
Actually, delay is not 700 days, my lord. Delay is 4 years.
4 years.
4 years. Your lordship may kindly turn to.
Now there is a divergent finding.
Your lordship may kindly see my lord, page 44. RA, copy application. Lord, copy applied on 11/11/2019.
11.
Ink page 44, my lord. I am going to decree.
ಹೌದು.
11/11/2019 ಗೆ ಅಪ್ಲೈ ಮಾಡಿದರೆ secured on 16/12.
ಜಡ್ಜ್ಮೆಂಟ್ ಆಗಿದ್ದೆ ಅವಾಗ?
ಅಲ್ಲ, ಜಡ್ಜ್ಮೆಂಟ್ ಆದದ್ದು ಡೇಟ್ ಆಫ್ ಜಡ್ಜ್ಮೆಂಟ್ ಈಸ್ 8/11/2019.
ಆಯ್ತು. 3 ದಿವಸದಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ.
3 ದಿವಸದಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ. 11/11/2019 ಗೆ ಹಾಕಿದ್ದಾರೆ. 16/12 ಗೆ ದೇ ಸೆಕ್ಯೂರ್ಡ್ ದ ಕಾಪಿ. ಇನ್ ದಟ್ ಇವೆಂಟ್ ಅಲ್ಲಿಂದ 3 months ಅಂದ್ರೆ March 2020 was the last date for filing appeal. They have filed this appeal in January 2024. It is virtually, my lord, 1,400 days, not 700 days, my lord, as the office has computed. And during this,
ಯಾಕೆ ಅಂತಂದ್ರೆ ಕೋವಿಡ್ ಪೀರಿಯಡ್ ಅಲ್ಲಿ ಎಕ್ಸೆಂಪ್ಷನ್ ಇದೆ, ಅದನ್ನ ಕಳೆದು ಅಷ್ಟು ಹಾಕಿದ್ದಾರೆ.
Yes,
ಕರೆಕ್ಟ್.
And during this interim, my lord,
ನಿಮಗೂ ಅಪ್ಲೈ ಆಗ್ತದೆ ಕೋವಿಡ್ ಎಕ್ಸೆಂಪ್ಷನ್. Don't try to more over smart. You are aware of the fact that COVID period there was an exemption for the limitation. Don't
yes,
try to mislead the court. ಹೇಳಿ next ಹೇಳಿ.
Next, my lord, during this interim, my lord, in 2000.
ನೀವ್ ಯಾಕ್ರಿ ಕಾಪಿ ತಗೊಂಡಿದ್ರಿ 19 ಅಲ್ಲೇ? ಅಪೀಲ್ ಆಕ್ಟ್ 24 ಹಾಕಿದಿರಿ.
ಅದೇ ಅವನ್ ಕಷ್ಟ, ಅವನ ತಾಯಿ ಹುಷಾರಿಲ್ಲ ಅಂತಂದ್ರೆ that is the ground, my lord. ಮೆಂಟಲಿ ರಿಟೈರ್ಡ್. ಅವ್ರದ್ದು GPA ತಗೊಂಡು ಸೇಲ್ ಡೀಡ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ.
ಯಾರ್ GPA ತಗೊಂಡು?
ಇವರು ಮೆಂಟಲಿ ರಿಟೈರ್ಡ್ ಪರ್ಸನ್.
Mentally retarded person.
That is the finding of the trial court.
It is not like that. My lord, entire appeal, my lord, nothing survives in, my lord, as per Supreme Court judgment.
I3 divergent finding.
My lord, in 2021 also, my lord, he has filed different cases. He has prosecuted so many cases, my lord. I have got material. This is just a chance taking litigation. My lord, now
not chance taking ರೀ. 60,000 ಕೋಟಿ ಫೀ ಕಟ್ಟಿ ಯಾರು ಬರ್ತಾರೆ? ಚಾನ್ಸ್
60,000 ಕೋಟಿ ಫೀ ಕಟ್ಟಿದ್ದಾರೆ. Your lordship may kindly see, my lord, plaintiffs 1 and 2 are brother and sister.
ಆಯ್ತು.
Brother and sister. Plaintiff
case is that you have to obtain the power of attorney of an unsound person.
Not unsound person.
ಮತ್ತೆ represented
fatherdu. My lord, property was belonging to Sanjeev Alwa.
Sale deed power of attorney ಬರ್ಕೊಟ್ಟಾರೆ ಯಾರು?
Power of attorney Sanjeev, their father, plaintiff's father has given power of attorney to one Marla. He has not been examined. Marla has sold to me, defendant number 1.
ಏನ್ರಿ ಮತ್ತೆ ನಿಮ್ ಸಬ್ಮಿಷನ್?
Unsound mind, your plaintiff 2 is of unsound mind ಅಂತ ಹೇಳುದವರು.
This is misleading. You kindly see, my lord, the page number 17. 17. Fact, my lord.
Appeal alla.
Appeal is also. Just kindly fact, my lord. It is alleged that some of the property standing in the name of mother at Japinmogro were occupied by tenants. They, in connivance of relatives of this plaintiff by name one Srinivas Marla and Veera Marla, have concocted and got up general power of attorney purported to have been executed by the plaintiff.
Executed by the plaintiff.
Plaintiffs in their favor ಅಂತ ಹೇಳಿ. It is not a plaintiff's father as executed general power of attorney. It is
Your lordship kindly see, my lord, in page 16.
On On the face of court, my lord, they are misleading the.
Plaint, I will take your lordship, my lord.
On the face of court.
Ink page 40, my lord, 46.
Plaint ಅಲ್ಲಿ.
Ink page 46, my lord. 47. Facts of the case, para 2. Sanjeev Alva and Sumati Alva are the husband and wife. Out of their wedlock, Sumati Alva begotten 2 children, Naveen Alva and Anita Shetty, plaintiff 2. Their father, Sanjeev Alva, was the absolute owner of scheduled property. After his death, they succeeded to the scheduled property. Plaintiff one during his lifetime permanently resided. The second plaintiff is mentally retarded. On account of her insanity, she was inpatient continuously for so and so. Mental. Their plaintiff's mother had value so and so, so and so. My lord, now your lordship may kindly see, my lord. They verified that the sets down, my lord. He contended that they executed sale deed in favor of the defendant through power of attorney holder of Srinivas Marla.
ಆಯ್ತು, ಪವರ್ ಆಫ್ ಅಟಾರ್ನಿ ಯಾರ್ದು?
ಫಾದರ್ದು.
ಎಲ್ಲಿದಾಗಂತ?
One Ravi Kumar Swans, who is defendant, produced a sale deed dated 97 invoice, and he contended that the second defendant, my lord, now
father had executed a power of attorney.
Yes.
In favor of Marla. ಅಂತ ತೋರ್ಸಕ್ಕೆ ಎಲ್ಲಿದೆ? According to you, father had executed.
Yes.
According to him, mother was executed.
Yes.
ಹೌದೇನ್ರಿ?
Mother property parents ದು. ಅದ್ ನಮ್ಗ್ ಬಂತು.
ಅದೇ ಫಸ್ಟ್ ಪ್ಲೇಂಟಿಫ್, ಸೆಕೆಂಡ್ ಪ್ಲೇಂಟಿಫ್ ಮೆಂಟಲಿ ರಿಟಾರ್ಡೆಡ್.
ಹೌದು, ನಮ್ದು ಜನರಲ್ ಆಫ್ ಪವರ್ ಆಫ್ ಅಟಾರ್ನಿ ಕಾಂಕಾಟ್ ಮಾಡಿ ಕ್ರಿಯೇಟ್ ಮಾಡಿ ಅದ್ರ ಬೇಸಿಸ್ ಮೇಲೆ ಸೀಲ್ ಡೀಡ್ ಮಾಡಿದ್ದಾರೆ. ನಮ್ ಕೇಸ್.
ನಿಮ್ ಕೇಸ್.
ಅವ್ರು ಹೇಳ್ತಿರೋದು ಏನಂತ, ನನ್ ತಂದೆ ತಾಯಿ ಇದು ಜನರಲ್ ಪವರ್ ಆಫ್ ಅಟಾರ್ನಿ ಮಾಡಿದ್ದು ಅದ್ರ ಬೇಸಿಸ್ ಮೇಲೆ ಮಾರಿದೆ ಅಂತ ಹೇಳಿ. ಇಟ್ ಇಸ್ ವೆರಿ ರಾಂಗ್, ಮಿಲೋಡ್. On the face of, because the trial court, milord, in
original power of attorney exhibit D1 ಇದೆಯಲ್ಲ,
ಅದು ನಾನ್ ಮಾಡಿದ್ದು ಅಂತ, ನಾನ್ plaintiff 1 and 2 ಮಾಡಿದ್ದು ಅಂತ,
plaintiff 1 and 2
ಮಾಡಿದ್ದು ಅಂತ ಹೇಳಿ ಅವ್ರ ಕೇಸ್.
ಅವ್ರು ಹಾಕಿರೋದೇ ಅದು.
ಹೌದು.
ಮತ್ತೆ ಆಯ್ತು, ಡಿಲೇ ಕಂಡೌನ್ ಮಾಡೋಣ.
I will file my objections, my lord.
ಹಾಕಿಲ್ವಾ?
Then ಹಾಕ್ಲಿಲ್ಲ. Because first time it is coming. And my lord, one more submission I want to make.
ಹೇಳಿ.
Sale was in my favor of first defendant. At the time of suit, my lord, he has sold to defendant number 2. So second defendant is also arrayed. I had filed caveat for R1 only. Now, my lord, in 2021, second defendant has sold to one third person, my lord. I will furnish the details. He is in necessary party right now.
Once again, he had
once again, second defendant has sold to one Srinivas Shetty.
During the pendency of the
2020 December.
Appeal ಇದ್ದಾಗಲಾ ಅಥವಾ
ಅಲ್ಲ, appeal RA dispose ಆದ್ಮೇಲೆ, RA dispose ಆಗಿದ್ದು November 2019 ಅಲ್ಲಿ.
In between
December 2020 ಅಲ್ಲಿ D2 has sold to
within appeal period. Milord, may I make submission? Milord, actually, milord, this matter
and milord, one more
back.
Matter
has to be remanded back. When milord, the first appellate court had held, milord, when one of plaintiff died, the suit entirely milord gets abated. Only on that account, milord, the RA was allowed. Milord, there is no, milord, only one question was answered. Point of consideration was answered. Others were not considered. Kindly see, milord, the
ಆಯ್ತು, ರಿಮೈಂಡ್ ಮಾಡ್ಬೇಕಾದ್ರೂ ಈಗ ನೋಟಿಸ್ ಕೊಡ್ಬೇಕಲ್ವಾ?
ಹೌದು, ಮಾಡಿ ಪ್ಲೀಸ್. ಪ್ಲೀಸ್
ಆಯ್ತು, ಇಶ್ಯೂ ನೋಟಿಸ್ ಅಗೇನ್ಸ್ಟ್ ದಿ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 2 on IA number 1 of 24.
Yes.
And counsel for the KVTR is given 2 weeks time to file objections to IA number 1 of 24. Notice on IA and also on main, madam, R2 ge returnable by date.
And my lord, one more my submission will be recorded, but now the property is in the hands of third person.
Okay. ನೀವು ವಕಾಲತ್ ಹಾಕ್ಬೇಕಾಗತ್ತೆ, 90 days ಲ್ಯಾಪ್ಸ್ ಆಗಿದೆ.
ಹೌದು, ಕೇವಿಟ್ ನಾನು 2019 ಅಲ್ಲಿ ಫೈಲ್ ಮಾಡಿರೋದು.
ಆಯ್ತು, 212. ಅವಾಗ ಹಾಕಿರೋದು.
ಹೌದು, 2019 ಅಲ್ಲಿ ನಾನು ಕೇವಿಟ್ has lapsed 90 days.
Counsel M. Sudhakar Pai is permitted to file wakalat on behalf of R1.
Yes.
And to file objections to IA number 1 of 24.
Yes. Now, my lord, may I make one
issue notice against respondent number 2 on main and also on IA.
Liberty to
I will furnish you the details. Now purchase in 2020 by third person.
ಅದ್ ಕೊಡಿ ನೋಡೋಣ, ನೀವೇನು ಸೇಲ್ ಮಾಡಿದ್ರೆ ಅವ್ರಿಗೆ ಕೊಡಿ, ಡೀಟೇಲ್ಸ್ ಕೊಡಿ.
ಅಲ್ಲ, let him implement, my lord, let the notice go out to him also, because he has to contest.
ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ತಲೇ ನೋಟಿಸ್ ಮಾಡಕ್ ಬರಲ್ರಿ. ಕೋರ್ಟ್ ಮುಂದೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ತಲ್ಲ, ನೀವು ಡೀಟೇಲ್ಸ್ ಕೊಡ್ಬೇಕು, ಅವ್ರ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಬೇಕು, ಹೇಗ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ?
2020 ಅಲ್ಲಿ
in the meanwhile registry is directed to get the records of the trial court and appellate court.
When my lord, I have questioned my lord the basic cell deed itself, my lord. My lord.
ಆಯ್ತ್ರಿ
I
ನೋಟಿಸ್
understand,
ಹೋಗಿ
yes.
ಬರ್ಬೇಕು.
Please, please.
ನೀವು ಡಿಲೇ ಇದೆ.
Yes, my lord. I will, my lord.
ನೀವು ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ತಗೊಂಡು ಆರಾಮಾಗಿ ಕೂತ್ಬಿಟ್ಟಿದಿರಿ.
I will, my lord.
ಮತ್ತೆ
I seek for my lord.
only on the ground that mentally retarded,
Please.
represented through a nest friend.
Please, I understand. Lord,
But
I
entire
seek
nothing-
liberty to, my lord, serve it on the counsel appearing for the respondent 2 in trial court.
Respondent number 2. ಆಯ್ತು. And appellate court is also direct. Appellant counsel is also permitted to serve the copy of this appeal memo and IA and the counsel who appeared on behalf of the R2 before the appellate court.
Please,
Appellate court.
Please.
ಆಯ್ತು.
Great.
212.
30.
212. Please.
Prasad Hegde case, sir, ಇದು in filing.
Filing. List this matter on 1311 for admission along with IAS.
30. Vijay Shekhar Gowda.
This is also. Delay ಅಲ್ಲ? Bringing LRs ಬೇರೆ ಇದೆ?
Already
Huh? List this matter for admission on 1311. 15 also. Huh?
ಇದರಲ್ಲಿ ಎಲ್ಲಾರ ಅಪ್ಲಿಕೇಶನ್ ಇದೆಯಲ್ಲ ಸರ್. ಫಸ್ಟ್ ಮಾಡ್ಬಿಟ್ಟು ಆಮೇಲೆ ಪರ್ಮಿಷನ್ ಕೊಡ್ತಾರೆ.
ಆಮೇಲೆ ಪರ್ಮಿಷನ್ ಕೇಳ್ತಾ ಇದಾರ?
ದಯಲಕ್ಷ್ಮಿ ಅನ್ನೋ
ಅವರೇ ಇಲ್ವಲ್ಲ ಬಿಡಿ, ಲಾಯರ್ ಇಲ್ಲಲ್ಲ. ಡೇಟ್ ಕೊಡಿ 1311 ನಾವೆಲ್ಲ ನೋಡೋಣ.
50.
Nataraj HD. List this matter for admission along with IA number 1 of 24 on 1311.
60.
Same order.
70.
17 same order.
17 ಅಲ್ಲಿ
18 same order. 1311.
90. Prasanna DP.
1311.
20.
20 1311.
21.
ಎಲ್ಲ ಫೈಲಿಂಗ್ 21 1311.
appearing for the appellant in this
1311 ಆಯ್ತು.
there is a delay of 251 days.
451 days.
251 days, my lord.
274 days ರೀ.
ಅದಲ್ಲ ಸರ್ 21 ಹೇಳ್ತಾರೆ.
21 ನಲ್ಲಿ 251 days.
251, 21.
ಆಯ್ತು 1311. ನಾನು ಓದ್ಕೊ ಬರ್ತೀನಿ, ಅವತ್ತು ಬನ್ನಿ ನೀವು.
Notice may be issued.
ನೋಟಿಸ್ ಮಾಡೋದಿಲ್ಲ. ಫಸ್ಟ್ RSA ನಲ್ಲೆಲ್ಲ ನೋಟಿಸ್ ಮಾಡೋದಿಲ್ಲ. ಫಸ್ಟ್ ಯು ಕನ್ವಿನ್ಸ್ ದಿ ಕೋರ್ಟ್ ಯು ಹ್ಯಾವ್ ಎ ಕೇಸ್ ಫಾರ್ ಕನ್ಸಿಡರೇಷನ್ ಆಫ್ RSA. Then I will issue notice.
Oblige, my lord.
Question matter
22.
Onkarappa LD. Praveen Kumar NK.
Dismissed, confirmed.
Plaintiff second appeal, my lord. Plaintiff has filed the suit for declaration and for possession of the encroached area. And so far as the client schedule is concerned, my lord, is a property agriculture land measuring 1 acre 7 guntas, out of which 35 guntas has been encroached by the defendant on the northern side of the suit schedule property. Now, Your Lordship, kindly see the court below. Both the courts have taken different view. The first trial court has taken the contention that we have not filed the title document so far as the partition is concerned. But somehow the other
Partition alla declaration.
Suit for
Suit is
declaration.
filed for the relief of declaration.
But I have not filed that partition entered. So far as that document is concerned, that was not produced. Even though my Lordship, kindly see in the para 7.
ನೀವು ರಿಲೇ ಮಾಡ್ತಾ ಇರೋದು ಬರೀ exhibit P1 and P2 ಹೌದಾ?
Yes, my lord.
RTC and endorsement.
Yes.
Issued by the Tahsildar.
Yes.
Whether the court can pass an order of declaration based on the RTC?
No, my lord.
And then that's what.
So far as that is concerned, my lord, other side has confronted by producing the Xerox copy of the my title document, that is the partition. That document is concerned, that has been marked as exhibit D1.
ಆಯ್ತು.
So far as that is concerned, my lord, here is a case, my lord, the endorsement issued by the.
ನಿಮಗೆ ಪಾರ್ಟಿಷನ್ ಆಗಿತ್ತಾ in between earlier? ಯಾರ್ಯಾರಿಗೆ?
ನಮ್ಮ father ಗೆ ಮತ್ತೆ brother ಅವ್ರಿಗೆ. In that, my lord, we have got one.
Then you ought to have pleaded that property was devolves upon your parents.
Yes,
in a partition ಅಂತ ಹೇಳ್ಬೇಕಲ್ವಾ?
That has to be mentioned, my lord.
ಹೇಳಿದೀರಾ ನೀವು?
Yes, my lord.
ಎಲ್ಲಿ ಹೇಳಿದೀರ ಅದನ್ನ? One acre 7 guntas situated in Kasba Hobbli, Holalkere Taluk.
Yes, my lord.
Acquired the settled property under a registered partition ಇದೆಯಲ್ರಿ?
ಹೌದು.
ಮತ್ತೆ ಅದ್ಯಾಕೆ ಹಾಕ್ಲಿಲ್ಲ?
That was not, actually the para 7 of the plaint, it has been mentioned that, my lord, the registered partition deed has been produced by along with the plaint, but it is also a copy and the original was missing, that's why it was not produced at the time of trial.
ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ತಗೊಂಡೆ ಹಾಕ್ಬೇಕಿತ್ತು ರಿಜಿಸ್ಟರ್ಡ್
Actually, but
ಪಾರ್ಟಿಷನ್
then other side, the cross examination confronted that.
ಅವರೇ ಕನ್ಫ್ರಂಟ್
Also, exhibit D1. ಅದು ಮಾಡಿದ್ದಾರೆ. But whereas the contention of the defendant is that, my lord, he has purchased the property measuring 2 acres 2 guntas from my uncle. That there was earlier partition 1959. So far as the extent is concerned, my lord, that was only 2 acres 12 guntas. He has purchased under the register said in 1993. But so far as that is concerned, there is no dispute at all. Only thing is that, my lord, here when I have applied for the Tatkal Kodi.
ಅದು ಡಿಫರೆಂಟ್ ಪ್ರಾಪರ್ಟಿ ಅಂತನಾ?
Also.
ನೀವ್ ಹೇಳ್ತಾ ಇರೋದು
But so
what
far
the
as
property was purchased by the defendant from your uncle.
yes, my lord.
That is a different property. ಆಯ್ತು.
So far as the encroachment is concerned, my lord, I have applied for the Tatkal Kodi during the year 2011. During that point of time, Tahsildar has issued an endorsement stating that there is an encroachment of 35 guntas on the northern side by the defendant. Then, my lord, I requested the defendant to leave that property, whatever you have encroached, but he did not agree. Then ultimately I filed the suit. And during the course of the trial, my lord, Lordship kindly say the court commissioner has also been appointed. The court commissioner has visited the spot and draw the spot sketch, and as per C1, my lord, Lordship kindly Peru, he has draw the sketch, my lord, wherein he has clearly said, my lord, actually the 352/2, that is the property belongs to defendant Maharudrappa. He is entitled for 1 acre 6 guntas only. Out of 2 acres 12 guntas, my lord, he has sold 1 acre 6 guntas in favor of Shiv Prakash. And only has retained 1 acre 6 guntas.
ADLR survey report ಏನು?
That is, my lord, there is an encroachment of 20 guntas by the defendant. That sketch drawn, my lord. I have got that sketch. Wherein, so far as my property is concerned, he has said, but my lord,
ನಿಮ್ ಸರ್ವೆ ನಂಬರ್ ಏನು?
353/2.
353/2.
Yes, ma'am.
ಡಿಫೆಂಡೆಂಟ್ ಏನು?
352/2.
ಅವ್ರದ್ದು 353/2 ನೇನಾ?
Actually, there was no support, and there is a giant RTC is coming in all the name, my lord.
Total extent ಎಷ್ಟಿದೆ ಈ ಸರ್ವೆ ನಂಬರ್ 353/2 ನಲ್ಲಿ?
Totally, my lord, 6 acres, I think. 1 minute. RTC disclosed, but my lord, even that is produced by the other side. 6 acres, 6 guntas, my lord, I think. But so far as the encroachment is concerned, according to the ADLR report, my lord, it is 20 guntas. My claim is 35 guntas. Totally measuring 4 acres 34 guntas and 6 guntas Karab in 353/2, wherein, my lord, the name of appellant SP Mallikarjunappa bin late P Basolingappa 1 acre 7 guntas as per the MR number so and so, and PS Maharudrappa bin Pujar Siddhappa is the defendant. His extent is 1 acre 6 guntas, and Basappa and some other person, my lord, they are the my family members. They got 1 acre 7 guntas, and whereas B Jayamma, HP Mallikarjunappa, Sharadamma, they have got 1 acre 8 guntas along with the plaintiff, my lord. That is the appellant herein. That is an extent of 1 acre 8 guntas. What the court commissioner has done, my lord, whatever the land belongs to my joint family along with me, he has shown that I have in proportion of 1 acre 10 guntas. But northern side is concerned, my lord, is the sketch prepared by the surveyor is very clear. He said that, my lord, it has reported that 1 acre 20 guntas has been encroached by the defendant. The trial court has taken.
ನೀವೇ ಅವ್ರೇನೋ ಕನ್ಫ್ರಂಟ್ ಮಾಡಿ ಡಾಕ್ಯುಮೆಂಟ್ ಮಾರ್ಕೆ ಆಗಿಲ್ವಲ್ಲ ನಿಮ್ ಪಾರ್ಟಿಷನ್ ಡೀಡ್ ನಿಮ್ ಪ್ರಕಾರ ಏನೋ ಹೇಳ್ತಾ ಇದೀರಿ.
So far as that is concerned, my lord.
ಎಲ್ಲಿದೆ ಮಾರ್ಕ್
During the first,
ಆಗಿರೋದು?
that has been exhibited D1, my lord.
Huh?
The exhibit D1. That has
D1.
been compared through PW1. D1.
ನೀವನ್ನ ರಿಲೇ ಮಾಡಿಲ್ವಲ್ಲ ಮತ್ತೆ ಇವರು?
That's what, my lord,
Trial court
because I have not produced the document. The trial court has taken the view that because the suit for declaration position of the encroached area, when I have not produced the title documents, that's why I have not
copy
entered.
of the partition deed exhibit D1.
Yes, my lord.
Ah.
Wherein I have got
That-
1
that-
acre 7 guntas.
Ah.
That is the what I am seeking declaration, my lord.
ಬಟ್ ಅದೂನುವೆ ನೀವು ಕೊಟ್ಟಿರ್ತಕ್ಕಂಥ ಬೌಂಡ್ರಿ ನಾಟ್ ಟ್ಯಾಲೀಸ್ ವಿತ್ ಅಂತ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ನವರು ಡಿಸ್ಕಸ್ ಮಾಡಿದ್ದಾರೆ. The said boundaries affixed in the exhibit D1 to the property allotted in favor of the plaintiff differs that of the boundary shown towards the western side of the suit scheduled property. However, since the plaintiff has filed as discharged his burden in proving his title over the suit scheduled property by producing the trustworthy title deeds, his pleadings and oral evidence adduced in this no use. At this stage, it is settled law that in a suit for declaration of title or the immovable property, the plaintiff shall prove his title on his own and cannot so and so. In the present case on hand, this plaintiff has not put forth any material to show that he is having title over the suit scheduled property. He cannot take the advantage of any weakness of the defendant. ಏನ್ರಿ ನೀವೇ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಲ್ಲ ಎಕ್ಸಿಬಿಟ್ D1 ಪ್ರಕಾರ ಅವನಿಗೆ ಬಂದಿರತಕ್ಕಂತ ಸೂಟ್ ಶೆಲ್ಡ್ ಪ್ರಾಪರ್ಟಿ.
On lordship, the case of the plaintiff or appellant before this honorable court, I was encroached the land of them which belongs to the 35 the guntas of land which is belongs to them, lordship. But in the cross examination, they are specifically admitted that I am in the sole possession of 1 acre 7 guntas 6 guntas itself, lordship. It's in the part of the cross examination where I was conducting cross examination, lordship. Lordship, please comes to the
Commissioner, according to him, says that you are in possession of the property of the plaintiff to the extent of 20 guntas.
No, lordship, that is false, and I was conducted the cross examination and commissioner also, lordship. He is also admitted certain things, lordship.
No, my lord.
Lordship, please comes to the ink page number 15, ink page number 10, lordship of the.
You are not disputing the title in respect of the plaintiff to the extent of 1
Title
acre.
is not in dispute, lordship, and they are making the allegation
How
that
can
I
they-
was encroached, and they should specify that which portion I was exactly encroached about.
Then how
And
can-
they are not provided the boundaries, and they are not provided any materials before the trial court, lordship. And the loop of the defendant, lordship, they try to grab the property which is exclusively belongs to the defendant, lordship, where I was the purchaser of the bona fide purchaser of their own family members, lordship. The case was start from the 1959, lordship. The case is this, lordship. The originally the survey number 421/2 measuring about 6 acre 30 to 36 guntas, lordship. Out of 6 acre 36 guntas, lordship, there among the family members, they are divided into 2 portion, lordship, and 1 portion the which fallen into the share of the
appellate court ಅಲ್ಲಿ ಹೋಗ್ರಿ ನಿಮ್ಮ admission.
So far as that is
PW1 clearly admits that ಈಗ 2 ಎಕರೆ 12 ಗುಂಟೆ ಜಮೀನಿನ 1 ಎಕರೆ 6 ಗುಂಟೆ ಜಮೀನಿನಲ್ಲಿ ಮಹಾರುದ್ರಪ್ಪ ಮತ್ತು ಉಳಿದ 1 ಎಕರೆ 6 ಗುಂಟೆ ಜಮೀನಲ್ಲಿ ಶಿವಪ್ರಕಾಶ ಸ್ವಾಧೀನ ಇದ್ದಾರೆ ಎಂದರೆ ಸರಿ. ಅದು ಅವ್ರ ವೆಂಡಾರ್ ಇಂದ ಪರ್ಚೇಸ್ ಮಾಡಿದ್ದು.
Yes, sold half extent.
Half extent.
2 acre 12 guntas.
ಹೌದು. In half extent
1 acre 6 guntas he has to be in possession. But whereas the commissioner report says that he is in possession of 2 acres 1 acre
commissioner report
26.
ಗೂ ಬರ್ತೀನಿ. ಬಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 30 ಗೆ ಹೋಗಿ appellate court order ಗೆ.
my lord.
30 ನಲ್ಲಿ ಕನ್ನಡದಲ್ಲಿ ಇದೆ ನೋಡಿ ಎಕ್ಸ್ಟ್ರಾಕ್ಷನ್ ನಿಮ್ಮ ಅಡ್ಮಿಷನ್.
ಈಗ 2 ಎಕರೆ 12
PW1 clearly admitted in his cross examination that ಈಗ 2 ಎಕರೆ 12 ಗುಂಟೆ ಜಮೀನಿನ 1 ಎಕರೆ 6 ಗುಂಟೆ ಜಮೀನಿನಲ್ಲಿ ಮಹಾರುದ್ರಪ್ಪ ಮತ್ತು ಉಳಿದ 1 ಎಕರೆ 6 ಗುಂಟೆ ಜಮೀನಿನಲ್ಲಿ ಶಿವಪ್ರಕಾಶ್ ಸ್ವಾಧೀನದಲ್ಲಿ ಇದ್ದಾರೆ ಎಂದರೆ ಸರಿ. ಮಹಾರುದ್ರಪ್ಪ ಮತ್ತು ಶಿವಪ್ರಕಾಶ್ ಕ್ರಯಕ್ಕೆ ಪಡೆದಾಗಿನಿಂದ ಅವರೇ ಸ್ವಾಧೀನದಲ್ಲಿ ಇದ್ದಾರೆ ಎಂದರೆ ಸರಿ. ಅವರ ಹೆಸರಿಗೆ ಖಾತೆಯಾಗಿ ಅವರೇ ಎಲ್ಲಾನು ಅಡ್ಮಿಷನ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಿ.
That is admitted because, my lord, their extent is only to an extent of 2 acres 6 guntas, that is 12 guntas, out of which 1 acre 6 guntas retained by the defendant. Another 1 acre 6 guntas he has sold. He has sold to Shivaprakash. And so far as the commission report says that he is in
Commissioner report ಹೋಗ್ರಿ ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ ಹೋಗ್ರಿ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್
Paragraph number 32.
ಕಮಿಷನರ್ ಒಟ್ಕೋತ್ಕೊಂಡ್ ನೋಡಿ.
ಅಲ್ಲಲ್ಲ, but his report ಮೇಲೆ kindly see the
ರಿಪೋರ್ಟ್ ಬಿಟ್ಬಿಡ್ರಿ, ಅವ್ನು ತಕರಾರ್ ಹಾಕಿದಾರೆ, ಅವರು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದಾರೆ, ಅವ್ನು ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ದಾರೆ.
So far as that is
ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ದಾರೆ, ಆನ್ಸರ್ ಎಲಿಸಿಟ್ ಮಾಡಿದ್ದಾರೆ.
so far as the examination of commissioner is concerned, my lord, here is a case, my lord, even though he
Is it your case that no he is in the extension of extra land ಅಲ್ಲಿ ಇದಾನೆ ಅಂತ?
ಹೌದು ಮೈ
ಎಲ್ಲಿದ್ದಾರೆ? ನೀವೇ PW1 ಅಡ್ಮಿಷನ್ ಇದೆಯಲ್ಲ?
ಅಲ್ಲ, that's what my lord.
1 ಎಕರೆ 6 ಗುಂಟೆ 1 ಎಕರೆ 6 ಗುಂಟೆನಲ್ಲಿ ಅಂತ
1 ಎಕರೆ 6 ಗುಂಟೆ ಬಿಟ್ಟು ಉಳಿದ
Now you cannot rely upon the commissioner report. When commissioner comes before the court and he categorically admits
so far as that is evidence is concerned, my lord.
ನೋಡಿ, ನೀಸಿ ಒಂದ ನನ್ನ ವರದಿಯ ಪ್ರಕಾರವೇ ವಾದಿ ಸಹ 3 ಗುಂಟೆ ಹೆಚ್ಚುವರಿ ಜಮೀನಿನಲ್ಲಿ ಸ್ವಾಧೀನ ಇದ್ದಾನೆ ಎಂದರೆ ಸರಿ.
It belongs to not to the defendant, my lord. It is our joint family property.
ನಿಮ್ದೆಷ್ಟು ಎಕ್ಸ್ಟೆಂಟ್ ಇರೋದು?
ನಮ್ದು 1 acre 7 guntahs, one extent, another in joint family, along with my mother and brothers. That is what 1 acre 7.
ದಾವಾ ಸ್ವತ್ತಿಗೆ ಭೇಟಿ ಕೊಟ್ಟು ಅಳತೆ ಮಾಡಿದ ಸಂದರ್ಭದಲ್ಲಿ ಕಂಡು ಬಂದಂತೆ ವಾದಿ ಹೆಸರಿಗೆ ಇರುವ ಪಾಣಿಯಲ್ಲಿರುವ ಅಳತೆಗಿಂತ 3 ಗುಂಟೆ ಹೆಚ್ಚುವರಿ ಜಮೀನನ್ನು ಒತ್ತುವರಿ ಮಾಡಿರುವುದು ಕಂಡು ಬಂದಿತ್ತು.
But so far as the 3 guntahs excess is concerned, it is not the property belongs to the either the defendant. But thing is that, my lord, that land extent is belongs to our family. The surveyor has wrongly mentioned and measured that, but actually on the northern side is concerned, my lord, the defendant's property only measures 1 acre 6 guntahs, but he is in possession of 1 acre 26 guntahs. That's what this case reported by the court commissioner, my lord.
They are not stick on to the particular lordship where they are taking the shelter under the commissioner report, and again they are disputing before this honorable court, where this honorable court the rightly the pointed out the commissioner the cross examination portion, which is at ink page number the 29 at paragraph number 32, lordship. And now they are taking the shelter under before this honorable court. The encroached portion is the belongs to their family members, lordship, and no family members are come before the trial court as well as the first appellate court if they are being aggrieved by that, lordship. And they are themselves only admitted that I am in the possession of the 1 acre 6 guntahs itself, lordship. And where is the question of encroaching by their property, lordship? If it is so, lordship, something should be, some record should be shown. And their title itself, they are not, their title itself not being cleared by them before the trial court. And whatever the document, sorry.
When the suit is filed for the relief of declaration.
Yes, please, lordship.
And those sought for the relief of encroachment to the extent of 35 guntahs.
Please, lordship.
If they have not established the encroachment of 35 guntahs, is it not the duty of the trial court to grant the relief of declaration to the extent what he has got in a partition deed? You are also not disputing the claim with regard to the property of him.
I'm not disputing his title at all, lordship.
And appellate court also comes to the conclusion that when they have filed a document of partition deed, that is rejected by answering the negative, saying that no, document already marked as exhibit D1 before the trial court. But exhibit D1, which you have confronted to the witness, clearly shows that he got the property to the extent of
1 acre 7 guntahs.
1 acre 7 guntahs.
Exactly, lordship.
Declaration ಕೊಡಬಹುದಿತ್ತಲ್ಲ.
Yes. My point is this, lordship. Is one who approach, his burden is lies on him, lordship.
ಆಯ್ತ್ರಿ, ನೀವೇ ಹಾಕಿದಿರಿ, ನೀವೇ ಕನ್ಫ್ರಂಟ್ ಮಾಡಿದಿರಿ ಅವ್ರ ಟೈಟಲ್ ನ. Once their title is available before the court, trial court has to consider both the documents of plaintiff and also the defendant. ಹೌದಲ್ಲ? ನೀವೇ ಕನ್ಫ್ರಂಟ್ ಮಾಡಿ ಅವನಿಗೆ ಅವನ್ ಪಾರ್ಟಿಷನ್ ಮೂಲಕ ಬಂದಿರೋದೇ 1 ಎಕರೆ 6 ಗುಂಟೆಸ್ ಅಂತ ಹೇಳಿ ಕನ್ಫ್ರಂಟ್ ಮಾಡಿದಿರಿ. And trial court ought to have relied upon the document exhibit D1 and granted the relief of declaration in favor of the plaintiff.
That is pertains, that is only pertains to the 1 acre 6.
Appellate court ಅಲ್ಲಿ ಅವ್ರು ಯಾವಾಗ ಪಾರ್ಟಿಷನ್ ಡೀಡ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಕ್ ಹೋಗ್ತಾರೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ, ಅವರೇನೆ ಫಸ್ಟ್ ಆಫ್ ಆಲ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ನಾಟ್ ರಿಲೇಡ್ ಅಪಾನ್ ಎಕ್ಸಿಕ್ಯೂಟಿವ್.
Exactly, lordship.
ಆವಾಗ ಮತ್ತೆ ಅಡಿಷನಲ್ ಇದನ್ನ ಅಪ್ಲಿಕೇಶನ್ ನ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತಾರೆ.
I'm sorry, lordship. They are not chosen to produce that material before the trial court itself. They made an attempt before the trial court by way of filing the application under 41, lordship.
Instead of you only filed the registered document of partition deed of the plaintiff, ಅವ್ರು ಹಾಕ್ಲಿಲ್ಲ ಅಂದ್ರೆ at least ನೀವು
title is not dispute here, lordship. That a dispute is only extent, lordship, and themselves only admitted that I am in the extent, I am in the possession of extent of 1 acre 6 guntahs itself, lordship. And without providing anything to that, I am encroached upon their property.
ಆಯ್ತ್ರಿ, ರೆಕಾರ್ಡ್ ಬಂದಿದೆ ಮೇಡಮ್. ನಿಮ್ಮಾಗ ನೀವು ಟೈಟ್ಲಿಗೆ ಏನು ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡ್ತಾ ಇಲ್ಲ.
No, lordship.
This court will grant the relief in favor of the plaintiff only to the extent of 1 acre 6 declaration, that's all.
Lordship, it may be have it next week,
Number one
lordship.
is
Who cannot seek for an encroachment of 35 guntas of land, no such encroachment is concerned. You only admitted in the PW one
And
cross
lordship, please come to,
examination.
for a minute,
Both,
lordship.
both of them are in possession to the extent of 1 acre 6 guntas. The vendor as well as the purchaser, they are in possession to the extent of only 1 acre 6 guntas each. How can you claim that 35 guntas he is in possession of your land?
So far as that is concerned, court commissioner has been appointed, madam.
Commissioner, court commissioner ಮತ್ತೆ admit
ಅಲ್ಲಲ್ಲ ಇಲ್ಲಿ ಸ್ಕೆಚ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅಲ್ಲಿ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ ಒಪ್ಕೊಂಡಿದ್ದಾನೆ ಅವನು. ನೀವೇ 3 ಗುಂಟೆ ಎಕ್ಸ್ಟ್ರಾ ಇದೀರಿ.
He turned, but here is the sketch prepared by him, my lord. Kindly peruse this.
ಸ್ಕೆಚ್ ಇರ್ಲಿ ರೀ, ಅವನ ಅಡ್ಮಿಷನ್ ಇದೆ ಇಲ್ಲಿ.
ಅಲ್ಲಿ admission ಇದೆ.
ಮಾಡಿದ್ದಾರೆ.
ಅಲ್ಲಲ್ಲ ಇಲ್ಲಿ ಸ್ಕೆಚ್ ಅವರೇ ಡ್ರಾ ಮಾಡಿರೋದು, ಇದ್ರಲ್ಲಿ 20 ಗುಂಟೆ ಅವರು ಒತ್ತುವರಿ ಆಗಿದೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಡಿಪೆಂಡೆಂಟ್.
ರೀ ನಿಮ್ಗೆ ಹೇಳಿದ ಅರ್ಥ ಆಗಲ್ಲೇನ್ರಿ?
That's what my lord.
ಕಮಿಷನರ್ ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ ಇದೆ. ಅವ್ನು ಕಮಿಷನರ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದಾಗ ಕೋರ್ಟ್ ಮುಂದೆ ಬಂದಾಗ ಅವ್ನು ಅಡ್ಮಿಷನ್ ಕೊಡ್ತಾನೆ. ಏನಂತ? ನೀವೇ 3 ಗುಂಟೆ ಎಕ್ಸ್ಟ್ರಾ ಇದೀರಿ, ಕಮಿಷನರ್ ವರದಿ ಪ್ರಕಾರ 3 ಗುಂಟೆ ಸ್ವಾಧೀನದಲ್ಲಿ ಇದ್ದಾನೆ ಎಂದರೆ ಸರಿ, ವಾದಿನೇ.
That's true, my lord.
ಮತ್ತೆ ಇನ್ 20 ಗುಂಟೆಗೆ ಎಲ್ಲಿದೆ?
ಅಲ್ಲ, to whom it belongs, that is important, my lord.
ಯಾವುದು?
That to 20 guntas.
ಓ ನೀವು ಅದಕ್ಕೆ ಟೈಟ್ಲ್ ಕೇಳ್ತಾ ಇದ್ದೀರಾ? ಬೇರೆ ಯಾವ್ದು?
ಯಾಕಂದ್ರೆ the remaining portion
you cannot seek such relief.
But so far as that is concerned,
you are making an attempt.
No,
to an extent
so
of
far as that is concerned, my lord, whatever the admission made by the PW1.
ನಿಮ್ಗೆ ಎಷ್ಟಿದೆ ನಿಮ್ ಪಾರ್ಟಿಷನ್ ಪ್ರಕಾರ?
1 acre 7 guntas.
ಹೌದಾ?
To allotted to me.
1 acre 7 guntas ಗೆ ಮಾತ್ರ.
Another 1 acre 8 guntas in joint family, our joint family.
ನಿಮ್ ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿ ಇದೆಲ್ಲ ನೀವು ಕೇಳಕ್ ಬರಲ್ಲ ಇಲ್ಲಿ.
ಅಲ್ಲ, that's why
ನೀವ್ ಅವ್ರೇನ್ ಅದನ್ನ ನೀವ್ ಹೆಂಗ್ ಕೇಳ್ತೀರಿ? ನಿಮಗೆ ಎಷ್ಟು ಬಂದಿದೆ
ಅಲ್ಲಿ ಸರ್ವೆ ಮಾಡುವಾಗ
ನೋಡ್ರಿ, ನಿಮಗೆ ಎಷ್ಟು ಬಂದಿದೆ ಅಷ್ಟೇ ನೀವು ಮಾತ್ರ ಕೇಳ್ಬೇಕು ಅಷ್ಟೇ.
I am also one of the shareholder in the joint family in the so far as the RTC.
ನಿಮಗೆ ಪಾರ್ಟಿಷನ್ ಆಗಿದೆಯಲ್ರಿ?
ಅಲ್ಲ, ಇನ್ನೊಂದು ಜಾಯಿಂಟ್ ಆಗಿದೆ ಸ್ವಾಮಿ.
ಏನ್ ಜಾಯಿಂಟ್ ಅಲ್ಲಿ ಇದೆ?
that remaining
ಜಾಯಿಂಟ್ ಅಲ್ಲಿ ಇರೋದಕ್ಕೆ ನೀವೇನ್ ಡಿಗ್ರಿ ಕೇಳಿಲ್ಲ?
ಅಲ್ಲ, ಅದು ಕೇಳಿಲ್ಲ.
ಯಾವ್ದಕ್ಕೆ?
ಅದು ಕೇಳಿಲ್ಲ.
ಮತ್ತೆ
so far as the
ಅದಕ್ಕೆ ಡಿಗ್ರಿ ಕೊಡಿ ಅಂತ ಕೇಳ್ತೀರಾ? ಈ ಕೋರ್ಟ್ ಅಲ್ಲಿ
call for the record, so the
ಟೈಪ್ ಆಫ್ ಆಫೀಸರ್ ನೀವು, ಕೋರ್ಟ್ ಆಫೀಸರ್. ಅಟ್ಲೀಸ್ಟ್ ನಾವ್ ಹೇಳೋದಾರು ಕೇಳ್ಬೇಕು.
ಅಲ್ಲಲ್ಲ,
ನಾವ್ ಹೇಳಿದ್ನಾರು ಅಟ್ಲೀಸ್ಟ್ ಕನ್ವಿನ್ಸ್ ಆಗ್ಬೇಕು. ನೀವು ಏನ್ ಜಡ್ಜ್ಮೆಂಟ್
ಅಲ್ಲಲ್ಲ, ಈಗ
ಕೇಳಿರೋದು ಎಷ್ಟು ಕೇಳಿದ್ರಿ? ಡಿಕ್ಲರೇಷನ್
1 acre 7 guntas. 1 acre 7 guntas.
ನಿಮಗೆ ಪಾರ್ಟಿಷನ್ ಅಲ್ಲಿ ಎಷ್ಟು ಬಂತ ಅಷ್ಟಕ್ಕೆ ಮಾತ್ರ, ಹೌದಲ್ಲ? ಅಷ್ಟು ಮಾತ್ರ ಕೊಡ್ಬೇಕು. ನೀನ್ ಎಕ್ಸಸ್ ಹೆಂಗ್ ಕೇಳ್ತೀರಿ ನೀವು? ಮೇ ಬಿ ಏನ್ ಲ್ಯಾಂಡ್ ಆಫ್ ದಿ ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿ. ಒಂದ್ ಎಕರೆ 7 ಗುಂಟ ಏನಿದೆಯೋ ನಿಮಗೆ ಪಾರ್ಟಿಷನ್ ಬಂದಿದೆ, ಅಷ್ಟೇ. ನೀವು ಬೇರೆದು ಕೇಳಕ್ಕಾಗಲ್ಲ. ನೀವು ಆ 1 ಎಕರೆ 7 ಗುಂಟೆ ಇಟ್ಕೊಂಡು ಬೇರೆ ಲ್ಯಾಂಡ್ಗೂ ಕೇಳ್ತಾ ಇದ್ದೀರಿ, ಹೌದಿಲ್ಲ? ಸರಿಯಾ ಮಾಡೋರು ನಿಮಗೆ ಅಪಲೇಟ್ ಕೋರ್ಟ್ನವರು, ಟ್ರಯಲ್ ಕೋರ್ಟ್ನವರು. ಇನ್ನೇನ್ ಮಾಡ್ಬೇಕು ಕೇಳಿ ಮತ್ತೆ?
ಅಲ್ಲ, so far as the defendant's property is concerned, he is entitled for 1 acre 6 guntas only. ಅದಕ್ಕೆ
ನೋಡ್ರಿ, ನೀವು ಯು ಶುಡ್ ಸ್ಟ್ಯಾಂಡ್ ಆನ್ ಯುವರ್ ಓನ್ ಲೆಗ್ಸ್. ನಿಮ್ಗೆ ಈಗ ಇದೆ ಡಿಕ್ಲರೇಷನ್ ಇದೆ, ಐ ವಿಲ್ ಮಾಡಿಫೈ even in the absence of records also, because they are not disputing it. 1 ಎಕರೆ 7 ಗುಂಟೆ ಏನಿದೆಯೋ ಅದಕ್ಕೆ ಮಾತ್ರ ನಿಮಗೆ ಡಿಗ್ರಿ. ನೀವು on the guise of 1 acre 7 guntas you are making an attempt to
the other extent
on the ground of encroachment to the extent of 20 guntas. ಕಮಿಷನರ್ ಅಪಾಯಿಂಟ್ ಮಾಡ್ಕೊಂಡು ಕಮಿಷನರ್ ಕೇಳಿ ಬರ್ಸ್ಕೊಂಡ್ರಿ. ಬಟ್ ಕಮಿಷನರ್ ಕೋರ್ಟ್ ಮುಂದೆ ಬಂದ ಅವನೇ ಹೇಳ್ತಾನೆ, ಇಲ್ಲ ಇಲ್ಲ ನೀವೇ 3 ಎಕರೆ 3 ಗುಂಟೆ ಜಾಸ್ತಿ ಇದೀರಿ ಅಂತ.
ಅಲ್ಲ, ನಾವು 3 ಗುಂಟೆ ಇದೆ, ಬೇರೆ ಹೇಳಿಲ್ಲ.
The second appeal is listed for admission.
It's it by order 7 rule 3 also, lordship.
ಏನ್ ಹೇಳಿ?
Order 7 rule, it's it by order 7 rule 3 also, lordship. The plaintiff, they are not that properly describe the scheduled property, lordship.
Schedule ಏನ್ ತೋರಿಸಿದಾರ ಅವರು?
No, encroach portion.
Partition deed ಪ್ರಕಾರ schedule ಏನ್ ತೋರಿಸಿದಾರ್ರಿ? ಓ ನೀವು ಶೆಡ್ಯೂಲ್ ಕರೆಕ್ಟ್ ಆಗಿ ಕೊಟ್ಟಿಲ್ಲ.
No, lordship.
ಓ ನೀವು ಅದರಲ್ಲೇ ನಿಮಗೆ ಮಾಡಿರೋದು.
ಅಲ್ಲಲ್ಲ, so far schedule is concerned.
ಒಂದು ಇಲ್ಲಿದೆ ನೋಡಿ, ಅದನ್ನೇ ನಾನು ಅಬ್ಸರ್ವ್ ಮಾಡಿದೆ. ಅದಕ್ಕೆ ಕರೆಕ್ಟ್ ಆಗಿ ಡಿಸ್ಮಿಸ್ ಮಾಡೋರು ಬಿಟ್ರಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ನವರು.
ಅಲ್ಲಲ್ಲ, so far
ಏನ್ ಮಾಡಿದಿರಿ ನೋಡಿ, ಬೌಂಡ್ರಿ ತೋರಿಸ್ಬೇಕಾದ್ರೆ ಅದಕ್ಕೆ ಯು ಆರ್ ನಾಟ್ ರಿಲೈಯಿಂಗ್ ಅಪಾನ್ ದಿ ಪಾರ್ಟಿಷನ್ ಡೀಡ್. The set boundaries affixed in the exhibit D1 to the property allotted in favor of the plaintiff differs that of the boundary shown towards the western side of the suit scheduled property.
And they are not entitled for declaration too, lordship.
ನೀವು western
so far
boundary,
that is boundary, one of the boundaries disputed thing is that is on the northern side, the defendant's property is there, my lord. That's why northern side, not on the western
ನೀವು
side.
ವೆಸ್ಟರ್ನ್ ಬೌಂಡ್ರಿಗೆ ಇನ್ನೊಂದು ಬೇರೆ ಲ್ಯಾಂಡ್ ತೋರಿಸ್ತಾ ಇದೀರಲ್ಲ ಯಾಕೆ?
No, that is only the mistake of the wrong boundary, one of the boundary. But
Not
think with that, my
mistake.
lord.
Not mistake. You thought that you can get the decree in respect of the other property also to the extent of 35 guntas. That's why you have not filed the partition deed before the trial court. And also the boundary is shown, western boundary different from exhibit D1.
That's what, my lord. Even though I have produced at the time of filing the
Thought that
plaint
I can
itself.
grant the
ಅಲ್ಲ
relief.
plaint ಹಾಕುವಾಗಲೇ ಹೇಳಿದ್ದಾರೆ ಸ್ವಾಮಿ.
ಏನಂತ?
Partition, registered partition deed mention ಮಾಡಿದ್ದಾರೆ, produce ಮಾಡಿದ್ದಾರೆ.
ನಿಮ್ ಬೌಂಡ್ರಿ ನೀವೇನ್ ಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ತೋರಿಸಿದಿರಿ, ವೆಸ್ಟರ್ನ್ ಬೌಂಡ್ರಿ ನಾಟ್ ಇನ್ ಟರ್ಮ್ಸ್ ಆಫ್
That's
exhibit
true, my
D1
lord.
ರೀ.
But so far as
D1.
the admission made by the other side by producing the exhibit D1, I am entitled for 1 acre 7 guntas.
ನೀವು ಬೌಂಡ್ರಿ ಕರೆಕ್ಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಇಲ್ವಲ್ಲ, ಮಾಡಿಲ್ವಲ್ಲ ನೀವು? ಎಕ್ಸಿಬಿಟ್ D1 ಪ್ರಕಾರ ನೀವು ಬೌಂಡ್ರಿ ಈಗ
ಹಿಂದೆ ಯಾವಾಗಲೂ ಆಗಿರುತ್ತೆ.
ಈ ಬೌಂಡ್ರಿ ತೋರ್ಸಿ ನೀವು ಡಿಗ್ರಿ ತಗೊಳಕ್ ಆಗಲ್ಲ. ಯಾಕೆಂದ್ರೆ ನಿಮ್ ಬೌಂಡ್ರಿ ಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಇರೋದೇ ಬೇರೆ, ನಿಮಗೆ ಪಾರ್ಟಿಷನ್ ಡೀಡ್ ಅಲ್ಲಿ ಬಂದಿರೋದೇ ಬೇರೆ ಬೌಂಡ್ರಿ.
Only on the western side.
That is the reason only the trial court dismissed. You played fraud on the court, showing the boundary.
No, not the fraud, my
different
lord,
boundary. Tol.
So
This
far as
matter
that
this matter is listed for admission.
So far as that is in that
I
matter
heard
has
the
to be
counsel
remanded.
appearing for the appellant and also the counsel for the respondent. The main contention of the counsel appearing for the appellant before this court that both the courts committed an error in not granting the relief of declaration and also the relief of encroachment made by the defendant. And counsel also vehemently contend that court below are not justified in holding that respondent not encroach the suit land. Even though court commissioner report and sketch is very clear about encroachment made by the respondent. And court below is erred in not considering the entries made in the RTC Pani reflects about the possession of the suit land by the appellant to the extent of 1 acre 7 guntas as per the registered partition deed dated 9/5/2012. It is marked as per exhibit D1 in view of the presumption under section 133 of the KLR Act. And counsel also vehemently contend that both the courts committed an error in not granting the relief of declaration and also with regard to the encroachment is concerned and committed an error and it requires interference. Counsel appearing for the respondent would submit that even though there is no dispute with regard to the title to the extent of plaintiff that he got 1 acre 7 guntas of land, but the plaintiff clandestinely did not place it on record before the court the title document of partition deed under which he got the property of 1 acre 7 guntas and made an attempt before the trial court to get the decree more than what he got in the partition deed. And the same is taken note of by the trial court while dismissing the suit. In paragraph number 19, when the document was confronted by the defendants themselves, exhibit D1 partition deed of the plaintiff. And trial court made an observation in the end of the said paragraph number 10 that the said boundary affixed in the exhibit D1 to the property allotted in favor of the plaintiff differs that of the boundary shown towards the western side of the suit shell property. And counsel would submit that showing the wrong boundary made an attempt to knock off the property of the defendant and hence rightly dismiss the same. The counsel also would submit that the trial court discussed in detail even first appellate court also while dismissing the appeal taken note of admission on the part of appellant in paragraph number 30 wherein also categorically admitted that defendant is in possession to the extent of 1 acre 6 guntas which he had purchased and his vendor is in possession to the remaining extent of 1 acre 6 guntas. And also when the commissioner given the report erroneously, statement of objection was filed and the commissioner was also summoned before the court. And commissioner in the cross examination categorically admitted that in terms of the report, the plaintiff himself is in excess possession of 3 guntas of land. And further, he categorically admits that when he visited the spot and surveyed the land, found excess 3 guntas of land in possession of the plaintiff, and rightly taken note of the said fact and not committed any error. Having heard the appellant counsel and also the counsel appearing for the respondent, and also on perusal of material available on record, and no doubt the plaintiff got the property to the extent of 1 acre 7 guntas under a registered partition deed. And though plaintiff has not produced the document, but defendant themselves have confronted the document of exhibit D1, and also an attempt is made by the appellant before the appellate court by producing the document of registered partition deed, and appellate court did not receive the same in coming to the conclusion that document already marked before the trial court in trial court as exhibit D1. It is also important to note that the plaintiff made an attempt filing a suit for the relief of declaration and also contending that defendant has encroached to the extent of 35 guntas, but the admission given by the plaintiff in the cross examination categorically admits that defendant is in possession to the extent of 1 acre 6 guntas which he had purchased, and also his vendor is in possession to the extent of 1 acre 6 guntas which he retained. And when such being the case, the trial court rightly comes to the conclusion that the plaintiff has not proved the encroachment of 35 guntas, answering the issue number 2. And also the appellate court reassessed the evidence available on record, extracting the admission in paragraph number 30 and also in paragraph number 31, the categorical admission on the part of the commissioner. And when such being the case, and also when the plaintiff an ingenious method made an attempt to get the decree showing the boundary, western boundary of the scheduled property different from the boundary which is mentioned in exhibit D1. And when such being the case, and the same is also observed by the trial court in paragraph number 19, and hence when the plaintiff did not approach the court with clean hand, seeking the relief of declaration in respect of the property which he obtained, he got the title in terms of the exhibit D1 partition deed, but an attempt is made showing the different boundary in the western side, that too making an allegation of defendant has encroached to the extent of 35 guntas, but the commissioner who has been examined before the trial court as CW1 categorically admits that the plaintiff is in excess of the 3 guntas of land what he has got under the exhibit D1. And when such admission is given, and both the courts taken note of the fact that the plaintiff made an attempt to enrich the extent of the land more than what he has got by showing the western boundary different from the boundary which is shown in exhibit D1. And when such being the case, when the plaintiff has not approached the court with clean hand with a specific boundary, and apart from that, the plaintiff did not produce such document before the court, and even the defendant took pain to produce the document of partition deed of the plaintiff and got clarify the same, that western boundary shown in the plaint is different from exhibit D1. Under the circumstances, the appellant is not entitled for any relief before the court in respect of the boundary which is shown in the plaint, which is not in accordance with exhibit D1 partition deed, and hence rightly trial court as well as the appellate court dismissed the suit of the plaintiff, and hence I do not find any ground to admit and frame substantive question of law. In view of the discussions made above, I pass the following order. The second appeal is dismissed.
In request, Lordship. it's it by order 7 rule 3 may be incorporated in the dictation.
ಏನಕ್ಕೆ ಬೇಕದು?
Description is not being properly produced before the trial court.
ಮಾಡಿದೀನಲ್ಲ, ಹೇಳಿದ್ನಲ್ಲ, ಪ್ರಾವಿಷನ್ ಒಂದು ಹೇಳಿಲ್ಲ ಅಷ್ಟೇ.
Please.
But
That
document has
provision
been
may
produced,
be
my lord, along with
taken.
And the prayer is sought by the plaintiff is not in consonance with order 7 rule 3
Please,
and the
Lordship.
proper description is not shown in the plaint.
the document is produced along with the plaint, but that was not marked. Only the Xerox copy has been produced. That's what my the order, paragraph 7 of the plaint disclosed.
Why you have suppressed the partition deed before the trial court?
No, it has been produced. A
Yeah,
copy has
produced
been produced. In the plaint itself, it has been disclosed.
ಮಾರ್ಕ್ ಯಾಕೆ ಮಾಡ್ಲಿಲ್ಲ ನೀವು?
The original was missing, my lord. That's why it
ಒರಿಜಿನಲ್
was
ಮಿಸ್ಸಿಂಗ್
not.
ಆದ್ರೆ ಸರ್ಟಿಫಿಕೇಟ್ ಅಲ್ವಾ? ರಿಜಿಸ್ಟರ್ಡ್
But by that
ಪಾರ್ಟಿಷನ್
time,
ಡೀಡ್.
my lord, they have not chosen to
ನೀವು
get it.
ಉದ್ದೇಶಪೂರ್ವಕವಾಗಿ ಬೌಂಡ್ರಿ ವೆಸ್ಟರ್ನ್ ಬೌಂಡ್ರಿ ಡಿಫರೆಂಟ್ ಬೌಂಡ್ರಿ ತೋರಿಸಿ.
But he is not on the western side. Defendant is on the northern side of the property.
ಆಯ್ತು.
That is not the western boundary.
ನೀವು ಅವ್ರದ್ ವೀಕ್ನೆಸ್ ಯಾಕೆ ನೋಡ್ತಿರ್ರಿ? ನೀವು ಫಸ್ಟ್ ಕರೆಕ್ಟ್ ಆಗಿ ಇರ್ಬೇಕು ಕೋರ್ಟಿಗೆ ಬಂದಾಗ.
True by, but only thing is there is some mistake.
ಆಯ್ತು.
So far as the declaration is concerned.
Because of the fraudulent act you lost the case. That's all. ನೀವು 1 ಎಕರೆಗೆ 7 ಗುಂಟೆಗೆ ಕರೆಕ್ಟ್ ಆಗಿ ಬೌಂಡ್ರಿ ತೋರಿಸಿದ್ರೆ you would have got the decree of declaration also. That you have also lost.
Grateful Lordship.
23 SS Parikshit.
Suit for injunction in relation to property. Trial court decreed the suit, first appellate court dismissed by appeal. Defendants 1 to 3 are before your lordship. Now 2 questions will arise, my lord. Your lordships will kindly see. Title of the plaintiff was denied by us. Then substantial question of law, my lord, kindly come to paragraph 35, page 12. That's the first question that I have raised. It is covered by the decision of the Supreme Court, Anatullah Sudhakar's judgment. Then, my lord, so whereas 33 is concerned, substantial question of law, para 33. There is a discrepancy in the schedule shown in Exhibit P1 under which plaintiff claims title, plaintiff's husband claims title, and the schedule shown in the plaint. They are altogether different. That the plaintiff also admits.
Exhibit P1 ಏನು?
Exhibit P1 is a sale deed, my lord, executed in favor of.
They are relying upon the sale deed.
Yes, that's right. Yes.
Suit schedule property ತೋರಿಸಬೇಕಾದ್ರೆ boundary as per Exhibit P1 ಇದೆಯಾ ಇಲ್ಲ?
ಇಲ್ಲ. P1 ಪ್ರಕಾರ ಇಲ್ಲ. ಅದನ್ನೇ ನಾವು ಪಾಯಿಂಟ್ ಔಟ್ ಮಾಡಿದ್ವಿ. And title is disputed. There is a simple suit for injunction.
ಆಯ್ತು. Whether you are claiming title in
Yes, my
respect
lord,
of
we
the
are claiming
property of the plaintiff?
Same property we are claiming.
Same property.
ಹೌದು.
You are claiming.
Yes. And return statement ಅಲ್ಲಿ ಅದನ್ನ ಹೇಳೇ ಇವರ ಟೈಟಲ್ ಇಲ್ಲ, ಸ್ವಾಧೀನ ಇಲ್ಲ ಅಂತ ಕೂಡ ನಾವು ಡಿನೈ ಮಾಡ್ತೀವಿ
ಅವ್ರಿಗೆ.
ಹೌದು.
ನೀವು ಸೇಮ್ ಸರ್ವೆ ನಂಬರ್ ಟೈಟಲ್ ಕ್ಲೈಮ್
ಹೌದು.
ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ನಾವು RTCಗಳೆಲ್ಲ ಎಕ್ಸಿಬಿಟ್.
Then why you have not filed the suit for the declaration?
Lord, the defendant number 3.
ನಿಮ್ ಪ್ರಾಪರ್ಟಿ, one second, ನಿಮ್ ಪ್ರಾಪರ್ಟಿ ಯಾವುದು?
ಸರ್ವೆ ನಂಬರ್ 38.
Your father and married. You were signatory for the sale deed. His father only sold the property. He is the signatory for my sale deed. My property is converted.
That is in relation to a different survey number.
What has happened?
Number.
Different survey.
ಆಯ್ತು. ನಿಮ್ ಪ್ರಕಾರ ಸರ್ವೆ ನಂಬರ್
38 ನಮ್ದು ಬೇರೆ 38.
ನಿಮ್ಮದು ಬೇರೆ ರೀ. ನೀವು ಸೇಲ್ ಡೀಡ್ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡ್ಕೊಟ್ಟು ನಿಮ್ ಫಾದರ್.
That is in relation to a different property.
ಯಾವ್ದು ಹೇಳಿ?
47/2 ಅವರೇ ಹೇಳ್ತಾರೆ.
Kindly come to paragraph 20.
In respect of 47/2.
No, my lord, one rectification deed was also executed thereafter and the same property was sold back to my vendors. My husband purchased the property about 23 years back from the father of the defendant.
ಯಾವ ಸರ್ವೆ ನಂಬರ್ ಕೊಂಡ್ಕೊಂಡ್ರಿ ನೀವು?
ಸರ್ವೆ ನಂಬರ್ 47 ಅಂತ ಮಿಸ್ಟೇಕ್ ಆಗಿತ್ತು.
47/2
rectification deed ನ ಯಾರು ಬರ್ಕೊಟ್ರು?
Rectification same person who has purchased
not in his favor.
They resold the property to
not in his favor, man. Not in his favor.
ದಯವಿಟ್ಟು my vendors.
ನೀವಿಬ್ರು ಜಗಳಾಡ್ಬೇಡಿ. ನನ್ನ ಪ್ರಶ್ನೆಗೆ ಉತ್ತರ ಕೊಡಿ. ಆಯ್ತು. ಫಸ್ಟ್ ಸೇಲ್ ಡೀಡ್ ಮಾಡುವಾಗ ನಿಮ್ ಸರ್ವೆ ನಂಬರ್ 47 ಮೆನ್ಷನ್ ಮಾಡಿ.
ನಂದಲ್ಲ ಸರ್. The property originally belongs to one Lakanda and Marigowda. They sold the property to one Deviramma in the year 1971. In that, the survey number was shown as 47/2. Then the Deviramma resold the property back to her vendors.
ಹಿಂದಿನವ್ರಿಗೇನೆ
ಹಿಂದವ್ರಿಗೇನೆ ಯಾರಿಗೆ ಮಾರಾಟ ಮಾಡಿಲ್ಲ ಅವ್ರಿಗೇನೋ ವಾಪಸ್ ಕೊಟ್ಬಿಟ್ರು.
ಯಾರಿಂದ
rectification deed ಮಾಡಿ. There was a mistake in mentioning survey number. Therefore, they rectified the survey number as well as the extent. 34 ಇದ್ದಿದ್ದು 30 ಅಂತ reduce ಮಾಡಿ. And it has come in the evidence that the family of Lakkanna and Marigoda had no property in survey ಆಗಿದೆ special deputy commissioner. They sold the property to 10 persons, including me. Among the 10 persons, I am one. He is the signatory for all the sale deeds. His father has also sold. I have produced the sale deeds of other persons to demonstrate the boundaries and other things. And what has happened is, your lordship is very well aware, whenever conversion takes place, the extent ಅದು ಹಾಗೆ ಬಿಟ್ಬಿಡ್ತಾರೆ. ಭೂ ಪರಿವರ್ತನೆ ಆಗಿದೆ ಅಂತ ಕಾಲಮಲ್ಲೂ ಮೆನ್ಷನ್ ಮಾಡಲ್ಲ. Taking advantage of that revenue entry, all these deeds have been created fraudulently to attack my property because my husband, after death, I am staying in Bangalore. To knock off my property, I did not purchase any agriculture, purely a converted land. That is also mentioned.
Yes, ನೋಡೋಣ ಅವ್ರು ಹೇಳಿ ಏನ್ ಹೇಳ್ತಾರೆ ಅವ್ರದ್ದು.
He has admitted that he is signatory for my sale deed.
He has filed the suit for the relief.
Only injunction.
Survey number 38.
Only injunction. According to him, it is a converted land. But my lords will court does not deal with any of those things. Kindly look at exhibit D6 series, my lord. Kindly come to exhibit D6 to D30.
ಆಯ್ತು, ನೀವು ಮಾರುವಾಗ ಸರ್ವೆ ನಂಬರ್ ಯಾವ್ದು ತೋರಿಸಿದ್ರಿ ಅವ್ರಿಗೆ?
ಇವ್ರಿಗೆ ಮಾರಿಲ್ಲ, ಬೇರೆಯವ್ರಿಗೆ ದೇವಿರಮ್ಮನ್ ಅನ್ನೋರಿಗೆ 47/2 ಅಂತ ಮಾರಿದ್ವಿ. ಅದಾದ್ಮೇಲೆ ಅವರಿಂದ ನಾವು ವಾಪಸ್ ತಗೊಂಡ್ಬಿಟ್ವಿ.
ವಾಪಸ್ ತಗೊಂಡ್ರಿ?
ಆಮೇಲೆ
ಯಾವ್ದ್ರಿ?
47/2ನೇ.
ಒರಿಜಿನಲಿ ಪ್ರಾಪರ್ಟಿ ಬಿಲಾಂಗ್ಸ್ ಟು ದಿ ದೇವಿರಮ್ಮ.
ಕರೆಕ್ಟ್. ಇಲ್ಲ, ಒರಿಜಿನಲಿ ಪ್ರಾಪರ್ಟಿ
ಫಾದರ್
ಎಂತದ?
ಮರಿಯಾ.
ಅವ್ರು ಮರಿಯಾಗ್ ಮತ್ ಮರಿಯಾನೇನಾ?
ಹೌದು, ಮರಿಯನ್ ಮಗ ಮರಿಯಾನೆ. ಮತ್ತೆ ಇನ್ನೊಬ್ಬ ಚಿಕ್ಕ ಅಂತ.
ಚಿಕ್ಕಣ್ಣ.
ಈ ಚಿಕ್ಕ ಅಂತ.
ಆಯ್ತು.
ಇವರು D3 ಮಗ ಬಂದು D3 ಬಂದು ಮರಿಯನ್ ಮಗ.
D3 ಬ್ಯಾಡ್ರಿ ಫಸ್ಟ್ ಆಫ್ ಮರಿಯಾ. ಆಯ್ತು. ಮರಿಯಾ, ಅವನಿಗೆ ಮರಿಯಾ ಅಂತ ಒಬ್ಬ ಮಗ, ಚಿಕ್ಕ ಅಂತ ಒಬ್ಬ ಮಗ. ಹೌದಾ? 71 ಅಲ್ಲಿ ಮಾರಿದ್ರು. ಮರಿಯಾ 1971 ಅಲ್ಲಿ ನಿಮಗೆ ಮಾರಿದ್ರು?
ನಮಗಲ್ಲ, ನಾವು ನಾವು ಚಿಕ್ಕಣ್ಣ ಬಂದ್ ಮರಿಯನ್ ಮಗ ಬಂದು D3, ಚಿಕ್ಕಣ್ಣ ಮತ್ತೆ ಇವರು.
ನೀವ್ ಯಾರಿಂದ ಕೊಟ್ಕೊಂಡ್ರಿ ಹೇಳ್ರಿ?
ನಾವು ಫಸ್ಟ್ ಇವರು ಲಕ್ಕಣ್ಣ ಮತ್ತು ಇವರು ಮರಿಗೌಡ ಊರಿಗೆ ಮಾರಿದ್ರು ದೇವಿರಮ್ಮನ್ಗೆ 71 ಅಲ್ಲಿ 47/2.
ಒರಿಜಿನಲಿ ಪ್ರಾಪರ್ಟಿ ಬಿಲಾಂಗ್ಸ್ ಟು ದಿ ಲಕ್ಕಣ್ಣ.
ಎಸ್, ಅವ್ರ ತಂದೆಗೆ, ಅದೇ ಹೇಳಿದ್ನಲ್ಲ ಮರಿಯಾಗೆ.
ಮರಿಯನ್ ಮಗ ಇರೋದು ಇಬ್ರೆ, ನೀವು ಚಿಕ್ಕಣ್ಣ ಲಕ್ಕಣ್ಣ ಅಂತೀರಿ.
ಲಕ್ಕಣ್ಣ ಮಕ್ಕಳು ಬಂದು ಮರಿಗೌಡ.
ಹೇಳಿ. ಚಿಕ್ಕಣ್ಣನ ಮಕ್ಕಳು ಮತ್ತೆ ಲಕ್ಕಣ್ಣ
ಮತ್ತು ಮರಿಗೌಡ. ಈ ಮರಿಗೌಡ ಮತ್ತೆ ಲಕ್ಕಣ್ಣ ಬಂದು ಇವರಿಬ್ರು ಈ ಚಿಕ್ಕ ಬ್ರಾಂಚ್ ಬಂದು 1971 ಅಲ್ಲಿ ಮಾರ್ತಾರೆ 47/2.
1971 ಅಲ್ಲಿ ಯಾರಿಗೆ ಮಾರಾಟ ಮಾಡಿದ್ರು?
ದೇವಿರಮ್ಮನ್ಗೆ ಮಾರಿದ್ರಲ್ಲಿ ವಾಪಸ್ ಮತ್ತೆ ಅವ್ರು ರೀಸೇಲ್ ಮಾಡ್ಬಿಡ್ತಾರೆ ಇವರಿಗೇನೆ 47/2ನ.
47/2ನ?
ಹೌದು, ಅದು ರೆಕ್ಟಿಫಿಕೇಶನ್ 1980.
ಮತ್ತೆ ವಾಪಸ್ಸು ಲಕ್ಕಣ್ಣ ಮತ್ತೆ ಮರಿಗೌಡಂಗೆ ಬರುತ್ತಾ?
ಹೌದು, ಬರುತ್ತೆ. ಹೌದು.
ಅದೇ ಯಾವ ವರ್ಷದಲ್ಲಿ?
ರೆಕ್ಟಿಫಿಕೇಶನ್ ಡೀಡ್ 11/3/85 ರೆಕ್ಟಿಫಿಕೇಶನ್ ಡೀಡ್ ಆಗಿ ಅದನ್ನ 38 ಅಂತ ಸರ್ವೆ ನಂಬರ್ ಅಂತ ಮಾಡ್ತಾರೆ.
ಮಾರಾಟ ಮಾಡುವಾಗ್ಲಾ? ವಾಪಸ್ ಮಾರಾಟ
ರೆಕ್ಟಿಫಿಕೇಶನ್ ಡೀಡ್ ಆಗುತ್ತೆ. ಮಾರಾಟ ಮಾಡುವ 47/2.
ರೆಕ್ಟಿಫಿಕೇಶನ್ ಡೀಡ್ ಇನ್ ಬಿಟ್ವೀನ್ ಹೂಮ್ ಆಯ್ತ್ರಿ?
ಬಿಟ್ವೀನ್ ದಿಸ್ ದೇವಿರಮ್ಮ ಅಂಡ್ ಲಕ್ಕಣ್ಣ ಅಂಡ್ ಮರಿಗೌಡ. ಅದನ್ನೇ ಎಕ್ಸಿಬಿಟ್ D2 ಅಂತಿದೆ.
ಲಕ್ಕಣ್ಣ ಮರಿಗೌಡ sold the property in favor of ದೇವಿರಮ್ಮ.
Yes.
Mentioning survey number 47/2.
Please.
In the year 91.
Please, ma'am.
Rectification deed ಮತ್ತೆ ಯಾರು ಬರ್ಕೊಟ್ರು?
ಅವರೇ ಸೇಮ್ ಪರ್ಸನ್ ಸರ್.
in existence, only survey number 38 and the same is.
There was no necessity for rectification deed by way of caution ಮಾಡ್ಸಿದ್ದಾರೆ ಅಷ್ಟೇ, ಯಾರು ಅಡ್ವೊಕೇಟ್ ಹೇಳಿ ಮಾಡ್ಸಿದ್ದಾರೆ.
85 ನಲ್ಲಿ ಯಾರು ಅದು rectification deed ಮತ್ತೆ ಮಾಡ್ಕೊಟ್ಟಿದ್ದು?
ಇವರು ದೇವಿರಮ್ಮ, ಬಿಟ್ವೀನ್ ದೇವಿರಮ್ಮ ಅಂಡ್ ಹರ್ವೆಂಡ ಅಷ್ಟೇ. ಅವರಿಬ್ಬರಲ್ಲಿ ಬೇರೆ ಪಾರ್ಟಿ ಇಲ್ಲ. Nobody else is involved.
ದೇವಿರಮ್ಮ once again in favor of ಲಕ್ಕಣ್ಣ.
ಹೌದು. rectification deed.
ಅದು rectification deed survey number 38 ಆಯ್ತು. ಮೊದಲೇ 18 ಮಾಡಿ 38 ಅಂತ ಮಾಡಿದ್ಮೇಲೆ ಮತ್ತೊಂದು ಸರಿ ಬೇಕಾಗಿರ್ಲಿಲ್ಲ. ಆಯ್ತು, ಬೈ ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ ಅಂತ. ಅಲ್ಟಿಮೇಟ್ಲಿ ಪ್ರಾಪರ್ಟಿ ಇನ್ ದ ಇಯರ್ 1980 ವೆಸ್ಟ್ ವಿತ್ ಲಕ್ಕಣ್ಣ ಅಂಡ್ ಮರಿ ಗೌಡ. ಹೌದಾ? ಹೌದು. ಸೋಲ್ಡ್ ಅಂಡ್ repurchased. Then who?
Then they obtained conversion order jointly.
ಅವರೇ conversion.
ಅವರೇ jointly 30 guntasku jointly they obtained conversion order. I have produced the order passed by the deputy commissioner as well as the
ಲಕ್ಕಣ್ಣ ಮರಿಗೌಡನೇ ಕನ್ವರ್ಷನ್
ಮಾಡಿ.
ಅದು ಯಾವ ವರ್ಷದಲ್ಲಿ?
ಅದು 20 P exhibit P21 ಪ್ರಕಾರ 34/1983 ಮಾಡಿದ್ದಾರೆ. ಆಮೇಲೆ exhibit P2 ಪ್ರಕಾರ ರಸೀದಿ ಕಟ್ಟಿಸ್ಕೊಂಡಿದ್ದಾರೆ. ಯಾರು? ತಹಸೀಲ್ದಾರ್ ಅವರು ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದು.
83 ಅಲ್ಲಿ ಕನ್ವರ್ಷನ್ ಆಗಿದೆ.
83 ಅಲ್ಲಿ ಕನ್ವರ್ಷನ್ ಆದ್ಮೇಲೆ ನಮಗೆ ಅವ್ರು ಸೇಲ್ ಮಾಡಿದ್ರು. ಒಂದ್ ಸೈಟ್ ನಮಗೆ ಸೇಲ್ ಮಾಡಿ
ಕನ್ವರ್ಷನ್ ಮಾಡಿ ಸೈಟ್ಸ್ ಫಾರ್ಮೇಶನ್ ಮಾಡಿ
10 ಜನಕ್ಕೆ ಮಾರಿದ್ದಾರೆ. 10 ಜನದಲ್ಲಿ ನಾವು
ಒಬ್ರು.
ನಮ್ಮ ಸೇಲ್ ಡೀಡ್ಗೆ
ನೀವು ಪರ್ಚೇಸ್ ಮಾಡಿದ್ದು ಯಾವಾಗ?
ನಾವು ಪರ್ಚೇಸ್ ಮಾಡಿದ್ದು ವಿ ಪರ್ಚೇಸ್ ಇಟ್ ಇನ್ ಆಫ್ಟರ್ ಕನ್ವರ್ಷನ್, ದಟ್ ಈಸ್ ಇನ್ 1 minute. (28 1983) after conversion.
28/1983.
That is plaintiff's husband Panchakshara our purchase. And the appellant number 3.
What is the extent you have purchased?
I have purchased the extent at 220 into 70.
220
into 70. It is roughly about 15,400 square feet. And the property comes within the town limits of Chandrayapatna. ಹೌದು, ಚಂದ್ರಾಯಪಟ್ಟಣ. It assessed to now tax weeks na mutations ಎಲ್ಲ ಆಗಿದೆ.
Based on this you have claimed the relief of permanent injunction. Then what is your defense in the return statement?
Defense is this, my lord. The property what was sold in favor of Deviramma was altogether different than what is sold here. But anyhow, my lord, this is a suit for injunction. I would title will have to be gone into incidentally. Your lordship need not go deep
into incidentally. ನಿಮ್ದು ಹೇಳಿ ಪ್ರಾಪರ್ಟಿ ನಿಮ್ಗೆ ಹೆಂಗ್ ಬಂತು ಅಂತ.
ನಮ್ಗೆ ಯಾಕೆ ಬಂತು ಅಂದ್ರೆ ಇದೆ ಚಿಕ್ಕ ಮರಿಯನ್ ಬಂದಿತ್ತಲ್ಲ, ಮರಿಯಂದಿತ್ತಲ್ಲ, ಮರಿಯ ನಮ್ಮ ತಾತನ್ಗಿತ್ತಲ್ಲ, ಅದರಿಂದ ಬಂದಿದೆ. ಮರಿಯ ಮತ್ತೆ ಚಿಕ್ಕ ಇಬ್ರು ಮಕ್ಕಳಿಗೆ ಬಂದಿರೋದು. ಈ ಮೂವರೆಗೂ ಇದು ಬಂದಿದೆ. ಮತ್ತೆ ಒಂದು ಪೀಸ್ ಆಫ್ ಲ್ಯಾಂಡ್, one piece of land was sold in favor of
ನೀವು ಸರ್ವೆ ನಂಬರ್ 38 ಗೆ ಕ್ಲೇಮ್ ಮಾಡ್ತಾ ಇದ್ದೀರಿ.
38 ನಾವು ಕ್ಲೇಮ್ ಮಾಡ್ತೀವಿ.
ಹೌದಲ್ಲ? ಹೌದು. Once the ಲಕ್ಕಣ್ಣ and ಮಾರ್ಗೋಳ್ ಎಂತದು repurchased the property.
Yes, ma'am.
And got converted the property.
That is also denied.
Survey number 38.
Conversion is not done. Your lordship will kindly see.
Conversion is not done.
Done according to us. Kindly look at exhibit D5 to D30, ma'am. All the revenue records are still RTC ನಲ್ಲೇ ಬರ್ತಿದೆ. ರೆವೆನ್ಯೂ ಇದು ಕನ್ವರ್ಷನ್ ಎಲ್ಲೂ ತೋರಿಸ್ತಿಲ್ಲ, ಎಲ್ಲೂ ಇಲ್ಲ ರೆವೆನ್ಯೂ ರೆಕಾರ್ಡ್.
ಸೈಟ್ಸ್ ಫಾರ್ಮೇಶನ್ ಮಾಡಿದವರು ಯಾರು?
ಸೈಟ್ ಯಾರು ಮಾಡಿಲ್ಲ, ಅವ್ರವ್ರೇ ಹೇಳ್ತಾ ಇದಾರೆ ಅಷ್ಟೇ. ಯಾರು ತಗೊಂಡ್ರು
ಅವ್ರವ್ರೇ ಹೇಳ್ತಾ ಇದಾರೆ ಅಂದ್ರೆ ನೀವು ಸೇಲ್ ಡೀಡ್ ಆಗಿ ಬರ್ಕೊಟ್ರಿ. ಮತ್ತೆ
ಯಾರಿಗೆ?
ನಿಮ್ ಫಾದರ್.
ನಮ್ ಫಾದರ್ ಬೇರೆ ಸರ್ವೆ ನಂಬರ್
ಬೇರೆ ಸರ್ವೆ ನಂಬರ್ ಯಾವುದು?
ಅಲ್ಲ ಇದು
ಯಾವುದು ಬೇರೆ ಸರ್ವೆ ನಂಬರ್ ಹೇಳಿ?
47/2.
47/2 ನಿಮ್ಮ ಹತ್ರ ಲ್ಯಾಂಡ್ ಇಲ್ವಂತಲ್ಲ?
ಅಲ್ಲ,
ನೀವು ರೀಪರ್ಚೇಸ್ ಮಾಡಿದಾಗ ಸರ್ವೆ ನಂಬರ್ 38 ಆಗಿ ಪರ್ಚೇಸ್ ಮಾಡಿದ್ರಿ. First earlier you sold the property by mentioning survey number 47/2.
Correct.
Houda?
Correct.
Then again you have purchased the property from the very same seller.
Correct. I understand.
Repurchased it.
I understand.
Survey number 38 repurchase ಮಾಡಿದ್ರಿ.
Correct.
ಹೌದಾ?
Correct.
ಮತ್ತೆ ಯಾಕೆ ಮಾಡಿದ್ರಿ?
Different extent, my lord. What is sold is different extent. What is purchased is different extent.
ಬಿಟ್ಬಿಡಿ.
Yes.
Why you have purchased the property from them in respect of survey number 38?
Yes, that's a fact. That's a fact which you are
now you cannot play.
No, 1 minute.
Saying that no, property which was sold by us.
1 minute, I'm not on that point. What I am saying is this, my lord. Plaintiff under exhibit P1 claims certain property. In this suit he claims altogether different property.
Altogether
ಹೌದು ನೋಡಿ, ತಾವೇ ನೋಡಿ. ಎಕ್ಸಿಬಿಟ್ P1 ನಲ್ಲಿರೋ ಸೇಲ್ ಡೀಡ್ ಬೇರೆ, ಅದರಲ್ಲಿ ಪ್ಲೇಂಟ್ ಶೆಡ್ಯೂಲೇ ಬೇರೆ ಕೇಳ್ತಾರೆ. ಇಂಜಂಕ್ಷನ್
ಪ್ಲೇನ್ ಶೆಡ್ಯೂಲ್
ಹೌದು,
ಏನ್ ತೋರಿಸ್ತಾರೆ?
ಬೇರೆ ತೋರಿಸ್ತಾರೆ ನೋಡಿ. ಒಂದ್ ನಿಮಿಷ
ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ ಏನಿದೆ ಹೇಳಿ.
ಒಂದ್ ನಿಮಿಷ. Your Lordship will kindly come to the schedule.
ನೀವೇ ಸರ್ವೆ ನಂಬರ್ ಚೇಂಜ್ ಮಾಡ್ಕೊಬಿಟ್ಟು ಆಲ್ಟರ್ ಹೋಗಿದಾರೆ ಡಿಫರೆಂಟ್ ಅಂತ ಹೆಂಗ್ರಿ? ನೀವೇ ಸೇಲ್ ಮಾಡುವಾಗ 47/2 ತೋರಿಸಿದ್ರಿ, ಆಮೇಲೆ ರೀಪರ್ಚೇಸ್ ಮಾಡುವಾಗ 38ನೇ ಪರ್ಚೇಸ್ ಮಾಡಿದ್ರಿ.
My lord, kindly take exhibit P1.
ಯಾವ್ದು ಕನ್ವರ್ಷನ್ ಆರ್ಡರ್ ಯಾವ್ದು ಎಕ್ಸಿಬಿಟ್?
Exhibit P2 and P21 and P2.
P2 ನಾ?
P2 ಇದೆ. That is
ಲ್ಯಾಂಡ್ ಕನ್ವರ್ಷನ್ ಸರ್ಟಿಫಿಕೇಟ್ dated 14/6/1983.
Exhibit P21 only. That is from the office of the special deputy commissioner.
ಅದ್ ನೋಟಿಸ್ ಕೊಟ್ಟಿರೋದು.
ಹೌದು.
So Exhibit P2 is the notice asking my vendors to pay the deposit amount.
Dated 10/2/1971.
Exhibit P21 is the letter from.
Kindly take exhibit P1, my lord. Exhibit P1. ಈತಿಗೆ ಪ್ರಾಪರ್ಟಿ ರಿಟೈನ್ ಬೈ ಲಕ್ಕಣ್ಣ ಮರಿಗೌಡ ನಮ್ದು ಬಂತು. P1 ನಲ್ಲಿ.
P1 is the sale deed of plaintiff. ಹೌದಾ?
ಅದ್ರಲ್ಲಿ ನೋಡಿ, ಈತಿಗೆ ಪೂರ್ವಕ್ಕೆ ಲಕ್ಕಣ್ಣ ಮತ್ತು ಮರಿಗೌಡ ಅವ್ರ ಜಮೀನು ನಾವೇ.
ನೀವೇ ಅಂದ್ರೆ ನೀವು ಕೊಟ್ಟಿರೋದು ಓನ್ಲಿ ಪೀಸ್ ಆಫ್ ಸೈಟ್ ಮೆಜರಿಂಗ್ 220/70.
P1 ನಲ್ಲಿ ಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಬೇರೆ ಬರುತ್ತೆ.
220/70
ಪ್ಲೇಂಟ್ ನೋಡಿ ಒಮ್ಮೆ.
ಅದರಿಂದ ನಿಮ್ ಪ್ರಾಪರ್ಟಿನೇ ಇರುತ್ತೆ, ಬೇರೆ
ಇಲ್ಲ. ಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಬೇರೆ ತೋರಿಸ್ತಾರೆ.
ಆಯ್ತು, ಅವ್ರ ಸ್ವಲ್ಪ ಎಕ್ಸಿಬಿಟ್ P1 ಅಲ್ಲಿ ಏನಿದೆ?
ಪೂರ್ವಕ್ಕೆ
ರಸ್ತೆ
ಇಲ್ಲ ಇದರಲ್ಲಿ ರಸ್ತೆ, ಪೂರ್ವಕ್ಕೆ ರಸ್ತೆ ತೋರಿಸ್ತಾರೆ. ಚೆಕ್ ಬಂದಿ ಪೂರ್ವಕ್ಕೆ ರಸ್ತೆ ಮತ್ತು ರಾಮಸ್ವಾಮಿ ಅವರ ಮನೆ ಅಂತ ಯಾವ್ದೋ ಬೇರೆ ತೋರಿಸ್ತಾರೆ
ಪ್ಲೇಂಟ್ ಅಲ್ಲಿ.
ಹೌದು.
ಆಯ್ತು.
ಪಶ್ಚಿಮಕ್ಕೆ ನೋಡಿ,
ರಸ್ತೆ ಆದ್ಮೇಲೆ ರಾಮಸ್ವಾಮಿ ಅವರ
ಪಶ್ಚಿಮಕ್ಕೆ ನೋಡಿ P1 ನಲ್ಲಿ ವೆಸ್ಟ್ಗೆ ಅಯ್ಯರ್ ಮನೆ ಅಂತಿದೆ, ಅಯ್ಯರ್ ಕೊಟ್ಟಿರೋ ಸೈಟು ಅಂತಿದೆ. ಇಲ್ಲಿ ವೆಂಕಟರಾಜು ಮತ್ತು ಇತರರ ಮನೆ ಅಂತ ತೋರಿಸ್ತಾರೆ. ಆಮೇಲೆ ಉತ್ತರಕ್ಕೆ ಲ್ಯಾಂಡ್ ಆಫ್ ಕಾಳಪ್ಪ ಶೆಟ್ಟಿ ಅಂಡ್ ಚನ್ನಶೆಟ್ಟಿ. ಇಲ್ಲಿ ಉತ್ತರಕ್ಕೆ ಸಣ್ಣಗೌಡ ಮತ್ತು ಕಾಳಪ್ಪ ಕಲ್ಪನಾರವರ ನಿವೇಶನ. ಎಲ್ಲ ಚೇಂಜ್ ಆಗ್ಬಿಡುತ್ತೆ. ಮತ್ತೆ ದಕ್ಷಿಣಕ್ಕೆ ಪ್ರಸಾದ್ ಮತ್ತು
ಕೃಷ್ಣಮೂರ್ತಿ
ಕರಿಗೌಡ. ಇಲ್ಲಿ ತೋರಿಸ್ತಾ ಕೃಷ್ಣಮೂರ್ತಿ ಮತ್ತು ಪ್ರಸಾದ್ ರವರ ಮನೆಗಳು. ಎಲ್ಲ ಆಲ್ ಟುಗೆದರ್ ಡಿಫರೆಂಟ್ ಶೆಡ್ಯೂಲ್. Suit is based on the exhibit P1, but there are different boundaries here. There are different boundaries.
Boundaries are ಬೇರೆ ತೋರಿಸಿದಿರಿ ನೀವು. ಬೇರೆ ಜಡ್ಜ್ಮೆಂಟ್ಸ್, ಬೇರೆ ಸೇಲ್ ಡೀಡ್ಸ್ ಎಲ್ಲ.
ಐಡೆಂಟಿಟಿ ಡಿಸ್ಪ್ಯೂಟ್ ಇದೆ, ಟೈಟಲ್ ಡಿಸ್ಪ್ಯೂಟ್ ಇದೆ. ಅದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಪ್ರಕಾರ.
ಟೈಟಲ್ ಏನ್ ಡಿಸ್ಪ್ಯೂಟ್ ಇಲ್ಲ, ನೀವೇ ಸೇಲ್ ಮಾಡಿರೋದು.
ಡಿನೈ ಮಾಡಿದ್ದೀವಿ ಸ್ವಾಮಿ, ಡಿನೈ ಮಾಡಿ ಅದನ್ನ ಹೇಳಿದ್ದೀವಿ.
ನೀವು ಏನ್ ಡಿನೈ ಮಾಡಿದೀರಿ? ನೀವು ಸೇಲ್ ಡೀಡ್ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಿರೋದು ಡಿನೈ ಮಾಡಿದೀರಾ? ನೀವು ಸೇಲ್ ಡೀಡ್ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಿರೋದು ಡಿನೈ ಮಾಡಿದೀರಾ? ಏನಂತ?
ಬೇರೆ ಯಾವ್ದೋ ಆಸ್ತಿ ಇದಕ್ಕೆ ಸಂಬಂಧ 38ಗೆ ಸಂಬಂಧಪಟ್ಟಿದ್ದಲ್ಲ ಅಂತ ಹೇಳಿ.
ನೀವು ಸೇಲ್ ಮಾಡಿದಿರಾ ಇಲ್ಲ ಅಂತ ಒಪ್ಕೊಂಡಿದ್ದೀರಾ? ಇಲ್ಲ,
ನಮ್ಮ ತಂದೆಯವರು ಸೇಲ್ ಮಾಡಿದ್ 47/2 ಅಂತ ಹೇಳಿದ್ದೀವಿ ಅಷ್ಟೇ. 38 ಸೇಲ್ ಮಾಡಿಲ್ಲ ಅಂತಾನೆ ಹೇಳಿದ್ವಿ.
ಆಯ್ತು. 47/2ಗೆ ಲ್ಯಾಂಡ್ ಇದೆ ಅಂತ ತೋರ್ಸಕ್ಕೆ ಏನಾದ್ರು ದಾಖಲೆ ಹಾಕಿದ್ರೆ?
ಅದಕ್ಕೆ ಕೊಟ್ಟಿಲ್ಲ.
ಮತ್ತೆ there must be an existence of property survey number 47.
In a suit for injunction, my lord, why should the court go into all those questions?
16 of the judgment. Para 16.
Further in the cross examination, dated 31/5/2011, he stated that the Ramshan had 1 acre 31 foot and then property survey number 38. The same reveals that father of Lakshmana and Marigura had property in survey number 38, and after his death, Lakshmana and Marigura owned the property. But the he is the signature of the petition.
That is D3, DW1, or different number 3. But
DW1.
ಇವರೇ 3 ಜನ ಇದ್ದಾರೆ. 3 ಜನ ಪೈಕಿ ಒಬ್ರು ಮಾಡಿ, ಒಂದು ಬ್ರಾಂಚ್ ಅವ್ರು ಮಾಡಿದ್ದಾರೆ ಅಷ್ಟೇ. ಇನ್ನೊಂದು
DW1 ಯಾರು? ನಿಮ್ ಫ್ಯಾಮಿಲಿ
ಡಿಪೆಂಡ್ ನಂಬರ್ 3 ಮಾಡಿರೋದು.
ಅವನೇ ಸಿಗ್ನೇಚರ್
ಮಗ
ಎಕ್ಸಿಬಿಟ್ P1.
ಮರಿಯನ್ ಮಗ ಮಾಡಿರೋ.
ಅದೇ ಅವ್ನ ಸಿಗ್ನೇಚರ್
ಬೇರೆ ಇಬ್ರು ಮಾಡಿಲ್ವಲ್ಲ ಅವ್ರು.
ನೀವ್ಯಾರಿಗೆ ಮತ್ ಮರಿಯನ್ ಮಗನ್ಗಲ್ವಾ?
ಇಲ್ಲ ಚಿಕ್ಕಣ್ಣನ ಮಕ್ಳು ಇಬ್ರು ಇದಾರಲ್ಲ.
ಹಾ.
ಲಕ್ಕಣ್ಣ ಮತ್ತೆ ಮರಿಗೌಡನ್.
ನೀವು ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡೋದು ಯಾರಿಗೆ?
ಮೂರ್ ಜನಕ್ಕೂ ರೆಪ್ರೆಸೆಂಟ್.
ಯಾರ್ಯಾರಿಗೆ?
ಇವರು ಚಿಕ್ಕಣ್ಣ ಮತ್ತೆ
DW1 ನೀವು ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡ್ತಿರಿಲ್ಲ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ?
ಮಾಡ್ತಾ ಇತ್ತು.
ಮತ್ತೆ your own witness admitted the signature in exhibit P1.
One of them.
He believing that deed was in respect of survey number 47.
Therefore,
boundaries ಏನಿದೆ ಹೇಳಿ.
DW1 during the transaction page stated relevancy of state is P6 to P9.
Boundaries ಬಗ್ಗೆ ಎಲ್ಲೂ ಡಿಸ್ಕಸ್ ಮಾಡೋದೇ ಇಲ್ಲ.
Eastern western boundaries is shown as property of Punjab and husband. The same discloses the existence and location of the shoe property. That is the state deeds of my neighbors. That is the purchasers is the same property. They have shown my property towards the eastern and western boundaries, which discloses the existence and location of my property. I have also produced the photograph to show that the suit schedule property is only a vacant land and no crop is grown in the center. Again, in paragraph 22, your lordship may kindly see. DW3 during this last examination stated that Lakshman and Marigura had no property in survey number 47. They had property in survey number 30. Again, in paragraph.
DW3 ಯಾರು?
DW3, they
son of ಚಿಕ್ಕಣ್ಣನ?
Son of ಚಿಕ್ಕಣ್ಣ. ಅವರು ಯಾರೋ ಸರ್ವೇಯರ್ ಮಾಡಿಸ್ತಿದ್ದಾರೆ, private service without taking any court order or any request from anybody. They got appointed a private surveyor, and he comes before the court to give evidence. And he says that I have not obtained any document from Tahsildar's office to support the case of the defendant.
To show that it is not converted, only to the extent that the land was not converted.
Exhibit P1 was executed by whom?
By Lakana and
Marigoda.
Those who got the land converted, and those who got the land back from the original.
Original owners only.
You ಚಿಕ್ಕಪ್ಪನ.
ಚಿಕ್ಕಪ್ಪ ಅಂದ್ರೆ ಮರಿಗೌಡನಾ?
ಹೌದು. ಮರಿಗೌಡ ಚಿಕ್ಕಪ್ಪ.
ನಿಮ್ಮನೆ ಒಪ್ಕೋತಾನೆ ನೋಡಿ. DW1 during his cross examination at page 16 stated that Lakkanna and Marigoda sold property in survey number 38 to 10 persons and he has no objection for the sale deed and he has also signed the sale deeds. The same reveals that Lakkanna and Marigoda had title to the property survey number 38 and sold the same to the various persons including the plaintiff.
Correct.
So this matter is listed
Your
for
Lordship
admission.
I only request this, my lord. The Lordship may not touch upon the title because leave it open for.
I am also not touching upon the title.
Yes.
Only the
Your Lordships are only considering.
For any their injunction, that's all.
Yes. Your Lordship may also refer to these two judgments. Consider my argument. That a mere suit for injunction, mere suit for. That is followed subsequently by the Supreme Court, which I will point out.
Once you have sold the property,
1 minute.
you cannot claim again title in respect of the very same property.
Let me point
by
out.
relying upon the judgment of Anantala Sudhakar. Para 14 read ಮಾಡ್ಬಿಡಿ. Anantala Sudhakar ಕೇಸಲ್ಲಿ para 14 read ಮಾಡ್ಬಿಡಿ.
ಇದೊಂದು ಅಣ್ಣಮ್ಮ ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಡ್ತಾರೆ.
ನನಗೆ ಕೊಡಕ್ಕಿಂತ ಮುಂಚೆ ನೀವು ಓದಿ.
ನಾವು ಓದಿದ್ದೀನಿ, ಬೇಕಾದ ಸತಿ ಓದಿದ್ದೀನಿ.
ನಾನು ಓದಿದ್ದೀನಿ.
ಅದ್ರಲ್ಲಿ ಗೈಡ್ ಲೈನ್ ಒಂದ್ ನಿಮಿಷ. ಅಣ್ಣಮ್ಮ ವರ್ಸಸ್ ಪೊಟ್ಟಮ್ಮ ಅಂತ ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್. ಒಂದ್ ನಿಮಿಷ ಓದ್ದೆ, ಯಾರು ಬರಲ್ಲ, ಯಾರು ಕೋರ್ಟ್ಗೆ ಬರಲ್ಲ. ಯಾವ ಲಾಯರ್ ಕೋರ್ಟ್ ಓದ್ದೆ ಬರೋದೇ ಇಲ್ಲ.
ಹೌದೌದು.
ಅಣ್ಣಮ್ಮ ವರ್ಸಸ್ ಪಟ್ಟಮ್ಮ ಒಂದ್ ನಿಮಿಷ. ಅದರಲ್ಲಿ ಪ್ಯಾರಾಗ್ರಾಫ್ 17 and 20 ನೋಡ್ಬಿಡಿ. ಇದೊಂದು ಸ್ವಲ್ಪ ತಾವು ತಮ್ಮ ಗಮನಕ್ಕೆ ತರ್ತೇನೆ. ಯು ಮೇ ಡೀಲ್ ವಿತ್ ಇಟ್. ಪ್ಯಾರಾ 17 and 20 ಶೆಡ್ಯೂಲ್ಗಳು ಯಾವುದು ಮ್ಯಾಚ್ ಆಗ್ತಾ ಇಲ್ಲ. ಎಕ್ಸಿಬಿಟ್ P1 ಇದಕ್ಕೆ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಮೇ ಕನ್ಸಿಡರ್ ದಟ್. 1707 ಅಲ್ಲಿ ಇದೆ ನೋಡಿ. ಆಮೇಲೆ 20 ನಲ್ಲೂ ಅದನ್ನೇ ಹೇಳ್ತಾರೆ, ರೀಟ್ರೇಟ್ ಮಾಡ್ತಾರೆ. Other contention, your lordship will kindly.
The law is well settled that there cannot be an injunction in respect of an unascertained or undisputed property. ಹೌದಾ?
ಹೌದೌದು.
ಆಯ್ತು.
ಅನ್ಅಸರ್ಟೈನ್ಡ್. ಆಮೇಲೆ ಜಸ್ಟಿಸ್ ಓಕ್ ಅವರು ಈಗ ರೀಸೆಂಟ್ ಆಗಿ ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಅದನ್ನ ರೀಟ್ರೇಟ್ ಮಾಡ್ತಾರೆ. ಅದನ್ನೇ ರೀಟ್ರೇಟ್ ಮಾಡ್ತಾರೆ. ಅದು ಅದೆಲ್ಲೇ ಇದು ಆ ಜಡ್ಜ್ಮೆಂಟ್ ಓಕ್ ಅವ್ರದ್ದು ಕೃಷ್ಣಾರೆಡ್ಡಿದು ಅದನ್ನ ಕೊಟ್ಬಿಡ್ಬೇಕಾಯ್ತು. ಇಲ್ಲ ತಾವು ಡೀಲ್ ಮಾಡಿ ಪರವಾಗಿಲ್ಲ. ಡೀಲ್ ಅಷ್ಟೇ.
This matter is listed for admission. I heard the counsel appearing for the appellant and also the counsel appearing for the respondent. This second appeal is filed against the concurrent finding of the trial court for granting the relief of permanent injunction in OS number 115 of 2007 with judgment dated 9th day of November 2017. And also the concurrent finding of the appellate court in RA number 54 of 2017 dated 15th day of September 2021, confirming the judgment of trial court. The factual matrix of case of plaintiff while seeking the relief of permanent injunction in respect of the suit scheduled property. It is contended that suit property was earlier survey number 38 of Guranahalli village. One Chikkegoda was the original owner of the said property, and his sons Lakkanna and Marigoda got converted the said
Kindly
property.
pardon me. Just go to 24. My colleague will be.
Measuring 30 guntas as per the orders dated 13/6/1983. And accordingly, Katai number 92 was made in Gurnalli Grama Panchayat. Out of 30 guntas, Lakkanna and Marigoda sold the suit property under the registered sale deed dated 2/8/1983 in favor of the plaintiff's husband, D.M. Panchaksharaya. Since then, plaintiff's husband had been in possession of the suit property. The suit property was brought within the limits of Chandrapatna municipality and self-assessment number was also given to the suit property. After the death of the plaintiff's husband, the plaintiff continued in the possession of the suit property. The municipal record stands in the name of the plaintiff. The defendants have no right or possession over the suit scheduled property. But defendant number 1 and 2, on the strength of some documents alleged to be executed by defendant number 3, are trying to interfere with plaintiff's possession and hence filed the suit for the relief of permanent injunction. In pursuance of the suit summons, defendants appeared through counsel and defendant number 3 had filed written statement. Defendant number 1 and 2 have filed memo adopting the written statement filed by the defendant number 3. Defendant number 3 contended that there is no cause of action to file a suit and suit is not maintainable. The plaintiff has not properly valued the suit. The plaintiff has not approached the court with clean hand and he has suppressed the material facts. One Maria of Gurnalli village had 2 sons, namely Maria and Chikka. The defendant number 3 is son of the said Maria. The said Chikka had 2 sons, Lakkanna and Marigoda. The said Lakkanna and Marigoda sold property measuring 34 guntas in survey number 42 on 10/2/1971. 71. 47/2. 47 47/2 on 10/2/1971 to one Devi Ramma. That said Devi Ramma resold the said property mentioning the survey number 38. The said Devi Ramma had not acquired any title as per the sale deed dated 10/2/1974. Therefore, Lakkanna and Marigoda had no title to sell the property on 2/8/1983 to sell the property in favor of the plaintiff's husband. The said Devi Ramma and Lakkanna And Marigoda got entered into rectification deed dated 11/3/1985, rectifying the sale deed dated 10/2/1971, and thereby rectified the survey number 38 as instead of survey number 47/2, and extent of 30 guntas instead of 34 guntas. On the said date, possession was handed over. Thereafter, Lakkanna and his family members sold the land measuring 17 guntas in favor of Marigoda under the registered sale deed dated 28/10/2005. The defendant number 3 gifted 6.5. ಏನ್ರಿ ಡಿಫೆಂಡ್ ನಂಬರ್ 3 ಹೇಗೆ ಬಂತು? ಇದೇನ ಸೇಲ್ ಡೀಡ್ ರೆಫರ್ ಮಾಡ್ತಾರಲ್ಲ?
ಅಗ್ರಿಕಲ್ಚರ್ ಅಂತ ರಿಲೀಸ್ ಮಾಡಿರಲ್ಲ ರೆವಿನ್ಯೂ ಡಿಪಾರ್ಟ್ಮೆಂಟ್. ಟೇಕಿಂಗ್ ಅಡ್ವಾಂಟೇಜ್ ಆಫ್ ದಟ್ ರೆವಿನ್ಯೂ ರೆಕಾರ್ಡ್ಸ್. ದಿಸ್ 3 ಫಸ್ಟ್ ಕೇಸ್.
ಅದು ಯಾರು ಮಾಡೋದು ಮತ್ತೆ?
ಅದು ಸೇಮ್ ಚಿಕಪ್ನ ಮಾಡ್ತಾರೆ.
ಯಾರು? ಲಕ್ಕಣ್ಣನ. ಲಕ್ಕಣ್ಣ ಇನ್ ಫೇವರ್ ಆಫ್ ಮರಿಗೌಡನ. ಅಲ್ಲ ಸರಿ, ನಿಮಗ್ ಸೇಲ್ ಮಾಡಿದ್ ಯಾರು? ಇಬ್ರು ಸೇರೇ ಮಾರಾಟ ಮಾಡಿದ್ದಾರೆ. ಹಾಗೆ ಆಯ್ತು. Thereafter, Lakkanna and his family members sold land measuring 17 guntas in favor of Marigoda under the registered sale deed dated 28/10/2005. The defendant number 3 gifted 6.5 guntas out of 17 guntas in favor of defendant number 3 on 8/11/2006 and sold 1.5 guntas under the registered sale deed dated 8/11/2006. Accordingly, defendant number 2 and 3 are having title and possession over the suit shell properties. The remaining property measuring 9 guntas is in possession of defendant number 3. The plaintiff is not in possession of the suit property. The above said 17 guntas is in possession of defendant. The trial court, having considered the pleadings of the parties, framed the issues whether the plaintiff proves that plaintiff is in possession and enjoyment of the suit shell property, and whether the interference by the defendants, whether entitled for relief of permanent injunction. The plaintiff got marked the document exhibit P1 to 28 by examining herself as PW1, and defendant, in order to substantiate their defense, got examined defendant number 3 as DW1 and also examined 2 witnesses as DW2 and 3 and got marked exhibit D1 to 30. The trial court, having considered the material available on record, particularly admission on the part of DW1, who is the defendant number 3, in paragraph number 16, taken note of survey number 47 mentioned, and he was also a signatory to the document of exhibit P1, but only stated that he was under the impression in respect of survey number 47. But the fact is that father of Lakkanna and Marigoda had property in survey number 38 and not having any property in survey number 47. And earlier it was erroneously mentioned, and subsequently a rectification deed was also came into existence in respect of property number 38. And also trial court taken note of in paragraph number 21 that DW1 during his class examination admitted that Lakkanna and Marigoda sold property in survey number 38 to 10 persons, and he has no objection for the sale, and he has also signed the said sale deeds. The plaintiff also claims that in the said sale deed of 10 in number, he is one of the purchaser, and plaintiff document of exhibit P1, the DW1, that is defendant number 3, is also a signatory, and defendant also admitted the same, and even DW3 witness who has been examined on behalf of the defendant, categorically admits that Lakkanna and Marigoda had no property in survey number 47, and they had only the survey number 38. And in paragraph number 22, in detail discussed the same. And with regard to the discrepancy mentioning in the sale deed as well as in the plaint description, in paragraph number 24, taken note of the sale deed exhibit P6 to P9 executed by the very same Lakkanna and Marigoda in favor of other purchasers, and comes to the conclusion that plaintiff has proved the description of the suitable property and granted the relief of permanent injunction. The first appellate court also, on assessing the both oral and documentary evidence, particularly taken note of the oral and documentary evidence available on record and also extracted the admission on the part of DW1 in paragraph number 38. And so also in paragraph number 39 and also in paragraph number 41. In paragraph number 44, comes to the conclusion that the property belongs to the family, only survey number 38 and not survey number 47, and also taken note of evidence of DW2 and DW3 with regard to the evidence wherein also categorically admitted that property survey number 47 was not in existence and survey number 38 is in existence, and the same belongs to the family of the Lakkanna and Marigoda, and confirm the judgment of the trial court. The main contention of the counsel appearing for the appellant in this case, in this second appeal, that both the courts have committed an error in granting the relief of permanent injunction when the title is disputed. And also counsel would vehemently contend that very identity of the property is also disputed. And counsel contend that survey number 38 even now is not converted land, and same stands as an agricultural land in view of document exhibit D 16 to 30. And both the courts have committed an error in granting the relief of permanent injunction when the property was sold and not in survey number 38, and survey property was sold as property number 47. And defendant also claims the title in respect of the suitable property, and counsel would contend that in view of the judgment of Anantula Sudhakar ought to have sought for the comprehensive relief of declaration when there is a cloud on the property. The counsel also relies upon the judgment reported in the ILR 1991, Karnataka 1696, Annamma versus Puttamma, and brought to the notice of this court. The discussion made in paragraph number 17, wherein observation is made that law is well settled that there cannot be an injunction in respect of an unascertained or undisputed property, and contend that both the courts committed an error. Per contra, the counsel appearing for the respondent would submit that the property belongs to the Chikkanna is not in dispute, and that said Chikka having two sons, Lakkanna and Marigoda, and both of them have sold the property in the year 1971 in favor of one Srimati Devi Ramma, and while selling the property wrongly mentioned the property number as 47/2, but the very same property was sold or repurchased by the Lakkanna and Marigoda in the year 1983, and while reselling the property, having noticed that there was a mistake in mentioning the property survey number 47/2, mentioned the survey number as 38. And also rectification deed was executed in the year 1985. And the same was intercept between the Lakkanna and Marigoda and also the Devi Ramma. Hence, it is clear that Lakkanna and Marigoda repurchased the property in respect of survey number 38. It is the contention of the plaintiff counsel that Lakkanna and Marigoda got converted the property in the year 1983, and having converted the property, sold the property in favor of 10 persons, and out of 10 persons, the plaintiff husband is one of the purchaser, and he had purchased the same on 2/8/1983 to the extent of 220 into 70. And thereafter, when the plaintiff husband passed away, and property exclusively belongs to the property of the plaintiff, and all the revenue records are also standing in the name of the plaintiff, and the same was taken note of, and trial court also discussed in detail regarding misdescription of the property, since the property 47/2 was not in the family of the Lakkanna and Marigoda at no point of time, and the same is also admitted by DW3, who has been examined on behalf of the defendant, and defendant number 3, who claims the property belongs to him, also categorically admit that he is a signatory to the said 10 sale deeds which were executed by Lakkanna and Marigoda, and also admitted in respect of exhibit P1 also he was a signatory, and hence the very contention of the plaintiff defendant that property is different cannot be accepted, and no question of different property when the family was having only property bearing survey number 38 and not 47/2, and the same is emerged during the course of evidence. Having heard the appellant counsel and also the counsel appearing for the appellant and counsel appearing for the appellant and respondent, and also suit is filed for the relief of bare injunction. It has to be noted that only court has to take note of, as on the date of filing of the suit, whether the plaintiff is in possession. In a case of suit is filed for the relief of bare injunction, the plaintiff mainly relies upon the document of exhibit P1 sale deed dated 2/8/1983, and also no dispute that DW1 is the signatory to the said sale deed, and also it is clear that the sale deed executed by the Lakkanna and Marigoda, in which the DW1 is a signatory, and the same is subsequent to the conversion of the property, which was obtained in the year 1983, sites were formed and sites are sold. And the DW1 also categorically admits in the class examination he was signatory to all the sale deeds, and particularly in respect of exhibit P1 also he was one of the signatory, and the same is taken note of by the trial court in paragraph number 21. He categorically admits that Lakkanna Marigoda sold the survey number 38 to 10 persons, and he has not objected for the said sale. He also signed the sale deed, and hence it is clear that family was having only survey number 38 and not 47/2. But in the paragraph number 16 also taken note of the admission on the part of DW1 that he claims that he signed the sale deed exhibit P1, believing that the same in respect of survey number 47. But when it is emerged that family was not having survey number 47, and mistakenly it was mentioned in the earlier sale deed of the year 1971, was mentioned as 47/2, and subsequently same is mentioned as 38 while purchasing the property by the Lakkanna Marigoda in the year 1980, and subsequently in the year 1985, document also came into existence of rectification deed in respect of survey number 38, and the very contention of the defendant that title is disputed cannot be accepted once admitted that DW1 is a signatory to the document of plaintiff exhibit P1. Once the DW1 admits his signature in the document of exhibit P1 and the very contention of the counsel appearing to the appellant that judgment of Anantula Sudhakura comes into play cannot be accepted, and only when there is a cloud on the title is concerned, the judgment of Anantula Sudhakar is applicable, and hence the judgment of Anantula Sudhakar will not come to the aid of the defendant, since the admission on the part of DW1 is very clear that he was a signatory to the document of plaintiff of the sale deed exhibit P1. The counsel appearing for the appellant also brought to notice of this court judgment paragraph number 17 in a case of Annamma versus Puttamma, wherein also in the reasoning it is held by this court that the law is well settled that there cannot be an injunction in respect of an unascertained or undisputed property. But in the case on hand, the property which was sold by the Lakkanna and Marigoda is specific that sites are formed in the very same survey number after the obtaining the conversion, and also the DW1 who is a party to the said sale deed, and the definite property which is mentioned in the plate is also sold. The main contention of the counsel appearing for the appellant would the appellant that document exhibit D (16 to 30) is very clear that survey number 38 is not converted land and remains as an agriculture land. Also cannot be accepted for the reason that DW1 categorically admitted that sites are formed in survey number 38 and the same is sold, and this admission takes away the contention of the appellant. And when such being the case, when the property is identifiable, and though content that description mentioned in the plaint as well as in the sale deed are different, but the plaintiff, in order to substantiate the boundary mentioned in the plaint is concerned, produce the other documents of exhibit P6 to 9, who are the adjacent owners who have purchased the property from the very same Lakkanna and Marigoda, and in which also the DW1 is signatory to the document, and he categorically admits that for all the sale deed he was a signatory and he is not having any objections for the said sale, and the same is discussed in paragraph number 21. And when well reasons are given by the trial court and appellate court also reappreciated both oral and documentary evidence available on record, and with regard to the factual aspect as well as question of law, both has been considered by the trial court and the appellate court, and hence I do not find any ground to admit the second appeal, and no ground is made out to invoke section 100 of CPC. In view of the discussions made up, I pass the following order. The second appeal is dismissed.
24.
Madam, ಸ್ವಲ್ಪ ನೀರು ತರ್ಸಕ್ಕೆ ನೀರು ತಂದು ಕೊಡಕ್ಕೆ 24 ಅಲ್ಲ?
Please, my lord. Lord, suit for partition between two sisters and one brother. So the trial court, though decrease the suit, it notional partition is granted on the ground that father was not alive as on before 2005. That is the finding before the third trial court, paragraph 23 of the trial court judgment, my lord. May I read this, my lord? In the present case, the court has to consider whether the plaintiff have proved their case by adducing oral and documentary evidence. Since the plaintiff have opposed this court, they have to prove their case on perusal of entire evidence and documents produced by the plaintiff and keeping in view the said rulings. In position of law, I conclude that plaintiffs and defendants too are not being co-partners, as the father of them had not alive as on 9/9/2005. Hence, they are not entitled for equal self-hold properties.
It is well settled principle that whenever a male Hindu dies, the property of male Hindu must develop on son, daughter, widows, mother, son of predeceased son, widow of predeceased on as per section 8 of the Instruction Act. Thus, they being a legal heads, whatever the property that would have been allotted to her father from them, notional partition have to be allowed to the share.
Now this issue will not arise in view of Vinita
That's
Sharma case.
exactly the point, my lords. That's the only point for consideration, my lords. The defendant number 2 also supports that she has also have got a right in the suitable property. Lord, ignore this fact that not any of this judgment. There's only short point, my lord, that arises, my lord's consideration. And the appeal is by the first plaintiff, and the second plaintiff is arrayed as third respondent, who is represented by the counsel there, my lord, Sonal. And the third defendant before the trial court, second defendant, is also represented by the
First appellate court ಅಲ್ಲಿ modify ಮಾಡಿದ್ದಾರೆ.
Modify
ಏನಂತಂದ್ರೆ 1.50 acres ಅಲ್ಲ ಅದು.
Please, that is
only
correct.
a cent ಅಂತ.
I do concede that is correct, my lord. I do concede. That's correct.
Now only, what is your grievance now?
Now, my lord, see, the parties are entitled for equal share in all the properties. That is the only short point by considerations. Any of this Vinita Sharma judgment.
ಈ observation ಏನಿದೆ trial court, para 23 goes now in view of the judgment of the, they are equally entitled ಅಷ್ಟೇ. ಎಷ್ಟು ಕೊಡ್ಬೇಕಾಗಾರ? one ಜನ ಇದ್ದಾರೆ,
3 ಜನ ಹೆಣ್ಮಕ್ಳು 1 ಗಂಡ ಮಗ. ಫಸ್ಟ್ ಡಿಫೆಂಡೆಂಟ್ ಗಂಡ ತೀರ್ಕೊಂಡಾಗ
1/4 ಬರ್ಬೇಕು ಅಷ್ಟೇ.
ಹೌದು 1/4. ಹೌದು 1/4
ಈಚ್ ತೋಡ್ ಎಲ್ಲ ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡಿದಾರಲ್ಲ.
ಫಸ್ಟ್ ಡಿಫೆಂಡೆಂಟ್
ಸರ್ವ್ಡ್ unrepresented. Third, heard the appellant counsel and also the counsel appearing for the respondents. This second appeal is filed by the plaintiff, praying this court to modify the judgment and decree of the trial court. ಏನಿದೆ ನಿಮ್ಮ prayer?
Lord, in the appeal minutes or in the
Set aside the judgment in OS 40 of 2016.
Please, man.
ಎಲ್ಲಾನು set aside ಕೇಳಿದಿರಾ?
Not in the prayer, not paragraph.
In substantive question of law ಎಲ್ಲಿದೆ?
Not these two, because principal suicide, so and so, not they should have said not unto decree the suit. Consequently, decree the suit in the prayer 2, my lords.
Decree the suit ಅಂದ್ರೆ ನೀವು ರಿಲೀಫ್ ಏನ್ ಕೇಳಿದ್ರಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ?
Trial court equal partition.
Equal 1/4 ಕೇಳಿದ್ರಿ.
Please, my lord.
1/4 ಕೇಳಿದ್ರಿ.
Please.
Relief of partition and separate possession of legitimate share ಅಂತಿದೆ. ಎಷ್ಟು ಅಂತ ಇದೆ? ಏನಾಯ್ತು ಮೇಡಮ್? Praying the court to grant the equal share. ಇವರೆಲ್ಲ ಸಿಸ್ಟರ್ಸ್.
Please, my lord. First defendant, that is defendant number 3, ಅವರ ಯೋಗೇಶ್ ಅವರ ಹೆಂಡತಿ, ಸೊ ಅತ್ತಿಗೆ ಇದ್ದಾರೆ.
ಫಸ್ಟ್ ಡಿಫೆಂಡೆಂಟ್
ಹೌದು, ಶೈಲಾ, KY ಶೈಲಾ is the wife of ಯೋಗೇಶ್, son of Lord ಹೊನ್ನಪ್ಪ.
4 ಜನ, 3 ಜನ ಸಿಸ್ಟರ್ಸ್,
ಒಬ್ಬ ಗಂಡ ಮಗ.
ಫಾದರ್ ಅಣ್ಣ ಸತ್ತೋಗವನೇ ವೈಫ್.
ಹೌದು ಸರ್.
ಹೌದಾ? ಏನಾಯ್ತು ಮೇಡಮ್ ಲಾಸ್ಟ್ ಸೆಂಟೆನ್ಸ್? Equal share, claiming that plaintiff number 1 and 2 are the daughters of late KR Honnappa, and the first defendant is the wife of son of Honnappa, Mr. KH Yogesh, and second defendant is also the sister of the plaintiff. Correct, Henry?
Please, madam.
And they are equally entitled for a share in the property left by the father, and father acquired the same by a partition deed. Howdalla?
Please, my lord.
And the same is an ancestral property, and the father passed away on 12/2/2003, leaving behind the plaintiff and defendant. The defendants appeared and filed the written statement contending that daughters are not entitled for the share of the property. However, the trial court made an observation in paragraph number 23 that plaintiffs and defendant number 2 not being a co-partners as the father of them had not alive on 9 September 2005, hence they are not entitled for equal share in the suit schedule properties, and hence granted only 1/8 share each that plaintiffs and second defendant are entitled. The same is questioned by the plaintiffs in the appeal in RA number 40 of 2018. And appellate court, having reassessed the material on record, confirmed the judgment of the trial court, and hence the second appeal is filed before this court. The issue between the parties is only with regard to the whether they are entitled for equal share. The counsel appearing for the appellant brought to notice of this court the observations made by the trial court in paragraph number 23 is not correct, and in view of the judgment of the apex court in a case of Vinod Sharma, the very reasoning given by the trial court is not correct, and counsel appearing for the respondent is also not disputes the principles laid down in the judgment of the apex court in Vinod Sharma case. The factual matter is clearly discloses that the plaintiffs number 1 and 2 and the second defendant are the daughters of Honnappa, and the first defendant represent the branch of son of Honnappa as a legal heir. And when such being the case, in view of judgment of Vinod Sharma case, they are equally entitled for the share in the property of ancestral property left by the father, and the fact that property is an ancestral property is not in dispute. And when such being the case, the judgment and decree of the trial court and appellate court requires to be modified, granting equal share of 1/4 each among the plaintiffs and defendants, and accordingly the second appeal is disposed of.
25 Adjournment, 26 KV Narasimhan.
Lord, I appear for the appellant. Lord, in this matter, the last date of hearing, my lord, cost title was supposed to be filed.
Non-filing of amended cost title.
Needful is done, man.
Needful done. Really, admission gate.
My lord, this matter, my lord, may have to be connected with one more RSA, my lord, RSA 426 of 2020.
RSA idea.
Please, man. Arising out of the same judgment.
426 of
2022.
Appellant counsel would submit that one more RSA 426 of 22 is also pending, and the same are also arising out of the common judgment passed by the first appellate court. Howda? And hence post the same along with this appeal on Yavag Madam 13/12.
7.
Memo already LRs are on record. RSA 985 of 2013 reports the death of also in the that are the surviving copy of the appeal memo on the so the appellate counsel in other matter, respondent counsel who appeals on behalf the memo is and the appellate counsel to amend the cost title. No, I tell you.
Namma Pilaguve, she is the second respondent. My submission may accepted. I will file memo in my appeal also.
So the appellant counsel in RSA 2000 of 23 also files memo stating that R2 na? R2 is no more. And respond number yaru?
My lord, appellants and number 1.
Appellants or an LR?
Same appellants and respond number 1.
Appellants and respond number 1 are the legal heirs of respondent number 2 na?
ಹೌದು.
Respondent number 2 and hence memo is accepted. Both counsels are directed to title. ಏನ್ ಇವತ್ತು ನಾವು ಹೇಳ್ತೀರಾ ರೆಡಿ ಇದ್ದೀರಾ?
ರೆಡಿ. ನಮ್ಮದ್ರಲ್ಲಿ
ಹಾ
ಅವ್ರಿಗೆ ನೋಷನಲ್ ಶೇರ್ ಕೊಡ್ತಾರೆ ಅಂತ ಇದೆ ಡಾಕ್ಟರ್ ಫೈಲ್ಡ್ ಇದೆ. ಇನ್ನೊಂದು ಕೇಸಲ್ಲಿ
ಫಸ್ಟ್ ಡಿಸ್ಮಿಸಲ್ ಆಗಿತ್ತು.
ಡಿಸ್ಮಿಸ್ ಆಯ್ತು, ಇಲ್ಲಿ ರಿವರ್ಸ್ ಆಗಿದೆ. ನೋಷನಲ್ ಶೇರ್ ಕೊಟ್ಟವ್ರೆ, ನಾವು ಈಕ್ವಲ್ ಶೇರ್ ಬರ್ಬೇಕು ಅಂತ ಡಾಕ್ಟರ್ಸ್. ಮ್ಯಾಟರ್ ನೀಡ್ಸ್ ಟು ಬಿ ಹರ್ಡ್ ಮೈ ಲಾರ್ಡ್, ಇಟ್ ಮೇ ಬಿ ಅಡ್ಮಿಟೆಡ್.
ನಿಮಗೆ ಕೊಟ್ಟಿಲ್ವಾ? ಆಯ್ತು, ಡೈರೆಕ್ಟೆಡ್ ಟು ಅಮೆಂಡ್ ದಿ ಕಾಸ್ಟ್ ಟೈಟಲ್ ವಿತ್ ಇನ್ 2 weeks. ಆಯ್ತಾ? ಇಶ್ಯೂ ಆಯ್ತು. ಇಶ್ಯೂ ನೋಟಿಸ್ ಅಗೇನ್ಸ್ಟ್ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್
ನಂಬರ್ 1.
ಒಬ್ರೇನಾ ಈಗ? ಒನ್ ಇನ್ RSA 2000/23. ಹೌದಾ? ಅದ್ರದ್ದು ರೆಕಾರ್ಡ್ಸ್ ಎರಡು ಕಾಮನ್ ಇದು.
ಕಾಮನ್ ರೆಕಾರ್ಡ್
ಬಂದಿದೆ. ಇದ್ರಲ್ಲಿ ಯಾರಿಗೂ ಇನ್ ನೋಟಿಸ್ ಮಾಡೋದಿಲ್ಲ. ಕನೆಕ್ಟೆಡ್ ಅಲ್ಲ. RSA 985
ನಾನು ಅಪೇರ್ ಆಗಿದ್ದೀನಿ, ಎಲ್ಲರಿಗೂ ಆಗಿದ್ದೀನಿ.
ಅಪಿಯರ್ ಆಗಿದ್ದೀರಿ. ಹೌದು. ಶಾರ್ಟ್ ಕ್ವಶನ್ ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಮಾಡೋಣ. ಏನಿದೆ?
ಅಲ್ಲ, ಅವರೇ ತಾಂಡಿದ್ರು ಸುಲಭ ಆಗ್ಬಿಡೋದು.
ಹೋಗ್ಬರ್ಲಿ, ನೋಟಿಸ್ ಹೋಗ್ಬರ್ಲಿ R1 ಗೆ. ಆಯ್ತು, 3 ವಾರ ಕೊಡಿ ಮೇಡಮ್. PF ಇವತ್ತೇ ಕೊಡಿ. PF ಇವತ್ತೇ ಕೊಡಿ. ಇಶ್ಯೂ ನೋಟಿಸ್ ಅಗೇನ್ಸ್ಟ್ R1 ಅದಾಯ್ತಲ್ಲ. ಹೌದು. ರಿಟರ್ನಬಲ್ ಬೈ 212. ಅವಾಗ್ಲೇ ಓನ್ಲಿ ಡಿಸ್ಪೋಸಲ್ ಮಾಡಿರ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್ ಅಲ್ಲಿ. ನೆಕ್ಸ್ಟ್ 28 ಅಂಬಾಜಿ ರಾವ್.
Day after tomorrow, I'm not feeling well, kindly, day after tomorrow,
ಎಸ್ ಕೌನ್ಸಿಲ್ ಮೈಕ್ ನೋಡ್ರಿ, ನೀವು ಮೈಕ್ಸ್ ಕರೆಕ್ಟ್ ಆಗಿ ಇಟ್ಕೊಳ್ಳಿ.
day after tomorrow,
ಏನಕ್ಕೆ ಕೇಳಿ ಟೈಮು? ವೈ ಯು ಆರ್ ಸೀಕಿಂಗ್ ಟೈಮ್?
I'm not feeling well,
16 ಕೊಟ್ಟಿದ್ದಾರೆ. ಐಟಮ್ ನಂಬರ್ 1 and 3 ರಿಮೈನಿಂಗ್ ಐಟಮ್ಸ್ ಆರ್ ಡಿಸ್ಮಿಸ್ಡ್, ಕನ್ಫರ್ಮ್ಡ್ ಬೈ ದಿ appellate court.
Yes, my lord. Just for modification of the judgment, I am before your lordship, my lord.
ಏನ್ ಮಾಡಿಫಿಕೇಶನ್ ಆಗ್ಬೇಕು ಹೇಳಿ?
ರಿಮೈನಿಂಗ್ ಪ್ರಾಪರ್ಟೀಸ್ ಅಲ್ಲಿ ಈಕ್ವಲ್ ಆಗಿ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಬಂದಿದ್ದೀನಿ ಸ್ವಾಮಿ. ದಿ ರಿಮೈನಿಂಗ್ ಪ್ರಾಪರ್ಟೀಸ್
ಐಟಮ್ ನಂಬರ್ 2, 4 and 5 ಕೊಟ್ಟಿಲ್ಲ ಅಂತ.
2, 4, 5 ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಬಂದಿದ್ದೀನಿ ಸ್ವಾಮಿ.
ಹೌದ್ರಿ, ಕರೆಕ್ಟ್. ರೀಸನ್ಸ್ ಏನು ಕೊಡ್ಬೇಕಾದ್ರೆ ಕನ್ಫರ್ಮ್ ಬೈ ದಿ appellate court.
Yes, my lord.
Those properties are not belongs to the family and hence you are not entitled ಅಂತ.
The only question involved is my father was alive as on the date of purchase of the properties. That is not considered, my lord.
Father was?
My father-in-law was alive as on the date of purchase of the shoot-shed properties. Therefore,
appellant counsel 6 time list this matter on ಯಾವ್ದಾರ ಡೇಟ್ ಕೊಡ್ರಿ. ಕೇಳೋದಿಲ್ಲ. Also 6 time list this matter on ಯಾವ್ದಾರ ಡೇಟ್ ಕೊಡಿ ಮೇಡಮ್. 13/11.
Please, my lord. Grateful to you.
Next. Right of easement of necessity. PI granted, confirmed.
It's the scheduled properties, survey number 75, in which I was granted to an extent of 2 acres 8 gunta. That in the remaining in between the property of Guttappa and myself, my lord, there exists 7 guntas of land. They are claiming that, my lord, it is a road. But earlier it was not a road, and during the pendency of the suit, my lord, that there were some orders passed by the government, and based on that they formed the road, but they have removed all our the muds because the mud was stored for the purpose of the bricks, my lord, preparation of the bricks. So that has been removed. All the documents, my lord, that the Tiffany and other things, my lord, that it is stated that there exists a road, but there was no road at all in the earlier point of time. But the trial court has relied on the exhibit P6, that is the grant certificate which was issued in favor of the Guttappa, that the other person along with me, he was also granted 1 acre 3 guntas. So our 23 guntas. That 23 guntas is assigned with the survey number 97, and another part is after the road, my lord. So that there is no road in between my property and the property of the Guttappa. Both the courts have come to the conclusion that there exists a road from time immemorial.
Documental ide anta.
Documental that they are relying upon the grant certificate which is issued in the name of Guttappa, and it is not because the plaintiff is claiming
the road to reach their property in survey number 25/2. And it is not in the very same survey number 75. So that is all, both the courts have come to the conclusion, but the government has issued a notification by virtue of in 2009 that it is reserved for the road. So therefore that it is the only way to reach the property of the plaintiff, that the judgment has been passed by both the courts. But they have failed to appreciate with regard to that the other village maps and other things, my lord, that they are, it is not stated that there was an existence of the road or the car track at the earliest point of time.
Go to paragraph number 16 of the trial court. Exhibit P6, that is sketch prepared by the Taluka
that is
surveyor.
the sketch, my lord.
Suit schedule road is shown in dotted line. Exhibit P8, that is RTC. Exhibit P14, that is grant certificate.
RTC, my lord.
In favor of Guttappa.
Please, my lord, that I am not.
Clearly establishes the existence of a cart track road.
Exhibit
number 75 of Vitiganahalli village as pleaded by the plaintiff. It is also true that defendant has not at all challenged the entries made in exhibit P8, 6, 14 and 45. Further, defendant has not at all above the fact that suit schedule road and property is not at all in existence, and see further page to prove that plaintiff is not having any easementary right over the same.
The exhibit P6, my lord, that is.
On P14 also.
In P14 also.
Appellate court also considered in paragraph number 29.
Yes, my lord, that I have based on that.
Yeah, no case.
Earlier to that, my lord, that there was no road at all. The revenue sketch, my lord, that it is produced, the other documents also produced by the defendant before the trial court, but they have not been properly appreciated with regard to that the existence, the road and earliest point of time. But there is no road at all. But it was only the vacant land which I am using. That the RTC, my lord, that which is mentioned as 7 guntas as a road. It is after the order passed in during the pendency of the suit. It is not much earlier to that. At the time of making effect duras, that they say that there is a road. It is only for reservation of the road. That is the observation made by the Tahsildar.
All documental entries ಇದೆ, even revenue entries ಇದೆ, revenue documents ಅಲ್ಲಿ ಇದೆ.
Revenue documents ಅಲ್ಲಿ ಅದು order pass ಆದ್ಮೇಲೆ then they say that it is reserved for road.
Even grant itself in exhibit P14.
P14 grant.
ಏನಿಲ್ಲ ಕೇಸಲ್ಲಿ second appeal ಅಲ್ಲಿ.
Since I have preferred an appeal before the Karnataka appellate tribunal, challenging the order passed by the government, that appeal is pending. Both the courts have that I have not placed any materials with regard to the pendency of the appeal. I have produced a document before the trial court that the appeal is pending.
In the documents itself, in a grant itself, which clearly discloses.
In my grant certificate, there is no boundary with regard to the towards the western side. There exists a road. Only in Guttappa's grant certificate that they mention that it is Bandidari. So based on that, the trial
road ಇದೆ ಅಂತ even entry ನಲ್ಲೂ ಇದೆ, revenue records ಅಲ್ಲಿ ಇದೆ.
The revenue records ಅಲ್ಲಿ ಅದು ನಂತರದಲ್ಲಿ ಆಗಿರೋದು ಅಂತ. It is only reserved for road ಅಂತ ಮಾಡಿ ಅದು ನಂತರದಲ್ಲಿ that they mention it as 7 guntas as a road.
What's up? Third.
So that
this matter is listed for admission. I heard the counsel appearing for the appellant. The second appeal is filed against the concurrent finding of the trial court and also the appellate court. The case of the factual matters of case of plaintiff before the trial court, that plaintiff is the absolute owner in possession of land bearing survey number 25/2, measuring 14 acres. 33 guntas situated at KG Hanumantapura village, Kaspa Obli, Malur Taluk. Plaintiff purchased the land from one Srimati Vasanta Kumari under the registered sale deed dated 25/1/2006. And plaintiff is also having some property adjacent to the property in survey number 25/2. The southern boundary of the property in survey number 25/2 is up to the limit of survey number 75 of Mitiganahalli village. In the said survey number 75, there is a road from east to west direction. The said road is in existence from immemorial time and it is a government road. The suit schedule road is the only road for the plaintiff to approach and to reach his land from the aforesaid main road, there is no other alternative road to the plaintiff property. The suit schedule road is carved out in survey number 75 of the Mitiganahalli village. The plaintiff vendor were using the said road within bracket suit schedule property to reach their land from the main road. From the date of purchase, plaintiff is also using the suit schedule land to reach her property. In the year 1993, one Guttappa and defendant herein has given application to the government to classify the existing road in the said 7 guntas of land as road officially. The defendant was granted an extent of 2 acres 4 guntas of land in survey number 75 of Mitiganahalli village. Later it was renumbered as new survey number 102. The land situated on the eastern side of the suit land in survey number 102 belongs to the plaintiff. The land on the western side of the scheduled property belongs to the Guttappa. It's survey number 97. The grant certificate which is issued in favor of Guttappa clearly shows the existence of the suit scheduled property, and further plaintiff contend that the grant shall not claim any right, possession and interest over the same, and grantee shall not obstruct the ingress and egress of the adjacent landowners. The suit scheduled land is in existence from many decades, but it is regularized in the year 1993. The revenue documents also discloses the existence of the suit scheduled road. The government of Karnataka notified and declared that the suit scheduled property is a road. The survey authorities and Tahsildar have visited the spot and demarcated the suit scheduled property as road. Such being the case, defendant is having no absolute right possession over the suit road. Plaintiff is also having right of easement in respect of the same, and the defendant with an intention to grab that road, he has made several attempts to block the same and cause inconvenience to the users of the easement, and also obstructed the plaintiff right of easement over the suit scheduled road, and hence filed the suit. After the issuance of the suit summons, defendant number 2, defendant appeared and contend that 2 acres 8 guntas of land in survey number 75, new survey number 102 is the self-acquired property of the defendant, and the same is granted by the government. The revenue records are standing in his name and he is paying tax. The suit scheduled property is situated on the eastern side of their property, and defendant is in actual possession and enjoyment of the same since from 50 years without any disturbance from anybody. Plaintiff has built up the records by using her influence to farm the road in the suit scheduled property. Hence, defendant filed OS number 240 of 2007 against the government. Defendant also filed the application before the concerned authorities to confirm his unauthorized occupation in respect of the land situated on the western side of their property. Further, defendant contended that he has dumped 200 loads of mud in the suit scheduled road. The same was removed by the plaintiff by using her influence. In the additional written statement also contended that order passed by the learned Deputy Commissioner Kolar by reserving 7 guntas of land in survey number 75 to road is stayed by Karnataka Appellate Tribunal in appeal number 371 of 2009. A said stay order is in force. The suit scheduled property is within survey number 102, measuring 2 acres 8 guntas of land, and press his court to dismiss the suit. The parties are allowed to lead evidence, and PW1 examined before the court and also examined 2 witnesses and produced exhibit P1 to 45. The GPA holder of defendant also examined DW1 and produced 87 documents. The trial court, having considered particularly the documents which have been relied upon by the plaintiff, in paragraph number 15 comes to the conclusion that recitals of exhibit P45 is very clearly shows that the suit scheduled property is situated on the western side of new survey number 102, which belongs to defendant. It is also true that the suit scheduled property is situated towards western side of 34 guntas of land in block number 1 in survey number 75 of Mitiganalli village, which is allotted to Guttappa son of Ramaya. The boundary stated in exhibit P14, that is grant certificate issued in favor of Guttappa son of Ramaya, and exhibit 45, that is sketch, corroborates with each other. The boundary stated in exhibit P6, that is sketch prepared by the Taluka surveyor. And Exhibit P8 RTC and Exhibit P14 grant certificate issued in favor of Guttappa. All document clearly corroborates each other that the above said documents clearly exhibits the existence of the suit schedule road as alleged by the plaintiff. The trial court also taken note of the answer illustrated from the mouth of DW1 in paragraph number 17. DW1 admitted the land granted to the Guttappa and its boundaries, and also admitted that plaintiff has purchased the land in survey number 25/2 of Hanumantapura village, which is situated on the southern side of their land in new survey number 102. However, denies the existence of road, but not at all given any explanation to believe her pleading that there is alternative road for the plaintiff to approach their land. ನಿಮ್ ಸೂಟು ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ
IA was dismissed because it was not my land. So therefore that it is a government land.
The trial
therefore I
court
have no
also
control
taken
over it.
note of all the documents in paragraph number 18 comes to the conclusion that the existence of road is very clear and plaintiff is having a easementary right to reach his property and granted the relief. The same is challenged before the appellate court in RE number 44 of 2017, and appellate court also, having considered the grounds urged by the appellant defendant before the appellate court, reassessed both oral and documentary evidence and particularly taken note of grant certificate exhibit P14, and the same is discussed in paragraph number 29, and also taken note of recitals of exhibit P14 and exhibit P6 in paragraph number 30, and also in paragraph number 31 taken note of document exhibit P41, which is the report given by the Deputy Commissioner Kolar to the Secretary Revenue Department stating Government of Karnataka dated 4/12/2008, wherein 7 guntas of land in survey number 75 of Miteganalli village is reserved for the purpose of farming road. And appellate court, having reassessed the material, taken note of admission on the part of DW1 and discussed the same in paragraph number 35. And having reassessed the evidence available on record, concur the judgment of the trial court. Being agreed by the said finding of trial court as well as the appellate court, the present second appeal is filed before this court. The main contention of the counsel appearing for the appellant before this court is that both the courts have committed an error in not properly assessing the material on record, whether the plaintiff is entitled for right of easement as per section 4 of the Easement Act when the plaintiff has not proved the prescribed period to claim such right when there is no existence of road. And also counsel would contend that both the courts are not justified in granting the relief that he is having an easementary right to reach the land bearing survey number 25/2, and the very approach is erroneous, and hence this court has to admit the second appeal and frame substantive question of law. Having heard the appellant counsel and also on perusal of the reasoning of the trial court, particularly the trial court having considered the case of the plaintiff in paragraph number 2 and also the defense of the defendant in the written statement in paragraph number 6, and taken note of both grant order exhibit P14 and also the exhibit 45 recitals, and also the document exhibit P6, and also the in paragraph number 16, 17, paragraph number 17 taken note of admission on the part of DW1, and in paragraph number 6 also discussed in detail that no other alternative road is to reach the land of the plaintiff, and also defendants have not led any evidence to show that plaintiff is having any other alternative road to reach the land in survey number 25. And also the appellate court having reassessed the material also taken note of very grant order exhibit P14 and also the report of the Deputy Commissioner in terms of exhibit P41 as well as the admission on the part of DW1 in the cross examination that we had purchased the and the land was granted in favor of the defendant, and the same is also an adjacent land of the plaintiff. That is survey number 25/2 of KG Hanumatapura village, which is situated on the southern side of their lands in survey number 102. But denied the existence of road claimed by the plaintiff. But the material available before the court is very clear that the road is in existence, and a very grant certificate also discloses the same. And though defendant filed the suit in OS number 113 of 2009, and the application filed by the defendant also dismissed in the said suit, and no doubt counsel appearing for the appellant brought to notice of this court that an appeal is filed before the KAT and stay is granted, but the same is the pending and not adjudicated. And when searching the case, when the plaintiff categorically pleaded that he is not having any other alternative road to reach his land except the said road which is in existence in the grant certificate as well as the other revenue records also, particularly exhibit P6 as well as exhibit P41. I do not find any error committed by the trial court as well as the appellate court in coming to such a conclusion that plaintiff is entitled for the easement right in the absence of any alternative road to the reach the land of the plaintiff, and hence I do not find any ground to admit and frame any substantive question of law, and hence not a case for invoking section 100 to admit and frame substantive question of law. In view of the discussions made above, I pass the following order. Second appeal is dismissed. 30.
Because there was a delay, my lord, along with the delay.
Delay is this.
Along with the delay, the
Heard on I number 1 of 23, and there is a delay of 29 days in filing the appeal, and delay is only 29 days, and hence delay is condoned.
30. Gopal Krishna Murthy C.
My lord, in this matter, my lord, I may kindly be permitted to file memo reporting the death of appellant number 1. My lord. Copy is also served to my learned friend.
Appellant tirkondidara?
Houdu sir. And other appellants number 2 to 4, my lord, the
Yararu?
other appellants.
Are the legal representative?
Yes, my lord. 2
Third,
to
appellant counsel reports the death of appellant number 1, and appellant number 2 to 4 are the legal representatives of the appellant number 1. And copy of the memo is also served on the counsel appearing with the respondent, and respondent not disputes the same. And hence memo is accepted. Appellant counsel is directed to amend the cost title in terms of the memo. Hearing.
And I may kindly be permitted to amend the cost title and file amended cost title, my lord. And kindly have done 2 weeks. Because ಹುಷಾರಿಲ್ಲ ಸಮ ಅದಕ್ಕೋಸ್ಕರ ಅಷ್ಟೇ.
Appellant counsel is directed to amend the cost title and file amended cost title within 2 weeks. List this matter on 13/2 at the request of the appellant.
Great.
Counsel.
31. Kiranyan.
13/11. ಯಾಕೋ 12 ಹೋಗ್ತಾ ಇದೆಲ್ಲ ಅವಾಗಿಂದ. 13/11. ಡಿಸೆಂಬರ್ ಹೋಗ್ಬಿಟ್ಟು. 16 share except the sold property under exhibit D2 and D16.
There is a delay of 9 years, my lord. There is a delay of 9 years.
Delay of 9 years?
For filing the first appeal before the first appellate court, my lord.
ಏನಾಯ್ತು ಅಲ್ಲಿ?
The IA has been dismissed.
9 years act delay?
Intention of the appellant is, my lord, she has given the brief to 2 advocates after the pronouncement of the judgment and decree. Whereas she has categorically, she has deposed before the first appellate court that she has given the instruction to the 2 advocates. They have taken the brief and they have not filed the appropriate appeal before the appellate court. Once the same factor has been got to the knowledge of the appellant, she approached
ಆಯ್ತ್ರಿ ಬ್ರೀಫ್ ಲಾಯರಿಗೆ ಕೊಟ್ರು. ಲಾಯರಿಗೆ ಕೊಟ್ಟಾದ್ಮೇಲೆ ಏನ್ ಮಾಡ್ಬೇಕು? ಕ್ಲೈಂಟ್ ಲಾಯರ್ ಹತ್ರ ಹೋಗ್ಬೇಕಲ್ವಾ?
ಹೋಗಿದ್ರು ಸ್ವಾಮಿ, ಫೈಲ್ ಆಗಿದೆ, ಸಿ ಇಸ್ ಇಲ್ಲಿಟ್ರೇಟ್ ಮೈ ಲಾರ್ಡ್, ಫೈಲ್ ಆಗಿದೆ, ನಿಮ್ ಕೇಸ್ ಬರುತ್ತೆ, ನಾಳೆ ಬರುತ್ತೆ. ಇಬ್ರು ಕೂಡ ಅದೇ ತರ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ.
ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ ಈಗ? ಏನ್ ಕೇಸಲ್ಲಿ ಏನ್ ಇಲ್ರಿ, ಅವ್ರ ದೇ ಕ್ಲೈಮ್ ದೇರ್ ರೈಟ್ ಅಷ್ಟೇ.
The trial court has
you are not ready to give a share in favor of the plaintiffs.
I have not been allotted for in item number 134. The share has not been allotted by the trial court in the original suit.
1/6 share in the suitable properties except in the properties sold under exhibit D2 and D6. ಸೇಲ್ ಡೀಡ್ಸ್ ಇನ್ ಫೇವರ್ ಆಫ್ D6 and 7. ಆಲ್ರೆಡಿ ಸೇಲ್ ಆಗಿರೋ ಪ್ರಾಪರ್ಟೀಸ್ ಅಲ್ಲಿ ಕೊಟ್ಟಿಲ್ಲ, ರಿಮೈನಿಂಗ್ ಪ್ರಾಪರ್ಟೀಸ್ ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ ಶೇರು.
Sale agiro property is a house, my lord. It is an old house. It is acquired by the defendant number 1 through the income of the joint family assets, my lord.
ಆಲ್ರೆಡಿ ಪ್ರಾಪರ್ಟೀಸ್ ಆರ್ ಸೋಲ್ಡ್ ಅಲ್ಲೇನ್ರಿ?
During the pendency of, before filing the, prior to the filing of the suit, the property has been sold without the knowledge of the appellant, my lord.
ಏನ್ ಮಾಡ್ಬೇಕು? ಯಾವಾಗ ಸೇಲ್ ಆಗಿತ್ತು? ಸೇಲ್ ಆಗಿರೋದು ಯಾವ ವರ್ಷದಲ್ಲಿ?
2006, my lord.
ಮತ್ತೆ ಕಾಪಿ ಆಫ್ ದಿ ಸೇಲ್ ಡೀಡ್, ಕಾಪಿ ಆಫ್ ದಿ ಸೇಲ್ ಡೀಡ್ ಎಕ್ಸಿಬಿಟ್ P8 and 9. ನೀವು ಪ್ಲೇಂಟಿಫ್ ನಂಬರ್ 2 ಮಾತ್ರನಾ?
ಹೌದು ಸ್ವಾಮಿ.
ಅಪೀಲ್?
ಹೌದು ಸ್ವಾಮಿ.
ಪ್ಲೇಂಟಿಫ್ ನಂಬರ್ 1 ಹಾಕ್ಲಿಲ್ಲ?
Plaintiff number 1 is not in communication with the present appellant, my lord.
ಬಟ್ ಸೂಟ್ ಹಾಕುವಾಗಿದ್ರಲ್ಲ ನಿಮ್ ಜೊತೆಲೆ?
ಆಗಿದ್ರು ಸ್ವಾಮಿ, ಅವ್ರು ಮದ್ವೆ ಆಗಿ ಯಾವ ಊರಲ್ಲಿ ಇದ್ದಾರೆ ಅಂತಾನೆ ಕೂಡ ಗೊತ್ತಿಲ್ಲ.
ಅಲ್ಲರಿ, ಸೂಟ್ ಡಿಕ್ಲೇರ್ 2011, ನೀವು ಅಪೀಲ್ ಹಾಕಿರೋದು 21 ಅಲ್ಲಿ, 10 ವರ್ಷ ಆದ್ಮೇಲೆ.
ನಾವು
ನೋ ಗ್ರೌಂಡ್ಸ್.
She is a innocent, my lord. At least maybe
innocent ಏನ್ ಮಾಡೋದು ಹೇಳಿ?
ಅವ್ರಿಗೆ ಏನ್ ಗೊತ್ತಿದೆ ಸ್ವಾಮಿ, because the advocates
ಏನ್ ಕೊಟ್ಟಿದಾರ ಅದಷ್ಟೇ.
they have shown the negligence on the part of the.
Now your grievance in respect of the sold property na?
ಹೌದು ಸ್ವಾಮಿ.
ಮತ್ತೆ ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ? You kept quiet for a period of 10 years.
I was not kept quiet, my lord, but
heard on A number 1 of 25. ಯಾರು impleading ಯಾರನ್ನ ಕೇಳಿದಿರಿ?
R7, my lord.
R7 ಯಾರು?
Plaintiff number 1.
ಅವ್ರು ಎಲ್ಲಿದ್ದಾರೆ ಅಂತ ಗೊತ್ತಿಲ್ಲ ಅಂತೀರಿ ನೀವು?
ಅದನ್ನ ಪಾರ್ಟಿ registry has raised the objection for impleading them as respondent.
Defend defend number 1 ಅಲ್ಲ, plaintiff number 1 ಇರಬೇಕು.
Defendant number 1 also deceased, my lord. He is my father. ಅವ್ರು ತೀರೋಗಿದ್ದಾರೆ ಸ್ವಾಮಿ.
ಅವ್ರನ್ನ ಸತ್ತವ್ರನ್ನ ಪಟ್ಟಿ ಮಾಡಕ್ಕಾಗುತ್ತೆ?
Defendant respondent number 2, 4 and 7 are the LRs.
ಆಲ್ರೆಡಿ LRs ಇದ್ದಾರೆ.
LRs
ಅದು ಬರಲ್ಲ ಬಿಡಿ. ಈಗ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಏನು ಇಲ್ವಲ್ಲ ಮೇಡಮ್ ಇದರಲ್ಲಿ? ಇದೆಯಾ? ನಾನ್ ಕಂಪ್ಲೇಂಟ್ಸ್ ತಗೊಳ್ಳಿ. The appellant counsel submitted that defendant number 1
memo for
is the father of the appellant and he is no more.
Memo to
hence he has not been made as party. ಅಷ್ಟೇ ಸಾಕು. ಅಷ್ಟೇ ಅಲ್ವಾ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್?
ಹೌದು ಸ್ವಾಮಿ.
defendant number 1 ಗೆ not been made as party in RE and RSA and hence counsel submission is accepted. Merits ಮೇಲೆ ಏನಿಲ್ಲ. Delay is condoned. ಎಷ್ಟು? 125 days. Delay of 125 days is condoned. Third.
Notice is issued to the respondent. Matter will be get resolved, madam. Matter will be
10 ವರ್ಷ ಎಲ್ಲ ಡಿಲೇ ಇದ್ದಾಗ ಏನು ನೋಟಿಸ್?
Delay is not on the fault of the appellant, my lord.
ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ? ನಿಮ್ ಕೆಲಸ ಅದು. ಹೋಗಿ ಲಾಯರ್ ಹತ್ರ ಕೇಳ್ಬೇಕು ಏನಾಯ್ತು ಕೇಸ್ ಅಂತ.
ಕೇಸ್ ಇದೆ, ಕೇಸ್ ನಡೀತಾ ಇದೆ ಅಂದಾಗ
2011ರಲ್ಲಿ ಸೂಟ್ ಡಿಸ್ಪೋಸಲ್ ಆಗಿದ್ರೆ ನೀವು 2021ರಲ್ಲಿ ಅಪೀಲ್ ಹಾಕಿದ್ರೆ
ಅವ್ರ ನಾಲೆಜ್ ಬಂದಿದೆ ಸ್ವಾಮಿ.
ಏನ್ ಕೊಟ್ಟಿದ್ರಿ ರೀಸನ್ಸ್ ನೋಡಿ?
She could have approached that honorable court, my lord. At each and every hearing she was before the court.
Each and
every in the trial case, my lord. ಆ ಕೋರ್ಟ್ ಅಲ್ಲಿ day by day she has attended the court.
ಆಯ್ತು, ಸೂಟ್ ಡಿಸ್ಪೋಸ್ ಆಗಿ 2011
ಗೊತ್ತಾಗಿದೆ ಸ್ವಾಮಿ. We have given the file to the
every day appear ಆದ್ರೆ 21ರಲ್ಲಿ ಯಾಕೆ ಅಪೀಲ್ ಹಾಕಿದ್ರಿ?
2016 ನಲ್ಲಿ we have handed over the file to 2 advocates, my lord.
16. What about in the judgment was passed in 2011? ಅದಕ್ಕೆ ಅವ್ರು ಹಾಕಿಲ್ಲ ಲಾಯರ್. ಫೀಸ್ ಇಸ್ಕೊಂಡು ಜೋಬಲ್ ಇಟ್ಕೊಂಡು ಸುಮ್ಮನೆ ಅವ್ರು. ಯಾಕೆ ನೀವು ಹೋಗಿದ್ದು 2016.
ಆ ಟೈಮ್ ಅಲ್ಲಿ
it was disposed of in 2011.
I got married and I got 2 children.
11 ರೀ ಅಲ್ವಾ?
It was a social obligation, my lord.
ಏನ್ ಸೋಶಿಯಲ್ ಅಬ್ಲಿಗೇಷನ್?
ಮಕ್ಕಳಾಯ್ತು, ಮದುವೆ ಆಯ್ತು. She was in the marital house.
ಲಾಯರ್ ಫೀಸ್ ಕೊಟ್ಟಿ ಲಾಯರ್ ಮೇಲೆ ಕೇಸ್ ಹಾಕೊಳ್ಳಿ ಅಷ್ಟೇ.
At the right of the petitioner, upon the fault of the advocates.
ಏನ್ ಮಾಡಕ್ಕಲ್ಲ. You are entitled for a share over the properties ಅಂತ ಆಲ್ರೆಡಿ ಕೊಟ್ಟಿದ್ದಾರೆ. 1/6 share in the social properties except exhibit D2 and D6. D2 and D6 ಯಾರು ಸೇಲ್ ಮಾಡಿದ್ದಾರೆ ಪ್ರಾಪರ್ಟಿ?
My father, my lord.
ಮತ್ತೆ ತಂದೆನೇ ಮಾರಾಟ ಮಾಡಿದ್ದಾರೆ.
ಹೌದು ಸ್ವಾಮಿ.
ಎಲ್ಲಿದೆ ಅದಕ್ಕೆ ರೀಸನಿಂಗ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ?
In page number 48, my lord. Issue number 4.
ಇದೆಯಲ್ಲ. Specific case of the defendant that social properties are the self-acquired properties of defendant number 1. Muniswamina.
ಹೌದು ಸ್ವಾಮಿ.
And it is acquired by him out of his own earnings and had every right of alienation. On such right, the defendant number 1 had sold some of the properties in favor of the defendant number 6 and 7. Further, defendant number 6 and 7 also taken the specific defense. Social properties are the self-acquired properties of the defendant number 1, and he had acquired the same out of his own earnings. On such right, the defendant number 1 and 5 have sold an extent of 1.5 land, including 1 guntas of land, totally 2.5 guntas. One ಮಾರ್ರದ 1.5 ಗುಂಟೆ ಏನ್ರಿ?
Extent of one. No, my lord, it is item number 4 and 5, my lord. It is very 3 acre, 1 acres has been 1 acre 8 guntas out of 5 acres, my lord. In page number 57.
$32 guntas.
Howದು sir?
And an extent of 8 guntas of land with Karab. 2006 ಸೇಲ್ ಮಾಡಿದ್ದಾರೆ.
So me 2/1/2006 is the sale deed dated, my lord. When my father got to know that we are proposing to file a suit, he has alienated the property to in favor of respondent number.
ಲೋನ್ ತಗೊಂಡಿದ್ದಾನ್ರಿ ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ. ಆ ಲೋನ್ ಯಾವ್ದೋ ಬಲಮಂದೆ ಅಗ್ರಿಕಲ್ಚರಲ್ ಕೋಆಪರೇಟಿವ್ ಸೊಸೈಟಿ ಡ್ಯೂರಿಂಗ್ ದಿ ಇಯರ್ 2000-2001 ಫಾರ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಆಫ್ ಸಿಲ್ಕ್ ವಾರ್ಮ್ rearing house and mortgaged all the scheduled properties to the society. Defendant number 1 had failed to repay the said loan amount, interest thereon. At that time, government of Karnataka announced a scheme of waiving of interest if the principal amount paid back at a time. Then the defendant number 1 approached defendant number 7 and requested him to purchase his land, bearing number 8 so number and extent of 8 guntas of land. And a registered sale deed, defendant number 7, the defendant after the inquiry about the legal necessity of the defendant number 1 had paid rupees 2 lakh and the defendant number 1 had discharged the loan of the said bank cooperative society and got benefit of rupees 2,12,000 towards the interest under the government scheme. Subsequently, defendant number 7 had executed the sale deed in favor of this defendant 7 and the other defendant number 2 to 5 have signed the said sale deed as witness. Hence, it is the contention of the defendant that defendant number 1 had sold the social property for the legal necessity of the family. ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ ಲೋನ್ ತಗೊಂಡಿ ಲೋನ್ ಕ್ಲಿಯರ್ ಮಾಡಕ್ಕೋಸ್ಕರ ಮಾರಾಟ ಮಾಡಿದಾರ್ರಿ.
ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ ತಗೊಂಡಿದ್ದಕ್ಕಲ್ಲ ಸ್ವಾಮಿ. he has
ನಿಮ್ಮದು ಮದುವೆ ಆಗಿದ್ದೆ ಅವಾಗ ಹೇಳಿ.
ಮದುವೆ ಆಗಿರೋ ಡೇಟ್ ಗೊತ್ತಿಲ್ಲ ಸರ್. she is the party present. ಅವಾಗ ಮದುವೆ ಆಗಿರೋ
ನಿಮಗಿಂತ ನಿಮ್ ಕ್ಲೈಂಟೇ ಜೋರಾಗಿದ್ದಂಗಿದೆ.
In the year 2016, she got married. 2016, Mala.
16. ಅವಾಗ ಮಾರಾಟ ಮಾಡುವಾಗ ಆಕೆ ಮನೆಯಲ್ಲಿ ಇದ್ಲು. ಬೇರೆಯವರೆಲ್ಲರೂ ಸೈನ್ ಮಾಡಿದಾರೆ ಮನೆಯವರೆಲ್ಲ, ಹೌದಾ?
ಹೌದಾ? Plaintiff number 1 and 2 have not signed, Mala.
ಆಯ್ತು.
And the court has directed to pay the amount.
No case counsel on merits also. Third, this matter is listed for admission. I heard the counsel appearing to the appellant. The first appeal is filed before the trial court almost after 10 years, almost 9 years. Delay in filing the appeal and reason assigned in the application before the first appellate court that case was entrusted after the disposal of the suit. She approached the advocate A. Narayanappa, Sri Narayanappa, practicing in Bangarpet, to file the appeal. He has defrauded her by stating that the appeal was filed and pending for hearing. In the year 2016, she got married and blessed with 2 baby boys, with no leaser. She was constrained to take care of her kids. In the meantime, her advocates have neglected her case. When she learnt about their misconduct, she has taken back the file and handed over the same to another advocate, Sri Nagendra Rao. Even he too unreasonably delayed to file the appeal. Ultimately, she has taken back the records in the month of 2021. Due to frequent lockdown imposed by the government, the appeal came to be filed by the advocate on record In this way, 9 years has been elapsed for no fault of time. Hence, there is an inordinate delay of 9 years in preparing this appeal, excluding the limitation period extended by the High Court of Karnataka due to COVID-19. She was less educated. She used to believe the above said advocates at every point of time, and hence prayed the court to condone the delay. In pursuance of the appeal is filed and copy on the delay is served on the respondent. The respondent appeared and filed the objections, contending that frivolous and baseless grounds are urged, and also the same is not supported by any material that papers are entrusted to the two advocates. And in view of objection statement filed by the respondent, allowed the plaintiff to allow the appellant to examine herself before the court, and she has been examined as PW1 and got marked 2 documents, Exhibit P1 and P2. The trial court, having considered the evidence available on record, 2 documents, that is Exhibit P1 and P2, taken note of the fact that the judgment and decree of the trial court was passed on 14/9/2011 and not specifically pleaded when the papers were entrusted to the advocates. And no material is placed before the court for having taken any disciplinary action sought by the applicant against those advocates. And no material is also placed in support of the same, and even not examined the advocates to whom papers are entrusted to file an appeal. And the fact that she had the knowledge about the disposal of the suit and also approached the court after almost 9 years, and also taken note of the fact that certified copy was also taken in 2016 itself, and judgment was disposed of in 2011, and in between 2011 to 2016 there is no any explanation in approaching the advocate. And also comes to the conclusion that delay can be condoned if the reason for such delay is satisfactorily explained and sufficient cause is shown, but not shown any sufficient cause, and hence dismiss the same. The counsel would immediately contend before this court also that the papers are entrusted to the advocate, and when the approach was made to the particular advocate in 2016, it was married.
That is the second advocate, Malan, in 2016.
But ನಿಮ್ಮ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ತಗೊಂಡಿರೋದೇ ನೀವು 2016 ಅಲ್ಲಿ.
ಅದು ಸೆಕೆಂಡ್ ಅಡ್ವೊಕೇಟ್ ತಗೊಂಡಿರೋದು ಸ್ವಾಮಿ.
ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ?
ಫಸ್ಟ್ ಅಡ್ವೊಕೇಟ್ ಕೊಟ್ಟರೆ 2011 ನಲ್ಲಿ ಮಲ.
ಏನಿಲ್ವಲ್ಲ, ಅದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಿದ್ದು ಏನು ಇಲ್ವಲ್ಲ.
ಅವ್ರಿಗೆ ನಾಲೆಜ್ ಇದ್ರೆ ವಕೀಲರು
ಮೇಡಮ್.
For this court that the papers are entrusted to the advocate, and when they approached before the court, the particular advocate in the year 2016 when she was married.
When she was married and having 2 kids. But the fact is that sale was made in 2006 itself, and suit was filed in 2006 immediately after the sale of the property, and suit was disposed of in 2011. And affidavit is also not specific in which year approached the advocate, and for having entrusted the paper also nothing is placed on record, and even not examined those advocates to whom papers have been entrusted, and mere say of the papers are entrusted to the 2 advocates, and ultimately they have not filed the appeal, and then she approached in 2021. That too after almost 9 years cannot be a ground to condone the delay. and no action is taken against the advocates who have received the brief and not filed the appeal, and no disciplinary action is also taken by giving any complaint against the advocates to whom papers are entrusted, and nothing is placed on record, and only bald statement stating that cases are entrusted to the advocates to file an appeal, and also kept quiet for a period of 10 years to pursue the matter with the advocates to whom papers are entrusted to file an appeal, and when such no attempt was made by the appellant and the reason assigned in the affidavit in support of the delay of 9 years is not satisfactory, and each day delay has to be explained, and she has to show the sufficient cause, and also particularly she says that her marriage was solemnized in 2016 and suit was disposed of in 2011 itself, and what prevented in filing an appeal immediately? Nothing is stated except bald statement of papers are entrusted to the advocates, and hence I do not find any ground to admit and frame substantive question of law with regard to the delay is concerned, and trial court even giving an opportunity to the trial court or appellate court even giving an opportunity to the appellant to explain the same in the evidence also, and the same is not satisfactorily explained, and hence the delay of 9 years cannot be condoned, and hence the order passed by the appellate court cannot be interfered even with regard to the delay is concerned, and hence second appeal is dismissed. Remaining matters at 2:30.
Serial number 32, my lords.
32, ಹೇಳಿ.
My lord seeks one accommodation, my lords. Can be taken up
No
next week, my
counsel
lords.
earlier
That's-
date was also fixed for today. Dismissed, confirmed. ಏನ್ ಹೇಳಿ?
My lords.
ಮಧ್ಯಾಹ್ನ ಹೇಳಿ, ನೋಡ್ಕೊಂಡು ಹೇಳಿ.
There are certain documents to be received, my lords, in the compromise.
ಈಗೇನ್
petition.
ಬರೋದಿಲ್ಲ. ನೀವು ಅಪೀಲ್ ಹಾಕಿರೋ 24 ಅಲ್ಲಿ. ಈಗೇನ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ರಿಸೀವ್ ಮಾಡೋದು?
One accommodation, my lords. I'll move on.
ಫಿಕ್ಸ್ ಮಾಡಿದಿರಿ ಲಾಸ್ಟ್ ಟೈಮ್ ಅಡ್ಮಿಷನ್ ಗೆ.
Yes, my lords.
ನೋ ಅಡ್ಜರ್ನ್ಮೆಂಟ್. ಬೇಕು ಅಂದ್ರೆ ಕೊಡ್ತೀನಿ ಕಾಸ್ಟ್ ಮೇಲೆ 10,000.
My lords, one final accommodation, my lords.
Choice is yours.
On third, Monday, my
Choice
lords.
is yours. ಕೊಡ್ತೀನಿ. ನಾನು ಕೊಡಲ್ಲ ಅಂತ ಹೇಳೋದಿಲ್ಲ. ಕಾಸ್ಟ್ ಆನ್ ಕಾಸ್ಟ್. ಅಡ್ಮಿಷನ್ ಗೆ ಇವತ್ತು ಡೇಟ್ ಫಿಕ್ಸ್ ಆಗಿದೆ. ಹೌದಲ್ಲ? ಅಬ್ರಪ್ಟ್ಲಿ ಬಂದಿರೋ ಮ್ಯಾಟರ್ ಅಲ್ಲ.
Yes, my lords.
Last time ಬಂದಾಗ delay application will be considered along with the main appeal at the time of admission ಅಂತ ಅಡ್ಜರ್ನ್ ಮಾಡಿದ್ವಿ. ಹೌದಾ?
Yes, my lords.
ಅಷ್ಟೇ. That's all. ಏನು? Choice is yours.
Monday it can be taken up.
ಕೊಡ್ತೀನಿ. 10,000 ಕಾಸ್ಟ್. ಏನ್ ಬೇಕು ಹೇಳಿ. ಮಧ್ಯಾಹ್ನ ಓದ್ಕೊಂಡು ಹೇಳ್ರಿ ಏನಿದೆ ಕನ್ಕರೆಂಟ್ ಫೈಂಡಿಂಗ್ ಇದೆ ಅದಕ್ಕೆ ಯಾಕೆ ಮತ್ತೆ 10,000 ಪಾರ್ಟಿ ತಲೆಗೆ ಹಾಕ್ತಿರಿ ನಿಮಗ್ ಬೇರೆ ಕೊಟ್ಟಿರ್ತಾನೆ ಮತ್ತೆ ಅವನ ತಲೆಗೆ ಬೇರೆ 10,000 ಹೇಳಿ.
One accommodation, my
ನೋ
lords.
ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಹೇಳಿದ್ ಪ್ರತಿ ಸಾರಿ ಅದನ್ನೇ ಕೇಳಬಾರದು. 3 ಸರಿ ಹೇಳಿದ್ದೀನಿ ನಾನು. ಮಧ್ಯಾಹ್ನ ಮಾಡ್ತೀರಾ ಇಲ್ಲ ಕಾಸ್ಟ್ ಮೇಲೆ ಅರ್ಜೆಂಟ್ ಮಾಡ್ಲಾ 2 ವಾರ ಕೊಡ್ತೀನಿ. ಚಾಯ್ಸ್ ಈಸ್ ಯುವರ್ಸ್. ಐ ರೆಡ್ ದಿ ಪೇಪರ್ಸ್ ಕನ್ಕರೆಂಟ್ ಫೈಂಡಿಂಗ್ ಇದೆ ಏನಿಲ್ಲ. ಡಿಕ್ಲರೇಟರಿ ರಿಲೀಫ್ ಡಿಕ್ಲರೇಷನ್ ಅಂಡ್ ಪೊಸೆಷನ್.
Exhibits are not present, my lords.
ಏನ್ರಿ ಹೇಳಿ ನಿಮ್ದೇನ್ ಹೇಳಿ. ಆಯ್ತು ಹೇಳಿ ಮಧ್ಯಾಹ್ನ ನೋಡೋಣ 2:30ಗೆ. ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದೆ. Court has compared the signature. Please. All the signatures are the appellant. Still you insist for recommending the papers to the handwriting expert. I will pass an order. Subject to criminal case will be registered in case if report comes that all the signatures are belongs to your client. You inquire with your client, then pass an order. ಏನಂತ?
They entrusted the papers one advocate Suresh.
ಅದೆಲ್ಲ ಬಿಟ್ಬಿಡಿ ಹಳೆದ ಆಯ್ತು.
ಅದೇನು ಇವ್ರು ಕೊಟ್ಟಿರ್ಬೋದು ಆತರ ಏನಾಗಿದ್ರೆ
ಕೊಟ್ಟಿರ್ಬೋದು ಹಾಗೆಲ್ಲ ಗೊತ್ತಿಲ್ಲ. Matter was heard.
Please.
When he has engaged the advocate, all the papers including the lower court papers discloses that all the signatures even entrusting the papers to the advocate before this court also belongs to the same. This court can compare the signature under section 73 of the Evidence Act, which clearly discloses. Even if you want a report from the handwriting expert, I will refer the matter to the handwriting expert, and if report comes against your client, criminal case will be registered against him.
I advise them to withdraw that.
ಮತ್ತೆ
They are before the court.
ಮತ್ತೆ
They are before the court, they will withdraw that. They withdraw that application.
ಯಾವ್ದನ್ನ ಈಗ ಹಾಕಿರೋದ್ನ ಇಷ್ಟೆಲ್ಲ ಸರ್ಕಸ್ ಮಾಡಿದ್ರಲ್ಲ 3 ಸರಿ.
ಈಗಲೂ ಅದ್ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ನಾವು ಮಾಡಿಲ್ಲ ಅಂತ. ಅದಕ್ಕೋಸ್ಕರ
ಅದಕ್ಕೆ ಹೇಳ್ತಾರೆ ಈಗ ಅವನಿಗೆ ಹೆದರಿಕೆ ಯಾಕೆ?
ಬೇರೆ ಪೇಪರ್ಸ್ ಏನಾದ್ರು ಇವ್ರಿಗೆ they may be given.
ಅವತ್ತವರೆಗೂ ನಾನು ಹೋಗೇ ಇಲ್ಲ ಅಂತ ಆ ಲಾಯರೇ ಬಂದು ಹೇಳಿದ್ರು, ನಾನೇ ಕರ್ಕೊಂಡು ಹೋಗಿದ್ದೆ ಲಾಯರ್ ಆಫೀಸ್ಗೆ, ಅಲ್ಲೇ ಹೋಗಿ ಪೇಪರ್ಸ್ ಇಂಟ್ರೆಸ್ಟ್ ಮಾಡಿ ಬಂದಿದೀವಿ ಅಂತ.
ಇವ್ರ ಅಪ್ಲಿಕೇಶನ್ ನಾವು ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲೂ ಅದೇ ಹೇಳಿದ್ವಿ.
There must be some limit.
As per their
ಬಿಡಿ, ಈಗಲೂ ಇಂಟ್ರೆಸ್ಟ್ ಮಾಡಿಲ್ಲಲ್ಲ.
GN ಸುರೇಶ್ ಅಂತ
ಹ್ಯಾಂಡ್ರೈಟಿಂಗ್ ಎಕ್ಸ್ಪರ್ಟ್ ಕಳ್ಸೋಣ.
ಸುರೇಶ್ ಅಂತ
ಬರ್ಲಿ, ರಿಪೋರ್ಟ್ ಬರ್ಲಿ.
He was died.
It is nothing but an abuse of court process.
He was died. And he has not
spent time. Almost half an hour every time. ಹೌದಾ?
ಹೌದು.
ಮತ್ತೆ I will permit to withdraw the application with cost.
Withdraw the
cost. Told. ಮಧ್ಯಾಹ್ನ 2:30 I will declare the order. ಕಾಸ್ಟ್ ಹಾಕ್ತೀನಿ 50,000. ಕೋರ್ಟ್ ಟೈಮ್ ವೇಸ್ಟ್ ಮಾಡಿದೆ ನಾನು.
They are not able
We should not indulge in such act. Going to the office of an advocate and entrusting the paper, and advocate comes and argues on behalf of your client. And when this court passes an order on merits on the limitation,
I mentioned in the application they entrusted one another advocate Suresh, GN Suresh. That is the.
ಅದ್ ಹೇಳಿಲ್ಲ, ಇದುವರೆಗೂ ಅದ್ ಹೇಳಿಲ್ಲ. ನಾನು ಯಾರಿಗೂ ಕೊಟ್ಟೇ ಇಲ್ಲ, ಸಿಗ್ನೇಚರ್ ಫೋರ್ಸ್ಡ್ ಎಲ್ಲ ಹಿಂದಿನ ಸರಿ ಎಲ್ಲ ಹೇಳಿರೋದು. ನಾರಾಯಣ ಸ್ವಾಮಿ, I know you from the date of practice. ಹೌದಲ್ಲ?
As per their instruction only, I have filed application.
Don't.
Even lower court I have not conducted. As per their instruction.
ಆಯ್ತು, ಇವನ್ ಬಂದಿಲ್ವಾ? ಸುಳ್ಳು ಹೇಳ್ತಾನಲ್ಲ ನಿಮ್ ಕ್ಲೈಂಟ್. Let him pay cost.
10 ಸಲ 20 ಸಲ ಕೇಳಿದ್ದೀನಿ.
ನೋಡ್ರಿ, ಆಲ್ರೆಡಿ
ಪ್ಲೀಸ್
this court spent time, half an hour, 2 times. Even when he called before the court, and specimen signatures are also taken, and all specimen signatures and signatures signed while entrusting the papers to the advocate also same, and papers signed to you also the same, and lower court records are also now secured, and signatures available in lower court records are also all one and the same. He misled the court and also to you. Let him pay the cost 50,000. I will permit to withdraw the application with a cost of rupees 50,000. Let him pay. Or in case if he fails to pay, it will be recovered. There must be some limit for abuse of court process. ಹೌದಲ್ವಾ?
ಹೌದೌದು.
ಮತ್ತೆ
ಅಗ್ರಿ, ಬಟ್
ಅಲ್ಲ ರೀ, ಫಸ್ಟ್ ಆಫ್ ಆಲ್ ಈಗಲೇ ನೀವು ಒಂದು ಕೇಸ್ ನೋಡಿದ್ರಿ. ಲಾಯರಿಗೆ ಫೀಸ್ ಕೊಡ್ದವ್ರೆ, ಲಾಯರ್ ಯಾರು ಬಂದ್ ಕೋರ್ಟ್ ಮುಂದೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಾರ್ರಿ. ಆನ್ ಬಿಹಾಫ್ ಆಫ್ ಹಿಮ್ he came and argued the matter when the matter was listed for admission. ನಾನೇ 3 ಪೇಜ್ ಬರ್ದಿದ್ದೀನಿ ಆರ್ಡರ್ನ. ಮತ್ತೆ ಆಮೇಲೆ ಬಂದ್ಬಿಟ್ಟು ಇಲ್ಲ ನನ್ ಕೇಸೇ ಕೊಟ್ಟಿಲ್ಲ, ಆ ಲಾಯರೇ ನಂಗೆ ಗೊತ್ತಿಲ್ಲ, ನಾನು ಹೋಗಿಲ್ಲ ಲಾಯರ್ ಆಫೀಸ್ಗೆ ಅಂತ ಅಂದ್ರೆ, ಆ ಲಾಯರ್ ಯಾರು ಕರ್ಕ ಬಂದ್ ಕೇಸ್ ಕೊಡಿಸ್ತಾ ಅವನು ಕೂಡ ಕೋರ್ಟ್ ಬಂದು ಹೇಳ್ತಾರೆ ಕೋರ್ಟ್ ಮುಂದೆ, ಇಲ್ಲ ನಾನೇ ಕರ್ಕ ಬಂದಿದ್ದೆ, ನನ್ ಕಾರ್ಲೆ ಕರ್ಕ ಬಂದಿದ್ದೆ, ಲಾಯರ್ ಆಫೀಸಿಗೆ ಕರ್ಕೋಗಿದ್ದೆ, ಮಾಡಿದೀನಿ ಅಂತೆಲ್ಲ. ಇಷ್ಟೆಲ್ಲ ಆಗಿದೆ, ಇಷ್ಟೆಲ್ಲ ಸರ್ಕಸ್ ಮಾಡಿದೀವಿ ಕೋರ್ಟ್ನವರು.
ಈಗ್ಲೂ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
ಇಲ್ಲ, ಅದನ್ನೇ ಹೇಳಿದ್ನಲ್ರಿ, ಕಳ್ಸೋಣ ಎಲ್ಲಾನು. ನೀವೇ ಹೇಳಿದ್ರಿ ಪೇಪರ್ಸ್ ಹ್ಯಾಂಡ್ ರೈಟಿಂಗ್ ಎಕ್ಸ್ಪರ್ಟ್ ಕಳ್ಸ್ಬೋದು ಅಂತ. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ ತರ್ಸಿದೀವಿ, ಎಲ್ಲಾನು ಕಳ್ಸೋಣ. ಅಲ್ಲ ಅಂತಂದ್ರೆ ಇಟ್ಸ್ ವೆಲ್ ಅಂಡ್ ಗುಡ್. ಐ ವಿಲ್ ಹಿಯರ್ ದಿ ಮ್ಯಾಟರ್ ಆನ್ ಮೆರಿಟ್ಸ್ once again, but if it is signature belongs to him, then it is nothing but an abuse of the court and fraud against the court, and not only against the court, even against the advocate who represented on behalf of him. Let him face the criminal consequences. Howdalla? It should not happen in court. ಈಗ ನೋಡ್ರಿ, ಲಾಯರ್ ಕೇಸ್ ತಂದು ಇಂಟ್ರೆಸ್ಟ್ ಮಾಡಿರ್ತಾರೆ. ಈಗ ಇಂಟಿಗ್ರಿಟಿ ಆಫ್ ಎನ್ ಅಡ್ವೊಕೇಟ್ and also the institution ಮರ್ಯಾದೆ ಪ್ರಶ್ನೆ, ಹೌದಿಲ್ಲ?
ಹೌದು.
ಮತ್ತೆ ಇಟ್ ಇಸ್ ಎ ಸೀರಿಯಸ್ ಮ್ಯಾಟರ್. ಲಾಯರ್ ಓದ್ಕೊಂಡು ಬಂದಿಲ್ಲ, ಅಸಿಸ್ಟ್ ಮಾಡಿ ಕೋರ್ಟ್ಗೆ ನಾನು ಮೆರಿಟ್ ಮೇಲೆ ಕ್ಲಿಯರ್ ಮಾಡಿ 3 ಪೇಜಿನ ಆರ್ಡರ್ ಬರ್ದಿದ್ದೀನಿ, ಆಮೇಲೆ ಬಂದ್ಬಿಟ್ಟು ನಾನು ಕೇಸೇ ಇಂಟ್ರೆಸ್ಟ್ ಮಾಡಿಲ್ಲ ಲಾಯರ್ಗೆ ಅಂತೆಲ್ಲ ಬಂದು ಸುಳ್ಳು ಹೇಳಿರಿ ನಿಮ್ ಕ್ಲೈಂಟ್. ಬೇರೆ ಯಾರಿಗಾರಾಗ್ಲಿ ಒಂದ್ಸರಿ ಒಬ್ಬರು ಲಾಯರಿಗೆ ಬರ್ಕೊಟ್ಟಿದೆ ಅಂತಾನೆ ಎಲ್ಲಾನು ವಕಾಲತ್ತು ಅಫಿಡವಿಟ್ ಎಲ್ಲ ಸೈನ್ ಮಾಡ್ಕೊಟ್ಟಿದ್ದೀನಿ. ಮತ್ತೆ ನಾನು ಮಾಡೇ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಕಳ್ಸರಿ ಸೈನ್ ಡಿನೈ ಮಾಡ್ದೆ, ಅದಕ್ಕೆ ನಾವು ಸ್ಪೆಸಿಮೆನ್ ಸಿಗ್ನೇಚರ್ ತಗೊಂಡೆ ಕೋರ್ಟ್ ಮುಂದೆ ಅಲ್ವಾ? ಮತ್ತೆ ಅದಕ್ಕೆ ನಾನು ಬಿಫೋರ್ ಸೆಂಡಿಂಗ್ ದಿ ರೆಕಾರ್ಡ್ಸ್ ಟು ದಿ ಹ್ಯಾಂಡ್ ರೈಟಿಂಗ್ ಎಕ್ಸ್ಪರ್ಟ್, ಐ ಹ್ಯಾವ್ ಸೆಕ್ಯೂರ್ಡ್ ದಿ ಲೋಯರ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ಸ್ ವೇರ್ ಇನ್ ಹಿ ಹ್ಯಾಡ್ ಫೈಲ್ಡ್ signed ವಕಾಲತ್, also laid the evidence affidavit was filed, he was cross-examined. All material clearly shows that he only made the representation before the trial court and also with the advocate to whom he entrusted the papers. Alva, it should not happen in future. This is in the interest of advocate fraternity and also the court. I will pass an order.
This is the first time in my practice also.
Practice.
I never come across.
I also know you from last 30 years. Then madam, nim client nimge mislead madam. Let him pay. Let him pay.
ಶಕ್ತಿ ಇಲ್ಲ ಅವ್ರು.
ಶಕ್ತಿ ಇಲ್ಲ ಅಂದ್ರೆ ಏನ್ ಮಾಡೋದು?
ಪೂಜೆ
ಶಕ್ತಿ ಇಲ್ಲದ ಹೊರ ಈ ಕೆಲಸ ಎಲ್ಲ ಮಾಡಕ್ ನಿಂತ್ಕೋಬಾರ್ದು, ಬರ್ಬಾರ್ದು ಕೋರ್ಟಿಗೆ. ಲಾಯರ್ ಹತ್ರ ಹೋಗ್ಬಿಟ್ಟು ಸುಳ್ಳು ಹೇಳೋದು ಇವೆಲ್ಲ ಮಾಡ್ಕೊಡ್ದು. ಬಡವ ನೀ ಮಡಗ್ದಂಗೆ ಇರುವಂತ ಒಂದು ಗಾದೆ ಇದೆ, ಹೌದಲ್ಲ? ಮತ್ತೆ ಏನಾಗ್ಬಿಟ್ಟಿದೆ ಈಗೆಲ್ಲ ಬಿಟ್ಟು ಹಿಂಗೆ ಎಲ್ಲಾರನ್ನು ಬಿಟ್ಟು ದಿನ ಎದ್ರೆ ಬೆಳಗ್ಗೆ ಇದೆ ಫೋರ್ಜರಿ ಇಂಥದ್ದು. ಫೋರ್ಜರಿ ಮಾಡ್ರು, ಅಲ್ಲಿ ಮಾಡ್ರ್ ಆಗ್ತವೆ, ಇಲ್ಲಿ ಬಿಲ್ ಸಿಗ್ತವೆ. ಏನ್ ಮಾಡ್ತೀರಿ? ಆಮೇಲೆ ಕಾಸಿದ್ದವ್ರಿಗೆಲ್ಲ ಕ್ವಾಶ್ ಆಗ್ತದೆ. With pain I am telling this. ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ? ಕಾಸಿದ್ದವನಿಗೆ ನ್ಯಾಯ, ಕಾಸಿಲ್ದವನಿಗೆ ನ್ಯಾಯ ಇಲ್ಲ ಕೋರ್ಟಲ್ಲಿ. ಏನ್ ಮಾಡೋದು? Let him feel the pinch of it. He should not do in future. I will impose cost. ನಾನು 1 ಲಕ್ಷ ಹಾಕಲ್ಲ, ಅವ್ನು ನೋಡಿದ ತಕ್ಷಣ ಗೊತ್ತಾಯ್ತು ಕಡಿಮೆ ಹಾಕೋಣ ಅಂತ, 50,000. ಗೊತ್ತಾಗಬೇಕು ಅವನಿಗೆ ನಾನು ಮಾಡಿದ ತಪ್ಪು ಅನ್ನೋದು ಹೆಂಗಾರು ಗೊತ್ತಾಗಬೇಕಲ್ವಾ? ಆಯ್ತು, ಇನ್ನೇನ್ ಮಾಡೋದು? ಅವ್ನು ನೋಡು, ಒಂದು 25 ಇಳಿಸ್ತೀನಿ.
ಪ್ಲೀಸ್
ಕಟ್ಟಿಸ್ಬೇಕು. ಯಾವಾಗ ಕಟ್ಟಿಸ್ತೀರಿ?
ಒಂದು ತಿಂಗಳ ಟೈಮ್, 30 ಡೇಸ್.
30 ಡೇಸ್
ವ್ಯವಸ್ಥೆ ಮಾಡಿ.
ಲಾಯರ್ ಫೀಸ್ ಕೊಡ್ತಾನೆ, ಇನ್ನೊಬ್ರು ಲಾಯರ್ನ ಇಟ್ಕೋತಾನೆ, 2 ಲಾಯರ್ ಇಟ್ಕೋತಾನೆ. RSA ನಲ್ಲಿ
ಒಬ್ಬರನ್ನೇ ಇಟ್ಟಿರೋದು,
ಒಬ್ಬರನ್ನಿಲ್ಲ, 2 ಇಟ್ಕೊಂಡಿದ್ದಾರೆ. ಅದಾಯ್ತು. ಅಂತದ್ದೆಲ್ಲ ಆದ್ರೆ MEC ಕೇಸ್ ಆದ್ರೆ ಆಯ್ತು, ಹೋದ್ರು ಅಲ್ಲೇನು ತಗೊಂಡ್ ಬಂದ್ರು ಸಿಗ್ನೇಚರ್ ಅಂದ್ರೆ ಓಕೆ. ಅದಲ್ಲ ಇದು. RSA ನಲ್ಲಿ 2ನೇ ಅಪೀಲು, 3ನೇ ಕೋರ್ಟು. ಫಸ್ಟ್ ಕೋರ್ಟು ಬೇಡ, ಸೆಕೆಂಡ್ ಕೋರ್ಟು ಬೇಡ, 3ನೇ ಕೋರ್ಟಿಗೆ ಪೇಪರ್ಸ್ ಎಲ್ಲ ಸೈನ್ ಮಾಡಿ ಕೊಟ್ಬಿಟ್ಟು ಅಪೀಲ್ ಹಾಕ್ಸ್ಬಿಟ್ಟು ಈಗ ಬಂದ್ಬಿಟ್ಟು ಇಲ್ಲ ನಾನು ಇಂಟ್ರೆಸ್ಟೇ ಮಾಡಿಲ್ಲ ಪೇಪರ್ಸ್ ಅಂತ ಅಂದ್ರೆ
ಇವ್ರಿಗೆ ಬೆಂಗಳೂರಿಗೆ ಬರೋಕು ಗೊತ್ತಾಗೋದಿಲ್ಲ, ಅಲ್ಲೇ ಪೇಪರ್ಸ್ ಕೊಟ್ಟಿರೋದು.
ಸರ್ ಏನ್ ಮಾಡೋದ್ರಿ? ಕೊಟ್ಟ ಮೇಲೆ ಸುಮ್ಮನೆ ಇರ್ಬೇಕು. ಇಲ್ಲ ನಾನು ಸೈನ್ ಮಾಡಿ ಕೊಟ್ಟಿದ್ದೀನಿ, ಆಗಿದೆ, ನಾವು ಕನ್ಸಿಡರ್ ಮಾಡಿದೀವಿ ಅಲ್ವಾ, ಆರ್ಡರ್ ಮಾಡಿದೀವಿ. ನಾನೇನ್ ಒನ್ಲೈನ್ ಆರ್ಡರ್ ಬರ್ದಿಲ್ಲ,
ಡೀಟೇಲ್ ಆರ್ಡರ್ ಇದೆ.
ಮತ್ತೆ ಕೋರ್ಟ್ ಟೈಮ್ ವೇಸ್ಟ್ ಅದಕ್ಕೊಂದ್ಸಾರಿ. ಆಮೇಲೆ 2-3 ಸಲ ಅವ್ನು ಬಂದಾಗ ನಾನು ಡಿನೈ ಮಾಡಿದಾಗ ಎಲ್ಲ ತರಿಸಿ ಪೇಪರ್ಸ್ನೆಲ್ಲ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದೀವಿ ಅಲ್ವಾ? ಪ್ರೀಸಿಯಸ್ ಟೈಮ್ ಆಫ್ ದಿ ಕೋರ್ಟ್. ಲೆಟ್ ಹಿಮ್ ಫೀಲ್ ದಿ ಪಿಂಚ್ ಆಫ್ ಇಟ್. ಹಂಗೆ ಬಿಟ್ಬಿಟ್ರೆ ಏನಾಗುತ್ತೆ? ಇದು ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ. ಇಂಥವ್ರ ಸಂಖ್ಯೆ ಜಾಸ್ತಿ ಆಗ್ತದೆ. ಹಂಗ್ ಮಾಡಕ್ ಆಗಲ್ಲ. ಐ ವಿಲ್ ನಾಟ್ ಲೀವ್ ಸಚ್ ಪೀಪಲ್. ಬೇರೆ ಎಲ್ಲೆಲ್ಲ ಏನಾಗುತ್ತೆ ನಂಗೆ ಗೊತ್ತಿಲ್ಲ, ಬಟ್ ಐ ವಿಲ್ ನಾಟ್. ಆಯ್ತು, ಮಧ್ಯಾಹ್ನ ವಿಲ್ ಪಾಸ್ ಆರ್ಡರ್ಸ್. 30 ದಿವಸ ಕೊಡಲ್ಲ, 2 ವಾರ ಟೈಮ್ ಕೊಡ್ತೀನಿ. ಇಲ್ಲ ಅಂದ್ರೆ ಕಟ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಮತ್ತೆ ಹೇಳ್ಕೊ ಬರ್ತಾರೆ. ಹೋಗಿ ಅವ್ನಿಗೆ ಹೇಳ್ಬಿಡಿ, ಫಸ್ಟ್ ಮಾಡಿದ ತಪ್ಪು, ನೀವ್ ಮಾಡಿದ ತಪ್ಪಿಗೆ ಇಷ್ಟು ದಂಡ ಕಟ್ಬೇಕು ಅಂತ ಹೇಳ್ಬಿಡಿ. ಅವ್ನಿಗೆ ಹೇಳ್ಬಿಡಿ ಫಸ್ಟ್, ಆಯ್ತಾ? ಐ ವಿಲ್ ಪಾಸ್ ಆರ್ಡರ್ಸ್ ಅಟ್ 2:30.
ನನ್ಗೂ ಬೆಳಿಗ್ಗೆ ನಾನು ಅರ್ಜೆಂಟ್ 438 ಏನು ಕೇಳಿಲ್ಲ. ಸಕ್ಸೆಸಿವ್ ನಿಜ, ಆದ್ರೆ 482 ಅದ್ ಮಾತ್ರ ಬರುತ್ತೆ. ಇದು ಬರಲ್ಲ.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್, ಯಾರು ಇದೇ ಇಲ್ಲಲ್ಲಪ್ಪ.
ಹೇಳಿ ಸರ್.
ಮೇಡಮ್ ಇದು 230 ಮ್ಯಾಟರ್ ಕ್ರಿಮಿನಲ್ ಪಿಟಿಷನ್ಸ್ ಕರಿತೀರಾ? 53 ಸೀರಿಯಲ್
ಹೌದು,
ನಂಬರ್.
ಕರಿತೀವಿ.
ಓಕೆ ಓಕೆ.
ಓಕೆ. ಏನ್ ಮೆನು ಹಾಕ್ತಿದ್ದೀರಾ?
ಮೇಡಮ್ ಕ್ರಿಮಿನಲ್ ಹಿಂಗೆ ತಿಳಿಸ್ದಂಗೆಲ್ಲ ಮಧ್ಯಾಹ್ನ ಕ್ರಿಮಿನಲ್ ಮ್ಯಾಟರ್ಸ್ ಅಲ್ವಾ?
ಏನು ಮೆಮೊ ಇಲ್ವಾ ನಮ್ಮಲ್ಲಿ?
180 ಮೆಮೊ
ಇಲ್ಲ. ಹೌದು.
ಬೇರೆ ಸಿಸ್ಟರ್ಸ್ಗೆ ಅಮ್ಮ ಪ್ಲೇಂಟಿಫ್ಗೆ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಾಗಿದೆ. ಬೇರೆಯವ್ರೇನೋ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅವ್ರಿಗೆ ಏನು ಡಾಕ್ಯುಮೆಂಟ್ ಅಮ್ಮ ಕೈಯಲ್ಲಿ ಏನು ಡಾಕ್ಯುಮೆಂಟ್ ಡಿಸ್ಕ್ರಿಪ್ಷನ್ ಅದನ್ನ ಯಾರಾದ್ರು ಡಾಕ್ಯುಮೆಂಟ್ ಏನು ಕೊಟ್ಟು ಡಾಕ್ಯುಮೆಂಟ್ ಅದು ಇದನ್ನು ಒಂದು ಶೆಡ್ಯೂಲ್ ನೀಟಾಗಿ ಟೇಬಲ್ ಮಾಡಿ ಕೊಡ್ತಾ ಇದ್ದೀವಿ. ಅವನು ಕರ್ಕೊಂಡ್ಬರ್ಬೇಕು, ಅವನ್ನ ಎಷ್ಟು ಕಟ್ಟಬೇಕು ನೋಡಿ, ಹಂಗೂ ಸೇರಿ ಅದಕ್ಕೋಸ್ಕರ ಇದೆಲ್ಲ.
ಈಗ ನಾವು ನಮ್ಮ ಪಂಚಾಯತ್ ಹೊಸ ಒಂದು ಸೊಸೈಟಿ ಫಾರ್ಮ್ ಮಾಡಿ ಎಲ್ಲ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾ
ಇಲ್ಲ ಸರ್ ಅಷ್ಟು ಬಂದಿಲ್ಲ ಸರ್ ಇದು ರಿಟರ್ನ್ ಆಗಿದೆ ಅಲ್ಲ
ಹೈಕೋರ್ಟ್ ಕಳಿಸಿ ಹೈಕೋರ್ಟ್ ಕಳಿಸಿ ಪೇಮೆಂಟ್ ಅವ್ರ ಹತ್ರ ಕಾಪಿ ತಗೊಳ್ಳಿ ಅಂತ ಆಮೇಲೆ ಈ ಪ್ರಕಾರ Sir, one ನಿಮಿಷ ಇರಿ. ಒಂದು ನಿಮಿಷ ಇರಿ. ನಾನು ಕಳಿಸ್ತೀನಿ. ನಂಬರ್ ಕಳಿಸ್ತೀನಿ. ಅಡ್ರೆಸ್ ಕೊಡಿ, ಅಡ್ರೆಸ್ಗೆ ಯಾರು ನಿಮ್ಮ ಹೆಸರು ಕಳಿಸ್ತೀನಿ, ನಂಬರ್ ಕಳಿಸ್ತೀನಿ.
ನಂಗೆ ನಿಮ್ಗೆ ಟೆನ್ಷನ್. ಈಗ ಖಾತೆ ಏನಾದ್ರು ಆಗಿದೆಯಾ? ಅಗ್ರಿಮೆಂಟ್ ಆದ್ರೆ ಈಗ ಹಾಕ್ಬೇಕು ಅಂದ್ರೆ ಅಗ್ರಿಮೆಂಟ್ ಆದ್ರೆ ಅಡ್ವರ್ಸ್ ಪೊಸಿಷನ್ ಅಡ್ವರ್ಸ್ ಪೊಸಿಷನ್ ಯಾವಾಗ ಹಾಕಿದ್ರು ಅಂದ್ರೆ ಅಗ್ರಿಮೆಂಟ್ ಅದ್ರ ಪ್ರಕಾರ ಖಾತೆ I prefer civil court, high court. So much advantage. Original documents ಎಲ್ಲ ತೆಗೆದು ಇದು ಸಂಬಂಧಪಟ್ಟಿದ್ದು ನೀವು ಕಂದಾಗೆಲ್ಲ ನಾನು ಕಟ್ಕೊಂಡು ಬಂದಿದ್ದೀನಿ. ಈಗ ಅನ್ಕಂಟ್ರೋಲ್ ಒಂದ್ಸಲ ಡಿಕ್ಲೇರ್ ಏನು ವಾಪಸ್ ಬರುತ್ತೆ. ಇದು ನಾನೇ back that I have got the documents. I have got the right Injection of plant RFI ಇನ್ನೂ 10 ವರ್ಷದಿಂದ ಪೆಂಡಿಂಗ್ ಇದೆ. ಏನ್ ಮಾಡ್ಬೇಕು? ರಿಜೆಕ್ಷನ್ ಆಫ್ ಪ್ಲಾಂಟ್ ಮೇಲೆ ಮಾಡ್ಬೇಕು. ಡಿಮ್ಯಾಂಡ್ ಅಲ್ಲ ಏನು ಮಾಡಿ ಇಲ್ಲಿ ಡಿಗ್ರಿ ಕೊಡಕ್ಕಾಗತ್ತಾ? ಎವಿಡೆನ್ಸ್ ಆಗ್ಬೇಕು. ಡಿಮ್ಯಾಂಡ್ ಆಗಿದ್ದರೆ ಕೇಸ್ ಗೆದ್ದೆ ಅಂತ ಅರ್ಧ ಕೇಸ್ ಗೆದ್ದೆ. ಮಾಡಿ ಮುಗಿಸ್ತಾರೆ ವಾಪಸ್ ಕಳಿಸ್ತಾರೆ. See, ವೈಟ್ ಆಗಿಲ್ಲ ಮಾಡಿ ಬಟ್ ಏನಿದೆ ಗೊತ್ತಾ, ಮೂವ್ ಮಾಡಿದ್ರೆ 4 ರೆಡಿ ಮಾಡಿಸಿ ಬದಲೇ ರೈಟ್ ಸರ್ ಫೈನ್.
ಹೇಳಿ. 20. ಮೇಡಮ್ ಏನು ಯಾವ ಸ್ಟೇಜ್ ಇದೆ ಮೆಮೋ ಮಾಡಿ ಅಷ್ಟೇ, ಯಾಕಂದ್ರೆ ಓಲ್ಡೆಸ್ಟ್ ಇಂದ ಹಾಕಕ್ ಹೇಳಿದ್ದಾರೆ. ಹೇಳಿ.
ಸೀರಿಯಲ್ ನಂಬರ್ 60 and 61 ಬರೀ ನೋಟಿಸ್ ಮಾಡ್ತಾರೆ ಅಷ್ಟೇ ಅಲ್ಲ, ಕೇರ್ ಮಾಡ್ತಾರೆ.
ನಂಗೆ ಗೊತ್ತಿಲ್ಲ ಮೇಡಮ್.
ಆರ್ಡರ್ಸ್ ಅಲ್ವಾ ಅಂದಿರೋದು?
ಆರ್ಡರ್ಸ್
ಅಲ್ವಾ? 230 ಮ್ಯಾಟ್ರಿಕ್ಸ್ ನೋಡಿ.
230ನಾ? ನೀವು ಗೌರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟಾ?
ಹಾ.
ಏನ್ ಹೆಸರು?
ಅನಿತಾ ಗಿರೀಶ್.
ಏನ್?
ಅನಿತಾ ಗಿರೀಶ್.
ಅನಿತಾ
ಗಿರೀಶ್.
HGP ನಾ? ಗೊತ್ತಿಲ್ಲ ಮೇಡಮ್. ಬೆಳಿಗ್ಗೆ ಇಲ್ಲಿ ಬಂದಿದ್ರು. ಹೇಳಿ. ಅದೇನಿಲ್ಲ, ಇಲ್ಲಿಗೆ ಬರ್ಬೇಕು ಅಂತ ಅಷ್ಟೇ. ಸಕ್ಸಸಿವ್ ಅಂತ.
ಲಾಸ್ಟ್ ಡೇಟ್ 29th ಅಂತ ಇದೆಯಾ 30th ಅಂತ ಇದೆಯಾ ನೋಡಿ ಒಂದ್ಸಲ
ಯಾವ್ದು
ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಇದು 65ನೇ ಮ್ಯಾಟ್ರು.
ಅದಕ್ಕೆ ಇವತ್ತಿಗೆ ಬಂದಿರೋದು. ಇವತ್ತು ಟ್ವೆಂಟಿ-9th ಅಂತಾನೆ ಇದೆ.
ಕ್ರಿಮಿನಲ್ ಮ್ಯಾಟರ್ಸ್ ಇರಬೇಕಲ್ಲ.
230 matters at 230, orders matter 60. Pinaketiyam.
60. Office subjections along with counsel.
Your Lordship, that is only with respect to the order sheet, Your Lordship. Some of the typed, they sought for the typed copy.
ಏನದು ಮ್ಯಾನ್ಸ್ಕ್ರಿಪ್ಟ್ ಓದ ರೀಸನ್
ಆರ್ಡರ್ ಶೀಟ್ ನ ಕೆಲವು ಡೇಟ್ಸ್ ನ
ರೀಡಬಲ್ ಇದೆಯಾ? ರೀಡಬಲ್ ಇದೆಯಾ?
ರೀಡಬಲ್ ಇದೆ.
ಎಲ್ಲಿದೆ ನೀವು ಹಾಕಿರೋದು? ಎಲ್ಲಿದೆ ಹೇಳಿ ತೋರಿಸಿ. ನೀವು ಅದು ರಿಲೇ ಮಾಡ್ತೀರಾ?
ಇಲ್ಲ, ಸೈಡ್ ಇಂದು ಆಫೀಸ್ ನೋಟ್ ಮಾತ್ರ. ಅದು ಕೋರ್ಟ್ ಇಂದೆಲ್ಲ ಟೈಪ್ ಮಾಡಿದ್ದಾರೆ. ವಿತ್ ರೆಸ್ಪೆಕ್ಟ್ ಟು ಜಸ್ಟ್ ಆಫೀಸ್ ನೋಟ್ಸ್ ಮಾತ್ರ ಕೈಯಲ್ಲಿ ಬರ್ಕೊಂಡು ಹೋಗಿದ್ದಾರೆ.
ಆಫೀಸ್ ನೋಟ್ಸ್,
ಆಫೀಸ್
ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲ. ಎಲ್ಲಿದೆ ಅದು ಆರ್ಡರ್ ಶೀಟ್?
ಲಾಸ್ಟ್ ಅಲ್ಲಿ
ಟೈಪ್ಡ್ ಕಾಪಿ ಇದೆಯಲ್ಲ,
ಪೇಜ್ 98.
ಓನ್ಲಿ ಆರ್ಡರ್ ಶೀಟ್ ಟೈಪ್ ಆಗಿದೆಯಲ್ಲ?
ಹಾ,
ಆರ್ಡರ್ ಶೀಟ್ ಟೈಪ್ ಆಗಿದೆ.
ಹೌದು, ಚಾರ್ಜ್ ಶೀಟ್ ಚಾಲೆಂಜ್ ಮಾಡಿ.
ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಷನ್ ಇಸ್ ಅಕ್ಸೆಪ್ಟೆಡ್. ಏನಿದು ಫ್ರೆಶ್ ಏನು ಹೊಸದಾಗಿ?
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್. ಓನ್ಲಿ ಥಿಂಗ್ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್.
ನೀವು ಏನು ಮೇಡಮ್, ವಾಟ್ ಇಸ್ ಯುವರ್ ಡೆಸಿಗ್ನೇಷನ್?
SCGP ಮ್ಯಾಮ್.
SCGP.
ಪ್ಲೀಸ್ ಮ್ಯಾಮ್.
SCGP is directed to take notice. ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಬೇರೆಯವರು ಯಾರು ಇದಾರಾ? ಅದರ್ ದನ್
ಪ್ರೈವೇಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್, ಕಂಪ್ಲೇನೆಂಟ್ ಒಬ್ರು ಇದ್ದಾರೆ.
ಕಂಪ್ಲೇನೆಂಟ್ ಇದ್ದಾರೆ, ನೋಟಿಸ್ ಹೋಗಬೇಕು.
ನೋಟಿಸ್ ಹೋಗಿ ಬರಬೇಕು.
ನೋಟಿಸ್ against respondent number 2
and hand summons ಕೊಟ್ಟು next week, because in this matter
the petitioner counsel is permitted to take out the hand summons on the respondent number 2.
Any
and
date?
the HCGP is also directed to serve the notice on respondent number 2 through IO.
Please
IO.
please.
ಎರಡು ವಾರ ಬಿಟ್ಕೊಡಿ, ಇವತ್ತಿಗೆ 15 ದಿವಸ.
any day
12/11.
12.
61 Tigdi Veerana.
For the petition.
Office subjection along with counsel ಏನಿದೆ?
Page number 104 ಅಲ್ಲಿ ನೋಡ, ಅದು ಕಾಪಿ ಲೆಜಿಬಲ್ ಇಲ್ಲ ಅಂತ, ಬಟ್ ಅದು ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಅಪ್ಲೈ ಮಾಡುವಾಗ ಅದೇ ತರ ಕೊಟ್ಟಿದ್ದಾರೆ ಅವರು.
ಪೇಜ್ ನಂಬರ್ 104.
ಪೇಜ್ 104 ಮಿನಿಟ್ಸ್. ಅದು ಕಸ್ಟಮರ್ ಫೀಡ್ಬ್ಯಾಕ್ ಫಾರ್ಮ್ ಅಂತ ಇದೆ, ಇದ್ರ ನಾವೇನ್ ರಿಲೈ ಆಗ್ತಾ ಇಲ್ಲ.
ಬಟ್ ಅದೇನ್ ಕಾಣದೇ ಇಲ್ವಾ?
ಅದು ಕಾಣ್ತಾ, ಅದು ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ
ನಾವೇನ್ ಓದ್ಬೇಕು ಹೇಳಿ?
ಅಲ್ಲ, ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಕೊಟ್ಟಿರೋದು ಅವ್ರು ಅದೇ ತರ ಇದೆ.
ಅಟ್ಲೀಸ್ಟ್ ನೀವು ಟೈಪ್ ಮಾಡ್ಯಾರ ತಗೋ ಮಾಡ್ಬೇಕು. ಏನ್ ರಿಲೇ ಮಾಡ್ತೀರಾ? ಏನಿದು ಡಾಕ್ಯುಮೆಂಟ್?
ನಮಗೂ ಕಾಣಿಸ್ತಾ ಇಲ್ಲ ಸ್ವಾಮಿ. ಟೈಪ್
ಏನೋ ಗವರ್ನಮೆಂಟ್ ಆಫ್ ಕರ್ನಾಟಕ ಅಂತ ಏನೋ ಇದೆ
ಮಾತ್ರ ಕಾಣಿಸ್ತಿದೆ.
ನೀವು ಟೈಪ್ ಮಾಡಾಕ್ಬೇಕಿಲ್ಲ ಅಂದ್ರೆ ಏನದು ಓನ್ಲಿ ವೆದರ್ ಯು ಆರ್ ಗೋಯಿಂಗ್ ಟು ರಿಲೇ ಅಪಾನ್.
ಇದು ಕಸ್ಟಮರ್ ಫೀಡ್ಬ್ಯಾಕ್ ಫಾರಂ ಅಂತ ಅಷ್ಟೇ ಇದು, ಹಾಗಾಗಿ ಇದ್ರ ಮೇಲೆ ನಾವು ರಿಲೇ.
ಫೀಡ್ಬ್ಯಾಕ್ ಫಾರಂ ನ ನೀವು ರಿಲೇ ಮಾಡ್ತೀರಾ?
ಇಲ್ಲ ಇಲ್ಲ,
ಇಲ್ವಾ? ರಿಲೇ ಮಾಡಲ್ವಾ? ತೋಡ್ petitioner counsel submit that not going to rely upon the document at page number 104 at the time of addressing the argument, and hence office objection and hence counsel submission is accepted. First time HCGP is directed to take notice. Idrilla respondents idara?
Respondent idara
and issue notice against respondent number 2
R2.
De facto complaint.
R1 is there, sorry.
HCGP is also directed to serve the copy of this. HCGP R2 na SPP for R1 ಅಂತಿದೆ. ಇಲ್ಲ ಮೇಡಮ್, ಇಲ್ಲ ನೋಡಿ ಎಷ್ಟು. R2 is HCGP na. HCGP is directed to take notice for R2 and issue notice against R1 through IO. Petitioner counsel is directed to serve one more copy on the HCGP to serve the same on the R1 through IO. Aita? List this matter on 12/11. ಏನಾಯ್ತು? ಹಾ. ಯಾರು ಅವ್ರ ಮುಂದೆನೆ ಆಯ್ತು. ಹಂಗಲ್ಲ, ನಾವು ಹಿಂದೆನೋ ರಿಜೆಕ್ಟ್ ಮಾಡಿದೀವ. ಯಾವಾಗ? ಹಾ. 438 ಆದ್ರು ನಾವು ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ರೆ ಬೇರೆ ಮುಂದೆ ಹೋಗಿ. ಹ್ಮ್. February 25. ಆಯ್ತು. 62.
Admission matter 62. Manjunath ಎಂಬ.
Successive petition milord. Appellate is account number 3 milord.
R2 is served.
ಹಾ ಸರ್ವ್ ಆಗಿದೆ.
ಹೇಳಿ ಏನು?
Actually milord, your lordship application of subject appeal was dismissed. On the ground that milord, the petitioner is the prime accused. He was taken superior. In the present case milord, the accused 1 to 6 milord. Except this appellant milord, all the accused are already enrolled on bail. Now milord, he is in custody milord 1 year 3 months. 302 ಇದೆ. ಇವನು ಸುಪಾರಿ ತಗೊಂಡಿದ್ದ ಅಂತ ಇವನು ರಿಜೆಕ್ಟೆಡ್ ಬೈ
ಸುಪಾರಿ ಕಿಲ್ಲರ್.
ಹಾ, ಇವನು ತಗೊಂಡಿದ್ದ ಇವನೇ ತಗೊಂಡಿದ್ದ ಅಂತ ಇವನು ರಿಜೆಕ್ಟ್ ಆಗಿತ್ತು.
ಮಾಡಿದವನ ಯಾರು?
ಮಾಡಿದವರು ಅಕ್ಯೂಟ್ ನಂಬರ್
No test certification period. Having got the Lieutenant Counsel for the appellant and Lieutenant Government Leader appearing to the respondent state and also taking note of the case of prosecutor is created.
A 1 and 2 made conspiracy milord 4 3 to 6 assaulted by iron rod.
ಹೇಳಿ. Para 7.
Para 7.
Hmm.
Let's clearly observed, but my humble submission of present petition, my lord. The present case, other accused was not attending regularly, my lord. Other accused some paid discharge application. Now 1 year 3 months charge not yet framed, my lord. Is in custody. Even assailant co-accused also enrolled in bail. They are out of court but not attending. Accused number 1 filed discharge application, my lord. Charge also not framed. Since 1 year 3 months is in custody, my lord. Only on based on voluntary statement, my lord. Yes, custody, my lord.
Not on voluntary statement. Recovery is
Recovery is
also
also there, my lord. Joint recovery, my
That's
lord.
what this court also discussed in
Discussed,
detail
my lord.
while rejecting the application.
Now, my lord.
And apart from that, he is the conspirator and he led all the accused persons to eliminate the deceased.
Everything is.
Everything is considered by this court while rejecting the same.
Now, my lord, in the present
Then
appeal,
what is the change circumstance?
1 year 3 months,
Only
my lord.
is in custody from last 1 year 3 months.
3 months, my lord, but the trial court not yet payment charge, my lord. ಹಿಂಗೆ ಹೋಗ್ತಲೇ ಇದೆ. ಹಾಗಾಗಿ
ಯಾವ ಊರಿನಲ್ಲಿ ಇರೋದು ಕೇಸ್?
ಇಲ್ಲೇ ಬೆಂಗಳೂರು ರೂರಲ್.
ಬೆಂಗಳೂರು ರೂರಲ್ ಎಷ್ಟಿದೆ ಕೇಸು? ಆ ಕೋರ್ಟಲ್ಲಿ ಎಷ್ಟಿದೆ ರೀ ಕೇಸು?
ತುಂಬಾ ಇದೆ.
302 ಗೆಸ್ಟ್ ಪನಿಷ್ಮೆಂಟ್
ಲೈಫ್
1 year 3 months is ಮತ್ತೆ
Mallards, there is serious allegation against the petitioner here in Mallards. Mallards, the column 17 Mallards clearly states about Mallards the involvement and the participation of this petitioner Mallards. And Mallards, from bottom to third line, Mallards, Naveen Kumar ಕಾರನ್ನು ಹತ್ತಲು ಡೋರ್ ತೆಗೆಯುತ್ತಿದ್ದಾಗ A3 this petitioner Mallards. A4 ಮತ್ತು A5 ಮತ್ತು 6 ಆರೋಪಿಗಳು ತಮ್ಮ ಕಾರಿನಲ್ಲಿ ಇಟ್ಟಿದ್ದ ಕಬ್ಬಿಣ ರಾಡುಗಳನ್ನು ತೆಗೆದುಕೊಂಡು ಒಂದು ನವೀನ್ ಮಾರ್ಗ 4 ಜನರು ಸೇರಿ ತಲೆಗೆ ಎಡಭಾಗಕ್ಕೆ ಬಲಭಾಗಕ್ಕೆ ಎಡಕಿವಿಗೆ ಎದೆ ಮೇಲೆ ಮಾರಣಾಂತಕವಾಗಿ ಹಲ್ಲೆ ಮಾಡಿದ್ದು ತೀವ್ರವಾಗಿ ರಕ್ತಗಾಯಗೊಂಡಿದ್ದು ನವೀನ್ ಕುಸಿದು ಬಿದ್ದು ಸ್ಥಳದಲ್ಲೇ ಮೃತಪಟ್ಟಿರುತ್ತಾರೆ. So due to his hazard, my lords, it clearly shows that my lords his participation and due to that assault, my lords, he leads to death of the deceased, my lords.
W1 complaint is only eyewitness, my lord, but yes, I have identified the kid in the police station, my lord.
He has committed the
eyewitness. He identified the kid in police station, but incident taken place 4 AM, my lord. He stated in the vehicle light ಬೆಳಕಲ್ಲಿ ನಾನು ನೋಡಿದೆ ಅಂತ stated.
So
specific court action.
Heard the petitioner counsel and also the counsel appearing for the state. This bail petition is a successive bail petition filed by the accused number 3, and earlier also this court considered the bail petition of this petitioner with order dated 17th day of April 2025 in criminal appeal number 530 of 2025. And while rejecting the earlier bail petition, this court taken note of the role played by this court and also made an observation that this petitioner is the architect of the crime in committing the murder by taking supari and eliminated the deceased, and also taken note of in paragraph number 7 that this appellant conspired with accused number 1 and 2, and thereafter he only took the accused number 4 to 6 along with him in order to implement the conspiracy and inflicted the injury to the deceased with iron rod. There was a recovery at the instance of this appellant, though it may be a joint recovery at the instance of other accused persons. And question of fairity doesn't arise as held in the judgment of the apex court in a case of Ramesh Bhavan Rathod versus Vishan Bai Hirabai Makwana within bracket Kohli and another, reported in 2021 within bracket 6 SEC 230, wherein held that while invoking the principles of parity, the court has to take note of the work act of each of the accused. Now the counsel appearing for the petitioner would vehemently contend that in view of the other accused persons have been enlarged on bail, and also one of the accused filed an application for discharge and the same is pending for consideration, and charge is also not framed, And counsel also would submit that he is in custody from last 1 year, 3 months. And hence he may be enlarged on bail. Per contra, the counsel appearing for the state would submit that this court, while rejecting the bail petition, in detail taken note of the material against this petitioner, and further observation is made that he is not entitled for bail on the ground of parity in view of the discussion made in the judgment of the apex court, and not made out any change circumstances to enlarge him on bail. Having considered the fresh ground urged before this court, and also considering the vote act and also the role of this petitioner, and merely because the petitioner is in custody from 1 year, 3 months is not the ground to enlarge him on bail. No doubt counsel would submit that charge is not framed. And also the very counsel submits that one of the accused filed an application for discharge, and the same yet to be considered. And when the heinous offense of 302 is invoked, and this petitioner is also a supari killer, and he took the other accused persons along with him to eliminate the victim, and when the recovery is made at the instance of this petitioner, and also the CW1 is the eyewitness to the incident, I do not find any ground to enlarge him on bail, and no change circumstances is made out in view of the discussion made earlier in paragraph number 6 and 7 of the order passed earlier, and hence bail petition is rejected.
The parity my lord, material witness approach this on. Material witness CW1 my lord. Parity mechanism.
Yen parity?
Approach on material witness my lord.
Parity no ಬರಲ್ಲ ಅಂತಲೇ ಆರ್ಡರ್ ಬರ್ದಿರೋದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ರೆಫರ್ ಮಾಡಿ.
Material witness ಅನ್ನೋದು.
ಮೆಟೀರಿಯಲ್ ವಿಟ್ನೆಸ್ ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ಮೇಲೆ ಬರ್ಬೇಕು ಅಂತಾನಾ? ಬನ್ನಿ, ಅದಕ್ಕೆ ನೀವೇನು ಲಿಬರ್ಟಿ ಅಂತ ತಗೊಳ್ಳೋ ಅವಶ್ಯಕತೆ ಇಲ್ಲ. ಬನ್ನಿ, ಅವ್ರು ಏನ್ ಸಪೋರ್ಟ್ ಮಾಡ್ತಾರೋ ಇಲ್ವೋ ನೋಡ್ಕೊಂಡು ಬನ್ನಿ.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅನ್ನು ಡಿಸ್ಪೋಸ್ ಆಫ್ PD ಟ್ರಯಲ್ ಅನ್ನು.
ಸ್ಪೀಡಿ ಟ್ರಯಲ್ ಅಲ್ಲಿ ಎಷ್ಟಿದೆ ಕೇಸ್ ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅದು ರೂರಲ್ ಕೋರ್ಟ್ ಬೆಂಗಳೂರಲ್ಲಿ. The trial court is directed to dispose of the matter expeditiously.
Please.
63 Marilinge-Gowda.
Senior is suffering from fever, my lord. Kindly have it on any other day. I kindly have it on any other day, my lord. Senior is suffering from fever.
ಮತ್ತೆ ಯಾಕೆ ಮೂವ್ ಮಾಡಿದ್ರಿ ಇದನ್ನ?
No, my lord, this is not a court. Court move ಮಾಡಿಲ್ಲ.
ಮೂವ್ ಮಾಡಿಲ್ವಾ?
ಇಲ್ಲ, please.
ಮತ್ತೆ ಯಾಕೆ ಲಿಸ್ಟ್ ಆಯ್ತು? ಆಯ್ತು.
Kindly have it.
Petitioner,
my lord.
Petitioner counsel seeks time on the ground that senior counsel is not feeling well. ಹೌದಾ? ಯಾವಾಗ ಬೇಕು ಹೇಳಿ?
12th of November.
List this matter on 12/11.
Great.
64
Hemant Kumar GM. Respond number 2 na. ವಕಾಲತ್ ಹಾಕಿಲ್ಲ?
Yesterday we have got the notice, my lord. Today morning reached we have filed the
ಹಾಕಿದ್ದೀರಾ?
Yes, sir.
ಆಯ್ತು. ಕೌನ್ಸಿಲ್ ಶ್ರೀ
Umapati, yes.
Umapati S submits that he has filed wakalat for R2
Yes, sir.
in the registry, and hence registry is directed to put up the same. Papers ಕೊಟ್ಟಿದ್ದೀರಾ ಅವರಿಗೆ?
Police, to police we have got. Through police we got the.
ಈ ಪಿಟಿಷನ್ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದಾರೆ ನಿಮಗೆ?
Yes, ma'am.
ಆಯ್ತು. ರೆಡಿನಾ ಏನು?
Yes, ma'am.
ಹೇಳಿ. ನೀವು ರೆಡಿ ಇದ್ದೀರಾ ಏನು?
Yes, ma'am. Only simple question of law.
My lord, the respondent number 2 filed the case before the first respondent in the crime number 97 of 2020, offense punishable under section 468, 469, 470, 420, 447, 120B, or 201 of IPC, my lord. Against the accused number 1 and 2 and others. The contention of the complaint is that in the year 1991, the created the forged will. My lord, petitioner is a witness on said will, my lord. After in the FIR and complaint, there is no name reflected in the FIR and complaint, my lord. After the charge sheet, they have insisted accused number 3 and 4 of the case, my lord. He is a witness of the said will, my lord. And one Padmama, wife of late Chengirappa, has initiated the OS number 451 of 98, my lord. In the FIR, in the complaint, there is no allegation in the OS number, my lord. The OS 451 of 98 is a partly decreed, my lord. Thereafter, the petition, respondent number 2 and one Nandini and others, he filed the RA before the district judge, my lord. That RA also dismissed, and preferred RSA also before the Samar court. RSA also dismissed, my lord, disposed of, for direction to file a suit for declaration. In this background, my lord, 1991 will, the petitioner is a witness
to the document.
Not the document. The lapse of 30 years, my lord, they have responded to after the lapse of 30 years to lodge the complaint before the respondent number 1 against the accused number 1 and others.
What was the finding of the court, civil court,
my lord,
with regard to
kindly,
will is concerned?
Will is not proved by the respondent number 2, my lord. They have kindly see the page number 95, 73 and 74, my lord. The suit find the issue number 3. Whether the plaintiff further prove that the alleged will dated 22/9/91 is got of document and does not bind on her for reasons stated in para 6 of the plaint. In the answer is negative, my lord. And kindly see the page number, same page, my lord, 73, additional issues. Whether the third defendant prove Chengirappa being the absolute owner of the suit shell property, he has bequeathed ground floor of item number 1 of the plain settled property to her and Vijay Kumari under the will dated 29/5/1978. That also issues is also negative, my lord. And fourth issues, my lord, is a respondent number 2, defendant number 7 in the said suit, my lord. The complaint, whether the defendant number 7 prove that Chengirappa being the absolute owner of the item number 1 of the plaint schedule, he has bequeathed the first floor of item number 1 of the plaint schedule along with staircase room in his favor as per the register will dated 29/5/1978. Avrela respondent number 2 1978 and registered will. That will is not proved, my lord. That additional issues also negative, my lord. After the completion of the civil case, they have filed the present complaint before the first respondent, my lord.
ಏನ್ರಿ ಕನ್ಕಾಕ್ಟೆಡ್ ವಿಲ್ ಅಂತ ಹೇಳಿ ಪ್ಲೀ ತಗೊಂಡು ನೀವು in the suit you took the specific defense that whether the plaintiff further proves that the alleged will dated 22/9/91 is a got up document and does not bind on her for the reasons stated in para number 3 of the plaint ಅಂತ ಇದೆ. This issue was answered as negative. ಹೌದಾ?
Yes, but they have not taken any contention in the memorandum petition. Only one page ಬರ್ತಿದ್ದಾರೆ. So here we want to find a detailed objection because this Honorable Court of Lordship has passed a 2 detailed order, number 1 and 2. And the Honorable
1 and 2 Gayatri. What about this? These persons are the witnesses to the will.
Yes, ma'am. That's the reason they have this colluded with the accused number 1 in creating a forged will, madam. That was the finding of the police report, and there is a specific allegation.
Police report ಆಯ್ತು ರೀ, ಕೋರ್ಟ್ ಅಲ್ಲಿ ನೀವು ಪ್ರೂವ್ ಮಾಡಿಲ್ವಲ್ಲ that document is a got up document ಅನ್ನೋದನ್ನ. You are unsuccessful in the civil court. Then how can you initiate the criminal case against those persons when you have not proved the will was the got up document? ಮತ್ತೆ ನಾನು ಅದಕ್ಕೆ ಕೇಳಿದ್ ನಿಮ್ಗೆ ರೆಡಿ ಇದೀರಾ ಅಂತ.
Only one page ಇದೆ ಸರ್ ನಿಮ್ಮ ಪ್ರೊಸೆಸ್ ಅಲ್ಲಿ. ಇದೆಲ್ಲ ಏನು ಹೇಳಲಿಲ್ಲ ಅವರು. You are innocent of the crime ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ. He can issue the summons, the absconding, ultimately non bailable.
ಹೇಳಿದಾರಲ್ಲ ಇಲ್ಲ OS 2 183 appeal is dismissed ಎಲ್ಲ ಹೇಳಿದಾರಲ್ರಿ. ಮತ್ತೆ
ಅಲ್ಲ kindly see the page number 74, my lord.
You are unsuccessful in all the courts including RSA. The complainant to counterblast the said civil suit, the present complaint is filed ಅಂತ ಬರ್ದಿದಾರಲ್ಲ. ಆಯ್ತು, ಯಾವ್ದಿದೆ ಆರ್ಡರ್ಸ್ ಎಲ್ಲಿದೆ?
The trespasser and ಲಾಕ್ಡೌನ್ ಅಲ್ಲಿ ಟ್ರೆಸ್ಪಾಸ್ ಮಾಡಿದ್ದಾರೆ ಪ್ರಾಪರ್ಟಿ ಮೇಲೆ ಅಂತ ಹೇಳಿ ಲಾಡ್ಜ್ ಕಂಪ್ಲೇಂಟ್ ಇರೋದು. Accused number 1 and 2. In the FIR, in the complaint, there is no mention in the petitioners, my lord. No, my lord. In the complaint, there is no allegation against the petitioner, my lord.
Chandra, along with the person whose signature forthcoming in the fabricated bill, dated 22/9/81. Yeah, for the signature of Giriappa and fabricated the bill. We have, there is a specific allegation, and police have also filed a charge sheet that they have colluded with the page number 1 and 2 at page number 5.
ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಕಂಪ್ಲೀಟ್ ಆಗಿದೆಯಾ?
My lord, charge sheet is for-
Charge sheet ಆಗಿದೆ.
In the second case, my lord, the charge sheet was also questioned by the appeal court. This all was pleased to dismiss the petition, ask them to pay the trial. And second case, my lord, plead in of 2025. Appeal court has approached this almost.
But wherein the report also taken that signature not of the signature of the person who had signed the will.
My lord,
Trial court ಅಲ್ಲಿ
Allah.
when the matter was dealt with in civil court,
Yes, my lord.
signature of the person who had signed the will was not sent to the handwriting expert. Now the handwriting expert was also
After lapse of
obtained.
30 years, my lord, they are not.
ಆಯ್ತು ಸಿಗ್ನೇಚರ್ ಅವ್ರದ್ದು ಅಲ್ಲ ಅಂದ್ರೆ ಮತ್ತೆ
ಇಲ್ಲಿ kindly see the page number 73, my lord. The additional issues.
ನಿಮ್ಮವ್ರ ವಿಟ್ನೆಸ್ ಸರಿ, ವಿಟ್ನೆಸ್ ಏನ್ ಹೇಳ್ಬೇಕು? ವಿಟ್ನೆಸ್ ಸೈನ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಏನ್ ಮಾಡ್ಬೇಕು? ಪರ್ಸನ್ ಹೂ ಎಕ್ಸಿಕ್ಯೂಟೆಡ್ ದಿ ವಿಲ್,
I am the
ಟೆಸ್ಟೇಟರ್ must be present and affixed their signature in their presence ಅಲ್ವಾ?
I am the witness in the set suit, my lord.
ಆಯ್ತ್ರಿ, ವಿಟ್ನೆಸ್ ಇನ್ ದ ಸೆಟ್ ಸೂಟ್ ಆಲ್ಸೋ ಡಾಕ್ಯುಮೆಂಟ್ ಗೂ ವಿಟ್ನೆಸ್ ವಿಲ್ಗುನು ಹೌದಲ್ಲ?
Yes, my lord.
ಮತ್ತೆ testator must be present while making the signature. He should say that in my presence only he had affixed the signature ಅಂತ ಹೇಳ್ಬೇಕು. ಇಲ್ಲಿ ನೋಡಿ, in so far as the will dated 29 is claimed by the petitioner, an allegation is made that there is an apparent act of forgery and that the will is not only fabricated but also forced the signature of Chinnagiriappa. Opinion ತಗೊಂಡಿದ್ದಾರೆ ಅವರು. That is not the signature of the testator ಅಂತ.
My lord, in the suit they have the two will also produced before the OS, my lord.
ಆಯ್ತ್ರಿ, ಆ ಡಾಕ್ಯುಮೆಂಟ್ ಕಳ್ಸಿಲ್ಲ. ಹ್ಯಾಂಡ್ ರೈಟಿಂಗ್ ಎಕ್ಸ್ಪರ್ಟ್ ಕಳ್ಸಿಲ್ಲ.
They have not examined the issue, additional issue number 4, my lord.
ಈಗ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟ ಮೇಲೆ ದಿ ವೆರಿ ಡಾಕ್ಯುಮೆಂಟ್ ವಾಸ್ ಸೆಂಟ್ ಟು ದಿ ಹ್ಯಾಂಡ್ ರೈಟಿಂಗ್
After lapse of 30 years, my lord.
ಆಗ್ಲಿ 30 years ಆದ್ರೇನು
In the as per High Court,
hand writing expert was sent to the
in RSA, my lord.
expert has given the opinion that the signature is forged. It requires trial only. How can you attest the will in the absence of the very executant? That is their case.
Kindly see the page number 45,
That's
my
why I
lord.
thought, that is the reason only this court has rejected the earlier petitions.
As per accused number 1 and 2, my lord, I am the witness.
1 and 2 no sari re 1 and 2 are claiming the benefit based on the forged will. ಹೋದಲ್ಲ ನಿಮ್ಮವರು
Accused number 1,
witnesses to that will. ನಿಮ್ಮವ್ರ ಹೆಂಗ್ ವಿಟ್ನೆಸ್ ಆಗಕ್ಕಾಗುತ್ತೆ? ಪರ್ಸನ್ ಬಂದು ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿಲ್ಲ ಅಂದ್ರೆ ವಿಲ್ ಅನ್ನ
person
must having the acquaintance with the executant testator. ಒಂದು ಎರಡನೇದು he must affix the signature in the presence of the witnesses. ಅದೇ ಇಲ್ಲಲ್ಲ
ಅಲ್ಲ, kindly see the
No,
OS
no, concept.
judgment, my lord. In additional issues,
ಯಾವ ಅಡಿಷನಲ್ ಇಶ್ಯೂಸ್ ಇದ್ರು ಅಷ್ಟೇ. ಅದರಲ್ಲಿ ನಾನು ಅಬ್ಸರ್ವ್ ಮಾಡಿದ್ದೀನಿ ಆರ್ಡರ್ ಮಾಡ್ಬೇಕಾದ್ರೆ
ಅಲ್ಲ,
the will was not sent to the handwriting expert. Now a will was sent to the handwriting expert. Now opinion is obtained. It is clear that forged signature will also created, fabricated and forged.
there is no
That is the
findings
reason.
in the civil court, my lord.
ಸಿವಿಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇಲ್ರಿ, ಈಗ ಕಳ್ಸಿದ್ರ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಕಳ್ಸ್ಬೇಕಾದ್ರೆ ಒಪಿನಿಯನ್ ತಗೊಂಡೇ ಇಲ್ಲ.
ಅಲ್ಲ, they have
Handwriting
produced the
expert ಗೆ.
two wills, my lord. Defend is a petitioner, respondent number 2 is
That's all
a
your
defendant
grounds.
number 7 in the set
That's all
suit,
your
my lord.
ground, counsel. I thought that they are misusing the ಇದು ಅಂತ. ಬಟ್ ಈಗ ನೋಡುವಾಗ ದಿ ಹ್ಯಾಂಡ್ ರೈಟಿಂಗ್ ಎಕ್ಸ್ಪರ್ಟ್ ವಾಸ್ ಇಟ್ ವಾಸ್ ಸೆಂಟ್. ದೇ obtained the report. When the signature is forged of a person with an intention to knock off the property and created the will, whether they can be discharged
ಅಲ್ಲ,
or quashed,
ಅಲ್ಲ,
proceedings.
Respondent number 2
It requires-
is a party in the set suit, my lord.
It requires
They have not filed the application.
it requires trial, that's all.
ಅಲ್ಲ, my lord, in the set suit, the respondent number 2 not filed the application to verification the signature as the expert, my lord.
That's all your ground.
And additional issue number 4, whether the defendant number 7 is a respondent number 2 before the
1 and 2 ga Chandra is accused number
1,
Nayaz Khan
accused number 2.
2.
They have not proved the will, my lord. Both the will is marked before the trial court.
This court passed detailed order, even referring the judgment of the apex court also.
My lord, that judgment, that civil case is not reflected, my lord. Respondent number 2 not filed the application before the trial court, my lord.
Not a case for quashing, counsel. You may get a bail, but not the quashing.
Kindly see the page number 144, my lord, exhibit 43. The will is produced, 1978 will also produced. Respondent number 2 ಹೇಳೋದು 1978 ಅಲ್ಲಿ ನನಗೆ
reason only cognizance was taken by the trial court considering the material. Go for trial, that's all.
They never stated in the civil and RA and RSA also, my lord. The will is forged. After lapse of 30 years, they have filed the false complaint against
That's all. Third. Or the petitioner counsel and also the counsel appearing for the respondent state. And so also the counsel appearing for the respondent number 2. These two petitioners are accused number 3 and 4. And in the petition it is contended that the respondent number 2 filed the complaint before the first respondent police on 3/10/2020. And police have registered the case in crime number 97 of 2020 for offences punishable on section 468, 469, 470, 420, 447, 120B, 201 of Indian Penal Code against the accused number 1 and 2 and others. That the offence was taken place on 22/9/1991. The allegation made in the complaint that property originally belonged to one Sri V. Channagiriyappa, who is the maternal uncle of respondent number 2, who had executed a registered will dated 29/5/1978, in which the property in question was given to three persons, Nandini, Vijay Lakshmi and V. Chandra and others. And the accused number 1, Chandra, started claiming on the basis of fraudulent documents. And respondent number 2 was not aware of such document, but Sri V. Channagiriyappa's estranged wife has filed OS number 451 of 1998, claiming rights over the property. And in the suit, Sri C. Chandra executed a will dated 22/9/91 is relied upon. And suit was dismissed. And finding has been recorded with regard to the would operate adjudicate. Based on the same, the said Chandra has gone before the municipal authorities, managed with municipal authorities and had obtained kata in respect of the properties in question. The respondent number 2 was challenged the same before the High Court in WP, and the High Court has set aside the same. The authorities has cancelled the kata which was in the name of Sri Chandra and reinstated the kata in the original owner Sri V. Chinnagiriyappa. The respondent number 2 had taken the copy of the notary will which was produced by Sri Chandra in OS number 451 of 98. And also obtained the court admitted certified copies of the signature available in Sri Chinnagiriyappa in the Wakalat and his affidavit filed on OS 2907 of 1990. And the respondent number 2 have sent the same for forensic examination. The forensic examination has given clear report that there is absolutely no resemblance in the admitted and the signature of Sri V. Chinnagiriyappa in the court proceedings and the signature found on notary will dated 22/9/1991, which is claimed is a created and fabricated document. It is also contended that it is only on virtue of the orders of the Honorable High Court dated 18/11/2019 that this entire issue could have been dealt with. No examination of criminality of the action of Chandra. Further exercise was undertaken in securing the certified copies and seeking opinion from a reputed forensic laboratory to find out its forged will. Respondent number 2, co-owner were in possession of a portion and distribution caused by Sri Chandra and other accused, and broke open the lock and facilitated and abated the trespassing into a portion of the property along with other accused. The material which discloses that will was created and forged and fabricated the documents, and hence complaint is lodged and the investigation is conducted and police have also filed the charge sheet. The main contention of the counsel appearing for the petitioner before this court is that earlier was original proceeding 451 of 98 specific stand was taken regarding the will is concerned, and the civil court comes to the conclusion that will is not proved, and also an appeal is filed. Appeal is also dismissed, and RSA also filed only afterthought dismissal of the suit, a counterblast of said civil suit. Present complaint is filed. The entire matter on hand is purely civil in nature. The complainant has chosen to given things of criminal color to a civil matter, and referring the findings of the civil court in OS number 451 of 98, RA number 183 of 2015 and RSA 1794 of 2017 contends that the very initiation of criminal proceedings against the petitioners who are the witnesses of the said will wrongly brought within the jurisdiction of criminal proceedings, and hence this court has to quash the same. Per contra, the counsel appearing with respondent number 2 submits that this court already considered the case of accused number 1 in criminal petition number 227 of 21, with order dated 1st day of March 2021, and dismissed the same that matter requires trial. And so also in respect of accused number 2 in criminal petition number 399 of 2025, with order dated 28th day of February 2025, dismissed the same that he has to face the trial. The counsel also submits that when the forensic report is given that will is created and forged and documents are fabricated, and these petitioners are also the part of in fabrication of document, and specific allegation is made against them that in collusion with accused number 1 and 2, these two petitioners are also indulged in creation of document and attested the same as witnesses to the will, and hence not entitled for quashing of the proceedings initiated against these petitioners. Counsel appearing for the state NCCP would submit that investigation is completed and charge sheet is also filed, and trial court also taken the cognizance considering the material available on record, particularly the offences under section 468, 469, 470, 420, 447, 120B and 201 of IPC, and hence no ground is made out to quash the proceedings. Having heard the petitioner, counsel, and also the counsel appearing for the respondent state and also the respondent number 2, petitioner also not disputes the fact that they are the witnesses to the document of will, which was allegedly executed in the year 1991. The counsel would submit that they are the witnesses and not having any intention to cheat anyone and not indulged in creation of any document. and there cannot be any criminal prosecution against these two petitioners. And though dismiss the petition of accused number 1 and 2, and they indulge in obtaining the document and also creation of document of tenancy. But these petitioners are not the beneficiaries and not got any pecuniary interest over the property, and hence there cannot be a criminal prosecution. And the said contention cannot be accepted for the reason that when the specific allegation is made against these two petitioners also that they are the witnesses to the will, and when the prima facie material discloses that Chinnagiriyappa had not executed any will, and when the created document was sent to the FSL, and FSL report is very clear that the admitted signatures which not tallies with the signature of Chinnagiriyappa, and such report is given very presence of the said Chinnagiriyappa for execution of the will is doubtful, and hence these two witnesses are attesting witnesses for the execution of the will. And when he was not present and executed the document, and document is created and forged, matter requires trial with regard to the very attestation of the will, and when such material available on record. This court already considering the material in detail in earlier petitions, criminal petition number 399 of 25, and also the other petition filed by the accused number 1, dealt with matter in detail. That matter requires trial. And in respect of the allegations against these two petitioners also, matters requires trial, and there cannot be any order of quashing of proceedings, even though there is a finding in civil suit, and wherein the civil court finding is given that the alleged document of will was not sent to the handwriting expert, and now handwriting expert opinion is also taken, and hence no ground is made out by the petitioner to quash the proceedings, and hence petition filed by the petitioners are dismissed.
65. C. Bhagwan.
Quashing the proceedings. 448 admissible. 427 516. Document number 2 is dated 26/4/2018. Page 30.
Earlier it was rejected.
No.
Criminal petition number 3709 of 2019. It was dismissed in February 2021. It appears that
I will look into that one.
They are not brought to the notice of you. ಇಲ್ಲಿ ಆರ್ಡರ್ ಇದೆ, ಅದಕ್ಕೆ ನಮ್ಮ
ಗೊತ್ತಾಯ್ತು
21 ಅಲ್ಲೇ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ.
ಗೊತ್ತಾಯ್ತು.
ಅದಕ್ಕೆ ನಾನು ನೋಡಿದೆ ಪಾರ್ಟಿ ನೇಮ್ ಜುಬೇರ್ ಅನ್ವರ್. ಹಿಯರ್ ಆಲ್ಸೋ ಎ ಜುಬೇರ್ ಅನ್ವರ್. This court earlier considered.
No, it may be taken up on some other date.
Petition.
I will look into it.
Petition number 3709 of 2019. And the same is brought to the notice of the counsel appearing for the petitioner. And hence petitioner counsel seeks time. List this matter on ಯಾವಾಗ ಬೇಕು 12th. List this matter on 12th.
Preliminary hearing matter 66. Ni Krishnaniam.
ಫೈಲ್ ಕೊಡಿ ಅಮ್ಮ.
ಉನ್ನಿಕೃಷ್ಣನ್ ಫೈಲ್ ಕೊಡಿ, ನೀವು ಪಕ್ಕಕ್ಕೆ ಸರಿರಿ, ಬೇರೆಯವ್ರಿಗೆ ಜಾಗ ಕೊಡಿ.
APF of petitioner, ma'am. Filing memo for withdrawal.
Withdrawal.
Yes, sir.
Petitioner counsel files memo seeking permission of this court to withdraw the petition, and hence permitted to withdraw. Why you are withdrawing, madam?
It's infectious, madam.
Huh?
Infectious, madam.
Infectious.
Yes.
Why? You got the relief. Earlier ಕೂಡ ಏನೋ ಒಂದು ಡೀಟೇಲ್ ಆರ್ಡರ್ ಆಗಿದೆ. ನಾವೇನ ಮಾಡಿದೀವಿ 18th day of March 2021. ಓ ಇದು ಯಾವ್ದು ಸೀರೀಸ್ ಇತ್ತು ಅವಾಗ. ಆಯ್ತು. Permitted to withdraw.
67 Geeta Devi entry.
Criminal RP modification of the order dated 8/4/20.
Your Lordship had passed an interim order and passed an order directing the, confirming the order of the appellate court granting maintenance of 20,000 rupees for their minor children and also awarded, directed him to provide residence or alternatively pay 10,000 rupees per month. Your Lordship passed an order on 8th April 2022.
I have received the objections to my IA only yesterday. They are filing along with the documents. It takes time to wait. Several documents.
Who filed the objections? Other side have filed the objections. ಯಾವಾಗ ನೆನೆ ನಿಮ್ಮ application?
Well, I have filed IA of 1 of 2023 for modification because I have lost my job. There's a change circumstances after the orders are on the court. 15 months after that, I have lost my job, my lord. Now recently in August 2025, they have filed an application for enhancement of maintenance, my lord.
Increase of interim maintenance.
Please, my lord.
Told. Counsel appearing to the respondent would submit that they have received the objection statement and the documents on IA number 1 of 25. And the counsel has to go through the same. And hence list this matter ಯಾವಾಗ ಬೇಕು ಹೇಳಿ ಯಾವಾಗ ನೋಡ್ತೀರಿ? Next Monday, next Wednesday? Criminal matter ಎಲ್ಲ Wednesday. ಇಲ್ಲ next Wednesday ಇಲ್ಲ 15th ಅಲ್ಲ ಯಾವಾಗ ಮೇಡಮ್? 12th. ಯಾವಾಗ? 12th. 2 ವಾರ ಬೇಕಾ ನೋಡಕ್ಕೆ? ಆಯ್ತು 12/11.
68
Yogananda P. Gayatri. Withdrawal of amount filed by the counsel for respondent.
For the petitioner in this matter.
Modification of the order dated 17/2/25.
To file the objection.
ಯಾವ್ದಕ್ಕೆ?
For both IA number 2 and 3 for the withdrawal of the amount and modification of the
ಈಗ
earlier order.
objections ನೀವು ಹಾಕಿದ್ರಾ?
Yes.
You are appearing for petitioner.
Petitioner.
ಆಯ್ತ್ರಿ ತಕರಾರ್ ಹಾಕಿದಾರೆ ಏನ್ ತಕರಾರ್ ನೋಡ್ತೀರಾ ತಾವೇನು ನೋಡಿ petitioner counsel files objections to IA number 2 of 25 and IA number 3 of 25 and copy of the objection statement is also served on the counsel appearing for the respondent and respondent counsel seeks time ಏನಾದ್ರೇನೋ 14 ಲಕ್ಷ 13 ಲಕ್ಷ ಅದೇನೋ ಆ ತರ ಇದೆ ಅಂತ ಆಯ್ತು ನೋಡಿ ಏನ್ ಯಾವಾಗ ಬೇಕು ಹೇಳಿ ನೆಕ್ಸ್ಟ್ ಕೊಡಿ ಮೇಡಮ್ 511 list this matter on 511.
Much obliged.
ಮುಗೀತಾ ಕ್ರಿಮಿನಲ್ ಮುಗೀತು.
faster matter still number 10. Serial number 10.
Serial number 10 passed over. ನೀವು ಯಾರಿಗೆ ಅಪೇರ್ ಆಗೋದು? ಅಪಲೆಂಟ್ RSA CM ನಾರಾಯಣ ಸ್ವಾಮಿ ತೋಳಿ counsel appearing for the present counsel appearing for the RSA seeks permission of this court to withdraw the application filed for recalling the order dated 22/4/2024. Having perused the records, this court earlier considered the RSA with order dated 17th day of April 2023 and dismissed the appeal by passing a detailed order which runs 7 pages. And thereafter, an application is filed recalling the said order. While filing such an application, an allegation is made against the earlier counsel R. Shashi Kumar that he did not entrust the case to file a second appeal. And also appellant appeared before the court and submits that he had not signed the wakalat affidavit, and also he did not go to the office of the learned counsel, Sri R. Shashi Kumar, since the earlier counsel made the submission before the court that appellant came along with the advocate Sri MP Narayana Swamy of Kolar. And hence, this court directed R. Shashi Kumar to get the advocate Sri MP Narayana Swamy of Kolar to know whether he had accompanied the appellant to the office of learned counsel Sri Shashi Kumar with order dated 23/7/25. When the said earlier advocate appeared through Sri MP Narayana Swamy before this court, and said advocate MP Narayana Swamy made the submission before this court that appellant was brought along with him in his car to the office of Sri R. Shashi Kumar, and appellant has executed the wakalat to file RSA. And even thereafter, the appellant had visited his office 4 to 5 times in order to pursue the appeal. And counsel submits that appellant only had executed the wakalat as well as other papers. And the same was reiterated by counsel R. Shashi Kumar. And in spite of this also, appellant who appears before the court denies the same. And this court, having taken note of matter, was heard earlier also, and subsequent development, when the appellant approaches this court by filing such an application, A number 2 of 24 as well as A number 1 of 24. When this court about to refer the documents to the handwriting expert, counsel appearing for the appellant earlier, Mr. R. Shashi Kumar, would submit that there is a chances of adopting of an ingenious method in signing the signature in different method, and hence trial court records may be secured wherein admittedly the appellant herein has signed the documents can be secured. And hence this court found that there is a force in the submission of the counsel, and hence directed to secure the records, and records are secured before this court. This court, having compared the signature, found that the signatures executed to the counsel R. Shashi Kumar as well as the present advocate, and also the wakalat executed before the trial court, and also the signature available on record, found similarity, and hence this court made it clear that if the documents are sent to the handwriting expert and if signatures are found on the appellant, and hence he has to face the serious consequences, or otherwise this court is going to give an opportunity if report comes in favor of the present appellant. And at this juncture, a submission is made before this court by the present counsel who appears on behalf of the appellant, and appellant also present before the court. 6. Permission of this court to withdraw the application, and having taken note of this aspect, when this court spent its time in view of the application filed by the appellant from 8/4/24 on different dates 22/4/24, 7/7/25, 14/7/25, 23/7/25, and again detailed order was passed on 25/7/25 and secured the records, and having taken note of the same, the appellant had indulged in even denying the signature which he had executed in favor of the earlier advocate, and thereafter files one more application to recall the order with the fresh wakalat executed in favor of the fresh advocate, and totally denied the very execution, and it is nothing but an abuse of process, and made this court to even secure the lower court records to send the records to the handwriting expert. At this juncture, seeks permission of this court to withdraw the applications, and hence permitted to withdraw with the cost of rupees 25,000 and directed to pay the amount of rupees 25,000 within 2 weeks from today. If cost is not paid, the registry is directed to recover the same from the present appellant in accordance with law.
Cost, to whom the cost paid?
ರಿಜಿಸ್ಟ್ರಿ ಇನ್ಯಾರಿಗೆ ಕೊಡ್ತೀರಿ? ಕೋರ್ಟ್ ಟೈಮ್ ನೀವೇ ಹಾಳು ಮಾಡಿದ್ದಲ್ವಾ?
32.
ಅವನೇನ ಬಡವಾನ ಅವತ್ತಿಗೆ 25 ಇಳಿಸಿದ್ವಿ, ಇಲ್ಲ 1 ಲಕ್ಷ ಆಗ್ತಿದ್ವಿ. ಆಯ್ತು, ಇನ್ನೂ ಏನು ಕಡಿಮೆ ಮಾಡೋಣ ಬಿಡಿ. ಅವ್ನು ನೋಡಿದ್ರೆ ಇಟ್ ಅಪಿಯರ್ಸ್ ಟು ಬಿ ಆಯ್ತು, ಒಂದು 15,000 ಮಾಡಿ, 15,000 ಮಾಡಿ. 15,000 ಕಟ್ಟಿಸ್ಬೇಕು 2 ವಾರದೊಳಗೆ. ಕಡಿಮೆ ಮಾಡಿದ್ವಿ, ಬೆಳಗ್ಗೆ 50 ಅಂತ ಹೇಳಿದ್ದೆ, ಕಡಿಮೆ ಮಾಡಿದ್ವಿ 25, ಈಗ ಇನ್ನೂ ಕಡಿಮೆ 15,000 ಕಟ್ಸ್ಬೇಕು. ಮತ್ತೆ ಕೋರ್ಟಲ್ ರಿಜಿಸ್ಟ್ರಿಯಿಂದ ರಿಕವರಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಇನಿಷಿಯೇಟ್ ಮಾಡಕ್ ಬಿಡಬಾರ್ದು.
32 ಸಾಗರ್ ಬಿಬಿ.
32 ಹೇಳಿ.
For the appellant, suit minutes for declaration and minutes possession. Minutes suit minutes is dismissed. In appeal minutes, the judgment and decree of the trial court minutes is confirmed. Concurrent findings minutes. Minutes case of the plaintiff before the trial court was that minutes that one Hucha Nayaka minutes who is the father-in-law minutes of the plaintiff. Minutes was granted land minutes in the year 1927 under Darkast proceedings, and that is how minutes they had continued. Minutes in support of her contention minutes, she has produced minutes exhibit P1. Minutes on perusal of exhibit P1 minutes, it appears that minutes that the land minutes that was minutes contended to have been granted minutes in favor of Hucha Nayaka minutes was not under Darkast proceedings, but minutes he has purchased it minutes in a public auction. Now minutes the document that is produced minutes for establishing minutes title of the plaintiff, title minutes of Hucha Nayaka, and minutes the pleadings in the plaint minutes are different. Primarily minutes on that ground minutes the
contrary to each other.
Yes, minutes the pleadings and minutes the evidence minutes that is tendered minutes to establish minutes the case minutes are different. Now minutes primarily minutes the suit minutes is dismissed minutes on that ground. Now minutes when the PW1 minutes, that is plaintiff minutes 1 was put to cross examination minutes, the tenor of the cross examination was that minutes that not only the plaintiff minutes that but the defendant minutes are also minutes entitled, and minutes that it is a ancestral property. It was suggested to the witness minutes that the exhibit P1 minutes is not a Darkast order minutes but a document minutes which reflects that Hucha Nayaka has purchased it minutes under a public auction. The witness minutes answer yes. The witness minutes has admitted that particular suggestion. Further minutes she deposes that minutes she is illiterate, and minutes she has minutes no clarity minutes on the mode of acquisition of title minutes of Hucha Nayaka. Now minutes Hucha Nayaka minutes being the father-in-law minutes of the plaintiff minutes can be gathered minutes from the very cross examination minutes. Questions are put
it is suggested that, my lords, that father, my lords, of the father-in-law's father, my lords, father-in-law's father name also was Ucha Nayaka. They, my lords, belong to the same family, my lords. It is suggested. Now, my lords, my respectful submission, my lords, these, my lords, are mufsel pleadings, my lords. Now, my lords, what is sought, what is, my lords, required, my lords, to be pleaded in a plaint, my lords, is material fact, my lords. Now, my lords, when it is contended that, my lords, that they are claiming title, my lords, under Ucha Nayaka, and if while doing so, my lords, if there is an error, my lords, in pleading, my lords, the mode of acquisition, my lords, that itself, my lords, should not have been, my lords, a ground for dismissal of the suit, my lords. Now, my lords, these are mufsel pleadings. Now, my lords, it is beyond the control of the litigant, my lords, as to what is pleaded in the plaint. Instructions are given. Now, the first appellate court also, my lords, places reliance, my lords, on pleading the
differing and evidence.
Yes, my lords. The difference.
Each other.
Yes, my lords. Yes, my lords. These are mufsel pleadings. It is not that, my lords, that the plaintiff, my lords, has no semblance of right.
Mufsel pleading or urban pleading must be, law is established that pleadings must be supported by an evidence.
My lords, materially, my lords, it is to be pleaded that, my lords, that they are claiming, my lords, title under Ucha Nayaka, my lords, that, my lords, is done in plaint. Now, my lords, the extract of exhibit P1, my lords, is also, my lord, pleaded in the plaint. Now, instead of saying that, my lords, that this is a extract of the Ketawar register, they say that, my lords, that this is a darkast order. Now, the difference is that, my lords, that the document, my lords, is said to be something different than what it is. Now, placing reliance on that, my lords, if the very suit is dismissed, my lords, it is not that, my lords, they don't have title. For that reason, my lords, now, my lords, in this appeal,
second appeal alli ಏನು ಮಾಡಬೇಕು?
substantial question of law.
Yes. ಅಲ್ಲ ನಿಮ್ ಪ್ಲೀಡಿಂಗ್ ಸರಿ ಇಲ್ಲದ ಮೇಲೆ ಎವಿಡೆನ್ಸ್ ಒಂದು ಪ್ಲೀಡಿಂಗ್ ಒಂದು ಹಂಗಿದ್ದ ಕೋರ್ಟ್ ಹೆಂಗ್ ಗ್ರಾಂಟ್ ಮಾಡ್ತಾರೆ ರಿಲೀಫ್ ನಾ?
Now, my lords, your lordships, my lords, in this
appeal alli ಏನು ಮಾಡಬೇಕು?
in this appeal, my lords. Now, my lords, one substantial question of law, my lords, that can be considered as, my lords. My lords, when material facts are pleaded, my lords, if, my lords, there is a
pleaded is different and placed is also different.
It is pleaded that, my lords, that they are claiming title, my lords, through Ucha Nayaka. Now, my lords, document, my lords, is tendered in evidence, my lords, with regard to Ucha Nayaka, my lords, having acquired the suit property. The only, my lords, mistake that has occurred in the plaint, my lords, is with regard to pleading with regard to mode of acquisition. Now, my lords, now the mode of acquisition, my lords, when document is produced, and, my lords, when the document, the particulars of the document, my lords, is also extracted in the plaint, my lords, it cannot be said that, my lords, that there are absolutely no pleadings. If, my lords, there is any error, my lords, with regard to pleading with regard to mode of acquisition, that
when you come to know about the same, you would have amended the plaint also and not done the same. Even also in the appellate court also, what can be done in second appeal? You can file a fresh suit, that's all, with correct pleading and with correct evidence.
There is a marginal delay, my lords, of 54 days.
Adna delay condone ಮಾಡೋಣ.
My lords, my respectful submission
For
is,
the
my lords,
counsel appearing for the appellant on IN number 1 of 24, and there is a delay of 52 days in filing the appeal, and for the reasons stated in the accompanying application, the affidavit delay is condoned. However, heard the matter in detail with regard to the relief is sought by the plaintiff before the trial court, wherein the plaintiff sought for the relief of declaration before the trial court and possession from the defendants, claiming that suit scheduled property is totally measuring 6.27 acres and is originally belonged to one late Ucha Nayaka, working as school Jawan, which was granted to him by the government during 1926-27, that is dated 12/6/1925. During his lifetime, he was in possession and enjoyment of the suit property. However, after his death, the property got mutated in the name of the mother of the first defendant, void mutation order dated 39/08, 39/8 and 9, dated 21/10/2008, which is not correct and made in collusion with the revenue officials. The plaintiffs are the absolute owners of the suit schedule property bearing land in survey number 127/2 to the extent of 1.36 acres.
What is claimed, my lords, is 1.36 out of the total extent of 6 acre 27 muntas.
Out of total extent of 6.27 acres. The defendants are totally strangers. And further content that defendants are in possession of the suit property which is illegal, and plaintiff approached them on 5/8/2009 and demanded to hand over the property to them and denied the ownership of the plaintiff and refused to hand over the possession, and hence the suit is filed. Defendants appeared and filed the written statement denying the ownership and also the possession of the plaintiff over the suit schedule property, and contend that it is the ancestral property of the defendants. The suit schedule property was granted to grandfather of the first defendant, Hucha Naika. He is further claimed that Putta Naika alias Hucha Naika was not in possession and enjoyment of the suit schedule property. The plaintiff has instituted 2 suits in OS number 156 of 2009 against one Timmamma in respect of survey number 127/1, and other one is 187 of 2009 with respect to instant suit scheduled property against Bira Naika, and 5 others for the relief of permanent injunction. Both the suits are filed before this court. The defendant further claims that suit property stands in the name of paternal aunt of first defendant, among other grounds praised for dismissal of the suit. ನೀವೇ suit ಹಾಕಿದ್ದು earlier ಎರಡು?
Earlier suit, my lords, is filed. That, my lords, has ended in a compromise, but not with regard to these defendants, my lord. That was a suit for partition which ended in a compromise.
Good. The trial court, having framed the issues, allowed the parties to lead evidence, and even additional issue is also framed whether the plaintiff is entitled for relief of declaration with respect to suit schedule property, and he is entitled for consequential relief. And trial court, having considered the material available on record, answered all the issues as negative, including the additional issues, and taken note of the fact that it was pleaded that land was granted to Ucha Naika long back in the year 1925.
27.
ಎರಡು ಹೇಳ್ತೀರಿ ನೀವು?
ಅಲ್ಲ, plaint ಅಲ್ಲಿ
26/27 dated 12/6/1925 ಅಂತಿದೆ. 26/27 ಅಲ್ಲಿ dated 12/6/1925.
The register, the extract of the register, my lords, is 27, but the auction, my lords, has occurred, my lords, in 24/25. The certified copy of the extract, my lords, that is issued, which is produced, my lords, as exhibit P1, the date on that, my lords, is of the year 27.
And trial court, having considered the material available on record, comes to the conclusion that it was pleaded that land was granted measuring 6 acres 27 guntas, and even fact remained is inconsistent when PW1 reveals in her cross examination that her father-in-law acquired the suit property in a public auction. The plaintiffs have produced the copies of plaint written statement of earlier suit in OS number 156 of 2009, and also taken note of even boundaries mentioned in the earlier suit also different from the present suit boundaries in paragraph number 10, and also taken note of the RTC for the year 1980-81 to 1991, 95-96, 2008-2009, which are marked as exhibit P3 to P6. The said documents uncover the fact that out of the total extent of 3.32 acres, an extent of 1.36 acres each are shown against the names of one Tulusamma, wife of Putta Naika, and Devamma, wife of Chikka Naika. Their names were mutated on the basis of MR 47 P6/8283. However, under Exhibit P6, the mutation number is shown as MR number 39 of 2008-2009, dated 21/10/2008, to which plaintiff claimed to be illegal. The mutation is also not under challenge before any forum till today. According to the plaintiff, Tulsamma is the second wife of late Hucha Naika. And an observation is made that if that is so, Exhibit P3 to P6 should have been revealed the name of Tulsamma, wife of Hucha Naika, and not as Tulsamma, wife of Putta Naika. And further observation is made that interestingly, the DW1 in her cross-examination was suggested by the learned counsel for the plaintiff that the first wife of Hucha Naika is Manchamma. But the stand-up plaintiff in voice number 156 of 2009 is that the name of first wife of late Hucha Naika is Chanamma. The trial court taken note of all these discrepancies mentioned in the discrepancy found in the documents as well as evidence. Comes to the conclusion that plaintiff have not proved their title and ownership over the social property either by way of oral or documentary evidence. And also made an observation with regard to the seeking of possession is concerned. When the plaintiff seeks the relief of recovery of possession, must first prove that the defendants are in illegal possession. In the chief examination, PW1 has reported that suit property originally granted to her father-in-law, and after his death, her husband was in possession and enjoyment of the property. However, after the death of Hucha Naika, the property got mutated in the name of mother of first dependent, which according to the PW1 is illegal and made in collusion with revenue officials. But the fact that possession is concerned, nothing is placed on record on what date possession was taken by the defendant, and hence even answered the issue number 2, and also taken note of the material available on record. Comes to the conclusion that pleading is contrary to the evidence which has been placed before the court, and comes to the conclusion that other documents placed before the court also not substantiate the case of plaintiff, and hence dismiss the suit. Being agreed by the judgment and decree, an appeal is filed in RA number 11 of 2019. And the appellate court also having perused both oral and documentary evidence available on record, even formulated the point whether the court below committed an error in coming to the conclusion that plaintiff has not proved that he is the absolute owners, and also with regard to the illegal possession of the suit settled property by the defendants, and answered all the points are also negative, and particularly discussed with regard to the evidence of PW1 in paragraph number 24, and comes to the conclusion that on careful perusal of the cross-examination of PW1, the counsel for defendant suggested that father-in-law of father of PW1 is Hucha Naika, but PW1 has denied the said suggestion put by the counsel for the defendants. Even during the cross-examination, deposed that scheduled property was acquired by Hucha Naika in public auction, and she got document to establish the same, and also taken note of the contra material placed by the trial court with regard to the pleadings as well as the evidence placed on record, and hence comes to the conclusion that the trial court has not committed an error and dismissed the appeal. The main contention of the counsel appearing to the appellant in this present second appeal is that both the courts are not justified in dismissing the suit as well as confirming the judgment by the first appellate court without verifying the title of the plaintiff who are the legal heirs of late Hucha Naika, and hence this court has to frame substantive question of law. The counsel also would submit that maybe the pleading is contrary to the documents which have been placed before the trial court, but the title is proved by placing the document, and even if the material placed on record is very clear that title is with the plaintiff and ought not to have dismissed the same. Having heard the counsel appearing to the appellant and also on perusal of the reasons assigned, it is not in dispute that very specific pleading is made by the plaintiff that property was granted in favor of Hucha Naika. But in order to prove the factum that property was granted in favor of Hucha Naika, no document is placed before the court. A document which is placed exhibit P1 is only a Ketwar. And even having purchased the property, except placing on record of exhibit P1, nothing is placed on record, and it is settled law that pleading must be proved by placing the documentary evidence before the court. And Order 7 Rule 3 is also very clear. There must be pleading and proof in consonance with the established principles of evidence, and the same is not done. The counsel would vehemently contend that mere relying upon the document contrary to the pleading cannot be a ground to dismiss the suit, and the same cannot be accepted for the reason that when the plaintiff approaches the court, particularly in a case of declaration, to declare the ownership based on the document, and document which he relies upon must be corollary to the pleadings what he has made, and in the absence of particular specific pleading, that how he derived the title, and the same is supported by any document, question of granting the relief of declaration doesn't arise. And hence I do not find any error committed by the trial court and also the first appellate court in appreciating both oral and documentary evidence regarding when the relief is sought for declaration and also sought for possession is concerned. And it is the specific pleading that after the death of Ucha Naika, family members are in possession of the property and their possession is continued. But none of the documents reveals that stands in the name of the plaintiff. And on the other hand, documents which have found were also taken note of by the trial court which stands in the name of other persons. And the same is also not tallies with the same. Under the circumstances, I do not find any ground to admit and frame substantive question of law. In view of the discussions made above, I pass the following order. The second appeal is dismissed.
33, Prasanna VR.
Appellants are the successors of the original defined number 3 notes. Suit for partition and separate possession filed by the sister of defendants defined number 3. The genealogy is at page number 14 notes. One Sesha Sherigara was the father of the plaintiff and defined number 1 to 4. It is the case of the plaintiff that Sesha Sherigara was the tenant, and upon his death, his son, the third defendant, filed form number 7 for and on behalf of the family. And pursuant to grant of occupancy right, they are also equally entitled for their respective shares and filed a suit for partition and separate possession of their 1/6 right each in the suit schedule property. The third defendant filed written statement claiming that on 16/3/1973, the father of the plaintiff and defendant executed a registered sale deed in his favor, transferring the property under which he has acquired absolute right, to which transfer deed the landlord was the signatory attesting witness. Then, as he has acquired absolute right, he filed form number 7 upon vesting of the land with the state government in the year 1974, and grant of occupancy right in his individual capacity does not inure to the benefit of the plaintiff as well as defendant number 1, 2, and 4, who are the married daughters. The trial simultaneously the defendant number 5 and 6, who are the purchasers of portions of land from the third defendant, written statement saying that they are the bona fide purchasers. Defendant number 7 and 8 are the financing bank to the defendant number 3 and defendant number 5 and 6, claiming that they are having their right to recover the loan borrowed by the defendants. The trial court has framed an issue, and the plaintiff number 1 was examined as PW1 and produced certain documents, including the order of the land tribunal, form number 7 filed by the defendant number 3. On the other hand, the third defendant has examined himself as DW1, produced exhibit D1, which is the registered transfer deed executed by his father prior to the date of vesting, 16/3/1973, under which he was created absolute right. Therefore, he has not continued the tenancy from his father, and he has taken the tenancy on his individual capacity. Therefore, plaintiffs are not entitled for any relief. The trial court, assuming that the tenancy was of their father and occupancy right granted in favor of third defendant as a senior most male member, and granted the relief as paid for by the plaintiff. On an appeal by the defendant number 3, the first appellate court has confirmed the same, ignoring the judgment of the Honorable Court Division Bench in the case of Nimbava versus Channaviraya, where it is specifically held that married daughters are not entitled for the share in the tenanted properties. In the present case on hand, 1973 was the transfer deed under which the third defendant had acquired absolute right. It was not a family tenancy. Father possessed his individual tenancy. He could not cultivate the land. Then he transferred, which fact is admitted by PW1. Therefore, having admitted the fact that he has transferred the property to this third defendant, the daughters are not entitled for the share. Even defendant number 1, 2 and 4, they were married prior to 1974. Of course, the marriage of the plaintiff number 1 and 2 is in the year 1975, 1976 and 1984. Since they were residing as on the date of grant of occupancy right outside the property and they were not cultivated, they are not entitled for the share.
Go to paragraph number 25 of the trial court statement.
Please. 25. On careful scrutiny of exhibit P1 form number 7 submitted by third defendant before land tribunal, the age of the third defendant was shown as 28 years. But in column number 8, with regard to the period for which the third defendant has been cultivating the land as tenant was shown as 50 of alleged commencement. Passing on a moment, I will clarify it. Father was a tenant, that is no dispute. But when he transferred by executing a registered deed to which the very landlord himself is the witness.
How can he transfer the tenancy?
It is prior to 1/3/1974. After 1/3/1974.
Tenancy confer agilla.
Illa. Avana Muli right, Muligeni right was transferred by virtue of registered document, which fact is admitted by DW2, who is the son of the landlord. Even landlord has admitted before the land tribunal that the tenancy is of the son, third defendant, based on which the tribunal granted occupancy right. Otherwise, father would have filed form number 7. He was alive up to 1970. He was alive. Therefore, when he has not filed form number 7, when the son was allowed to file form number 7, pursuant to a registered document, it is the tenancy of the son, individual tenancy. Therefore, moreover, as per the settled principles of law, married daughters are not entitled for any share.
He is an eldest member of the family, that's why he filed form number 7.
He is not the eldest member. Father was the eldest. Father would have filed form number 7, number 1. Number 2, the eldest
father executed the document in which year?
1973.
73.
1973.
Nimone avag hakkid application?
1974.
74.
How?
After 1 year?
Yes, 1 year. After 1 year, my the third defendant filed form number 7. Moreover, at best, trial court would have granted a decree in favor of the plaintiffs to the extent of 1/3, not 1/6, because defendant number 1, defendant number 4, and defendant number 2 and 4 were married much earlier to the date of vesting. Therefore, the case of Nimbava would be applicable here. Kindly see the judgment of the first appellate court, where I have relied upon the judgment, point number 2, page number 31. This court is of the opinion that as per the settled principles of law, as laid down by their lordships of the Honorable High Court of Karnataka, Bengaluru, reported in ILR 2013, Karnataka 6202, Nimbava versus Channaviraya, son of Gurushantaya, Kurulinga Devaramaya, and others, wherein their lordships have categorically held that conferring occupancy rights on a member of the family inures to the benefit of family. But it is quite.
Form number 7 ali, while claiming the tenancy.
Yes.
What he has stated?
Lord, tenancy was 50 years, since 50 years.
50 years.
50 years.
Whether in the name of family or what?
No, it is individual. Lord, exhibit.
Form number 7
Yes.
idea ನಿಮ್ಮ ಹತ್ರ?
May I pass it on? As on the date of filing form number 7, he was aged 28 years. Then kindly see the evidence, my lord.
ಸುಮಾರು 50 ವರ್ಷಗಳಿಂದ ಹಿಂದಿನಿಂದಲೂ.
ಹಿಂದಿನಿಂದಲೂ. My father was the tenant. Since he has transferred, my lords, he has relinquished his right. Exhibit D1, my lords. A specific terminology is used. Sale cum release deed. Then kindly see the evidence. I may be permitted to read one para of the evidence of PW1 admission. May I read, my lords? PW1 admits that father was not cultivating the land. Therefore, he has transferred the same to his son. And alienation, she admits. Cultivation, she admits. Marriage, she admits. In spite of that, what the trial appellate court presumed that it was the tenancy.
Issue notice, call for records. This matter on 112. 112 212 madam? 112. 212.
34. Sunil S. Narayan.
Concurrent suit for partition. Second defendant's appeals. Relationship is not in dispute, your lordship.
What is the error?
And G tree is also not in. I have produced the G tree. Geological tree is also not in dispute.
Not in dispute.
Not in dispute.
What is the error?
The only error is in my written statement. I have also admitted that it's a ancestral joint family property. Only thing is that I got married all my sister and my brother, and also I look after my mother. ನೋಡ್ಕೋತಾ ಇದ್ದೆ ಅವ್ರ ಮದುವೆ ಖರ್ಚು ಅವನ್ನೆಲ್ಲ ನಾನೇ ನೋಡ್ಕೋತಾ ಇದ್ದೆ. ಪ್ರಾಪರ್ಟಿ ಸಣ್ಣದಿದೆ, ನನಗೆ ಕೊಡಿ ಅಂತ ಹೇಳಿ. ದಟ್ ಈಸ್ ದ ಓನ್ಲಿ, ಬಿಕಾಸ್ ಐ ಶುಡ್ ಕನ್ಸೀಲ್. ಐ ಕೆನಾಟ್ ಸೇ ಸಮಥಿಂಗ್ ವಿಚ್ ಇಸ್ ನಾಟ್ ದೇರ್ ಇನ್ ಮೈ ಪ್ಲೀಡಿಂಗ್ಸ್. ಸ್ವಾಮಿ ಎಲ್ಲಾರು ಅದು kindly permit me to read the.
If that is done, I can sit together and split.
Kindly I will read the deposition.
ಅಲ್ಲೇ ಮಾಡ್ಕೋಬೇಕಿತ್ತು ನೀವು ಮೊದಲೇ.
ಮಾಡ್ಕೋಬೇಕಾಗಿತ್ತು ಸ್ವಾಮಿ, ಮಾಡ್ಕೊಂಡಿಲ್ಲ. ಅದಕ್ಕೆ
ಏನ್ ಮಾಡೋದು ಹೇಳಿ?
ನನ್ನ ಮುಖ್ಯ ವಿಚಾರಣೆ
legally they are entitled for the share.
Yes, it has been admitted in the written statement and in the cross examination.
No dispute with regard to the relationship between the parties.
Yes.
No dispute with regard to the nature of the property is concerned. And only your contention that you have performed the marriage and taken care of.
Yes.
That will not defeat the right of the other family members.
It lies this only that contention or ಕೆಳಗೆ ಮಾಡ್ಕೊಳ್ಳಿಲ್ಲ.
ಅಲ್ಲೇನಾರು FDP ನಲ್ಲಿ
FDP ಇದ್ದಾರೆ, ಅಲ್ಲಿ
FDP ನಲ್ಲಿ ಹೋಗಿ ಸೆಟ್ಲ್ ಮಾಡ್ಕೊಳ್ಳಿ.
ಅಲ್ಲ, ಅಲ್ಲಿ ಮಾತಾಡಲ್ಲ. ಇಲ್ಲಿ ನೋಟಿಸ್ ಬಂದ್ರೆ ಇಲ್ಲಿ ಬಂದ್ರೆ ಏನಾರು ಇಲ್ಲಿ ಸೆಟ್ಲ್ ಆಗ್ಬೋದೇನೋ ಅಂತ ಅಷ್ಟೇ ಸ್ವಾಮಿ.
ಸೆಕೆಂಡ್ ಅಪೀಲ್ ಅಲ್ಲೆಲ್ಲ ನೋಟಿಸ್ ಕೊಡ್ಬೇಕಾದ್ರೆ there must be a case. Without the case, how can the court can issue notice? ಸೆಕೆಂಡ್ ಅಪೀಲ್ ಅಲ್ಲಿ ಬಂದು ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಲಾಯರ್ ಇಟ್ಕೋಬೇಕು ಅಂದ್ರೆ ಅವ್ನಿಗೆ ಬರೋ ಶೇರ್ ಗಿಂತ ಜಾಸ್ತಿ ಕೊಡ್ಬೇಕಾತ್ ಲಾಯರ್ಗೆ.
ಎರಡು ಪ್ರಾಪರ್ಟಿ ಇದೆ, ಏನೋ ಒಂದಲ್ಲಿ ಶೇರ್ ಮಾಡ್ಕೋಬಹುದು. ದಟ್ ಇಸ್ ವಾಟ್ ಏನ್ ದಟ್ ಇಸ್ ಓನ್ಲಿ ಪಾಯಿಂಟ್.
ಸೂಟ್ ನಡೆಸಕ್ಕೆ ಕೊಡ್ಬೇಕು ಲಕ್ಷ ಫೀಸ್. ಅದು ನಡೆಸಲ್ಲ ಅಲ್ಲಿ. ಆಮೇಲೆ ಮತ್ತೆ ಫಸ್ಟ್ ಅಪೀಲ್ ಅಲ್ಲೂ ಆಯ್ತು. ಆಮೇಲೆ ಇನ್ ಮತ್ತೆ ಸೆಕೆಂಡ್ ಅಪೀಲ್. ಈ ನೋಟಿಸ್ ಯಾಕೆ ಮಾಡ್ಬೇಕು ಹೇಳಿ? ನೋ ಕೇಸ್. Heard the appellant counsel and matter is listed for admission. This appeal is filed against the concurrent finding of the trial court. The factual matrix of case of plaintiffs before the trial court that suit scheduled property is an ancestral property and plaintiffs and defendants are in joint possession and enjoyment of the same. And defendant took the specific defense that there was a partition on 27/1/2011.
D3 Swami, I appear for defend number 2.
Defend number 3 took the contention that there was a partition where the partition dated 27/1/2011. And the present appellant is defendant number 2. He is questioning the concurrent finding of trial court and not disputes the relationship between the parties, and also not dispute the nature of the property, that social property is an ancestral property. The claim is also made by the sisters.
Also.
And when the sisters are also entitled for a share in the social property, when there was no any earlier partition, and though D3 took the specific defense that there was already a partition, and the same is not substantiated by placing any record. And when such being the case, in the absence of any material that already there was a partition, and when the sisters are also entitled for a share in the property in view of the amendment to section 6, and they also become the co-partners equally with the sons. And when such being the case, I do not find any error committed by the trial court in granting the relief. The first appellate court, also having taken note of material available on record, while answering the point number 1, comes to the conclusion that the plaintiffs have filed the suit for the relief of partition and separate possession for claiming their right. And also the genealogical tree is admitted and relationship is also admitted. The second defendant also filed a written statement by admitting the averments of para 2, 3 and 4 of 4, but denied the averments made in paragraph number 5 and 6, and contend that already there was a partition and the same is not substantiated. And when such being the case, I do not find any ground to admit and frame substantive question of law, and both court comes to the conclusion that relationship is not in dispute and nature of the property is not in dispute, and also comes to the conclusion that there was no any partition between the parties, and hence the very contention of the counsel appearing for the appellant that this court has to frame a substantive question of law, that the admission given by the PW1 in our cross examination that appellant, that is second defendant, taken all responsibility and expenditures towards the marriage expenses, and the same cannot be a ground to defeat the right of the plaintiffs, and hence question of framing substantive question of law on the ground which have been urged by the appellant doesn't arise. No case is made out to admit and frame substantive question of law. By invoking section 100, in view of the discussions made up, I pass the following order. Dismissed. Next, Srinivasa V.
But I went for appellant in this case. But this is also a suit for partition. The relationship, there is no dispute between the relationship. Now, my lord, the property was belonging to father and mother of the plaintiff and defendants is also undisputed. Now, my lord, after the death of the mother, the property was mutated in the name of the father. Father in turn executes gift deed in favor of the sons with respect to item number 1 to 13 of Schedule A property and item number 1 to 5 of the B schedule properties. So now, my lord, consider, my lord, both the, my lord, in that regard, an issue have been framed also, that is issue number 3, page number 78. Now, my lord, based on this, my lord, though the trial court disbelieves the say gift deed, it only confines that 1/4 of the share. It makes a partition of 1/4 share, and the 1/4 share what is allotted to the father.
Father who can execute a gift deed in favor of the son in
that's what I'm coming. That's
property
where I am
of the
coming.
mother.
Allah, that's where I am also coming, my lord. Alig barta idini nanu. Trial court ಏನು ಮಾಡುತ್ತೆ 1/4 share ಅನ್ನ ಮಾಡ್ಬಿಟ್ಟು ಆ 1/4 share ಅಲ್ಲಿ ತಂದೆಗೆ 1 share allot ಮಾಡಿ ಆ 1/4 share ತಂದೆಗೆ ಯಾವ್ದು ಅಲಾಟ್ ಆಗಿರುತ್ತಲ್ಲ ಅದನ್ನ ಮಾತ್ರ ಡಿಫೆಂಡೆಂಟ್ ನಂಬರ್ 1 ಗೆ ಎಕ್ಸ್ಟ್ರಾ ಅಂತ ಹೇಳಿ ಬರೆದು ಜಡ್ಜ್ಮೆಂಟ್ ಅಂಡ್ ಡಿಗ್ರಿ ಪಾಸ್ ಮಾಡುತ್ತೆ. That was called in question. Now, my lord, the first appellate court, though there is no cross appeal, but without giving any finding, but just in paragraph number 64, paragraph number 64 1/3 ಅನ್ನು ಮಾಡ್ಬಿಡುತ್ತೆ. A gift deed it never considers it at all. Your lordship may kindly come to paragraph number 64.
Gift deed consider ಮಾಡಿದ್ರು it will not make any changes.
ಅಲ್ಲ ಏಕೆಂದ್ರೆ
father cannot execute a gift deed in respect of the property of the mother.
ಅಲ್ಲ ಒಂದ್ ನಿಮಿಷ, ಮದರ್ ಡೆತ್ ಆದ್ಮೇಲಿಂದ ಫಾದರ್ ಗೆ ಮ್ಯೂಟೇಷನ್ ಆಯ್ತು. ಅಸ್ಯೂಮ್ ಫಾರ್ ಎ ಮೊಮೆಂಟ್ ದಟ್ ಹಿ ಕೆನಾಟ್ ಎಕ್ಸಿಕ್ಯೂಟ್. ಮೇಲರ್ ಸೆಕ್ಷನ್ 15 ಪ್ರಕಾರ ಫಾದರ್ ಆಲ್ಸೋ ಎ ಶೇರ್ ಲೆಗೇಟಿ, ಅವರ ಶೇರ್ ಅನ್ನಾದ್ರೂ ಅಲಾಟ್ ಮಾಡ್ಬೇಕಿತ್ತಲ್ಲ. ದಟ್ ಇಸ್ ವಾಟ್ ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಡಿಡ್. That is what the trial court did, but the first appellate court have failed to consider that aspect. That is why I am before your lordship, my lord.
And my lord, whether the gift deed, my lord, that ಇದರಲ್ಲಿ ನಾನು ಅದನ್ನ ಗಿಫ್ಟ್ ಡೀಡ್ ನ ಚಾಲೆಂಜ್ ಮಾಡಿರೋದನ್ನ my lord, I may not dispute, but my lord, ಅದಕ್ಕೆ ಗಿಫ್ಟ್ ಡೀಡ್ ನ whatever he has executed, it is proved. Gift deed is executed by the father is also admitted. So therefore, the
even if there is an admission, when the father had no any right to execute the gift deed, what right you could get?
ಅದಕ್ಕೇನೆ ಅವರು 1/4 ಫಾದರ್ ಶೇರ್ ನಾರು ಕೊಡಬೇಕಾಗಿತ್ತು. 64
ಫಾದರ್ ಶೇರ್ ಹೆಂಗ್ ಕೊಡ್ತಾರೆ? ಫಾದರ್ ವಾಸ್ ನಾಟ್ ಅಲೈವ್ ಅಲ್ವಾ?
ಅಲ್ಲ, ಫಾದರ್ my lord, when he executed,
ಅದಕ್ಕೆ ಮಾಡಿದ್ದಾರೆ ಅಪಲೆಂಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಮಾಡಿಫೈ ಮಾಡಿ plaintiff and defendants are entitled equal share in item number 1 to 16.
Yes, adre father died, that is also undisputed. During the after the execution of the gift deed, father also died. Gift deed, father also died. So therefore, my lord, the share of the father, one share, father's share should have been carved out, and that should be allotted to the plaintiff, the defendants. Defendant number 1.
When the father is not alive at the time of the
Partition
sharing of the property, question of allotting the father share also doesn't arise. Notional share avella hoytu ಈಗ.
ಅಲ್ಲ, notional share alla, your lordship may kindly come to page number
you are not disputing the fact that property belongs to the father and mother. ಹೌದಾ?
My lord, we have only, my lord, Anusuyamma is the mother. She was not having any separate source of income. That is our case. Our case before the trial court was that she was not having any separate source of income. It was the father's income. It was purchased in the name of the mother.
Father's income ಅಂತಂದ್ರುನು ಏನ್ father what was he?
He was a police constable and also having a separate agricultural property, ancestral property, about 4 acres, 35 guntas.
Whatever it may be, now they become the co-partners, both the daughter and also the son.
Yes, my lord, but
equal share. That's why appellate court modified
that,
the same.
that portion is erroneous.
Modified the same.
My lord, that portion is erroneous.
Erroneous.
My lord, how erroneous antandre father share na, my lord, father died. After the death
Father
of
died.
father,
Whether father had executed any testamentary document?
Gift deed itself is
Gift deed in respect of the mother's property. How can he?
My lord, therefore, my lord,
No grounds. Srinivas, no grounds.
Alla, one nimisha. He cannot execute the entire extent of 1 to 13. That fact I cannot dispute also. Now, my lord, after the death of the mother, he is entitled for 1 share as a legatee under section 15 of the Hindu Succession Act.
Half share ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅದನ್ನ ಕೊಡ್ಲಿಲ್ಲ ಫಸ್ಟ್ ಅಪ್ಲೇಟ್ ಕೋರ್ಟ್. ಟ್ರಯಲ್ ಕೋರ್ಟ್, your lordship may kindly see. Your lordship may kindly come to paragraph number 40, page number 99. May I take your lordships to that portion, my lord? In this case, without
trial court order is modified by the appellate court.
Yes, my lord, modified. Modification ತಪ್ಪು ಅಂತ ನಾನು ಹೇಳ್ತಿದ್ದೀನಿ.
ತಪ್ಪಾಗ್ತದೆ ಹೇಳಿ.
ಒಂದ್ ನಿಮಿಷ, ಅದಕ್ಕೆ ಪೇಜ್ ನಂಬರ್ 40 99 ಬನ್ನಿ ಸರ್. ಒಂದೇ ಒಂದು ನಿಮಿಷ, ಪೇಜ್ ನಂಬರ್
99 ಅಲ್ಲಿ ಹೇಳಿ.
ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 40.
ಆಯ್ತು.
In this case, without division amongst the plaintiffs and defendant number 1, according to section 15 of the Hindu Succession Act, Father Gangadhar Gowda changed the kata in his name under Pauti kata and bequeathed item number 1 to 12 and 14 in favor of the defendants. As discussed above, Father Gangadhar Gowda is not having exclusive right to bequeath the item number 1 to 12 and 14 of CA schedule properties in favor of the defendant. Therefore, execution of gift deed at exhibit D1 is not binding on the plaintiff's share. According to section 15 of the Hindu Succession Act, hence the plaintiffs and number 1 and husband of Anusuyamma are having equal share at 1/4 each. Therefore, plaintiffs and defendant number 1 is entitled for 1/4 share in A schedule properties, and remaining 1/4 share will go to the husband of Anusuyamma. Hence, to the extent of 1/4 share of husband Amma, Anasuya will go to the defendant number 1, not full extent.
1/4 ಮಾಡಿದ್ದೆ ತಪ್ಪು, ಅದಕ್ಕೆ ಫಸ್ಟ್ ಅಪ್ಲೇಟ್ ಕೋರ್ಟ್ ಸೆಟರೇಟ್ ಮಾಡಿದ್ದಾರೆ. 1/4 ಹೆಂಗ್ ಮಾಡ್ತಾರೆ? ಇರೋದೇ ಇಬ್ರು,
3 ಜನ ಲೆಗೇಟೀಸ್, 2 ಡಾಟರು 1 ಮಗ.
2
ಡಾಟರು 1 ಮಗ.
ಆಯ್ತು.
ತಂದೆ 1, 4.
ತಂದೆ ಇಲ್ವಲ್ಲ ಈಗ?
ಈಗ ತಂದೆ ಇಲ್ಲ. ತಂದೆ ಗಿಫ್ಟ್ ಡೀಡ್
ತಂದೆ ಸತ್ ಮೇಲೆ ತಾನೇ ಸೂಟ್ ಹಾಕಿದ್ದು.
ತಂದೆ ಸತ್ ಮೇಲೆ ಡಾಟರ್ ಸೂಟ್ ಹಾಕಿರೋದು. ತಂದೆ ಸತ್ ಮೇಲೆ ಹಾಕಿರೋದ್ರಿಂದ ತಂದೆ ಗಿಫ್ಟ್ ಡೀಡ್ ನ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಿರೋದು ಅನ್ಡಿಸ್ಪ್ಯೂಟೆಡ್.
ಗಿಫ್ಟ್ ಡೀಡ್ ಇಲ್ವೇ ಇಲ್ವಲ್ಲ ಈಗ?
ಗಿಫ್ಟ್ ಡೀಡ್ ಇನ್ವ್ಯಾಲಿಡ್ ಅಂತ ಹೇಳಿ,
ಗಿಫ್ಟ್ ಡೀಡ್ is not in the of law.
Gift deed can be invalidated so far as 3/4 share.
ಈಗ ಇನ್ನೊಬ್ರು ಡಾಕ್ಟರ್ ಇದಾರ ಇಲ್ಲ?
ಇಲ್ಲ, ಗಿಫ್ಟ್ ಡೀಡ್ ಕ್ಯಾನ್ ಬಿ ಇನ್ವ್ಯಾಲಿಡೇಟೆಡ್ ಫಾರ್ 3/4 ಶೇರ್.
ಈಗ ಇನ್ನೊಬ್ರು ಡಾಕ್ಟರ್ ಇದಾರ ಇಲ್ರಿ?
ಇದಾರೆ.
ಹಾಫ್ ಶೇರ್ ಯಾಕೆ ಮಾಡಿದ್ರು ಮತ್ತೆ ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ? Plaintiffs and defendant number 1 are entitled equal share in item
plaintiffs, 2 plaintiffs ಇದರಲ್ಲಿ.
ಅದೇ plaintiffs
plaintiffs.
ಅಲ್ಲಿ 1/3 ಬರುತ್ತೆ.
There are two.
Each 1/3 ಬರುತ್ತೆ.
Each 1/3 ಬರುತ್ತೆ. ಅಲ್ಲಿ ಫಾದರ್ ಶೇರ್ ಏನಿದೆ, ಫಾದರ್ 1 ಶೇರ್ ಅಲಾಟ್ ಮಾಡಿ ಆ ಪ್ರಾಪರ್ಟಿನ ಡಿಫೆಂಡೆಂಟ್ ನಂಬರ್ 1 ಗೆ ಅಲಾಟ್ ಮಾಡ್ತಾರೆ.
Notional partition question ಬರೋದೇ ಇಲ್ಲ ಈಗ.
Notional partition ಅಲ್ಲ ಸ್ವಾಮಿ, it is a section under section. It is a succession under section 15.
ಹೌದು.
Father, my lord, your lordship may kindly understand.
As on the date of filing of the suit, father is not alive, counsel.
Yes, my lord.
Now then.
My lord, once when the father is not alive, they have filed the suit for partition.
ಹೌದು.
My lord,
now only children are before the court.
Yes.
ಹೌದಾ?
Yes.
Father had not agreement also.
Gift deed itself can be construed.
ಮತ್ತೆ gift deed ಹೆಂಗ್ರಿ ಬರ್ಕೊಡಕ್ಕಾಗುತ್ತೆ ಮದರ್ ಪ್ರಾಪರ್ಟಿ?
My lord, father section 15 ಅಲ್ಲಿ he is
ಹಕ್ಕಿದ್ರೆ ನೀವು ಗಿಫ್ಟ್ ಡೀಡ್ ಬರ್ಕೊಡ್ಬೋದು, ನಿಮ್ಗೆ ಹಕ್ಕೇ ಇಲ್ಲ. ವಿಧಾನಸೌಧ ನೀವು ಬರ್ಕೊಡಕ್ಕಾಗುತ್ತಾ?
ಎಂಟೈರ್ ಪ್ರಾಪರ್ಟಿ ಹಕ್ಕಿಲ್ಲ. ಅಲ್ಲ, ನಾನು ಎಂಟೈರ್ ಪ್ರಾಪರ್ಟಿ ಹಕ್ಕಿಲ್ಲ. Even I do admit.
Don't waste the time in second appeal.
My lord, entire property ಹಕ್ಕಿಲ್ಲ. I do admit that fact.
ಮತ್ತೆ
my lord, 3/4 property ಗೆ he is not entitled. At least he was entitled to execute a gift deed in so far as 1/4 share is concerned. Therefore the trial court granted 1/4 share ಅಷ್ಟೇ. ನಾನು ಫುಲ್ ಬರ್ಕೊಟ್ಟಿದ್ ಸರಿ ಅಂತ ನಾನು ಡಿಫೆಂಡ್ ಮಾಡ್ಕೊತಾ ಇಲ್ಲ.
ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಅದನ್ನ ಮಾಡಿಫೈ ಮಾಡಿ ಕರೆಕ್ಟ್ ಮಾಡಿದಾರೆ ಅಷ್ಟೇ. ಏನ್ ತಪ್ಪು ಇಲ್ಲ, ಏನಿಲ್ಲ, ಕರೆಕ್ಟ್ ಆಗಿದೆ. Plaintiffs and defendant 1 are entitled equal share in item number 1 to 16. So and so.
Paragraph number 64.
64. ಹೇಳಿ.
Insofar as granting shares to the parties is concerned, the trial court granted 1/4 share to each plaintiff in Schedule A property and 1/3 share in item number 1 to 3 of the schedule property and 1/3 in the schedule property. Admittedly, the plaintiffs and defendants are co-partners. Now, except the plaintiffs and defendants, there are no other survivors in the family. Admittedly, parents of the plaintiff are no more. As per the findings in the record, all the properties are joint to the properties of plaintiff and defendant number 1. The judgment and defendant in high court also granted share to defendant number 2 also. So far as granting share is that was not this observation itself is erroneous.
Defendant number 2 ಯಾರು?
Defendant number 2 wife.
ಯಾರ್ ವೈಫ್? ಯಾರ್ ವೈಫ್?
Wife of the Nagesh wife. Wife of Nagesh.
Wife of Nagesh. Nagesh ಯಾರು?
Wife of Nagesh.
ನಾಗೇಶ್ ಯಾರ್ರಿ?
First defendant.
ಅವನ ಹೆಂಡತಿಗೆ ಮತ್ತೊಂದು ಶೇರ್ ಕೊಡಕ್ ಬರುತ್ತಾ? ಅವ್ರಿಗೆ ಹೆಂಗ್ ಶೇರ್ ಕೊಡಕ್ ಬರುತ್ತೆ? ಗಂಡಗೊಂದ್ ಶೇರು ಹೆಂಡತಿಗೊಂದ್ ಶೇರ್ ಅಂತ ಕೊಡಕ್ ಬರಲ್ಲ. ಈವನ್ ಶೇರ್ ಕೊಟ್ಟಿಲ್ದ ಹೋದ್ರುನು ಈ ಆರ್ಡರ್ ಇಲ್ಲಿದೆಯಲ್ಲ ನೋಡಿ, ಇದೇ ಕರೆಕ್ಟ್. ಅಡ್ಮಿಟೆಡ್ಲಿ ಪೇರೆಂಟ್ಸ್ ಆಫ್ ದಿ ಪ್ಲೇಂಟಿವ್ಸ್ ಅಂಡ್ ದ ಡಿಫೆಂಡೆಂಟ್ ನಂಬರ್ 1 ಆರ್ ನೋ ಮೋರ್. As per the findings recorded above, all the properties are joint family properties of the plaintiff and defendant number 1. And apart from that earlier also, now except the plaintiffs and defendant number 1, there are no other survivors in the family. Admittedly, the plaintiffs and defendant number 1 are the co-partners. ಅಷ್ಟೇ. ಏನ್ erroneous ರೀ? That's all. I will pass orders. You take elsewhere. That's all. Told. Heard the appellant counsel and also peruse the order passed by the trial court. I will dismiss it with exemplary cost if you are not hearing to the court. Nenne could observe madidare Supreme Court na. When the court makes up its mind, even if the advocate insists for making further submissions. ಓದಿರ ನೇನೆ ಜಡ್ಜ್ಮೆಂಟ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ದು? ಹೇಳಿ. ಮಾಡೋ ಪ್ರಶ್ನೆ ಬರೋದೇ ಇಲ್ರಿ. He doesn't have a right over the property. He doesn't have a right over the property. ಅಷ್ಟೇ, that's all. ಅಡ್ಮಿಟ್ ಮಾಡಿದ್ರೆ ಮುಗ್ದೋಯ್ತು ಅಷ್ಟೇ. Section 30 applies. If section 30 is applied, whatever share of each should be, since consumer died interstate, her share should be allotted to
divided among the co-partners. Thereafter, since he has executed the deed in favor of defendant number one, that should be allotted to defendant number one. That is the only submission.
ಆಯ್ತು, ನಿಮ್ ಸಬ್ಮಿಷನ್ ಆನ್ಸರ್ ಕೊಡ್ತೀನಿ, ಆಗ್ಬೋದಾ? ಆಯ್ತು, ಥರ್ಡ್ ಏನಾಯ್ತು ಮೇಡಮ್?
At the consent for the appellant, there is the order of the trial court.
The said find the trial court granted relief of partition, granting 1/4 share each in the A schedule properties and 1/3 share each in the item number 1 to 13 and item number 15 to 17 of B schedule properties. Both in respect of the plaintiff as well as defendant number one. And the same is challenged before the appellate court by the defendant number one. Defendant number one. Appeal filed ಮಾಡಿ defendant number one. And defendant number one and two, that is husband and wife, took the contention before the appellate court, granting the relief of 1/4 share, even in spite of there was a gift deed executed by the father in favor of the first defendant, is erroneous. And appellate court, having considered the grounds which have been urged, formulated the point whether the suit schedule properties are the ancestral properties of the plaintiff and defendant, whether defendant proved some properties have been purchased by Gangadhara Gowda and Anusuyamma from the self income of Gangadhara Gowda, and whether the defendants proved since Gangadhara Gowda purchased the properties from his self income, the gift deeds executed by Gangadhara Gowda are valid, and whether it requires interference of this court. The first appellate court also taken note of the grounds which have been urged by the appellants that properties are purchased in the name of the mother out of the self income of the father. And appellate court, having considered the point for consideration, answered the point number one as affirmative that suit schedule properties are the family properties of the plaintiffs and defendants, and answered the point number 2 and 3 as negative in coming to the conclusion that in order to substantiate the contention of the defendant that property was purchased by the income of the father Gangadhara Gowda, nothing is placed on record, and comes to the conclusion that in the absence of any cogent evidence before the court cannot come to such a conclusion, and taken note of the fact that trial court granted the relief of 1/4 share each to the plaintiffs in A schedule properties and 1/3 share in item number 1 to 13 and 15 to 17 of B schedule properties and 1/3 in C schedule property. The trial court, having considered when the property is a joint family property, while answering point number 1, modified the judgment of trial court and comes to the conclusion that admittedly the plaintiffs and defendant number 1 are the co-partners. Now, except the plaintiffs and defendant number 1, there are no other survivors in the family. Admittedly, parents of the plaintiffs and the defendant number 1 are no more. As for the findings recorded above, all the properties are joint family properties of the plaintiffs and defendant number 1. The judgment and decree further indicates that trial court also granted share to the defendant also. And so far as granting share in respect of defendant number 1 is concerned, there is no dispute. So far as granting share to the defendant number 2 is absolutely wrong, as the defendant is not the co-partner. Defendant number 2 is the wife of defendant number 1 and daughter-in-law of Gangadhara Gowda and Anusuyamma. Therefore, question of granting the share to the defendant number 2 does not arise at all. The appellate court further observed that The plaintiffs have not filed any cross appeal either for correction of decree nor challenge the same share granted to the defendant number 2. In a suit for partition, all the parties are plaintiffs and defendants. The court has to look into the said aspect and grant decree in accordance with law. And having taken note of the said fact into consideration, modified the judgment and granted equal share to the plaintiffs 1 and 2 as well as defendant number 1 in respect of the suit scheduled properties is concerned. And hence the second appeal is filed before this court. The counsel appearing for the defendant number 1 and 2 in this second appeal vehemently contends that the first appellate court committed an error in modifying the judgment, and hence this court has to frame the substantive question of law that there is no any cross appeal filed by the respondent plaintiffs without invoking the provisions of Order 41 Rule 33 of CPC ought not to have modified the same. And also counsel would vehemently contend that this court has to frame substantive question of law that appellate court was not justified in granting equal share to the plaintiff and defendant number 1 by ignoring the gift deed without adverting to section 30 of the Hindu Succession Act. Having heard the appellant counsel and also the reasons assigned by the trial court as well as the appellate court, and having perused the operative portion of the judgment of the trial court granted the relief in favor of the plaintiff as 1/4 share in respect of A scheduled properties and 1/3 share each in respect of item number 1 to 3 and item number 15 to 17 of B scheduled properties. And also it is made clear that plaintiffs and defendant number 1 is entitled for 1/3 share each in C scheduled property. And further, defendant number 1 is entitled for 1/4 share in the A scheduled properties and 1/3 share in the item number 1 to 13 and item number 15 to 17 with respect to B scheduled property as similarly entitled for the plaintiff number 1 and 2. And further directed that defendant number 1 and 2 are entitled for 1/4 share of deceased Gangadhara Gowda in respect of A scheduled properties. And hence the appellate court modified the judgment in paragraph number 60, rightly comes to the conclusion that when there are 3 co-partners, plaintiff's father and mother are no more, and suit is also filed after the death of father and mother, and the suit is inter se between the plaintiffs and defendant, and they are the sisters and the brother, and no dispute with regard to the relationship between the parties. And the fact that property belongs to the family is not in dispute. That is the main contention of counsel appearing for the appellant, that when the father had executed a gift deed, even though court comes to the conclusion that father had no right to execute a gift deed in respect of the property of the mother, and he was not having any absolute right, and counsel would vehemently contend that when the father is also having a right in respect of the property of the mother is concerned, court can invoke section 30 of the Hindu Succession Act. And also counsel would vehemently contend that the same has not been considered by the trial court and also the first appellate court while granting the relief. And the said contention cannot be accepted. First of all, when the father had no right to execute any gift deed in respect of the property of the mother is concerned, and when he was not having any right, question of executing the gift deed in favor of the son also doesn't arise, and the same was taken note of by the trial court by the court while modifying the same. And when the court comes to the conclusion that property belongs to the joint family and all the properties belongs to the family, and only succession among the members of the joint family, that is co-partners, that is plaintiffs and defendant number 1, and hence the reasoning is given by the appellate court in paragraph number 64 is not erroneous, and hence I do not find any ground to admit and frame any substantive question of law, since the appellant also not disputes the fact that the plaintiffs along with defendant number 1, they are the co-partners, and defendant number 2, who is the wife of defendant number 1 also would not get any right in any of the property, and granting of share in favor of the defendant number 2 is not correct since operative portion passed by the trial court is erroneous. Granting the relief in favor of defendant number 1 and 2, and defendant number 2 is not a co-partioner, and the observation made by the appellate court is also in accordance with law. Hence, no ground is made out to admit and frame substantive question of law. In view of the discussions made above, I pass the following order. Second appeal is dismissed.
36. Manu Shankar SS.
Partition on 24/7/1990. As per the partition register partition. As per the partition land value journal number 494 what of 1966 out of that matter because of the different entitled here at 1.5 Loknath and Kameshwar are entitled as per the partition both parties are Loknath Loknath and Kameshwar are partition and 3 as per the partition 1.5 20 are entitled 1 acre 20 and after and Kameshwar
First partition between the family defendant and others ಅಂತ ಇದೆಯಲ್ಲ 24/7/1980 ಅದು ಯಾರ ಮಧ್ಯೆ ಆಗಿರೋದು? ವಿರೂಪಾಕ್ಷ ಮೂರ್ತಿ ಮತ್ತೆ ಫಸ್ಟ್ ಮಂಜುಳಾ ಪ್ಲೇಂಟಿವ್ಸ್ ಹಸ್ಬೆಂಡ್ ಗುನು ಡಿಫೆಂಡೆಂಟ್ 1 ಗುನು ಪಾರ್ಟಿಷನ್ ಆಯ್ತು ಹೌದಾ? ಇನ್ ದ ಇಯರ್ 1980 ಆಯ್ತು. ಒನ್ ಅಂಡ್ ಹಾಫ್ ಗುಂಟ ಮಾತ್ರನಾ? 3 acres. ಹಾ. ಫಸ್ಟ್ ಪ್ಲೇಂಟಿವ್ ಹಸ್ಬೆಂಡ್ ಗೆ ನೀವೇನ ಫಸ್ಟ್ ಪ್ಲೇಂಟಿವ್ ಹಸ್ಬೆಂಡ್ ಮಂಜುಳಾ ಇದಾರಲ್ಲ ಅವ್ರ ಗಂಡನ್ಗುನು BP ವಿರೂಪಾಕ್ಷ ಮೂರ್ತಿಗೂ ಪಾರ್ಟಿಷನ್ ಆಗಿದೆ ಹೌದಾ? ಅಲ್ಲಿ ಡಿಫೆಂಡ್ ನಂಬರ್ 1 ಗೆ 3 acres 1.5 ಗುಂಟ ಬಂತು. ವಾಟ್ ಅಬೌಟ್ ದಿ ಫಸ್ಟ್ ಪ್ಲೇಂಟಿವ್ಸ್ ಹಸ್ಬೆಂಡ್ ಗೆ? ಯಾರು? ಕಾಮೇಶ್ವರ ಯಾರು? What is the relationship between the first plaintiff's husband and the first defendant? Genealogical tree ಇದೆಯಾ? ಹಾಕಿದ್ದೀರಾ? ಮತ್ತೆ ರಿಲೇಶನ್ಶಿಪ್ ಏನ್ರಿ? ಪ್ರಾಪರ್ಟಿ ಬಿಲಾಂಗ್ಸ್ ಟು whom? ಯಾರು? ಪುಟ್ಟಾಚಾರ್ ಪುಟ್ಟಲಿಂಗಾಚಾರ್ ಆಯ್ತು. ಪುಟ್ಟಲಿಂಗಾಚಾರ್ ಸೇರಿದಂತ ಆಸ್ತಿನ ಇದು? ಪುಟ್ಟಲಿಂಗಾಚಾರ್ಗೆ ಎಷ್ಟು ಜನ ಮಕ್ಕಳು? ಒಬ್ಬನೇ ಮಗನಾ? ಆಯ್ತು. D1 ಆಯ್ತು. ಮತ್ತೆ ಫಸ್ಟ್ ಹಸ್ಬೆಂಡ್ ಯಾರು? ಪುಟ್ಟಲಿಂಗಾಚಾರ್ಗೆ ಒಬ್ಬನೇ ಮಗ ವಿರೂಪಾಕ್ಷ ಮೂರ್ತಿ ಹೌದಾ? ಆಮೇಲೆ ಮಂಜುಳಂಗೂ ಫಸ್ಟ್ ಡಿಫೆಂಡೆಂಟ್ ರಿಲೇಶನ್ಶಿಪ್ ಏನ್ರಿ? ಹೋಗ್ಲಿ, ವಿರೂಪಾಕ್ಷ ಮೂರ್ತಿಗೆ ಎಷ್ಟು ಜನ ಮಕ್ಳು ಹೇಳಿ? ಒಬ್ಬನೇ ಮಗ, ಅವನೊಬ್ಬನೇ ಮಗ ಪುಟ್ಲಿಂಗಾಚಾರ್ಗೆ. ಅವನಿಗೆ ಎಷ್ಟು ಜನ ಮಕ್ಕಳು? ಚೂಡಾಮಣಿ, ಲಿಂಗರಾಜು, ನಾಗಭೂಷಣ, ಶಶಿರೇಖಾ, ಹೌದಾ? ಆಯ್ತು. ಈ ಸೂಟ್ ಹಾಕ್ದವ್ರು ಯಾರು ಮತ್ತೆ? ಲೋಕನಾಥ್ ಯಾರು? ರಿಲೇಶನ್ಶಿಪ್ ಹೆಂಗ್ರಿ ಫ್ಯಾಮಿಲಿಗೆ? when they are seeking the relief of partition declaration ಆಯ್ತು. ನಿಮ್ಮ ಪ್ರಕಾರ there was a partition between BP Virupaksha Murthy, BS Lokanath and BS Kameshwara on 24/7/1918 ರೀ. ಇವ್ರು ಒಬ್ಬನೇ ಮಗ ಆದ್ರೆ ವಿರೂಪಾಕ್ಷ ಮೂರ್ತಿ ಜೊತೆ ಬೇರೆಯವ್ರಿಗೆ ಯಾಕೆ ಪಾರ್ಟಿಷನ್ ಆಗುತ್ತೆ? BS ಲೋಕನಾಥ್, BS ಕಾಮೇಶ್ವರನ್ಗೆ ಸರಿ ರೀ, ಆ ಪಾರ್ಟಿಷನ್ ಹೆಂಗಾಗುತ್ತೆ ಇವ್ರ ಜೊತೆ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀನಿ. ಅವನೊಬ್ಬನೇ ಮಗ ಅಲ್ವಾ ಪುಟ್ಲಿಂಗಾಚಾರ್ಯಗೆ? BP ವಿರೂಪಾಕ್ಷ ಮೂರ್ತಿ ಅದಕ್ಕೆ ಕೇಳ್ದೆ, ಜಿನಾಲಜಿಕಲ್ ಟ್ರೀನಾರು ಹಾಕಿದೀರಾ? ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ನೋಡ್ಕೊ ಬನ್ನಿ, ಡೋಂಟ್ ವೇಸ್ಟ್ ದಿ ಟೈಮ್. Third, list this matter on 12/11.
37 ಉಮೇಶ್ ಮೂರ್ತಿ GM.
ಇಲ್ವಾ? ಕೊಡಿ. ಲಾಸ್ಟ್ ಟೈಮ್ ಏನಾಗಿದೆ? ಫಸ್ಟ್ ಟೈಮ್ ತೊಗೊಳ್ಳಿ. Appellant counsel is absent. However, in the ends of justice, one more opportunity is given. If appellant counsel doesn't appear in the next state of hearing, appeal will be dismissed. List this matter on 12/11. 38. Dismissed with liberty to approach the revenue authority. Confirmed.
And the airport also gives a finding that the plaintiff is in possession of the property, instructed the plaintiff in possession of the property.
Where is that the reasoning?
Page number 27, page number 42 scholars.
42 reasoning.
27 no appellate court. Appellate court togolli.
Appellate court ಗಿಂತ ಫಸ್ಟ್ ಟ್ರಯಲ್ ಕೋರ್ಟಿಗೆ ಬನ್ನಿ.
It should be in 41 page, page number 41. Whether the plaintiff proves that she is in possession.
ಅದೆಲ್ಲ ಬೇಡ್ರಿ, ರೀಸನಿಂಗ್ ಗೆ ಬನ್ನಿ.
In the background reasoning number 1. Page number 42. In the background of the pleadings of the parties.
Reasoning ಅಂದ್ರೆ ಡಿಸ್ಕಷನ್ ಬೇಡ. ಯೂಸ್ ಮೇಡ್ ಮೆನ್ಷನ್ ದಟ್ plaintiff is in possession ಅಂತ ಕೋರ್ಟ್ ಕನ್ಕ್ಲೂಷನ್ ಗೆ ಬಂದಿದ್ದಾರೆ. ಬಿಲ್ಡಿಂಗ್ ಈಸ್ ಕನ್ಸ್ಟ್ರಕ್ಟೆಡ್ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ, ಆ ರೀಸನಿಂಗ್ ಎಲ್ಲಿದೆ?
It can be gathered that the plaintiff has constructed the restriction house in suit site number so and so 16, and the defendant also not disclosed in the construction of the house, and the plaintiff is in
possession of it.
ಈ ಬೈಂಡಿಂಗ್ issues number 1 ನೆಗೆಟಿವ್ ಅಂತ ಮಾಡ್ತಾರೆ.
ಅಂದ್ರೆ ಯಾವ ರೆವಿನ್ಯೂ ರೆಕಾರ್ಡ್ಸ್ ನಿಮ್ಮ ಹೆಸರಲ್ಲಿ ಇಲ್ಲ?
ರೆವಿನ್ಯೂ ರೆಕಾರ್ಡ್ಸ್ ನನ್ನ ಹೆಸರಿದೆ ಅಂತ ನಾವು ಹೇಳ್ತಾರೆ. ರೆವಿನ್ಯೂ ರೆಕಾರ್ಡ್ಸ್ ನನ್ನ ಹೆಸರೇ ಇದೆ.
ಎಲ್ಲಿದೆ ಹಾಗಂತ? ನಿಮ್ಗೆ ಯಾಕೆ ಲಿಬರ್ಟಿ ಕೊಡ್ತಾರೆ? ಲಿಬರ್ಟಿ ಟು ಅಪ್ರೋಚ್ ದಿ ರೆವಿನ್ಯೂ ಅಥಾರಿಟಿ ಅಂತ. ಆಯ್ತು, ನೀವು ಪೊಸಿಷನ್ ಪ್ರೂವ್ ಮಾಡಕ್ಕೆ ಏನ್ ದಾಖಲೆ ಕೊಟ್ಟಿದ್ದೀರಿ? ಲೇಔಟ್ ಪ್ಲಾನ್ ಇದೆ, ಸೇಲ್ ಡೀಡ್ ಆಯ್ತು. ಸೇಲ್ ಡೀಡ್ ವಿಲ್ ನಾಟ್ ಅದನ್ನೇ ಕೇಳ್ತಾ ಇದ್ದೀನಿ. ರೆವಿನ್ಯೂ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಏನಾರು ಇದೆಯಾ? ಖಾತಾ ಇದೆ, ಎಲ್ಲಿದೆ ಅದು? ಎಲ್ಲಿದೆ ಖಾತಾ? ನೀವು ಹಾಕಿರೋದೇ 3 ಡಾಕ್ಯುಮೆಂಟ್ಸ್: ಕಾಪೀಸ್ ಆಫ್ ಸೇಲ್ ಡೀಡ್ಸ್, ಎಕ್ಸಿಬಿಟ್ P1 to 3. ಮತ್ತೇನ್ ಕೊಟ್ಟಿದ್ದೀರಿ? 3 ಏನು ಅಂತ ಹೇಳಿ ಹೋಗ್ಲಿ. 3 ಸೇಲ್ ಡೀಡನಾ? ಮತ್ತೆ ಸೇಲ್ ಡೀಡ್ ಆದ್ಮೇಲೆ ಖಾತಾ ಮಾಡಿಸ್ಕೋಬೇಕು, ಟ್ಯಾಕ್ಸ್ ಕಟ್ಟಬೇಕು. ಎಲ್ಲಿದೆ ಅದನ್ನ? ಎಲ್ಲಿದೆ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀನಿ ನಿಮ್ಗೆ.
15th schedule ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ ಕಾಲ ಇದೆ ಅಂತ ಹೇಳಿ. ಅದನ್ನೇ ಅಪ್ರಿಸಿಯೇಷನ್ ಮಾಡಿದ್ದಾರೆ schedule ಅಂತ page number 51 very board municipal khata number 9652 site number 16 new municipal khata number 8916 9652 whether it is
ಅದ್ ನೀವು ಡಿಸ್ಕ್ರೈಬ್ ಮಾಡಿರೋದ್ರಿ. ಡೋಂಟ್ ಟ್ರೈ ಟು ಮಿಸ್ಲೀಡ್ ದಿ ಕೋರ್ಟ್. ಮತ್ತೆ what are the documents you have placed before the court to establish your possession? ನೀವು ನನಗೆ ಡಿಗ್ರಿ ಓದ್ಬಿಟ್ಟು ಅದ್ರ ನೀವೇನ್ ಶೆಡ್ಯೂಲ್ ತೋರಿಸಿದಿರಿ ಅದನ್ನ ಓದಕ್ ಹೋದ್ರೆ ಮತ್ತೆ I am repeatedly asking, what are the documents you have produced to show that you are in possession of the property? You are going to read the decree and schedule ಏನಿದೆಯೋ ಅದು ಶೆಡ್ಯೂಲ್ ನಿಮ್ದು, ಅದು ನೀವು ಕೊಟ್ಟಿರೋದು. ಆಯ್ತು, ಇಲ್ಲಿ ಹೇಳಿದ್ರಲ್ಲ ನೀವು ಖಾತಾ ಏನೋ ಹೇಳಿದ್ರಲ್ಲ, ಓಲ್ಡ್ ಮುನ್ಸಿಪಲ್ ನಂಬರು ಖಾತಾ ನ್ಯೂ ನಂಬರು, ಅದಕ್ಕೆ ಎಲ್ಲಿದೆ ದಾಖಲೆ, ಎಲ್ಲಿ ಕೊಟ್ಟಿದ್ರಿ ಕೋರ್ಟಲ್ಲಿ? ಏನು ಓದಿದ್ರಿ ಶೆಡ್ಯೂಲ್ ತೋರಿಸಿ. ಓಲ್ಡ್ ಮುನ್ಸಿಪಲ್ ಖಾತಾ ನಂಬರ್ 9652/732 of 16, site number 16, new municipal khata number 8960 of 9652. Where are those documents? ಮತ್ತೆ ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ. ಅದಕ್ಕೆ ಲಿಬರ್ಟಿ ಕೊಟ್ಟವ್ರೆ. You get the documents from the concerned revenue authorities ಅಂತ. ನಿಮ್ಗೆ ಯಾಕೆ ಏನ್ ಪ್ರಾಬ್ಲಮ್ ಏನು? ರೆವಿನ್ಯೂ ಅಥಾರಿಟೀಸ್ ನಲ್ಲಿ ಬೇಸ್ಡ್ ಆನ್ ಸೇಲ್ ಡೀಡ್ ಖಾತಾ ಟ್ಯಾಕ್ಸ್ ಇವೆಲ್ಲ ಕಟ್ಟಕ್ಕೆ. ಬಟ್ ನೀವೇ ನಂಬರ್ ಕೊಟ್ಟಿದ್ದೀರಿ, ಖಾತಾ ನಂಬರ್ ಎಲ್ಲ ಅದೆಲ್ಲಿದೆ? ಶೆಡ್ಯೂಲ್ ಅಲ್ಲಿ ನೀವು ಮೆನ್ಷನ್ ಮಾಡಿದಿರಲ್ಲ ಅದು. ಅಟ್ಲೀಸ್ಟ್ ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಎಲ್ಲಾರು ಹಾಕಿದ್ರಾ? ಮತ್ತೆ ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ, ಏನಂತ? ಕೇಸ್ ಆಫ್ ಡಿಪೆಂಡೆಂಟ್ ಏನು? ಮುನ್ಸಿಪಲ್ ಅಥಾರಿಟಿನಾ? ಅವ್ರದ್ದೇನು ಡಿಫೆನ್ಸ್ ಏನು? ಖಾತಾ ಕ್ಯಾನ್ಸಲ್ ಮಾಡ್ತೀವಿ ಅಂದ್ರೆ ದರ್ ಮಸ್ಟ್ ಬಿ ಎ ಖಾತಾ. ಅದೆಲ್ಲಿದೆ ಅದನ್ನೇ ಕೇಳ್ತಾ ಇದ್ದೀನಿ. ಹೋಗ್ಲಿ, ಇಲ್ಲಾರು ಹಾಕ್ರಿ ಆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ನ, ಇಲ್ಲಾರು ಹಾಕಿ ಆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ನ. ನೀವೇನ್ ಖಾತಾ ನಂಬರ್ ರೆಫರ್ ಮಾಡ್ತೀರ ಅದನ್ನ ಅದನ್ನಾರು ಹಾಕ್ರಿ, ಅಟ್ಲೀಸ್ಟ್ ಟು ಶೋ ದಟ್ ಯು ಆರ್ ಇನ್ ಪೊಸಿಷನ್ ಅಂತ ತೋರ್ಸಕ್ಕೆ. ಆಯ್ತು, ಯಾವಾಗ? Appellant counsel seeks time to place on record khata and other documents to establish the possession. And hence list this matter on 12/11. 39. 12/11, 13th ಬೇಕಾ? ಆಯ್ತು, 13/11. ಏನ್ ಡಿಲೇ ಆಯ್ತಾ? ಎಷ್ಟು ದಿವಸ? ಅದು ಅಲೋಡ್ ಕಂಡೋನ್.
39 ಮೋಹನ್ ಕುಮಾರ್ ಡಿ.
ಡೈವರ್ಜೆಂಟ್ ಫೈಂಡಿಂಗ್, ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್. ಇನ್ನು ಯಾರು ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಇದ್ದಾರಾ? ಒಬ್ರೇನಾ? ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 2/12. 40 ಸಿದ್ಮಲ್ಲಪ್ಪ PM. 26 confirmed.
For the appellants, my lords. Suit for partition, my lords. Concurrent finding, my lords. The properties are the ancestral properties of both the plaintiff and defendants, my lords. If number 3 is second appeal, my lords, the only
T3 is the appellant.
Yes, my lords. The one question of law that has to be considered is that, my lords, the widow mother is not entitled equal share in the ancestral property, my lords. Widow mother is not a co-partner to the
widow mother idara.
Yes, my lords.
The widow,
she is the first plaintiff, my lords.
Plaintiff idara.
Yes, my lords. The trial court has erred in allotting a equal share to the widow mother also, my lords.
Yara plaintiffs?
Plaintiff
mother and
one of the daughter, my lord.
Rangamma,
yes,
wife of late Kembalaya.
Yes, my lord.
Narsamma dead by LRs. See, Narsamma yaru?
Narsamma is the daughter, my lords.
Daughter?
Yes, my lords. Rangamma is the mother, my lords.
ರಂಗಮ್ಮ ಜಯಮ್ಮ ಜಯಮ್ಮ ಯಾರು?
She is also daughter, my lords.
Daughter. Mother and daughter filed the suit.
Yes, my lords. Against the remaining daughter and one brother, my lords.
Against the wife of the son. ಹೌದಾ?
Yes, my lords.
ಇದ್ದ ಗಂಗಮ್ಮ.
Against the son, my lords.
ಸನ್ ಇಲ್ವಲ್ಲ ಮೇಡಮ್ ಇಲ್ಲಿ? ಸನ್ ಹೆಸರೇನು?
Nagraj, my lords. Nagraj is the appellant, my lords.
Nagraj.
Yes,
that is
my lords.
defendant number 3.
Yes, my lords.
ಈ ಕುಮಾರ ಇಲ್ಲ ಯಾರು?
Kumara is one of the daughter is dead, my lords. One of the daughter's legal heir is Kumara, my lords.
1A, 1B, 1C are the Narsamma. Narsamma is also one of the daughter.
Yes, my lords. The relationship is undisputed, my lords.
ಸಿಮ್ಮೇಗೌಡ ಅಂತ ಇದೆ ಮೇಡಮ್ ಅವ್ರು ಯಾರು? ಲಕ್ಷ್ಮೀ ದೇವಮ್ಮ, daughter of late Kambalaya, that's correct. Kumara, son of Timmegoda, D2. Yes, madam. You are appearing for whom?
I'm appearing for the respondents.
Respondents? All respondents?
All respondents.
Only Kevetar or two? Kevetar or two?
Yes, yes, ma'am.
Madam, you?
Same.
Only same? There notice agilla?
No.
Yes, either noti, madam. ಅವರೆಲ್ಲ ಕಂಟೆಸ್ಟ್ ಮಾಡಿದಾರಾ?
No, they were placed ex parte before trial.
ಮೆಮೊ ಹಾಕ್ತೀರಾ ಹಾಕಿ? ಮೆಮೊ ಹಾಕ್ತೀರಾ ಹಾಕಿ?
I'll file a memo.
ಯಾರು? ತೊಗೊಳ್ಳಿ. Appellant counsel seeks time to file memo to dispense the notice against other respondents and hence list this matter on 212.
Date, my lord?
212, sorry, 212 ಬೇಡ, ಯಾವ್ದು 12 13 ಕೊಡ್ತಾ ಇದ್ದೀರಾ? 1311 41
ಅಂಕಲ್ ಕೋಟೆ ರಾಜೇಂದ್ರ ಶಾಂತಪ್ಪ.
ಡೈವರ್ಜೆಂಟ್ ಫೈಂಡಿಂಗ್. ಬೇರೆ ಯಾರು ಇದಾರ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್? ಎಲ್ಲ
ಅದರ್ ಕಂಟೆಸ್ಟಿಂಗ್ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್
1 to 7 ಮಾತ್ರನಾ? 8 ಇದಾರೆ ಇನ್ನೊಬ್ರು. Issue notice against the respondent number 8 and in the meanwhile registry is directed to get the records of both the courts and list this matter on 212 42 dismissed and reversed 1/3 share in A schedule property. ಎಲ್ಲ ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡಿದಾರೆ ಇಲ್ಲ? ನೋಟಿಸ್ ಆಗಿಲ್ವಾ?
Notice first time.
To notice against the respondents and also entry allowed in part 1/4 in respect of 1 to 17.
Yes, ma'am.
Modified 1/7, 1 to 10, 14 to 17, 11 to 13 dismissed.
Yes.
Non-furnishing of PF ಕೊಟ್ಟಿಲ್ವಾ?
ಇಲ್ಲ, ಅದಾಗಲೇ I have filed a memo for dispensation and a judicial order is also passed, my lord.
ಆಲ್ರೆಡಿ ಪಾಸ್ ಆಗಿದೆ.
ಆಗಿದೆ.
ಮತ್ತೆ ಯಾಕೆ ತೋರಿಸಿದಾರೆ? ಆಗಿದೆ ಮತ್ತೆ ತೋರಿಸಿದಾರ? ಇದೇನ ಗ್ರಾಂಟ್ ಆಫ್ ಲೀವ್ ಕೇಳಿದ್ರಲ್ಲ ಯಾರು?
I have sought, my lord. Now what had happened is there were two appeals. In one of the appeal, my lord, all the LRs were brought on record. In another appeal, my lord, the LRs were not brought on record.
ಅದಕ್ಕೋಸ್ಕರ ಲೀವ್
ಅದಕ್ಕೋಸ್ಕರ the leave, my lord, is
ಅದೇ ಅಪೀಲ್ ಅಲ್ಲಿ ನಾಟ್ ದಿ ಪಾರ್ಟೀಸ್ ಅಂತ.
Please.
That is the only ground?
Yes, my lord.
ನೀವು ಕೊಡಬಹುದು. Heard on A number 1 of 24 wherein prayer is sought to grant the leave on the ground that while bringing the LRs only in appeal, one appeal brought the LRs, in other appeal not brought the legal heirs, and when such legal heirs are not brought on record and they are not the parties before the first appellate court, leave is granted as sought in IA number 1 of 24. Yes. Next, the counsel appearing for the appellant would submit that in idu RSA ki madam, RSA 1110 of 2024 order idu. Appellant counsel also submit that issuance of notice to 10 R10 is already dispensed. Already dispensed and order has been passed. And hence registry is directed to see the order dated yavattindu 28/8/25 and delete the same ನೆಕ್ಸ್ಟ್ ಏನ್ ಹೇಳ್ರಿ?
delay 11 days delay.
11 days heard on IA number. ಇಲ್ಲೇನ ಸ್ವಲ್ಪ ಮಾಡಿಫಿಕೇಶನ್ ಎಲ್ಲ ಇದೆಯಲ್ಲ, ಬೇಕಾಗ್ಬೋದು, ರೆಕಾರ್ಡ್ಸ್ ಬೇಕಾಗ್ಬೋದು ಅಲ್ವಾ?
ಹೌದು.
Heard on IA number 2 of 24 and there is a delay of 11 days in filing the appeal and for the reasons stated in the accompanying application and affidavit in RSA 1110 of 2024, delay of 11 days is condoned. Registry is directed to get the records of both the courts and list the matter on ಯಾವೂರು? ಶ್ರೀರಂಗಪಟ್ಟಣ. ಮಂಡ್ಯ.
ಹೌದು.
ಯಾವಾಗ ಮೇಡಮ್? 1711.
Please.
44.
ಇದು ನಿಮ್ದು ಯಾಕೆ ಲಾಸ್ಟ್ ಟೈಮ್ ಏನೋ ನಾನ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಡಿಸ್ಮಿಸಲ್ ಅಂತ ಇದೆ?
ಬೋರ್ಡ್ ಅವತ್ತು ವರ್ಕ್ ಆಗ್ಲಿಲ್ಲ. ನಾನು ಅಷ್ಟೊತ್ತಿಗೆ ಪ್ರಸನ್ನ ಸರ್ ಅಲ್ಲಿಗೆ ಬಂದ್ರು.
ಬೋರ್ಡ್ ವರ್ಕ್ ಆಗ್ಲಿಲ್ವಾ
ಅವತ್ತು?
ಬೋರ್ಡ್ ನೋಡ್ಕೊಂಡ್ ಬರ್ತೀರಾ ನೀವು?
ಅಲ್ಲ 11 ಅಲ್ಲೇ ಇದ್ದೆ. ನಾನು ಸರಿಗೆ ಹೇಳಿದೆ ಬರ್ತಾ ಇದ್ದೀನಿ ಆನ್ ದಿ ವೇ ಇದೀನಿ ನಾನು ಅಂತ.
ಯಾವಾಗ ಹೇಳಿ? ಯಾವಾಗ ಬೇಕು? ಯಾವಾಗ ಬೇಕು? ಫಾರ್ ವಾಂಟ್ ಆಫ್ ಟೈಮ್ ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ after 12th 13/11. 45 ಮುನಿ ರೆಡ್ಡಿ ಕನ್ಕರೆಂಟ್ ಪೆಂಡಿಂಗ್ ಇದಾರಾ? ಇಲ್ಲ.
45
ಅಪ್ಲೆಂಟ್ ಕೌನ್ಸಿಲ್ ಇಸ್ ಆಬ್ಸೆಂಟ್. ತಗೊಳ್ಳಿ, ಹಿಂದಿನ ಸರಿ ಬಂದ್ ಹೋಗಿದೆ ನೋಡಿ, ಅವತ್ತೇನಾರು ಆಬ್ಸೆಂಟ್ ಇದಾರ ನೋಡಿ.
ಅಡ್ಮಿಷನ್ ಫಸ್ಟ್ ಟೈಮ್ ಬರ್ತಾ ಇರೋದು ಸರ್.
ಅಡ್ಮಿಷನ್ ಫಸ್ಟ್ ಟೈಮ್ ತಗೊಳ್ಳಿ. Appellant counsel is absent. In the ends of justice, one more opportunity is given, and if appellant counsel doesn't appear in the next date of hearing, appeal will be dismissed for non-prosecution. List this matter on 13/11, 12/11. 13/11.
46.
13/11. 46.
Divergent findings will not.
Recovery 50,000 per annum. 6 reversed. Call for records and issue notice. List this matter on. ಯಾವೂರಿಂದ ಬರ್ಬೇಕು ಮೇಡಮ್ ರೆಕಾರ್ಡ್ಸ್?
ಸಾಗರ್. ಸರ್ಬದಿಂದ ಬರ್ಬೇಕು.
ಸಾಗರ. ಸೊರಬ.
Yes.
212.
Sir,
212.
47. GJ
Sumkapur dismissed.
Permanent injunction.
Confirmed.
Concurrent
ಇದು ಕ್ಲೇಮ್ ಆಗಿದೆ.
ಕೌಂಟರ್ ಕ್ಲೈಮ್ ಅಲ್ಲ ಆಗಿದೆ.
ಯಾವಾಗ ಬೇಕು ಹೇಳಿ? ಯಾವಾಗ ಬೇಕು?
ಅಲ್ಲಿ ಎಕ್ಸಿಕ್ಯೂಷನ್ 31st ಇದೆ ಸಮಯ.
ಈ 31st ನಾಡಿದ್ದೆ.
ಅವ್ರು ನಾಟ್
ಎಕ್ಸಿಕ್ಯೂಷನ್
ಪ್ರೆಸಿಪಿಟೇಟ್ ಮಾಡಲ್ಲ ಅಂದ್ರೆ ಒಂದು ಡೇಟ್ ಕೊಡ್ಬೇಕು.
And for that sale deed, the husband of the plaintiff is a party. That she was permitted to reside. That she sought for injunction, that is refused. That I sought for counterclaim. Possession, that is on the basis of
sale deed ನೀವೇ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡ್ಕೊಟ್ಟು?
No my lord, we are not executed any sale deed my lord.
ನೀವು ಅಂದ್ರೆ ನಿಮ್ಮ ಹಸ್ಬೆಂಡ್?
No my lord, we are not executed. We are purchased in 1976. We are husband of the plaintiff purchased the property my lord. Till today we are in the possession of the property.
Possession ಆಯ್ತು. ಸೀಲ್ ಡೀಡ್ ನಿಮ್ಮ ಹಸ್ಬೆಂಡ್ ಬರ್ಕೊಟ್ಟಿದಾರ?
ಇಲ್ಲ ಬರ್ಕೊಟ್ಟಿಲ್ಲ.
ಮತ್ತೆ ಟ್ರಯಲ್ ಎರಡು ಕೊಟ್ಟರು, ಕನ್ಕರೆಂಟ್ ಪೆಂಡಿಂಗ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅಲ್ಲಿ ಇದು they are not sought any declaration my lord.
ಏನ್ ಡಿಕ್ಲೇರ್?
Even counter claim also there is no declaration. Declaratory relief is sought my lord. Only ejectment is the issue number 7 payment for the eviction my lord. Counter claim. Not for the declaration my lord.
ನೀವು ಸೇಲ್ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಿದಿರಾ?
Yes my lord.
ಏನ್ರಿ ಸೇಲ್ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಿದಾರಂತ?
Yes my lord. Even my evidence also we are disputed the.
Call for records.
Delay may.
ಡಿಲೇ ಎಷ್ಟು ದಿವಸ ಇದೆ?
14 ದಿವಸ ಇದೆ.
ಇಲ್ವಲ್ಲ, ಏನು ತೋರ್ಸಾ ಇಲ್ಲ ಇಲ್ಲಿ?
ಒಂದರಲ್ಲಿ ಇದೆ ಸರ್.
ಯಾವ್ದ್ರಲ್ಲಿ ಇಲ್ಲ? ಇದೆ ಮೇಡಮ್.
1317.
Respondent is directed not to precipitate the matter till next date of hearing. ಮಾಡಬೇಡಿ. ನೋಡೋಣ ಅದೇನೋ ಇದೆ ಅಂತ. ಸೇಲ್ ಡೀಡ್ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಿದಾರೆ ಅಂತ. ನೀವು ಬೇರೆ ಇಂಜಂಕ್ಷನ್ ಸೂಟ್ ಅಲ್ಲಿ ಪೊಸಿಷನ್ ಹೆಂಗ್ ಕೇಳ್ತೀರಿ? In a suit for injunction. Suit for injunction, you can seek for counter claim of injunction ಅಷ್ಟೇ. You cannot enlarge the scope of the suit. ಅದಕ್ಕೆ ಮಾಡಕ್ಕಾಗುತ್ತೆ. You cannot enlarge the scope of the suit by seeking a possession in the injunction suit. You have to seek for the relation of declaration and possession. That's all. Hengre Gopal avare, in a suit for declaration, how can you seek for the possession? Not anything. when the suit is for only the bare when the suit is only for the bare injunction.
Supposing we had asked for.
You enlighten the court. I am also subject to correction. You enlighten the court. ಯಾವಾಗ ಬೇಕು ಹೇಳಿ. ಡಿಲೇ ಡೇಸ್ ಬರ್ದಿಲ್ಲ ಅಂತಲ್ಲ.
14 days ಇದೆ.
ಅದನ್ನ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಬೇಕಲ್ಲ ಮೇಡಮ್, ಯಾಕೆ ಹಾಕಿಲ್ಲ? ಆಯ್ತು, ರೆಕಾರ್ಡ್ಸ್ ಕಾಲ್ಫರ್ ಮಾಡಿದ್ವಿ. ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 17/11 ನೋಡಿ, ಅಷ್ಟರೊಳಗೆ ನೋಡಿ.
Not to precipitate the matter.
When the scope of the suit is only for bare injunction, whether you could seek the relief of possession in a suit for bare injunction, nodi. As far as my knowledge, it's not possible.
Execution 16/20.
Right on the court. I am also subject to correction.
My lord, not to precipitate the execution.
ಮಾಡಿದ್ನಲ್ರಿ ಆರ್ಡರ್.
Please, my lord.
Till next date of hearing ಅಷ್ಟೇ.
Please, my lord.
ಈಗ ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ನೀವು ಬರ್ಬೇಕು. ಆರ್ಡರ್ ತಗೊಂಡ್ ಮತ್ತೆ ಬರ್ದೇ ಹೋದ್ರೆ ಇಲ್ಲ.
Please, my lord.
ಮುಂದಿನ ಸರಿ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಲ್ಲ.
48 ದಿವಾಕರ್ ಕೇನ್.
My lord, IAPR ನಾನೇ ಸರ್. IAPR for the appel. Sir, suit concurrent findings. My suit is one for.
ಯಾವಾಗ ಬೇಕು ಹೇಳಿ. ಟೈಮ್ 5 ಗಂಟೆ ಯಾವಾಗ ಬೇಕು?
4/11 ಆದಿತ್ತ ಅಂತ ಹೇಳಿ ಸರ್. 4th November. Is it if convenient to the court, sir?
ಆಯ್ತು, 4/11 ಆದೀತು ಅಂತಲೇ ಕೊಟ್ಟಿದ್ದೀನಿ. ಆಯ್ತು
ಸರ್, much obliged sir.
For want of time, this matter on 4/11. ಆಯ್ತು.
Pattern in hearing 49.
ಇಲ್ಲಿ ಮಂಗಳೂರಿಂದ ಕುಳಿತು ಮಾತಾಡ್ತಿದ್ದಾರಾ? ಆದೀತು ಎಲ್ಲಿದ್ರೆ ಅದೇ ಲ್ಯಾಂಗ್ವೇಜ್ ಮಂಗಳೂರದೇ ಇರ್ಬೇಕು. PPI ಕಡೆ ಹೇಳ್ಬೇಕು. ಆದೀತು ಅಂದ್ರೆ ಲ್ಯಾಂಗ್ವೇಜ್ ಎಲ್ಲಿದೆ? ಅದು ಆದೀತು
from Mangalore.
ಕುಂದಾಪುರ.
ಪುತ್ತೂರು ಸರ್. ಮಂಗಳೂರು ಪುತ್ತೂರು. ಹೌದು ಸರ್.
English from Puttur. My learned friend, he's my learned friend. Puttur, so Shuddha Bhasha.
Friend for voting to make you as a bar council member.
He has always supported me in other ways.
4/11 next. ರಾಜಶೇಖರ್ ಎಷ್ಟಿದೇನ್ರಿ
respondent?
ಸೆಟ್ಲ್ ಆಗ್ಲಿಲ್ಲ. ಸೆಟ್ಲ್ಮೆಂಟ್ ಗೆ ಅಂತ ಇತ್ತ ಇದು. Perusal of report received from KMC has not settled.
Mediation ಹೋಗಿತ್ತು. ಅವರು mediation ಅಂತ ಹೇಳಿ ತಗೊಂಡ್ರು. ಅವ್ರು ಗಲ್ಫ್ ಅಲ್ಲಿ ಇದ್ದಾರೆ, ಬೇಡ ಅಂತ ನಾವು ಹೇಳಿದ್ವಿ, ಮತ್ತೆ ಬರ್ಲಿಲ್ಲ. ತಗೊಂಡು ಮತ್ತೆ ಮುಂದೆ ಹೋಯ್ತು. ಈ ಟೆನೆಂಟ್ ಅಂತ ಕಂಟೆನ್ಷನ್ ಮಾಡಿಬಿಟ್ಟು 1 ಪೈಸೆ ಕೊಟ್ಟಿಲ್ಲ ಇಲ್ಲಿವರೆಗೆ. 15 ವರ್ಷದಿಂದ ಇದ್ದಾರೆ.
ಇದು ಯಾವ್ದು ಒಂದ್ಸರಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್
ಅದೇ ನಾವು ಏನು ರಾಜಿ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿ ಅವ್ರಿಲ್ಲ ಮನೆಯಲ್ಲಿ, ಬರ್ಲಿಲ್ಲ. ಸುಮ್ನೆ ರಾಜಿ ಅಂತ ಹೇಳಿ ಹೋಗಿ ಬಂತಷ್ಟೇ. ಬರ್ಲಿಲ್ಲ, ಗಲ್ಫ್ ಅಲ್ಲಿ ಇದ್ದಾರೆ ಅವರು ಆರಾಮದಲ್ಲಿ. ಇದು
ಯಾವಾಗ ಬೇಕು ಹೇಳಿ.
Starting in the property without paying anything.
ಲಾಸ್ಟ್ ಟೈಮ್ ಏನೋ ಕಾಂಪ್ರಮೈಸ್ ಮಾಡ್ತೀವಿ ಅಂದ್ರಲ್ರಿ?
ಅಲ್ಲ, ಸೆಟ್ಲ್ ಅದು ಮೀಡಿಯೇಷನ್ ರೆಫರ್ ಆಗಿತ್ತು.
ಆಗಿಲ್ಲ ಅಲ್ಲ, ನೀವ್ ಯಾಕೆ ಹೋಗ್ಲಿಲ್ಲ?
ಇಲ್ಲ, ಅದು
ಮೀಡಿಯೇಷನ್ಗೆ
ಬ್ಯಾಂಗ್ಳೂರ್ ಮೀಡಿಯೇಷನ್ ಸೆಂಟರ್ ರೆಫರ್ ಆಗಿತ್ತು. ಅವಾಗ ಇಲ್ಲಿ ಮೀಡಿಯೇಷನ್ ಡ್ರೈವ್ ಬಂತು.
You got it referred for mediation.
Suggested to.
ಇಲ್ಲ, ಅವ್ರು ಸಜೆಸ್ಟ್ ಮಾಡಿಲ್ಲ, ನಾವೇ ಸಜೆಸ್ಟ್ ನಾವ್ ಯಾರು ಸಜೆಸ್ಟ್ ತಾವು ಮಾಡಿಲ್ಲ, ನಾವು ಮಾಡಿಲ್ಲ. ಅವರೇ ಹೇಳಿದ್ ನಾವು ರಾಜಿ ಮಾಡೋಣ, ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿ. ಮಾಡ್ತೀವಿ ಅಂತಂದ್ರೆ
ಸೀನಿಯರ್ ನಾವು held up in other court. ಆ ಕೋರ್ಟ್ ಬೇರೆ ಕೋರ್ಟ್ ನಡೀತಾ ಇದೆಯಾ? 5 ಗಂಟೆಲ್ಲೋ
ಫಸ್ಟ್ ಕೋರ್ಟಿಗೆ ಹೋಗಿದ್ವಿ.
ಫಸ್ಟ್ ಕೋರ್ಟ್. ಆಯ್ತು, ಲಿಸ್ಟ್ ದಿಸ್ ಮಾಡಿ. ಯಾವಾಗ ಬೇಕು ಹೇಳಿ.
5th
ಅವಾಯ್ಡ್ ಮಾಡು. 6 to 7 5th ಅವಾಯ್ಡ್ ಮಾಡ್ಬೋದು ದಯವಿಟ್ಟು.
ಬೇಡವಾ? ನೋಡಿ ಮೇಡಮ್,
8, 9
ಫ್ರೈಡೆ ಬೇಡ. 10, 11
ಆಗ್ಬೋದು.
ಫಾರ್ ವಾಂಟ್ ಆಫ್ ಟೈಮ್ ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 10, 11. ಬಾಕಿದೆಲ್ಲ 50 ಮೇಲಿಂದೆಲ್ಲ ಕೊಡಿ. ಏನ್ ಮಾಡೋದು? 30 ಮ್ಯಾಟರ್ಸ್ ಅಡ್ಮಿಷನ್ಸ್ ಗೆ ಬಂದಿತ್ತು.
Serial number 50 I am appearing for appellant.
Madam, ಇದು
respondent number 1, my lord.
ಯಾವ್ದ್ರಲ್ಲಿ?
50.
50.
My lord, we have filed the memo along with documents. Respondent number 1 is deceased, my lord. Yes.
ನಿಮ್ದು ಅಪೀಲು?
ನಮ್ದು ಅಪೀಲ್. ಇಂಜಂಕ್ಷನ್ ಸೋಟ್.
R1 is no more ಅಂತಲ್ಲ.
ಇಂಜಂಕ್ಷನ್ ಸೋಟ್ ಉಳಿದರ ಮೇಲೆ ಪ್ರೊಸೀಡ್ ಮಾಡ್ತೀವಿ. ಉಳಿದ ಇಂಜಂಕ್ಷನ್ ಸೋಟ್ ಉಳಿದರ ಮೇಲೆ ಪ್ರೊಸೀಡ್ ಮಾಡ್ತೀವಿ.
R1. We are for R1.
ಅಂದ್ರೆ ನಿಮಗೇನ್ ಬೇಕಾ ಇಲ್ವಾ LRs?
ನೋಡ್ತೀನಿ, ಎಕ್ಸಾಮಿನ್ ಮಾಡ್ತೀನಿ. ಇಂಜಂಕ್ಷನ್ ಸೋಟ್
ನಾನೇ ಒಂದು ರೀಸನಿಂಗ್ ಕೊಟ್ಟಿದ್ದೀನಿ ನೋಡಿ. ಇಂಜಂಕ್ಷನ್ ಸೂಟ್ ಅಲ್ಲೂ ಯು ಹ್ಯಾವ್ ಟು ಬ್ರಿಂಗ್ ದಿ LRs.
I will file necessary application.
Earlier the very same was answered by this court.
ಮೆಮೋ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ಮೇಡಮ್.
ಕಾಪಿ ಕೊಟ್ಬಿಡಿ, ತೀರ್ಕೊಂಡಿದ್ದಾರೆ ಅಂತ ತಗೊಳ್ಳಿ. R1 counsel files memo reporting the death of R1. R1 ಅಲ್ಲ? R1 along with death certificate. Appellant counsel seeks time to take fresh steps.
LRs
are to make a mention regarding whether LRs are necessary or not. List this matter on ಯಾವತ್ತು ಹೇಳ್ತೀರಿ?
3 days.
ಕೊಡಿ
ಒಂದು
ಮೇಡಮ್.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಯಾವ್ದಾದ್ರು ಅಷ್ಟೊಳಗೆ ಹಾಕ್ತೀನಿ.
6/11.
51.
51 ಹೆಗಡೆ ಸುಮನಾ ಮಹಾದೇವ್ ಇಲ್ವಾ? ಗಂಗಾಧರಪ್ಪ ಇಬ್ರು ಇಲ್ಲ. ಬೋತ್ ಕೌನ್ಸಿಲ್ಸ್ ಆರ್ ಅಬ್ಸೆಂಟ್. ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್. ಯಾವ್ದಾರ ಡೇಟ್ ಕೊಡ್ರಿ ಅವ್ರಿಗೆ ಇಬ್ರಿಗೂ ಇಲ್ಲ ಅಂದ್ರೆ ಕೊಡಿ ನೆಕ್ಸ್ಟ್ January 26ಗೆ. ದೇ ಆರ್ ನಾಟ್ ಶೋಯಿಂಗ್ ಎನಿ ಇಂಟ್ರೆಸ್ಟ್. ಮತ್ತೆ ವೈ ಯು ಹ್ಯಾವ್ ಟು ಟೇಕ್ ಪೇನ್? 13/11
52.
ನಾವು ಕೊಟ್ರು ನಮ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಕೊಡಲ್ಲ. 52 ಶ್ರೀನಿವಾಸನ್ ಹೇಮಂತ ಕುಮಾರ್. ವಾಂಟ್ ಆಫ್ ಟೈಮ್. ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ ಯಾವತ್ ಮೇಡಮ್? 13/11. ಸಮಿತ್ ಎಸ್ ಸಿದ್ದರಾಮಯ್ಯ ವಿಬಿ.
ಫಾರ್ ರೆಸ್ಪಾಂಡೆಂಟ್.
13/11.
54.
ವಿಶ್ವನಾಥ್ ಶೆಟ್ಟಿ ವರುಣ್ ಪಾಪಿ ರೆಡ್ಡಿ. 13/11.
53 minutes may I request for 14th or 15th minutes? Request for 14th or 15th.
14th. ವಿಬಿ ಸಿದ್ದರಾಮಯ್ಯ ಇದಾರ ಇದ್ರಲ್ಲ ಅವ್ರೇನೋ 14th ಕೇಳ್ತಾರ ನೋಡ್ರಿ. ಆಯ್ತು 14/11
ಏನಾಗಿದೆ ಅಂದ್ರೆ ಪೇಪರ್ ಬುಕ್ ಸ್ವಲ್ಪ ಇನ್ಕಂಪ್ಲೀಟ್ ಇದೆ.
ಮಾಡಿ 14/11.
56.
ನೆಕ್ಸ್ಟ್ ವೀಕ್
ಈಶ್ವರ್ ಭಟ್.
Kundika Ishwar Bhatt and G Balakrishna Sastry. Appellant counsel present. Respondent counsel ilva? Absent. List this matter on 13/11 for want of time.
Srinivas SB. Vishwanath.
Appearing for appellant, my lord. My lord, serial number 57, appearing for appellant, my lord. We are ready, my lord. Any date.
After 15/11, any date may be fixed, my lord. 17/11.
57. 13/11 ಬೇಡವಾ? ಯಾಕೆ?
17/11 ಅಥವಾ 18/11
ಆಯ್ತು 4 ದಿವಸದಲ್ಲಿ ಏನಾಗಲ್ಲ. 17/11
ಆಗ್ಬೋದು.
Please, ma'am.
Sudhan MN and Vivek Holla. ಹೇಳ್ರಿ ಏನು?
ಶಾರ್ಟ್ ಕ್ವಶನ್ ಒಂದಿದೆ ಸರ್.
ಏನಿದು?
ಇಶ್ಯೂಸ್
ಸ್ಪೆಸಿಫಿಕ್ ಪರ್ಫಾರ್ಮೆನ್ಸ್
ಕನ್ಕರೆಂಟ್ ಫೈಂಡಿಂಗ್ ತಾವೇ ಅಡ್ಮಿಟ್ ಮಾಡಿದ್ರು.
13/11.
ಪ್ಲೀಸ್
13/11
ಪ್ಲೀಸ್.
59. KV
ನರಸಿಂಹನ್.
Yes, ma'am. Partition suit.
13/11.
13/11.
For want of time, list this matter on 13/11. 14 ನೀವ್ ಯಾರಿಗೆ? 14/11 ಬೇಕಾ? ಆಯ್ತು 14/11.
ಹೇಳಿದ್ರೆ ನೀವು ಸಾಹೇಬ್ರು ಹೇಳಿದ್ರು 52 ನಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ? 52 ನಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿ
52 320 of 21.
Yes.
ಎಂಟ್ರಿ ಮಾಡೋರು ಅಬ್ಸಲ್ಯೂಟ್ ಇದೆ, ಏನಕ್ಕೆ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿಸ್ತೀರಾ? ದೇ ಶುಡ್ ಬಿ ಎಂಟ್ರಿ ಆರ್ಡರ್ ಆಸ್ ಪ್ರೈಡ್ ಫಾರ್ ಲಿಮಿಟೆಡ್ ಅಲ್ಲ ಮಾಡ್ತೀವಿ.
Absolute stay.
Absolute
disposal ತನಕ ಇರುತ್ತೆ.
ಡಿಸ್ಪೋಸಲ್ ವರೆಗೂ ಇರುತ್ತೆ. ಅದನ್ನ ಅಬ್ಸಲ್ಯೂಟ್ ಅಂತ. ಅದಕ್ಕೆ ಗೊತ್ತಾಯ್ತು ನಾನು, ಅದಕ್ಕೆ ಹೇಳಿದ್ದೀನಿ. ಟಿಲ್ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಅಂತ ಇದ್ರೆ
ಕಂಟಿನ್ಯೂ ಆಗ್ಬೇಕು.
ಕಂಟಿನ್ಯೂ ಆಗ್ಬೇಕು. ಅದಕ್ಕೆ ಲಿಮಿಟೆಡ್ ಅದು. ಅಬ್ಸಲ್ಯೂಟ್
ಟಿಲ್ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಇಲ್ಲ ಅಂದ್ರೆ ನಿಮ್ ಡಿಸ್ಪೋಸಲ್ ತನಕ ಇರುತ್ತೆ.